Open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the budget estimates. The Senate has referred to the committee the particulars of proposed expenditure for 2022-23 for the portfolios of Home Affairs and the Attorney General and other related documents. These are budget estimates proceedings, and the outcomes to be heard during today's estimates are from the Attorney General's portfolio. The committee has set Friday the 16th of December 2022 as the date by which answers to questions on notice are to be returned. The committee has also decided that written questions on notice should be provided to the Secretariat by 5 p.m. Friday the 18th of November 2022. Understanding Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following tests of relevance of questions at estimates hearings. Any question going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purposes of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of the Department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policy or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of the 13th of May 2009 specifying the process by which a public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. Mobile phones should be switched off or turned to silent mode. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure budget estimates 2022-23 hearings are conducted in a safe environment. This guidance is also available from the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. In order to comply with COVID safety requirements, senators and Secretariat may use their electronic devices to communicate with one another during the hearing. We ask witnesses forbearance to do so and apologise in advance of any discourtesy. Officers called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphones. I welcome Senator the Honourable Murray Watt, representing the Attorney General. Minister, would you like to make an opening statement?
Good morning, everyone.
I call officers from the Attorney General's Department in relation to cross-portfolio corporate and general matters. Ms Jones, welcome. Would you like to make an opening statement before we go to questions?
Thank you, Chair. Yes, I would like to make a brief opening statement. Thank you, and thank you, committee members, for the opportunity to provide this statement. I'd note the Attorney General's Department purpose is to achieve a just and secure society through the maintenance and improvement of Australia's law, justice, security and integrity frameworks. We support the Attorney General in his capacity as First Law Officer to ensure the Commonwealth's domestic and international legal work is managed effectively, including through oversight and management of legal risk. Since its establishment, the Department's functions and the broader portfolio have expanded and changed considerably to include a much wider range of policy responsibilities and statutory agencies covering the federal justice system, criminal law enforcement and policy, integrity and oversight, national security and international relations, legal services and regulation and reform functions. I thought it would be helpful to briefly provide the committee with an overview of the machinery of government changes that have occurred relative to the Attorney General's Department.
Chair, start, sorry. Will you be tabling that, Secretary? Thank you very much. Is it possible to start the tabling now so we can follow it? If that would be... Thank you.
Senator First, we have sent it around in the WhatsApp group.
I'm being added to it as we speak.
Thank
I
you.
don't think we have actually.
No, I haven't got it
Oh,
yet.
it's coming. Right, okay, because the chair said it had been sent, but it hasn't.
Thank you.
In terms of outgoing functions, the workplace relations functions were transferred from the Attorney General's Department to the Department of Employment and Workplace Relations, including the 10 associated portfolio agencies. Responsibility for the National Archives of Australia transferred from the department to the Department of Infrastructure, Transport, Regional Development and the Arts. Responsibility for the National Emergency Declaration Act 2020 transferred to the Department of Home Affairs. In terms of incoming responsibilities, the National Office for Child Safety and the Open Government Partnership were transferred from the Department of Prime Minister and Cabinet into the department. Responsibility for copyright policy transferred from the Department of Infrastructure, Transport, Regional Development and the Arts to the department. Functions related to combating modern slavery, criminal law enforcement and policy, protective security services, high-risk terrorist offenders were transferred from the Department of Home Affairs to the Attorney General's Department. Portfolio responsibility for the Australian Federal Police, the Australian Transaction Reports and Analysis Centre, AUSTRAC, the Australian Criminal Intelligence Commission and the Office of Special Investigator also transferred from the Department of Home Affairs into the Attorney General's Department portfolio. The administrative arrangement orders were updated on the 13th of October 2022 to clarify that responsibility for cybercrime had moved to the Attorney General's portfolio from the Department of Home Affairs as part of machinery of government changes. A number of criminal justice functions returned to the Attorney General's portfolio, such as strategy and policy to counter cybercrime and child sexual abuse online. This aligns with our responsibility for cybercrime, law enforcement and criminal justice policy and places it in the one portfolio and brings together legislative, policy and operational functions to respond to the growing threat posed by cybercrime. The Department of Home Affairs continues to have a critical role as cybersecurity coordinator across government. Of course, the department continues to work extremely closely with other departments and agencies to ensure close coordination on criminal justice, law enforcement and national security matters. I'd just like to note to the committee that we undertook a restructure of the department that took effect on the 1st of October 2022 to ensure our new functions are fully integrated and balanced across the department to best support us to deliver for government. And we have provided a copy of the revised organisation chart to the committee. We work in close collaboration, as I've said, with colleagues across government to officially facilitate the machinery of government changes and to ensure minimal disruption to business as usual. I'm delighted and incredibly proud of how our respective teams have continued to support significant government reforms throughout this period, such as National Anti-Corruption Commission legislation to implement the outstanding recommendations of Respect at Work, working in close collaboration with the National Indigenous Australians Agency to progress implementation of the Uluru Statement from the Heart, including a referendum to enshrine a First Nations voice to Parliament in the Constitution, establishing justice reinvestment initiatives to support First Nations communities and establishing the Royal Commission into RoboDAP. In addition, we have continued to work to develop our departmental transformation strategy to ensure our organisation is modern, high-performing and committed to improvements that will best equip us to meet our current and future priorities. Thank you.
Thank you very much. Secretary, Senator Scarr, are you seeking the call?
Yes, thanks. Thank you, Ms Jones, and thank you to you and your team for joining us today. And from my perspective, if I can just say how impressed I've been with the work the department's done in relation to the National Anti-Corruption Commission, Ms Chidgey and her team, and also the work that's been done in relation to Respect at Work. We've had a recent hearing in relation to that, and I think the work the department's done has been outstanding.
Thank you, Senator.
So now I've given you the compliment. Can we discuss the machinery of government changes? When did you first become aware of the substantial changes being undertaken through the machinery of government changes that you referred to in your opening statement?
We were advised by the Department of Prime Minister and Cabinet. I have to take on notice the exact date of when we were made aware, but it was commensurate with the announcement that was made by the government.
Okay, so did you or anyone else in your department give you any advice to the Department of Prime Minister and Cabinet with respect to the costs and benefits of the machinery of government changes?
We weren't requested to provide advice in terms of costs and benefits, so I think, as has been the evidence before this committee, in terms of decisions around machinery of government changes, they're generally the prerogative of the Prime Minister of the day, and we were advised of the changes.
Right, so they certainly are the prerogative of the Prime Minister, I understand that, and the Minister at the table made that clear last time we were together. But having said that, the specific question I'm asking is whether or not your views or opinions or your insights with respect to the benefits and the costs, any other implications flowing from the machinery of government changes were actually sought prior to the announcement.
So, no, it was in terms of the announcement, obviously it's a matter for the Prime Minister. We obviously engaged with departments whose functions were either coming into the department or moving out of the department in terms of the implementation of the decision.
I'll move to implementation, but just to tidy up this point, your opinion and insights and views with respect to the benefits and costs of the machinery of government changes were not sought prior to the announcement by the Prime Minister. That's correct?
That's correct.
Thank you. With respect to implementation, how are you doing that practically? Do you have a team that's actually implementing the changes, and do you have an implementation plan? When we had the Department of Home Affairs before us, one of their senior operations general managers was running a change process, had an implementation plan. Would you outline how you're actually achieving the implementation in practice? You talked about the restructure taking effect as at 1 October.
Thank you, Senator. And my Chief Operating Officer, Cameron Gifford, is here, and he oversaw the entire process, including a steering committee that was established with other departments. So I might ask him to provide some answers there.
Mr Gifford.
Good morning, Senator Carr. Senator Scarr.
That's all right.
Good morning, Senators.
I take it as a compliment.
Exactly, hold on.
I take that as a compliment if you're listening, Senator Carr.
Memories,
Mr.
memories
Gifford.
indeed. Great start for the morning. Thank you very much for the question. So,
I hope so.
just in terms of the implementation, so I am the Chief Operating Officer, Cameron Gifford, from the department. So we had multiple steering committees and also an internal working group because this department was subject to 4 machinery of government changes. So we were working with the Department of Home Affairs for transfer functions into the Attorney General's Department, working with the Department of Infrastructure to see the copyright team transferred in, working with the Department of Employment and Workplace Relations to see our then named Industrial Relations Group transferred out, and with the Department of Prime Minister and Cabinet to see the National Office for Child Safety as well as the Open Government Partnership transferred in.
So it's been very complicated. You've had departments and agencies coming in, and you've had you've had responsibilities moving out and agencies moving out. Is that correct?
That is correct, and to support that then there was a steering committee with each of those partner departments to make sure that we could work through the implementation of each of those moves. Internally as well, we set up a working group within our enabling services teams to make sure that we could then work through that in a systemic way.
Okay. How much has this cost in terms of, there's the time cost, you've referred to a number of steering committees, presumably there's actual financial cost, there's the IT systems, which maybe data has to be transmitted across or transferred across between departments. What are the cost implications? How many people have you had working on this project?
Yeah, Senator, so we have at least 3 to 4 different streams of work going on within each of those MOGs. So as you've indicated, we had to work through the IT changes, the personnel changes, the financial changes as well. So our enabling services group was absorbing that effectively in terms of the people hours that was necessary to support each of the implementation of those MOGs. We didn't set up a cost centre so as to be able to record that along the way because it was being absorbed in terms of the ordinary costs of doing business. To be perfectly frank, Senator, I think to do so would actually have been an additional burden in itself to have that tracked down to what the actual cost was.
Well, it would be an additional burden, but there's obviously benefit in terms of actually tracking particular costs that have been incurred for a particular purpose. And just off the top of my head, I can think of the benefit in terms of looking at the cost performance of a particular department or function, and you'll have to take into account if that cost function or cost code includes the costs of the machinery of government changes, because you didn't have any input on those. So it would be wrong for us to say, well, why are those costs blown out? So that's the benefit of actually having a separate cost code. Are you able to identify the quantum of the costs incurred so far?
We could give a rough estimate in terms of how many people are involved, but then the people...
So perhaps if I can ask you just at this stage, if you could give an estimate in terms of what you think the people involved in terms of the process have been, and what the costs, financial costs so far, which you've had to allocate across the various departments have been.
We haven't undertaken an exercise to complete that estimate. As I was about to complete saying, we could make an estimate based on the people involved and the amount of work that was being done. The thing that makes that a little bit of an imprecise activity is that those same people also had core functions that they were carrying at the same time. So it's not as if you can allocate a single person who was offline for this purpose. This was being absorbed within the existing responsibilities of our officers.
Okay, well, if you can perhaps take on notice whether or not there's any information that you can obtain to provide this committee with more detail with respect to the number of personnel involved in terms of this process, and any estimate you can provide with respect to how much of their time was incurred, and to the extent you can provide any information on costs, that would be helpful. But Mr Gifford, it would be fair to say this has been a major undertaking?
I don't think there's been a time in the department's history where we've had 4 MOGs at the same time, so it's a significant undertaking, yes. But I should also say it's a well exercised business that routinely happens to departments and agencies. This isn't the first time for AGD that we've been MOG'd in this fashion.
It's a verb, is it?
It is a verb to be MOG'd.
To be or not to be, to be
we
MOG'd or not
MOG'd
to
at
be
various
MOG'd.
points in time.
Yeah.
But it is well exercised, so it's not a new imposition. It is a part of the cycle of government.
But this is the first time the department's been the subject of 4 MOGs at the same time, in your knowledge, is that correct?
Certainly the first time we were subject to 4 at the same time. We have had larger MOGs in the past. So, for instance, when the Department of Home Affairs was created, that was quite a significant undertaking in terms of its scale and scope. So I would suggest that's probably larger than what occurred in this instance.
Okay, thank you. Ms Jones, you refer in your opening statement to the Administrative Arrangements Order dated 14 October 2022, which made a change to the matters dealt with by the department by adding cybercrime. Can you explain the background to that change from your perspective? Did the department have any input in that respect in relation to that change of the matters dealt with by the department, namely to add cybercrime?
Senator, my understanding it was a routine update. We, from the time that the original machinery of government changes were announced and the changes to the AAOs, we were aware that criminal justice law enforcement responsibilities had come to the department. Equally, the AFP had moved into the portfolio and brought with it its involvement in cybercrime activity and addressing cybercrime. So we had been operating on the basis that broadly all criminal justice and law enforcement responsibilities had come to the department, and my understanding is on the changes that were on 14 October were for clarity.
So did anyone in the department, did you or anyone in the department advise Prime Minister and Cabinet that, or anyone else, that the change needed to be made for the sake of clarity?
No, Senator.
Right, so when did you first become aware of what you refer to as a routine change? But I must say in that respect, it seems to me that to have a further change occur so soon after there's been a major change has the hallmarks of something that wasn't routine, but something which hadn't been done correctly in the first instance and had to be fixed. So I'm keen to understand the department's role in terms of fixing the arrangements, given there appears to have been an oversight. So when did you first become aware of the change? The change was going to be made?
When it was announced.
Okay, so again, was your advice sought with respect to the need for the change, or what change should be made prior to this further change being made in October?
Well, Senator, as I previously mentioned, from our perspective, it was simply clarifying what we had understood to be the case, that responsibility for cybercrime had come to the department, consistent with all the broader criminal justice law enforcement responsibilities that had come across, and the fact that the AFP had moved into the Attorney General's Department portfolio.
But you had no communication, your input wasn't sought with respect to this clarification before it occurred?
No, it wasn't, Senator.
Okay. I want to ask you, just in relation to how some of these functions work in practice, because there appears to be some overlap, and I can imagine from a departmental perspective as Secretary, you and the Department of Home Affairs Secretary would presumably be having discussions about how this works in practice in terms of any overlap, and to make sure there's cooperation between the two departments. So with respect to the Attorney General's Department, matters dealt with by the department at least cybercrime, and then with respect to the Department of Home Affairs, it refers to cyber policy coordination. How do those fit together? Because I note in your opening statement on page 3 you say, this aligns responsibility for cybercrime law enforcement and criminal justice policy in the one portfolio and brings together legislative policy and operational functions to respond to the growing threat posed by cybercrime, end quote. But in terms of this administrative arrangements order, there's actually a demarcation between cybercrime, which is allocated to your department, the Attorney's Department, and cyber policy coordination, which is in fact with the Department of Home Affairs.
Thanks, Senator. In terms of cyber security and the cyber topic more broadly, it engages the responsibilities of a number of departments and portfolio agencies across government. I think a feature of the Commonwealth Government's approach to cyber matters has been a coordinated effort across multiple portfolios. That's been the case for quite some time now, where the Department of Home Affairs has a leadership responsibility on cyber matters in general, but it works closely with the Defence portfolio and ASD. It works with our department because there's a range of issues that may arise in the context of cyber, whether it's cyber crime, whether it's privacy. It works with the Department of Communications, works with the Department of Foreign Affairs and Trade in terms of our international engagement on cyber matters. So I think there's a well-established approach of a coordinated effort across government, given cyber touches on so many areas of government activity, commercial activity and private activity.
Senator Scarr, do you mind if I ask a follow-up question?
Sure. Well, I'm happy for you to go to just with the follow-up, Chair, on that, and then share the call.
This would be your last question, Senator Scarr.
Sure. So I'm happy to give it, cede it to Senator Patterson.
You've got one question.
Thank you, Chair. Ms Jones, I'm interested in that answer because prior to the election, the then opposition leader, now Prime Minister, Anthony Albanese, gave a speech at the Lowy Institute where he talked about the importance of cybersecurity. And he said, that's why I kept a dedicated role for cybersecurity in our shadow ministry that Tim Watts has performed since 2019. Cybersecurity needs to be someone's day job, not the last item on the minister's to-do list. And since he's appointed Ms O'Neill as the cybersecurity minister, he's repeatedly said, as she has said, that she's the dedicated cybersecurity minister. It doesn't really seem, in reflection on your last answer, that she's dedicated at all, or she's the sole minister at all, or that it's not just the last item on another minister's to-do list, because it is shared now across multiple ministries.
Can I jump in here? Because I think
Senator Watt.
I think Senator Patterson is trying to draw the Secretary into political commentary, which is obviously not an appropriate thing to do. And Senator Patterson will remember from when we talked about these issues at the Home Affairs estimates, that this is the first Australian government that has had a cabinet minister with the role of cybersecurity, and that is a good thing. And Minister O'Neill has been doing an exceptional job trying to fix the enormous gaps that were left in our cybersecurity system from the former government. I don't think it's at all unusual that in a broad policy area there are other ministers who have other roles, such as the Attorney-General in this case, but it is clear that Minister O'Neill is the Cybersecurity Minister, and I think she's doing a terrific job.
Just not responsible for cybercrime.
It's a shame that your government didn't do something about these issues for the 10 years that it had an opportunity to do so.
I think most
Thank you,
Australians would
Senator
think it's a
Patterson.
shame that
You
there's
no
not
longer have the
a
call, Senator
cybersecurity minister
Patterson. You
responsible for
don't have the
cybercrime.
call, Senator Patterson.
Thanks,
Do not
Chair.
speak over me, Senator Patterson, when I am speaking. You do not have the call. I have some questions. Thank you. I'd like to take you, Minister, I know you're an avid reader. Are you aware of the book Plagued by Simon Benson and Jeff Chambers? It contains a range of disclosures and discussions and deliberations by Cabinet during the term of the previous government, and it was discussed in some estimates last week, but you were obviously in here. Are you aware of that book?
Yeah, I am aware of that book. I must admit I haven't read the book. I was satisfied with the excerpts that got pretty good treatment on the front page of the Australian newspaper.
Thank you. Last week, the Senate Finance and Public Administration Committee was told that the Department of Prime Minister and Cabinet had referred the book and the disclosures it contains to the Attorney General's Department, which is obviously why I'm raising it now. Minister, can you confirm whether any further steps have been taken by the Attorney General since that time in respect to these disclosures?
I did see that evidence at Finance and Public Administration Committee that involved the Attorney-General's actions. I might have to take on notice, and I'm certainly happy to come back to you over the course of this hearing today with some further information about what the Attorney-General has done.
Okay.
But I think all of us were obviously surprised, including members of the now opposition, that Mr Morrison secretly took over portfolios and appears to have leaked sensitive information from the National Security Committee. So it's obviously a very important issue.
I just want to go to those swearing-ins, as they are referred to. The book itself discloses that Mr Morrison swore himself into a number of portfolios, including the health portfolio. We're beginning there. And it actually raises an issue around the former Attorney General, which is why I have some questions for you, Secretary. The book states Attorney General Christian Porter advised that it could be done through an administrative instrument and didn't need appointment by the Governor-General, with no constitutional barrier to having two ministers appointed to administer the same portfolio. My question, Secretary, is did the Attorney-General's Department ever provide Mr Porter with advice in connection with Mr Morrison's proposed swearing-in?
Thank you, Chair. Chair, I'll just note, I wasn't Secretary of the Department at the time, but based on inquiries that I've taken, the Department did not provide advice to the Attorney General on that issue,
Okay.
the then Attorney General on that issue.
Okay. Given that's the case, did Mr Porter tell the Attorney General's Department that he had provided advice to the former Prime Minister about that issue?
Chair, not that I'm aware of. We obviously, in the context of the inquiry that's being undertaken by Virginia Bell, and obviously with that inquiry on foot, I will be limited in what I would say, but I am not aware of any such advice.
All right. You've made some inquiries in regards to the matter. Can you just clear this up for me then? Did Mr Porter seek any legal advice from any external legal advisors on the Prime Minister's proposed course of action?
I don't have any information on that, Chair.
Okay. Is it unusual for the Attorney General to provide legal advice to a Prime Minister on a novel legal issue without seeking advice from the Attorney General's Department?
I couldn't sort of say, I think you couldn't rule it out from time to time as First Law Officer that an Attorney General would provide advice to a Prime Minister. So I couldn't sort of give you a sense of how often that would be the case, but I wouldn't rule it out that it happens.
Okay. It's pretty unusual though. Minister, you've said that you'll come back with some advice, is that right?
Yes, I will. I've actually got people working on that now to try to get some information. I understand the Attorney General has written some correspondence now that these issues emerged, and I'm trying to track down a copy of that correspondence for the committee as soon as possible.
Okay, thank you. I know Senator Waters has a short section of questions. I'll hand the call to her now.
Thanks very much, Chair. Hi, folks. Thanks for being here today. Can I start first with the open letter from a group of 100 experts in relation to costs in sexual harassment cases? It's received some wide media coverage over the weekend and today, and it was sent to the Attorney and the Minister for Women last Friday. Now, that letter references the proposal for equal access costs in the Respect at Work bill, and it says, and I quote, "The proposed model will ultimately make it harder for targets of sexual harassment to vindicate their legal rights. It will deter women from pursuing cases and reduce the compensation that they will achieve if they do proceed. Taking a cost neutrality approach to a relationship that is characterised by endemic inequality only serves to entrench that inequality." So can I please ask, have you seen that letter and what action has been taken in response to that letter?
Thank you, Senator. And I don't have a copy of the letter in front of me. I am aware of media reporting this morning in relation to it. So I'm mindful of the fact that we don't actually have the letter with us. But I think Deputy Simon Newnham can give some information in relation to that.
Thank you.
Good morning, Senator. Simon Newnham, Deputy Secretary, Integrity and International Group. Senator, we haven't seen that letter. All we could say is that in the course of assessments of various models, this was the model put forward by the Human Rights Commission and preferred. It's the model that we've taken into the bill that has been endorsed by the committee. And we'd note that it's also the model in relation to costs that has been consulted with various stakeholder groups over the course of working through the outstanding legislative amendments that respond to the Respect at Work recommendations, of which, as you would be aware, 7 are part of that legislative reform bill.
Look, I've got an electronic copy of that letter that I'm able to table if that would assist, but I'm wondering, given the urgency of the matter and the legislation's before the House today, and the letter was sent last Friday, is that usual that you wouldn't have seen the letter yet? It's and I can certainly forward that now to the Secretariat if that would assist.
Senator, sorry.
Senator, I was just going to note that obviously this is a matter that is under the outcome for the International and Integrity Group that was scheduled to be later in the day, not part of cross-portfolio.
I think everyone's very happy to assist Senator Waters, but it may be that the relevant officials who've been directly involved in this are available when we get to the, is it IIG, International and Integrity Group? And I think that's actually later this morning, so not too much later in the day.
Okay, so we don't have any of those folk in the room here because I confess, like normal, I'm juggling 3 committees today.
Well, Senator, I would certainly offer Ms Nawaz, my colleague, to speak, including on one of the matters I just mentioned a moment ago.
Yes, please, thank you.
Senator Aisha Nawaz, I'm the Assistant Secretary of the Human Rights Branch in the Attorney General's Department. Senator, can I just clarify, without having the benefit of the letter in front of us, which model are you speaking about in terms of cost? So there's 3 models on the table.
So
Mr Newnham was talking about the cost neutrality model, which is currently included in the bill. As he said, it's been consulted on. It's supported by the Australian Human Rights Commission in their most recent Free and Equal Access report. Is that the model you were asking of, or was there a different model?
No, clearly the letter needs to be read. There's 100 eminent legal, academic, union, all sorts of experts that have signed on to this, most of whom are practitioners in the sexual harassment case.
Senator
Yes, thank you. I have just forwarded that to the Secretariat to do so. Can I finish, please? The substance of the letter goes to the notion that if parties bear their own costs subject to the court determining otherwise, that will have a deterrent effect on women taking action. The proposal by these experts is that it be an equal access or asymmetrical costs approach, whereby the complainant can successfully be awarded costs if they win, but they will not be subject to paying the other side's costs if they lose, which I understand is what happens with whistleblowers. So not sure why whistleblowers are more important than women. They're both important. And also a bit concerned that it seems the letter either hasn't been received or hasn't been read.
Well,
If you can clarify, has anybody read this letter?
Well, as I say, it may be that the relevant officials who've been dealing with this are available at the time that this matter would ordinarily be discussed. I don't think you should infer that no one.
I'm just asking. Okay, look, I'll attempt to come back then. Well, I'll move on then in the brief time that I've got left. The settlement agreement between the government and Ms Rochelle Miller was not subject to a non-disclosure agreement. Consistent with recommendations in the Respect at Work report, has the Attorney-General's Department adopted a policy against imposing non-disclosure agreements on settlements in relation to harassment, bullying and misconduct?
Good morning, Senator. Michael Johnson, Assistant Secretary, Office of Legal Services Coordination. Apologies, as I was walking up, could I ask you to repeat the question, please?
Non-disclosure agreements. Has the department adopted a policy against using them in bullying, sexual harassment and the like cases?
No, Senator. The department has not adopted any new policy. The policy of government is already set out in the Legal Services Directions. That provision provides that essentially transparency by default, and that the Commonwealth in legal claims should only seek confidentiality if it's necessary to protect the interests of the Commonwealth.
Okay, so the Respect at Work recommendations were clear that there should that non-disclosure agreements should not be used in harassment, bullying and misconduct cases, and you're saying that the department simply has a policy otherwise. Is that right?
No,
Senator, perhaps if I could. I think there's been some work underway since
I believe
the
there is
release
some
of that
work
report.
underway, and I'd be keen for an update on that.
To review the approach in relation to non-disclosure agreements. So I'll ask Ms Nawaz to talk to that.
Thank you.
Senator. I might just start by reading out the recommendation just to make sure we're on the same page. So that's recommendation 38 of the Respect at Work report. Senator, it does not preclude the use of non-disclosure agreements or confidentiality clauses. Those terms are used interchangeably. So that recommendation says the Australian Human Rights Commission to develop guidelines or a practice note for best practice principles for the use of non-disclosure agreements in workplace sexual harassment matters to inform the development of regulation on NDAs. So the update I can provide you, and I understand this came up in the Finance and Public Administration Committee hearing as well last week, the update I can provide you is that this department is supporting the Respect at Work Council to finalise the guidance material. The heart of the Respect at Work report essentially went to the issue of there being insufficient guidance available for employees and employers as they were navigating this complex topic. So that's why the recommendation is focused on finalising guidance material. The work that we're doing with the Respect at Work Council also includes the Human Rights Commission, law firms and legal practitioners, and also non-government organisations. And we're expecting that the guidance will be published by the end of the year on the Respect at Work online platform. So the key heart of the guidelines, they're trying to balance the consideration, Senator, about ensuring that the confidentiality clauses don't conceal or protect perpetrators or prevent organisations from taking meaningful action to eliminate sexual harassment, but at the same time, they're seeking to support people who've experienced harassment who may wish to keep their matter private and deal with it in an efficient way. So really trying to balance those two considerations in the guidelines.
Thank you. I have more questions, but I fear I'll be testing everyone's patience if I persist. So, Chair, I will seek to come back later. Thank you.
Thank you. I've just been advised we've got media who would like to take photos of film. There's no objections to that occurring. Thank you, Senators. Senator Cash, you have the call.
Thank you very much. And Secretary, if I could just turn to now the issue of cost orders and the follow through with cost orders. Yep. Thank you. Just in the first instance, can I just confirm that the Attorney-General and the Attorney-General's Department are responsible for the Legal Service Directions 2017?
Yes, Senator, that is correct.
And Mr Johnson, I believe you'll be able to assist me. Thank you. And just in terms of the Legal Service Direction, and I do know from previous experience, you know them obviously very well, But just in terms of confirmation, the legal service directions themselves state if the Commonwealth enforces cost orders or is seeking to recover costs, it's not breaching the Commonwealth's obligations as a model litigant. In other words, the Commonwealth is able to enforce a cost order.
That's correct, Senator, yes.
Thank you very much. Just in terms of also then the public governance, performance and accountability rules, they basically state they require non-corporate Commonwealth entities to pursue the recovery of debts unless there are three circumstances that are complied with, or should I say one of the three. The accountable authority considers that it is not economical to pursue recovery of the debt, or the accountable authority is satisfied that the debt is not legally recoverable, or the debt has been written off as authorised by an Act. So they would be the circumstances in which the Commonwealth could determine not to pursue a costs order.
Senator, those rules are within the responsibility of the Department of Finance.
Yep, they are correct. I understand
they
that.
do interact with
Yes.
the legal services directions, but I must say I'm not an expert in those provisions, so I'll have to take your word for it.
Thank you very much. Just in terms of the responsibility of the Attorney-General, could you just confirm that the Attorney-General is ultimately responsible for all legal cases held by the government and can intervene as appropriate if desired?
I would frame that a slightly different way, Attorney-General. So the first principle is that agencies across the Commonwealth have primary responsibility for the management of legal matters that fall within their responsibility. The terminology we choose to use is the Attorney-General has overarching responsibility. It's deliberately designed to operate in parallel. It doesn't simply fall upon the Attorney-General, and it's a two-track approach to account for both specialisation within agencies and then ability to ensure centralisation and consistency across government. So the Attorney-General has overarching responsibility for all Commonwealth legal work. And yes, the Attorney-General does have some specific powers set out in the legal services directions, one of which is a broad power to issue what's termed a direction to a non-corporate Commonwealth entity in how litigation or claims are managed.
So in saying that, the Attorney-General could issue a direction not to pursue a cost order?
I expect the scope of that provision would allow that, Senator.
Just in terms of the cost orders that the government has followed up since March the 1st of this year, has there been any cost orders that were not followed up or pursued?
If I could just clarify, please, Senator, are you speaking of cost orders in legal matters that fall within the responsibility of the Attorney-General's Department or across the Commonwealth?
Across the board.
So notwithstanding the fact that in supporting the Attorney-General's overarching responsibility, my area of the Department, the Office of Legal Services Coordination, has a reasonably wide visibility of a large number of legal matters, particularly key legal matters across the Commonwealth. We do not have complete visibility of all legal matters across the Commonwealth. That goes to that two-track approach I spoke about. And I'm not aware of any cost orders that were not pursued. That does not at all.
No, so what I might get you to do is, are you able to take on notice then, given that you say you're not aware, are you able to take on notice whether or not there has been any cost orders that were not followed up or pursued? Just so, given you've got that overarching view, we can understand that. And in the event that there were cost orders that were not followed up or pursued, what was the reasoning behind each of these?
So I'm certainly happy to take on notice, Senator, that question and do our reasonable best to provide an answer to it. There is a fairly large caveat, however, to that, which is there is over 100 odd agencies in government. To truly answer that question, we would need to go out to each and every one of them and essentially survey them as to whether they have or have not. And I expect the both the time to do that and the quality
That's
of the,
fine.
of the
I'm
product.
quite sure that you can take the question on notice. You don't have to tell me here and now that you don't have the time and resources to do that, if that's what you're saying. Perhaps you could take it on notice and, to the best of your ability, within obviously what are clearly deficient resources, is what you've basically said, to follow these up, do your best to follow them up.
I will undertake reasonable endeavours.
Thank you very much. Secretary, has the department provided any direction or instruction to any Commonwealth agency or entity to not follow up or enforce any cost orders?
Senator, in terms of direction, I'm not aware of any such direction. I will just check with my colleague, Mr Johnson, but not that I'm aware of.
Not that you're aware of. Mr Johnson?
No, and I would even question, Senator, whether we even have the ability to do that. There is a distinction in a legal claim between whether seeking costs as part of a resolution of a legal claim, as opposed to then once a cost order is
Following
imposed,
it through.
and that would be more of a PGPA question on the agency.
Has the department been provided with any instruction, direction or advice from the Attorney-General or his office in relation to the enforcement by the Commonwealth or a Commonwealth entity or agency of any cost order or category of cost orders?
Senator, not that I'm aware of. I don't believe. I think the answer to that is no.
Could I get you to confirm that? Just to make sure you say I think the answer is no. I will give you the opportunity to confirm that.
Well, I think they might need to have a... I think the Secretary might need to check with a couple of officials.
No, that's what I mean. I will give the Secretary the opportunity to do that
Mr.
and
Johnson,
then come back.
Mr Johnson may be able to assist, Senator, because I think... sorry, I shouldn't say I think. From my perspective, the answer is no. I'll just make sure that there's not any information that Mr Johnson knows that can add to that.
Thank you. Yes, Senator. In my experience, in my knowledge, there has never been a situation where the Attorney-General has ordered an agency to not enforce a cost order. And again, that's distinct from the approach to costs in a legal process.
I'll leave it there for now, Chair, but I do have further questions.
Okay, Senator Shoebridge, you have the call.
Thanks, Chair. There are often compelling reasons why you don't chase up a costs order, including the ability to recover and other discretionary reasons why you wouldn't enforce a costs order. Isn't that right, Mr Johnson?
I expect that is the case, Senator. As I said previously, that really turns on considerations under the PGPA regime, which is the Department of Finance's responsibility.
And the individual case, obviously.
I'm sorry?
And the individual case, the circumstance
I expect so,
case.
yes, Senator.
And you wouldn't want a across-the-board policy to override those kinds of discretions?
I understand there are rules and guidelines from the Department of Finance that go to that exact point.
Secretary, who made the decision, or which government department brought the public interest immunity claim in the David McBride matter?
Thank you, Chair. In terms of... obviously, the McBride matter has been a complex matter. Ms Chidgey has come to the table. I think we can clarify...
She specialises in complex, don't you, Ms Chidgey?
She does.
Can I, Chair, just while Ms Chidgey is getting her answers, can I just check, are we still in corporate?
Well,
Because I expected Senator Shoebridge and others would have questions about this matter. I'm very happy to answer them, but it will be a lot easier if we stick to the timetable and have the relevant officials.
Well...
Minister, can I... Sorry. I am just going to raise that with you, Senator Shoebridge. I also have questions, and I think other senators have questions around various proceedings. And we do have an opportunity in the next section to be asking the Justice and Communities Group those questions.
This is a cross-portfolio question.
Well, my advice... there may not be the officials available, and you may be jumping ahead of time.
Well, if we can be assisted by other officials later, that's fine. But my initial question relates to cross-portfolio. Did it come from the Attorney-General's Department? Did it come from the Defence Department? The instruction to run a public interest immunity claim to knock out most of Mr McBride's whistleblower evidence?
So that matter would be dealt with as part of the Security and Counter-Terrorism Division's matters that are scheduled for later today.
All right. and you don't have an answer now?
Well, there's
Seems to me
Senator
there's an answer. There's an
Senator
answer waiting to
Shoebridge, as someone who used to try to use cross-portfolio to explore all sorts of issues, I know the tactic well, but just as the former government insisted on enforcing the program and asking questions in the right part of the program, I think it's only appropriate that we do that here as well, so that we can provide full answers with all the relevant officials.
Well, it's clearly a cross-portfolio matter.
Well, no, it's a matter involving the...
Right. You don't want to answer now? Okay.
No, please don't. It's far too early in the day to be verbaling anyone. I said earlier, we are very happy to answer the questions, but it assists provide accurate answers if we can do them in the right part of the program when we have the right officials ready.
All right. And you say that it's best covered in which session?
Well, I actually thought it was probably international and integrity, but the Secretary was saying possibly a different...
In national security.
National security and criminal justice at 1:15?
We can come back to you, Senator Shoebridge, at
could I
that
ask
time.
then about, in terms of the OPCAT process, are you in a position to answer that now, Secretary?
That would be covered off with the International Integrity Group.
All right, at 11:15.
Which I think is next, so you wouldn't have to wait long.
And then my last question is about the Republic process. Is that run through?
That would be under
At this
where
stage?
we have constitutional law. So it's in the Justice and Communities Group, which is the next group after we
Next
leave
group.
cross-portfolio.
Right. Well, let's get to them quickly.
Thank you very much. Senator Cash, you had remaining questions for the corporate?
No, I'll have questions later on today in a different section.
I've got a few questions on corporate, if I could.
Or we can move directly to the next.
Oh, I'll ask.
Thank you. We've got 10 more minutes till
they
we
are
move on.
corporate.
Thank
they are
you.
genuinely corporate questions.
We'll see.
I've read the department's, Ms Jones' annual report for the last year, and it's an impressive document. It does beg the question in my mind as to how you measure the performance of your department, and there's a heavy reliance upon surveys with respect to measuring the performance across different outcomes. And going through the relevant facts and figures in terms of the response rates, you've got response rates in the 20s, some 27, 29% in relation to the survey results. How comfortable are you that that survey process actually gives a true indication with respect to the performance of the department? And in particular, to be clear, my concern is if you've got a 29% response rate, that means you've got a 71% non-response rate. And what are the 71% thinking in terms of the performance of the department? That's the material concern I have with that methodology. So interested in your views with respect to that. I'm sure it's taken a lot of discussion in the past.
Thank you, Senator. We actually really appreciate this question because we've done an enormous amount of work in terms of
You didn't
performance
appreciate
reporting.
my earlier questions?
Well, I appreciate all the questions, but this one in particular because the Attorney General's Department was one of, I think, 3 agencies that were the first to start doing the more comprehensive performance reporting in the annual reports. We worked very closely with the ANAO to fully understand what's the most appropriate approach to performance reporting.
Yep.
It's a relatively new process for all Commonwealth agencies. And this is our 3rd year of doing the performance reporting. And I think it's fair to say that we've had to evolve our process over the course of those 3 years. We've learnt a lot in terms of what works in terms of either surveying, rather than just focusing on outputs and numbers, trying to get a better sense of actually, are you delivering through your programs, your policy? Policy is a challenging area to provide performance assessment of. So it's been a big learning for us, and I think we're now in the process of sharing how we've gone about this with other departments and agencies. In terms of the specifics of your question, in terms of the numbers of responses, I'm not a statistician, but my understanding is response rates of around 20 or 30% are actually quite strong in this type of process. But I might ask either Mr Gifford or Ms Carpenter, who's taken the lead on this process, to talk a little bit further about it.
Thanks, Senator. Actually, I'm very excited to talk about the annual report because I don't often get the opportunity to do that. So we have done quite a body of work with our provider for the purposes of the survey this year. One of the things I'd note in relation to your question about the uptake of response rates was actually their experience, and they have much more expertise about running these surveys and getting meaningful responses, is beyond the sort of 20 to 30% mark, you actually don't see any statistically different qualitative results from that. So notwithstanding that we would love to see 100% of people engage with the survey, that's sufficient to get the trends and the feedback that is meaningful for us in terms of our performance. The other thing I'd say, Senator, is we've done a little bit of work with our provider this time around so that we're actually complementing the survey with some engaged interviews with informed observers. So those people who had engaged then were able to sort of sit down and actually have a one-on-one with our survey provider to actually provide really detailed and nuanced views about the department's performance. And in that way we get a really holistic view.
Yeah, so I saw you've got a number of what I'd refer to as deep dive processes where you've got an external panel that comes in and they actually analyse performance with respect to certain areas. In terms of the response rates, the one thing that came to my mind is presumably the people you're seeking responses from are Commonwealth departments or Commonwealth agencies, correct?
Correct.
So why couldn't you simply advise the secretaries of the departments, the chief executive officers of the agencies, that their staff are required to answer the survey, please?
Yes, there's a couple of different things I'd say. It's not just Commonwealth departments and agencies, it's also our key stakeholders, so that includes, for instance, non-government organisations as well. Certainly we do that push, so we reach out, we write out to the stakeholders we're seeking feedback from. We encourage that participation. We forewarn them that it's going to happen. We too are then asked for feedback for other departments and agencies. I think it's fair to say that there's a degree of survey fatigue when these exercises are run. So we continue to review our processes to see if there's another way to sort of push that for a higher response rate. But as I say, we're not concerned that we're not getting meaningful response from a response rate around about 20 to 30%.
Okay, I'd like to take you to table 5 on page 26, if I could, of the annual report.
Yes, thank you, Senator.
So this is an area where the key performance indicator was not achieved, and the result was less than 80%. Can you explain why in that you didn't achieve the relevant result in that context?
Senator, if I could request that the answer to that question is best directed towards the area of the department that's responsible for legal financial assistance schemes, and they will be able to talk to that as opposed to my colleagues from the corporate area of the department.
Right, okay. Well, perhaps this is a reporting question. This will be my last question because we need to move on to the next area. It just seems to me when you put something in a table like that and the result was less than 80%, it begs the question, how far under 80% was it? Because there's no granularity with respect to, was it, I don't know the answer, was it 10%, was it 75%? And obviously there's a big difference between something which is at the lower end of under 80% and something which was on the margins. Can you see the point there in terms of understanding the extent to which the performance indicator was not satisfied?
Yeah, I think that's it's an observation, and the area that's responsible for that will be able to provide you with some more information.
Okay.
Senator, if I could note also in terms of our approach to performance reporting, we did get from the ANAO an unqualified assessment of our approach. So that's for us, that's the first time because we've basically been improving and iterating our approach. So we were pretty pleased with the outcome.
Okay, all right. Okay, thank you.
Thank you.
Nathan.
Well, we're just about to go to morning tea.
Well, I've got some questions. So.
Okay. Well, the committee will suspend for morning tea at 10:15 a.m. and we'll return with cross-portfolio matters after the break. Thanks.
So back at 10:15.
We will resume the hearing. And just before we proceed, I think, Minister, did you have a document you wanted to table?
Yeah, Chair. I think you had some questions about Plagued, the book about Mr Morrison's secret acquisition of cabinet roles. There's a letter that I have here that the Attorney General wrote to Mr Morrison about the issues concerning apparent breaches of cabinet confidentiality. So I've got copies of that, and I have provided them to the Secretariat for tabling.
Thank you. And what is the usual procedure? Would Mr Morrison, is invited to respond, I suppose?
I've only just seen this letter for the first time myself, but in essence, the Attorney-General has written to Mr Morrison expressing concern at the apparent extensive disclosures of cabinet information in the book, refers to what those disclosures are, and ends by saying that he trusts there will be no further disclosures from Mr Morrison's period in government that undermine national security and the integrity of the cabinet process. So it doesn't necessarily appear as if Mr Morrison is expected to respond, but I guess he may choose to do so.
Thank you, Minister. I am advised that senators have no further questions for cross-portfolio, and apologise for that miscommunication before the break. That being the case, I call officers from the Justice and Communities Group, Attorney General's Department. I don't think there needs to be a big change at the table, so I think we can proceed. Senator Scarr, I'm handing the call to you unless...
Yes, thank you. Thanks very much. So I've got some questions in relation to the Office of Constitutional Law branch. Is there anyone who needs to come to the table for that?
David Lewis will be joining us.
Thank you, Mr Lewis. Mr Lewis, how many staff members are there working in the department employed within the Office of Constitutional Law?
David Lewis, General Counsel, Constitutional Office of Constitutional Law. Thank you for the question, Senator. I would have to check that to be absolutely sure, so I'll take that on notice, but it's about 8.
It's about 8, right. And have there been additional staff deployed in that office since the federal election?
Yeah, sorry, I should clarify what I just said. There are about 8 in the Office of Constitutional Law working on our usual work. There have been some additional officers who've joined just temporarily to work on the Voice referendum, and they are by and large located at the National Indigenous Australians Agency.
All right, but they're part of your office?
Yes. Formally, yes.
But they're on secondment if you... They're... Right,
working
okay.
in a joined-up task force.
No, and I can understand that. So how many officers fall in that category?
So there's 3 there now, and there'll be another one soon.
Okay. I saw that the Attorney on June 8 retweeted a post from the Attorney General's Department advertising positions in the Office of Constitutional Law, which I guess is helpful of him to undertake that human resources role in terms of assisting the department to recruit staff. How many officers were employed after that? After the Attorney's tweet?
So
were you overwhelmed with applications?
There were a number of applications. That's right, and that advertisement was primarily for work on the Voice referendum. So for that work, we've had engaged. And they've come from various sources, some within the department, some from outside the department. But there are, as I said, 3 officers who we've formally joined the office to work on the Voice that are now located at the National Indigenous Australians Agency.
Right.
We're in the process of engaging one further officer. And in addition to those, at NIAA, we've engaged one extra officer in the office located where we are at Attorney General's.
Okay, so that's 5. Is that correct,
Yes.
if my math is correct? And presumably there are other officers within the department, other personnel who are also providing support with respect to issues, legal issues arising in relation to the voice. Would that be right?
Senator, I think the entire government efforts associated with the voice and constitutional recognition cover National Indigenous Australians Agency and the department. There's a significant task force over in NIAA. In terms of our input, it is broadly to support the process, but in particular around any of the legal issues associated with it. So it is broadly within the Office of Constitutional Law. Whilst we have various teams working on First Nations justice issues, in terms of the constitutional recognition, it's the Office of Constitutional Law.
Okay. So in that respect, are you leading, is your office responsible for leading any of the steering groups? Are there interdepartmental steering groups that your office has the responsibility of taking the lead on?
There are interdepartmental meetings. They are typically being led by the National Indigenous Australians Agency.
Okay. And in terms of those meetings, there's obviously a process in order to put a referendum to the people. Has any timeline been prepared by the department, or has the department provided any input with respect to timelines?
Well, as you know, Senator, the government hasn't made a decision about when any referendum would be held. As part of the ordinary planning for work towards a referendum, there has been discussions about steps that have to occur along the way to a referendum.
All right. So presumably you've prepared draft timelines and process maps with respect to the process to be followed, is that correct?
There have been documents prepared primarily by the National Indigenous Australians Agency for various different steps that have to be taken towards a referendum.
But presumably the department, your office has provided input in relation to the development of those plans?
Yes.
Could you table any documents that have been prepared in relation to those preparations, including any process maps, timelines, etc., which the Attorney General's Department has prepared in relation to the voice? Options?
So, Senator, as Mr Lewis has pointed out, it is a process that's being led by the National Indigenous Australians Agency. We contribute, but they are leading it. I also would note that there is a Cabinet committee that has been established to oversee the process and decision making, so any documentation may be subject to any issues around being prepared for the consideration of Cabinet, but they are developed by the National Indigenous Australians Agency.
Okay, but I'm interested in the Attorney's Department, Attorney General's Department input in relation to that process. I understand in relation to public interest immunity claims that might be made, but my question is, could you take on notice the provision of any and all documents and advice that have been provided to NIAA or anyone else in relation to the process to put the voice to a referendum, including the timetable, advice that's been given with respect to timetable and any planning that the Attorney General's Department has undertaken?
We can take that on notice, but I do note that we are only providing input. We are not creating the documentation.
No, I know. I emphasise I'm after the input. I'm after the input. So it's a referendum, and clearly there is a legal process to be followed in that respect. And I would have thought clearly the Attorney General's Department has a lead in terms of providing the advice on the legal issues. So I'm interested in relation to the legal input, including with respect to the process. Okay, so if you could take that on notice, please. Can I ask you, the Prime Minister on July 29 announced draft words in relation to a question to be put to the Australian people in the referendum in relation to the voice. And so there were draft words to be added to the Constitution. Did the Attorney-General's Department provide advice with respect to the formulation of those draft words?
Those words were very similar to some words that have been developed by a number of different formulations that have been developed by a number of groups and have been publicly available for a number of years.
Okay, so let's park that. I understand that. My particular question is, what advice did the Attorney-General's Department provide? What role did the Attorney-General's Department provide? Did they carry out with respect to the drafting of those words?
Our department didn't provide any advice on the drafting of those particular words.
So just to get this clear, the Attorney-General's Department did not provide any advice with respect to the draft words to be added to the Australian Constitution that were announced by the Prime Minister on July 29. Is that correct?
That's correct. And as you know, when the Prime Minister announced those words, he said this is a draft for discussion, and there's been public discussion about that draft, and I expect there'll be further discussion before the draft is finalised.
But there was no advice provided by the Attorney-General's Department with respect to the draft words, albeit for discussion, to be added to the Constitution that were announced by the Prime Minister on 29 July.
That's correct.
That's correct. Minister, does that surprise you that the Attorney-General's Department wasn't asked to actually give advice with respect to the drafting of words to be inserted in the Australian Constitution before they were announced by the Prime Minister?
It's not for me to talk about being surprised or not. You've had the evidence from the officials.
Did the Attorney provide any advice with respect to those draft words?
I'd have to take that on notice.
Can you take that on notice, please? And similarly, did the Department provide any advice or input in relation to the draft referendum question, which was announced by the Prime Minister on 29 July?
No, Senator.
So no advice was provided by the Attorney-General's Department in relation to the draft referendum question, which was announced by the Prime Minister on 29 July. Is that correct?
That's correct. We didn't provide any advice to the Prime Minister about that question.
I find that extraordinary, Minister.
Well, it's important to recognise, Senator Scarr, that these are proposed words that have been put forward by the Prime Minister. They're not necessarily the finished product. And the Prime Minister, when he made his announcement, referred to them as a starting point. And we welcome discussion and contributions from all members of the public, and I'd encourage you to put your own suggestions forward, Senator Scarr.
Well, the Prime Minister
You're a
didn't
lawyer.
consult me. I didn't necessarily expect the Prime Minister to consult me, but can I say to you, Minister,
as you know,
sorry, let me finish, Minister. I would expect that the Prime Minister, before tabling, given the significance of the Prime Minister tabling an amendment to our Constitution, would actually seek advice from the Attorney-General's Department with respect to the wording of the proposed amendment to the Constitution, the wording of the referendum question. So I'm absolutely staggered, I'm gobsmacked, to be frank, that the advice of the Attorney-General's Department was not considered, was not asked for prior to the announcement of those draft words.
Well, as I say, Senator Scarr, we would welcome your contribution to these words, as we would the opposition leaders. We're waiting for the opposition leader to tell the Australian public what the opposition's position is on the voice to Parliament. The Prime Minister put these words
Well, with
forward.
respect, Minister, you're deflecting from the key point, which is the Attorney-General's Department has a key responsibility with respect to constitutional law in this country, and they were not even asked for their opinion with respect to the draft words to be inserted in the Constitution.
Well,
it is extraordinary, don't you think?
Well, I think
Don't you believe that?
Well, would you like me to answer?
Absolutely.
Okay.
Not deflect, answer.
Senator
Well,
Scarr.
now's when I get to answer.
Yeah, sure.
Are you ready?
Do your best.
Senator
Are
Scarr.
you ready?
Yeah,
You're not going to interrupt?
I'm waiting.
Minister, just answer the question.
As I have said, when the Prime Minister made his announcement about the proposed words, they are merely that, proposed words, and he invited Australians to have their say. I know your government doesn't have a history of cooperating with state governments, territory governments, the public, industry groups, unions, First Nations people, but we do. And we are doing this in a consultative manner, inviting the wider Australian public to put forward their views about the proposed wording. We will listen to those views, and over the next period of time, the words will be settled, having listened to the Australian public, and you as a lawyer, any other lawyer, anyone from the Attorney-General's Department, anyone at all can have their say, and I think that's a healthy thing.
Senator,
Could I ask a follow-up question?
Could I
Sure.
just one additional point to note for the Senator. The government has established a constitutional expert group to provide legal advice and assistance to the referendum working group that has been established by the government to engage with First Nations people to help the process. So the constitutional expert group is comprised of a range of eminent constitutional lawyers. The attorney met with that group, as did Senator Dodson, on the 28th of October. The department has been supporting the Attorney-General in terms of his engagement with the constitutional expert group, and we anticipate that it will meet a number of times to support the government in determining the most appropriate final wording for the referendum.
So, Ms Jones, can I ask you this?
Senator Scarr,
The
just
cash
in terms
has
of
got a-
timing, this is you're coming up to your last question.
Well, this is a
Senator Scarr
really
wants a
important
follow-up.
issue,
That's
Chair.
fine. You can come back
So,
to it. That's
well,
the
we may
beauty
well
of
have
estimates.
to come back to it.
Yep.
But can I ask you, Ms Jones, your department has got a great deal of capacity and capability with respect to issues relating to the Constitution of Australia, hasn't it? Is that correct?
I'm of the view, yes.
Or am I
with
missing something?
Mr Lewis, yes, yes.
So they would have had capacity, and they would be probably some of the preeminent experts in the country who could provide input with respect to something as fundamental and important as drafting words for an amendment to the Constitution. Isn't that correct?
Well, what I would say is through our support of the Constitutional Expert Group engagement, we are providing that support and advice.
3 months after these words were issued.
These are not final words, Senator Scarr. This is a proposal that the Prime Minister has put forward that he is inviting public commentary on, and Ms Jones has made clear that there is a constitutional expert group who will be advising the government on all of these matters.
Why wouldn't you get
Senator
the input
Scarr,
of the
I do need
department
to
before
hand over
releasing
the
the
call.
words?
Senator Scarr, I am handing the call over. Senator Shoebridge, you have the call.
Can I ask about community legal centre funding? There's $8.1 million announced over 4 years for community legal sector organisations. Additional, can you please clarify which community-based providers of legal assistance are receiving that funding? Where's it going?
Thank you, Senator. I'll ask Ms Harvey and Ms Bogart to provide information on that funding.
Certainly. Did you want to? Sure.
Senator, I do have that information, just if you give me one moment to find it. Thank you, Senator. Esther Bogart, First Assistant Secretary of the First Nations and Justice Policy Division. So the question, just to clarify, was which community legal centres will receive that disaster funding? So in New South Wales, I've got a list. I'm happy to read it out if you like. Or,
Or you could table the list. Is it a long list? Just get started, I reckon.
I might just read it out quickly. Yep. So the Northern Rivers Community Legal Centre, so these are all in New South Wales. The Shoal Coast Community Legal Centre, the Mid-North Coast Community Legal Centre, the Illawarra Community Legal Centre, Central Tablelands and Blue Mountains Community Legal Centre, the Tenants Union of New South Wales, and the Welfare Rights Centre. And then in Queensland, the Caxton Legal Centre, Hub Community Legal, Pine Rivers Community Legal Service, Law Right and Tenants Queensland.
All right. So that's $8.1 million over 4 years. What's the average amount going to those legal centres in each given year?
So it's actually $12 million over the 4 years is the funding that I have. And there will be, each CLC that I listed will receive a total of $1 million over 4 years, so $250,000 each year, approximately.
Yep. Given that the since that announcement was made and the funding was made, the Community Legal Centre has been impacted by a 4.6% increase in the SHADS award. I think that's the Social Community Housing and Disability Awards, but the SHADS award, given that 4.6% increase in the SHADS award, is there an intention for additional funding to meet that award increase?
Senator, community legal centres receive indexation through the National Legal Assistance Partnership that they are funded under. So all community legal centres are funded under that partnership, and that funding that you've mentioned will also be rolled into the NLAP, National Legal Assistance Partnership. So the indexation is set for those slight increases over time throughout the 5 years of that NLAP agreement.
Will that indexation meet that award increase of 4.6%?
Senator, the indexation increase is 1.5% per year.
Yep. So given there's, that means that over the next 4 years, as that 4.6% hits, there's going to be an increasing gap because of the gap between the 1.5% in indexation and 4.6% this year, a further percentage increase next year. What are you going to do to keep the doors open of community legal centres?
Senator, I think I can say broadly we're engaged in discussions with National Legal Aid, with legal aid providers, Aboriginal and Torres Strait Islander legal services and community legal centres. We have in the next 12 months the commencement of a significant review of the National Legal Aid Partnership Agreement between the Commonwealth and the states and the territories. I think that review will be a significant opportunity to look at broadly funding and need across the legal assistance sector, to look at roles and responsibilities between the Commonwealth and the states and the territories, and with a view to looking at how we assist those services meeting demand, and also ensuring that they can attract the workforce that they need. So I think that the point that you've raised in terms of there's been an increase in the award is a good outcome in terms of being able to attract appropriate staff to work in those centres. And through that review, we will look at a range of issues associated
Ms.
with
Jones,
need.
No centre can attract staff if they've had a 4.6% award increase. They've had facing 5, 6, 7% inflationary costs on the rest of their inputs, and then the federal government only gives a 1.5% indexation. You cannot attract good staff with that gap growing and growing over the next 12, 24, 36 months, can you, Ms Jones?
With respect, I don't think the two necessarily directly relate.
Well, tell that to the community legal centres who have massive increasing deficits because the indexation is about a quarter of the inflation rate and a third of the award increase.
I think the point that I was going to make is that there are some very good staff that work in those centres, so they are attracting very good, committed people who work in them.
That is a kind of exploitative model of exploiting people on minimum wages and often impossible workloads because the federal government is refusing to indexation even close to inflation. It's an exploitative model.
I'm happy to jump in here, Senator Shoebridge, and probably like yourself, I've actually volunteered in a number of community legal centres and have a very good appreciation of the important work they do and the hard work that their teams undertake. The first point is to say that the funding agreement with legal assistance services that was negotiated by the former government runs until 2025. So that obviously dictates most of the funding for community legal services. The attorney himself, as you're probably aware, is a very long-standing supporter of community legal centres and has worked with many of them himself, and he's keenly aware of the pressures they are under. And can I point you to the fact that this year's budget contributed $32.4 million over 4 years from this financial year to support community sector organisations with the cost of wage increases and inflation. So we've only been in government for a few months. We won't be able to fix every problem immediately. We are aware of the issues that community legal centres are facing, and our budget does provide some substantial assistance towards this.
But Minister, we've just heard that the indexation rate is at 1.5%. We know the inflation rate is ticking away at 6-7%. We know that the award increase is at 4.6%. And there's no plan that this government has to fix the National Legal Assistance Partnership until 2025.
Well,
what are you expecting
no.
community legal centres to do over the next 3 years as the gap widens, demands increase, and they're being starved of Commonwealth funds?
Well, I don't think it's accurate to say that we have no plan to do something about it. As I say, the budget included $32.4 million over 4 years to support community sector organisations.
And we know
with the
that's
cost of
largely
wage increases and
1.5%
inflation.
indexation.
Senator Shoebridge, please let the Minister or the officials finish their answers before you interrupt.
Senator Tamsin Harvey.
Thanks, Ms Harvey.
Deputy Secretary, Justice and Communities Group. I think there are a couple of different legal assistance programs that this department looks after, and through the National Legal Assistance Partnership we fund legal aid commissions, community legal centres, Aboriginal and Torres Strait Islander legal services, and because that's a national agreement, that indexation was included at the time of negotiation of that agreement, which was a few years ago, as Minister Watt mentioned. We also have some additional funding sources, if you like, through the different programs, and it is those ones that will attract I can't remember the name of it, the community sector organisation funding. So those legal assistance services funded through the Community Legal Services Program, for example, and also some of our family services through the Family Relationship Services Program. But you are correct that that doesn't apply through the National Legal Assistance Partnership. There has been a significant increase in legal assistance. There has been additional funding gone in this budget. There's been additional funding in previous budgets, but that review that we will commence early next year, we would anticipate this would be one of the issues that will come up through that review, and the government is very conscious of the good work that legal assistance providers do and the funding pressures on them.
Where do we find some transparent information about where the NLAP money and the additional funds has actually gone? Where do we find a sort of dashboard about where Commonwealth money is going to community legal centres in particular? So,
Senator, we do publish the National Legal Assistance Partnership on our website, and that certainly talks about the funding that goes to the jurisdictions.
Yes.
That broader breakdown, we may have some detail with us. I might see if my colleague has any, but otherwise we'd be happy to provide that on notice.
Yeah, indeed. If you could, the funding that's gone in the last 12 months and the funding that's budgeted to go over the next 12 months to community legal centres out of that fund. But do you accept that the structural funding for community legal centres, putting outside time-limited programs, time-limited grants, the structural funding to the community legal centre is trapped in a 1.5% indexation over the next 3 years?
Senator, the National Legal Assistance Partnership does set out the indexation in advance.
And that's 1.5% until 2025?
At this point in time.
Senator Shoebridge, this is your last question.
Secretary, do you have an estimate of how far behind that will put the sector as against inflation and the award increase? In terms of purchasing power, if you like, how far behind the sector will be at the end of the NLAP? Have you made that analysis?
I don't have that analysis available now, but Senator, I think it's fair to say that aspect, that issue, amongst many others, will be subject to consideration in the review that Ms Harvey has been talking about.
Yeah, but nothing promised till 2025. This is going to clunk along effectively bankrupting the sector until 2025. That's the status quo.
I wouldn't use the term, accept the term bankrupting the sector, and of course we will continue to work closely with legal aid commissions, with state and territory governments, and look to do what we can to support community legal centres.
Thanks, Senator Shoebridge. I have some questions. I have some questions in regards to Section 78B notices. Now, I admit I did study law, but I'm definitely not an expert in these types of notices, and I just wanted to ask some questions about the purpose of them.
I will ask Mr Lewis to come back to the table. He is the expert on dealing with those matters.
And sorry, I am referring to a notice under Section 78B of the Judiciary Act, and I believe this is a notice that can be issued by a court. Am I right, Mr Lewis? Can you just explain the purpose of those notices?
Thank you, Chair. Yes, so Section 78B requires that whenever a constitutional issue is raised in a court, that the court not proceed with the matter generally. There's some exceptions, but the general approach is unless notice has been given to the Commonwealth and State and Territory Attorneys General of the constitutional issue and the facts relating to that in a reasonable time, for them to allow reasonable time to consider that. And that's related to Section 78A of the Judiciary Act, which then allows those Attorneys General to intervene in those cases.
And normally or how long is a piece of string, but in terms of reasonable time, is that to allow the Attorney General to consider that matter?
That's right. That's the purpose of the reasonable time, and I think what's reasonable will depend on the circumstances.
And after the Attorney General has considered a matter, once a notice has been issued, do they respond to the court that has issued that notice?
The general process is that it's a party who raises the constitutional issue, who issues the notice. No, that's okay. And it is the usual practice that Attorneys General do respond to a notice if there's a decision made not to intervene. I wouldn't say that's always done by all Attorneys General, but that's the usual approach.
And when you say a response to intervene, do you mean so the Attorney General has to make a decision whether to intervene in the proceedings? In what way?
If the Attorney General decides to intervene, they will usually provide notification to the court and to the parties that the attorney is intervening, and that will allow the Attorney General to make submissions on the matters in the case, especially on the constitutional matters, although they're not limited to that.
And if the matter is raised in a lower jurisdiction, does the intervention allow the matter to be moved to Supreme Court, High Court? Is the purpose really to get the matter before a court that has specific jurisdiction in terms of constitutional matters?
I wouldn't say that's the main purpose.
Yep.
The main purpose is to allow Attorneys General to intervene in the case in the court that it's in, okay, and make submissions. But there is a different provision of the Judiciary Act. From memory, I think it's Section 40, which does allow the High Court to remove matters from a lower court into the High Court, and there is special provision, that's for any type of matter, and there's special provision made for Attorneys General to apply to have constitutional matters removed into the High Court.
And how long does it usually take the Attorney General to respond to a Section 78 notice?
I think it varies quite a lot. It might depend on the complexity of the issue, how long there is before the next step in the proceedings. So typically, if it's an urgent matter, it'll be dealt with urgently. If there's a long time, it'll be dealt with on a more routine basis.
Okay. When did the Attorney General's Department first become aware of the proceeding in the New South Wales Supreme Court brought by a member of the New South Wales Liberal Party executive named Matthew Kaminzuli, filed against the former Prime Minister?
I'd have to take that on notice, Senator. My recollection of that matter, which was some time ago now, was that it was all happening fairly urgently. But as I said, I'd have to take on notice exactly when we received that notice.
Okay, and how did the notice come to the Attorney General's Department? Was it raised by the Attorney General himself?
Again, I'd have to take that on notice.
And after you were notified, did the department instruct AGS lawyers to monitor the proceeding? How were you engaging with that proceeding once you were notified?
Again, sorry, I'd have to take that on notice, Senator.
Can you also take on notice whether AGS or the Attorney General's Department were in contact with the lawyers of that case?
Yes, we can take that on notice, Chair.
Okay. And I guess I'm wondering whether you have a time frame about when you were notified. You don't have that advice in front of you?
No, I'm sorry. As I said, my recollection is that it was all quite urgent, so I think it happened in a matter of days, but I'd have to check that.
Did you or the department have any contact with the Prime Minister's office in relation to that proceeding?
I'd have to take that on notice.
That's a pretty significant interaction.
Sorry, Chair, I was just about to say I'd have to take that on notice, but I don't recall having any interaction with the Prime Minister's office.
Chair, it would be unusual for us to have an interaction directly with the Prime Minister's office. It would be
Sure.
through...
And there's a lot of unusual things that happened in the former government. Yeah. Can I just ask, understand the process around the Section 80B notice? A notice under that provision in the Judiciary Act was issued in this proceeding on the 30th of March 2022. When did the Attorney General's Department first receive that notice? Was it conveyed to the department or to the Attorney General's office?
Sorry, Chair, is that a different notice to the one you're referring to?
No.
Okay.
I understand the Section 78B notice was issued in this matter that we're speaking about.
On the 30th of March 2022?
Yeah.
I think, Chair, I've already taken that question on notice as to when we received that.
Okay, that's fine. And in terms of the response, I asked you before how long it usually takes for that intervention to occur. Do you know, is there someone, any of your officers available that know how long the response was?
I don't think we have anyone here who knows already, but as I said, I can take that on notice and seek to provide that information.
When did the Attorney General's Department let Mr Morrison's lawyers know that the former Attorney General would be seeking to remove the matter to the High Court?
Again, I'd have to take that on notice, Chair.
I just have one final question in regards to that. You don't have the details of timeframes, but you understand the proceeding more broadly, Mr Lewis, is that correct?
I do have a recollection of it, yes.
What was the Commonwealth's policy interest in this proceeding?
To tell you the truth, I can't remember precisely what the constitutional issue was, but whenever there's a...
Was there one?
Well, I think that the High Court, my recollection is that the High Court did make an order removing the matter from the lower court into the High Court, and my understanding is that was on the basis that there was a constitutional issue that arose in that matter. And whenever there's a constitutional matter arising in the High Court, we would give serious consideration to whether we should recommend that the Attorney General should intervene.
And is that what you did on this occasion?
I'd have to take that on notice, I'm sorry, Chair.
In terms of the constitutional question that was involved in this matter, when did... are you aware of the outcome in the High Court, Mr Lewis?
My recollection, again, and I can take it on notice to be absolutely sure, but my recollection is that the High Court made an order removing the matter into the High Court, and then it immediately remitted the matter back to the New South Wales Court. And then I think the New South Wales Court made a decision, and there might have been an application for special leave after that to the High Court.
Okay. Why do you know, or do you have advice about what Justice Keifel said about the gravity of the constitutional question, which was the basis for the removal application?
Sorry, I don't recall what the Chief Justice said, Chair.
Okay, we might come back to that. Can I also ask what resources did the Commonwealth spend on the proceeding in total?
I'd have to take that on notice as well.
Okay. The Solicitor General, can I just double check in terms of taking questions on notice? The Solicitor General doesn't bill for his time, is that correct?
That's correct.
Okay. But can you also take on notice how many hours he spent on that matter?
Yes.
And I'd also like to understand how many AGS lawyers worked on the matter as well.
Take that on notice.
Okay, we can put some more questions on notice. I have more questions that I'll come back to, but Senator Cash is not there.
I'll take the call in her
Thank you.
absence.
Yeah.
Is there anyone at the table who can answer questions in relation to the role of the Assistant Minister for the Republic?
I'm happy to
Are you?
try to assist, Senator.
And I can probably assist, obviously, as well.
Okay. Well, Minister, if I can ask you first, it is correct that the government has indicated that there will be no referendum on Australia becoming a republic in this term of government. Is that correct?
That's correct.
Okay.
We're solely focused on delivering the voice in this term of Parliament.
Okay.
And we'd welcome your support.
Okay. Now, so what then is the reason for the Prime Minister appointing an Assistant Minister for the Republic?
Well, I think you'd be aware that in at least the previous term, Mr Thistlethwaite was, I might get the exact title wrong, but I think he was the Shadow Assistant Minister for a Republic, and he may well have held that role even longer than that. I don't think it's exactly a secret that Labor supports the establishment of a republic in Australia, and it's a continuation of the past practice in that role that Mr Thistlethwaite has previously held.
So what's his role then? Is it to prosecute the case for a republic?
Well, he's already said that he's holding some small-scale community meetings around the country, which is about educating people about constitutional change. You'd be familiar, Senator
So he's
Scarr.
educating us as to why we should be a republic, is that correct?
Yes. He's going around...
So he's prosecuting a case?
Well, he's going around the country informing people of Labor's policy, which I think would not be a surprise to you, that we would at some point like Australia to become a republic, but it's not our constitutional priority in this term of office. And I understand there's actually been a media report saying that the Attorney-General is running a national listening tour about this, which is not correct. And as far as I'm aware, the Attorney-General's Department has no involvement in these issues because they're focusing on the voice.
So just in terms of that, the Attorney-General's Department isn't providing any support to Mr Thistlethwaite in terms of his activities in this regard, is that correct?
That's correct, Senator.
Okay, so...
I've actually been advised, just so I get the correct information on the record, Senator Scarr, that Mr Thistlethwaite was the Shadow Assistant Minister for the Republic, for a Republic from June 2019 and Shadow Minister for an Australian Head of State from April 2017. I mean, I think Mr Thistlethwaite undertaking these kind of community conversations is a good thing, and we like to be upfront with Australians about what we like to do rather than appoint secret ministries and things like that.
So he's prosecuting the case for a republic?
If you want to put it that way, yeah.
Well, what other way is there to put it? He's prosecuting the case for a republic. Is that correct?
Again, it might be a strange concept to you, Senator Scarr, but political parties do our political party likes to prosecute, to use your language, campaign, whatever you want to call it, about our political beliefs in public. We don't appoint secret ministers in secret and not tell anyone about it. That seems to be your party's way of doing things.
So, Minister, are you aware of the oration he gave at the Goulburn Soldiers Club on Friday, 28 October 2022?
I think I'm aware that he made an oration because I receive a lot of excellent transcripts of speeches from ministers and assistant ministers in our government, and I think I saw that one.
I don't know how you have the time to read them all, Minister.
Well, I must admit I didn't.
Must be very difficult.
I didn't read that one because I didn't need any convincing that at some point Australia should move to being a republic.
So if I can just ask you, Ms Jones, just for the record, the Attorney-General's Department would have had absolutely no input with respect to this speech that was given by the Assistant Minister at the Goulburn Soldiers Club on Friday, 28 October 2022, is that correct?
That's correct.
That's correct. Well, I'm glad to hear that because I would have been surprised if they had, given the content of the speech, to be frank. Can I ask you, Minister, first,
You do know
do
that
you
it's
think
okay
it's
for
useful,
politicians to express political views.
do you consider it useful in terms of prosecuting the argument for the Voice to conflate the issues of the Voice and the Republic?
I'm not going to express an opinion on a matter outside my portfolios, and I'm here today representing the Minister, the Attorney-General.
Does the Attorney-General think it's useful to conflate the issues of the Voice and the Republic?
Well, I think it's a pretty well practiced practice of estimate committees to not ask or answer questions about opinions.
Okay. There's a quote from the speech that he gave at the Goulburn Soldiers Club. I just want
Do you have
to put it
copies of
to
that
you.
speech? Because I haven't read it.
I do have copies of the speech, so if you'd like a
Table
copy
that,
of
Senator
it,
Scarr.
I can table it. I can indeed table it.
Now everyone can read it.
Thank you for distributing what I'm sure is an excellent speech to the wider Australian community.
Well, look, I think it could be used for many purposes, this speech, to be frank. I'll read you the quote whilst it's been tabled, because I think you'll understand the context in which I'm asking this question. And I quote, "We need a head of state that is accountable to the Australian people and acts in their interests, not the interests of another nation." End quote. And the concern I have, or the question I have, is when did our head of state ever act in the interests of another nation to the detriment of Australia?
It was always Whitlam.
Well, sorry, I think I've got the...
1975?
There was the dismissal.
Well,
You do have the call, Senator Scarr.
I think
Thank
I do
you,
have the
Senator
call.
Shoebridge.
Yep, sorry.
Well, I haven't seen the speech. I haven't heard the speech. I haven't yet received the transcript. I'd be cautious on commenting on a speech that is being quoted from an opposition senator. But what I can say in general terms is that I know that Mr Thistlethwaite, along with myself and probably the majority of Australians, does support the idea of Australia having its own head of state, and that is something that we want to work towards over time.
right. But you're not aware of any situation where our head of state has not acted in the interests of Australia?
I'm not going to comment on a speech I haven't seen.
Okay. Okay. I've got some questions in relation to the abolition of the Native Title Respondent Scheme. Oh, can you? Okay. As I understand it, from Budget Paper 2, there's a saving that's been booked of $6.4 million over 4 years from 2022 to 23, and being $1.8 million per year from the abolition of the Native Title Respondent Scheme, which funds the Native Title Respondent Funding Scheme and the Native Title Officer Scheme. Is that correct?
That's correct, Senator.
What was the reason for the abolition of the scheme?
So the government had an election commitment to stop the Native Title Respondent Funding Scheme, and that was implemented through the most recent budget.
Okay. Was any advice given by the department with respect to a cost-benefit analysis with respect to abolition of the scheme?
Senator, we assisted with the, as you would anticipate, with the implementation of the election commitment. I don't know that we did a cost-benefit analysis per se.
Okay. Who was the last recipient of funding under the scheme, and what were the costs associated with this recipient?
I'm not sure that we have. I'm not sure that I have the detail around the precise last recipient of that scheme. We had a range of grants that have, I think, just expired,
Right.
but I can take it on notice. I think for some of them we do provide that kind of level of detail around the grantees.
Can you take that on
and
notice
we can take that on notice.
provide us with a list of the last recipients of the scheme and what costs were associated, what costs were funded coming out of this scheme, which has now been abolished? How many applications, and maybe you need to take this on notice as well, how many applications were received in the last financial year with respect to the scheme, say the year ending 30 June 2022?
Take that on
I think
notice.
we'll have
You should have that.
If there's any information you can give me now that'd be useful, that'd be helpful.
Senator Sarah Samios, First Assistant Secretary, Courts, Tribunals and Commercial. The number of applications for last financial year, is that the question?
Correct.
Yeah, 342 applications under the respondent funding scheme.
Okay, and how many of those applications were successful? In terms of
269.
269. And do you have any breakdown as to even the nature of the applicants, or is there any?
I don't have that information. We can take that on notice.
Okay, so if you can take that on notice. So the Attorney General's Department wasn't consulted with respect to the decision to abolish the scheme.
Well, that's because it was an election commitment. It's a bit
No, I
like,
understand that.
It's a bit like the discussion we had last week
No, I
where you were
understand
saying
that.
that in
I know.
opposition you should go to tender.
No, I understand. No, I understand. I'm not criticising the department. They, it was the election commitment. Well, Minister, was there any, are you aware, was there any consultation with, say, the National Farmers Federation or the Minerals Council of Australia before Labor made its election commitment?
I'd have to take that on notice.
Can you take that on notice, please?
Sure.
Senator Scarr, I just do have to hand over the call in a moment, if you could.
Yep.
Thank you.
But what I can also tell you, Senator Scarr, because I asked about this, is that the policy rationale, well, I suppose there were two reasons for this election commitment. First of all...
So you can give me the reasons for this election commitment?
Yes, because I've asked.
Yep. Okay.
Obviously, I wasn't the shadow minister, but first of all, as you would be aware, the $1 trillion in debt that your government racked up meant that we had to find savings throughout the budget, and this was one matter that it was decided we could generate a saving from abolishing, and that was also because, as you would know, many of the legal principles surrounding native title issues are now well settled, given that this regime has been in place, the native title regime has been in place for about 30 years, well, exactly 30 years, and it was our view that this funding was not necessary to keep providing, given those legal issues have been settled and given the imperative to find savings in the budget.
Yep. I just have one little question that I think might be totally self-contained, if I can just get rid of it now.
You are stretching.
Okay, let me stretch. In a speech to the Australian Centre to Counter Child Exploitation on 9 September, the Attorney-General announced the appointment of an advisory group to support the delivery of the National Strategy to Prevent and Respond to Child Sexual Abuse. And the question I had was, and you might need to take that on notice, but if you've got the answer, my question really is whether or not the advisory group has been established, who are the members of it, and what role is it playing?
Certainly we should be able to provide some detail around the National Strategy Advisory Group. I know that they have been established and they have met and certainly have attended at least one of those meetings, but my colleague Ms Kilpatrick
that
might be
was the
better
main point of the
placed.
question, so I'm not seeking any in-depth answer, but if there's anything to keep things moving along.
Thank you, Senator Scarr. I'll just hand over the call to Senator Thorpe, who has questions.
Thank you, Chair. My question is
Thanks for that. Sorry.
in regard to the matter of sovereignty as affected by the First Nations voice to Parliament. Is it the intention of the government to cede First Nations sovereignty through the First Nations voice to Parliament?
Sorry, Senator, I'll wait till Mr Lewis has come to the table. I'm not sure perhaps if you could expand on that question so we can accurately answer it for you.
Is it the intention of the Australian government to cede First Nations people's sovereignty in this country through having a First Nations voice in this country?
I don't think we would characterise the process around constitutional recognition in those terms, but I might ask Mr Lewis if he can add to that.
I'd agree with that.
So, can you expand on that? Agree on what? What are you agreeing on?
I think in terms of the referendum around an Aboriginal and Torres Strait Islander voice, that goes to the issue of establishing a mechanism for advice to be provided to the Parliament around issues affecting Aboriginal and Torres Strait Islander people.
I understand that. Does it cede sovereignty though?
That's a separate issue.
Does it cede sovereignty is the question. I understand what it is or what it's meant to be or... but does it cede First Nations sovereignty in this country?
Senator, I don't think that would be the way we would characterise it. As the Secretary has said, as I'm sure you're very well aware, the proposal for a referendum for a voice to Parliament is part of this government's commitment to implement the Uluru Statement from the Heart in full, and that of course includes the establishment of a Makarrata Commission for truth-telling and agreement-making.
I understand that.
So I guess it's one...
It's not my question though, with all due respect. The question is First Nations people being sovereign people of these lands for thousands and thousands of generations. We are sovereign people. The question, very clearly, does going into the Australian Constitution through the voice cede the sovereignty of First Nations people in this country?
The answer is no, Senator Thorpe.
It doesn't.
No. And the departmental officials have twice said to you that they wouldn't characterise it that way, and as the representative of the Attorney-General, I can say it doesn't, from the government's point of view.
Great news. So when you say, so if our sovereignty is not ceded, what do you base your statement on that First Nations do not hold sovereignty?
I think we're getting into matters of constitutional law and Australian history, which are important questions to get into. I don't know that we can provide you with a full answer to these questions at this point. What we can talk to you about is the government's policy, the work that's being undertaken to deliver it, our attempts to gain support for this across the Parliament, and as I said to Senator Scarr, I'd welcome your support, Senator Thorpe, for the voice to Parliament. I'm not quite sure what the Greens' position is on the voice to Parliament.
I think, with all due respect, I'm not asking for a narrative of what you want to find out and what you're thinking. My question purely is for First Nations people around the country who don't want to cede sovereignty, given thousands and thousands of generations before the coloniser come just over 200 years ago, and all of a sudden said that they were sovereign. So you're saying, Senator, that it does not cede First Nations sovereignty. However, in my next question, the government is saying we don't have sovereignty.
No, I didn't say that.
We don't hold sovereignty.
No. Our position is that we have listened to First Nations people, particularly the matters arising from the Uluru Statement from the Heart, and it is our position to create a voice to Parliament so that First Nations people can have direct input on matters that affect them. And that's why we're keen to put this to a referendum. That's what I'm saying.
Thank you. I've also spoken to many, many First Nations people around the country because I'm First Nations.
Indeed.
But
well, as I say, I welcome your support.
Given that you acknowledge First Nations sovereignty in this country, and that it is your intention, it is not your intention to cede it through your planned referendum, you must have obtained sound legal advice that it won't do so. Is that correct, Senator?
It's probably best if those questions go to the department in terms of what advice has been provided.
Thank you. Secretary, do you have an answer for that?
Senator, in terms, we are, as we provided advice a little bit earlier on, we are engaged in work supporting the progress of the referendum on a voice to Parliament, and that's been the focus of our legal advice and input to that process.
So no legal advice on whether going into the colonial constitution will cede First Nations sovereignty? Is there any legal advice pertaining to that?
In terms of the way that you're framing that question, that has not been the focus of the work that we've been doing.
Australian Constitution and a referendum for the Australian Constitution, have you ever sought legal advice from the legal experts out there about First Nations sovereignty and whether it cedes sovereignty or not?
So I think just the way that you're framing it is not how we've been approaching this work, and it has been quite focused on looking at the issue of the whole Uluru Statement and the different aspects of implementation of that, of supporting the voice, of looking at the proposed question, supporting the constitutional legal experts group.
Ceding sovereignty.
We haven't been sought to frame any advice in that sense.
So has the Office of Constitutional Law Branch provided any advice to the government on how First Nations voice to Parliament will impact sovereignty of First Nations people?
We have been providing support, as I've previously said, to the process and particularly around the proposed question as put forward by the Prime Minister at the Garma Festival earlier
Anything
this
on
year.
sovereignty?
Not
Ceding.
specifically.
So the question is not about the Constitution, you know, it's not about the words that are being promoted.
Yep.
It's not about talking to the blackfellas. It's talking to your legal experts about First Nations sovereignty. So the question is very simple. Has any of your departments spoken to any of your legal people about how having a voice into the Constitution will cede First Nations sovereignty? It's yes or no. It's about sovereignty, not the three elements of the statement. Sovereignty.
All I can say, Senator, is to repeat that has not been the focus of the work that we've been doing to support the referendum.
So no.
No.
No. So has the government received any legal advice at all on how the voice will impact the sovereignty of First Nations people?
Senator, we have, I can just repeat what I've said. We've been working around the issue of the question that's been put in the referendum. I think we are working closely with the National Indigenous Australians Agency, so it would be important to also discuss this issue with them. But obviously, from the Attorney General's Department perspective, we are focused on looking at legal issues associated with the referendum, and we haven't provided any separate advice around sovereignty in the context of the referendum.
Is it something that you'll now go and do? Is it important?
Senator, you're asking for my opinion about
Well, is
something?
it important for the government
Senator
to find
Thorpe,
out whether
Senator
it
Thorpe,
cedes sovereignty
Senator
or not?
Thorpe, could you please let the Secretary answer the question? We do need to move
I'm not
on
getting
soon.
any
So if you want to
answers.
know that, well, you're entitled to put the question. They're entitled to answer. I will have to move on to other senators in a moment. So if you've got other questions to ask, this is a good time
Thank
to do
you.
it.
Does your department plan on getting any advice about First Nations sovereignty in this country and how it is impacted from the voice to Parliament?
Senator, in terms of any general advice, we're supporting the process, working with the National Indigenous Australians Agency, working with the Constitutional Legal Expert Group, and we will provide advice to the Attorney General and the Minister for Indigenous Australians as required.
Thank you, Ms Jones. My question, just getting back to my question, will your department now go and seek advice, legal advice, about First Nations sovereignty and how it is impacted by a voice to Parliament?
Senator, I think I've just answered that question.
Do you have any other
Could you take
questions?
it on notice?
Well, I think
I've
with
answered.
I mean,
respect,
I'm
Senator
not
Thorpe,
hearing an answer.
Well, no,
Sorry.
Senator Thorpe, with
Just
respect, I
speaking
think
to the NIAA
Senator
is
Thorpe,
not an answer.
order. Senator Thorpe.
Senator Thorpe, with respect, I think you've essentially asked the same question a number of times, and the department has tried to answer that question a number of times. I'm not really sure what more can be provided here, other than the answers that have been provided.
Okay, one more question.
This is your last
Thanks,
question,
Chair.
Senator Thorpe. Thank you.
Beg your pardon?
Is your last question, Senator Thorpe?
Thank you. So, my next question is on the Republic. Your government is considering establishing so-called citizens' assemblies to decide on the best Republic election model, making a non-binding recommendation to the government. Sorry, I'm just a bit annoyed that I didn't get my sovereignty answer question, but when are these assemblies going to be established and how long will they operate for and how many will there be?
Senator, I can't assist. The department at present is directing all of its efforts towards supporting the constitutional referendum around a voice to Parliament, and we have not undertaken any activity in relation to a Republican referendum.
Thank you. Is that part also, you say you're focusing on constitutional recognition, the voice, is that going to include advice on First Nations sovereignty?
I think we've covered that ground already, Senator.
Okay, I am going to hand over the call. Thank you, Senator Thorpe. Senator Smith, you have the call.
Thank you kindly, Chair. I've got some questions on the ban on direct cross-examination in cases involving family violence. Have we got the right officers at the table? Just a little shuffle? Yep.
Very shortly, Senator.
So this scheme's been in operation since 2019. Is it the case that it was underfunded from the start?
Thank you, Senator. Samantha Bing, Assistant Secretary, Family Safety Branch. The scheme was calculated at its inception based on some report that was undertaken by the Australian Institute of Family Study, and demand for the scheme was then estimated in consultation with both the courts and National Legal Aid, and it became apparent reasonably soon into the start of the scheme, which commenced September 2019, in effect, that the demand was greater than estimated.
So when did that become apparent?
In the course of the 1920 financial year.
Okay. How many times has that scheme had to pause because the funding to legal aid commissions had run out?
The department was advised on at least 2 occasions by one jurisdiction that they would likely need to suspend taking new matters. On both occasions, the department was able to facilitate additional funding being made available.
Okay. And are you aware that some families had cases that were only part heard and were left stranded until that funding was resumed, those jurisdictions?
I'm not aware of that fact, Senator.
So you said the funding was calculated based on estimates done by the AIFS. Was it a case that family violence present in cases coming before the family courts then was underestimated? Was that the challenge there?
My understanding that because this program was not going to be means tested, we didn't have a baseline to calculate demand in a way that we would have for other matters where we consult with the legal aid commissions. Since the program commenced, we've now been able to work closely with legal aid commissions to calculate demand using data directly from those legal aid commissions.
Right. So did the previous government ask the department to consider how to better fund the scheme so that families wouldn't be impacted by the funding deficiencies?
Senator, there was a budget measure in the March budget, which did provide additional funding for the cross-examination scheme, which responded to some of those factors that Ms Bing has outlined.
How much was that?
That was 52.44 million over 4 years.
So you said that was the March budget. I thought that was the October budget.
It was confirmed in the October budget.
Okay, so in the October budget we had $52.4 million invested in the scheme. So would that be the largest single investment in the scheme to date, or?
That's over the course of a 4-year period. Yes, that would be the largest scheme over a 4-year period.
Okay. And do you have any evidence that the scheme is achieving its purpose to date? That is, ensuring victims of family violence are able to achieve a just resolution in the family courts?
A review of the scheme was undertaken by Mr Robert Cornell, assisted by Miss Kerry Ann Lunscombe in March 2021, and we're still considering the recommendations of that review, but it has information within it that suggests that the scheme has been effective in supporting people from needing to go through the scheme has been effective in preventing people from being exposed to the trauma of being cross-examined by a perpetrator.
Okay. When are we expecting to see a response to that review?
That's a matter for government.
All right, thanks, Chair.
I'm just going to hand the call over to Senator Antic. Before I do, we are due to move on to Integrity and International Group shortly, Senators. I'll just remind you of the time. Senator Antic, you have the call.
Thank you, Chair. I'm looking for officials that can answer questions about litigation funding.
Yes.
And class actions.
Good to have you back, Senator Antic.
Oh, well, thank you, Murray.
Haven't seen you for a while.
That's good. Would you like me to? I could
It's
indulge.
the second time he's made that observation.
It's the second time you've made
First
that
on the record,
observation.
though.
You should be cautious about doing so, because
No,
I might just tell you why and embarrass you.
Genuinely, I'm
Yeah.
glad to see you.
Yeah, no, I wish I could say the same. There you go.
Seems.
I know I find your contributions very entertaining, Senator Antic, so I'm genuinely glad to see you back.
Once again, I wish I could say the same.
I know what
Anyway,
you really
moving
think
on
about
to
my
business. We're running
contributions.
short of time, Chair. So I've got some questions about class actions and litigation funding. And I want to know, prior to the introduction of the amendments to the Corporations Act for regulating litigation funding schemes, did the department provide advice to the Attorney-General about the impact of these changes? And did the advice include the impact of the changes on members of class action lawsuits, and on what date was any such advice provided?
Senator, can I just clarify, you're talking about the legislation that was introduced, sorry, I don't have the date in front of me either. Is that the legislation that was introduced last year or earlier this year, or are you talking about a slightly different piece of legislation? I just want to be clear about which
Sorry,
piece.
yes, this is the litigation funding, the class action litigation funding of this year, I think it was.
Is this the regulations?
It's the regulation.
The draft regulations? Yes. Yep. And Senator, sorry, so your question was, did we provide advice to the Attorney
Did the department
General?
provide any advice to the Attorney-General about the impact of the changes? And specifically on changes onto the members of class action lawsuits?
Yeah, look, Senator, I might need to take that on notice. Certainly the Treasury has been the lead agency on this, and I don't have that information to hand about whether or not we provided advice to the Attorney-General.
Can you tell me whether, can perhaps the Minister tell me whether the Attorney-General conducted any consultation prior to the announcement, and if so, who was the consultation with?
I would have to take that question on notice, but I think anyone observing the things the Attorney-General had to say about this before the election wouldn't be surprised by the actions he's taken.
So did the Attorney-General or any representatives meet with or correspond with Omni Bridgeway at any time since the election?
I would have to take that on notice, but I assume, Senator Antic, you're raising this because of the issues that attracted some publicity about the Attorney-General and Omni Bridgeway.
No, I'm just asking because
I can assure you that someone as high up the chain as the Secretary of the Department of Prime Minister and Cabinet, when asked, provided advice saying that the Attorney-General had no conflict of interest in relation to these matters.
That wasn't my question.
That's exactly what he said.
Well, I'm happy to table a copy of the letter.
Oh, if you could.
Yeah, please. So I was going to ask when was that communication and what was it, but this is the communication, the letter?
Yeah, so when when these issues arose, the Prime Minister wrote to his secretary of the Department of Prime Minister and Cabinet, seeking advice from the secretary about the Attorney General's position. I don't actually have a date of that letter, but on the 15th of September, Mr Davis, the Secretary of the Prime Minister's Department, wrote to the Prime Minister, and happy to table a copy of the letter, but among other things, Secretary Davis said that certain interests of Mr Davis pose no conflict of interest with his ministerial duties, but I'll let you read the letter for yourself.
Has there been a response issued?
A response?
A response to that letter?
No, the Secretary's letter to the Prime Minister was the response.
That was the response.
Minister, just a follow-up question on that, with your indulgence, Chair, on that specific issue, because I had some follow-up questions on this. Did the Attorney General's Department provide advice to Mr Davis with respect to that letter of interpretation of the Code of Conduct, which says that the word significant should be interpreted as meaning majority?
No, Senator.
So no legal advice was provided by the Attorney General's Department with respect to Mr Davis's interpretation of the Code of Conduct, which interpreted significant as meaning majority.
Senator, that matter is wholly within the responsibilities of the Department of Prime Minister and Cabinet, and not something to which this department has been engaged.
So no advice was received from the Solicitor General with respect to that interpretation, which equated significant with majority?
I am not aware that
Could you
that is
take
the
that
case.
on notice, please?
I think it has to be directed to the Department of Prime Minister and Cabinet.
Okay.
They are responsible.
If you could just check. So you're confident no advice was given by anyone with a connection with the Attorney General's Department with respect to that interpretation of the Code of Conduct, which equated significant with majority?
Senator Scarr, it might be better to ask the Prime Minister's Department what the Secretary's position was based on and what advice he took. That would give you a more comprehensive answer in terms of...
I'm just interested to know if I think the answer is, from the Attorney General's Department, they had absolutely no role in terms of the preparation of that advice or giving any advice on the interpretation of the Code of Conduct. Is that correct?
That's correct.
Thank you.
Has the Attorney General or any of the representatives met with any of the following? Maurice Blackburn, Mark, Slater and Gordon, or Shine Lawyers?
In what context,
In the
Senator?
context of these, or in the context of those amendments to the law, to the class action regulations?
I'd need to take that on notice. I believe the answer would be no, but can I please take that on notice?
Can you take on notice the issue of whether the department has met with any of those similar?
Sorry, I was only answering in the context of the department. I couldn't answer.
Sorry,
for
well, the question
Attorney.
was in relation to both the Attorney General and the department.
Okay. For the Attorney...
I could take it on notice for the Attorney. I assume, Senator Antic, you'd also be interested in any meetings the Attorney has had with well-known opponents of litigation funding and class actions as well, wouldn't you? You'd want to get a complete
You're writing
picture.
the questions now, Murray?
Well, you'd want to get a complete picture, wouldn't you?
You're right. I'll ask the questions.
Chair,
You can answer them.
Point of order. We've
So you're only focused on meetings?
Point of
I'm
order.
only focused
Point
on
of
the
order,
questions
Chair.
I'm asking.
Point of
so
order.
I'll
There's
leave
been
that to
a,
you.
Senator Antic, a member of your...
a point of order, please.
I am taking your point of order. I'm
Well, I haven't
actually...
given it yet.
Well, if you could let me finish.
Sure.
I'm chairing.
Yeah.
I've asked one of your own senators to not interrupt you while you call a point of order. I'm
Yep.
trying to assist.
Thank you.
What is your point of order?
My point of order is, during the course of the morning, we all dearly love our minister at the table and know he likes to engage in verbal repartee, and he does it very successfully. But I think at times it is leading to questions taking far longer to process through this committee, and I would hope we can get through the program today. So I just draw that matter to your attention. I know you've been doing your best to keep him in order, but I think we're getting at the stage where we need to progress through matters.
Senator Antic, you have the call.
Has the Attorney General met with any members of a class action since the election?
Any members of a class action?
Of a class action.
Well, again, I'd have to take that on notice, but
taking a lot
As someone
of
who used to
things on
run
notice
class
this morning.
actions, I know for a fact that some class actions have tens of thousands of members. So I'm not sure that I can give you a categorical answer as to whether the Attorney-General has met with the tens of thousands of Australians who are members of class actions
Well, normally
seeking
there's a
their-
representative
seeking
of-
redress.
Yeah.
So you're talking about lead applicants?
I'm talking about both.
So you want to know whether the Attorney-General has met with any of the tens of thousands of Australians who are members of class actions being undertaken right now?
You are starting to learn, Minister. That's the question.
Well, as I say, I'm not sure that it would be possible to give a categorical answer about whether the Attorney-General has met with the tens of thousands of
The
Australians.
Attorney-General doesn't keep a diary?
I'm sure he keeps a diary,
Really?
but I'm sure he doesn't.
The Attorney-General
ask
doesn't have
every
enough
single
staff to
person
go
he
back
meets
through
with
and-
whether they're
and answer
a
that
party
question.
to a class
Senator
action.
Antic, if you can let the minister answer the question, we
I'm
might
just-
get through this.
I'm not sure how much you know about class actions, Senator Antic, other than what the
Senator-
IPA
no, no,
A lot about
I've-
diary management, Minister, and it's not a
Senator
difficult
Antic,
question.
I've run class
Senator Antic,
actions.
Have you?
Minister,
For one of those firms?
both of you need to listen to me
Thought
when
so.
I am chairing this
Thought so.
hearing. Senator Antic, would you please let the minister answer the question, and then you can ask your question. Minister.
I'm actually trying to be helpful, Senator Antic, because having run a number of class actions, I know a little bit how they work. I don't just read talking points from the IPA and other groups. I've actually done them.
No, you read them from Maurice Blackburn.
No, I've actually run
Where
class
do you
actions.
get your talking points from?
I've run class actions on behalf of Australians who, against governments, against corporations, seeking redress. And they are a very effective
impressed.
tool for the kind of people you claim to represent,
Who?
seeking a redress against governments and corporations.
So there was a question in there somewhere.
And what I'm telling you is that the class actions that I've run, in some cases, there are tens of thousands of members
You're going
of
to
those
take
class
this on
actions.
notice, I think, is the point, isn't it? And you've taken everything else on
I'm
notice
happy
this
to
morning.
take on notice whether
So you might as well add
whether
this to
the
the pile.
Attorney
How about
General
that?
has met with the
Well, what
tens
about
of
the
thousands
question,
of
has the Attorney
Australians
General met
who
with any
run class-
litigation funders since the
Sorry?
election? Any litigation funders? That's a smaller class
I'm
for
happy
you.
to take that
Take
on
that one
notice.
on notice as well.
Well, I don't have his diary in my head. I can tell you what I've been doing, but I don't.
I'm not
I
sure.
can't
You
tell
might take
what-
that on notice as well, though.
Well, I can tell you what I've been doing.
What about
I
any?
can't tell you-
What about any plaintiffs? It just will narrow it down to that. Can you tell us that?
Well, again, I'll take it on notice because
Oh.
I don't. Senator Antic,
I take it on notice.
I don't recall a situation ever where a minister at the table comes to estimates hearings with the complete diary of the minister they're representing
Well,
and
not this morning.
has
this morning, that's for sure.
detail on every single
Senator
meeting. But I'm happy to provide answers. And again, I assume that you would be interested in the full range of meetings that the minister has had, whether it be with plaintiff lawyers, defendant lawyers, litigation funders,
Union
opponents
heavies.
of class actions, the kind of people
John
you hang out
Setka.
with.
Who else is he talking to?
Because I'm sure you'd want a full picture of this.
I'm asking the questions.
So you don't really care whether the attorney has meetings with
So
people
this is
who
not how
oppose
it
class
works. You don't
actions?
get to ask me questions. I get to ask them of you.
Well, I think we all know what's going on here.
Do we?
Yeah.
Okay. All right.
What's the IPA asked you to
Senator
ask
Antic,
next?
Senator Antic, do you have any more questions
Well,
for the minister?
I was going
Or
to ask the
just
question
comments
about whether
under
the
your breath?
attorney sought any advice regarding conflicts of interest, or for any of his members of the ministry that it may have regarding those class action litigation funders or lawsuits when developing the legislation. But I expect you'll take that on notice.
Well, yes, I would, because I
Oh,
don't
yeah,
have the
all right.
answer.
Well, that's my
I'm
10th
gonna stop
question.
you
Have you
there,
taken them all on
Senator
notice?
Antic.
You should get a cup for that.
Senator Antic,
Get some sort of shield,
Senator
perpetual
Antic,
shield.
I'm speaking, so
A
you
notice
are
on
not.
motion shield.
Senator Antic, I can suspend the hearing if you want to continue to
Oh,
talk
do us all
over
a
me
favour, that'd be
as
good.
the chair.
That'd be excellent.
All right, we'll suspend the hearing there because Senator Antic doesn't understand that
No, I
I'm the
understand.
chair.
I understand
We'll
taking on
suspend the
notice.
hearing for a short suspension. Thank you. Resume the hearing there. Thank you, senators. And Senator Antic is no longer here. Senator Shoebridge has the call.
Successful private meeting. A very successful private meeting. The
Minister.
probably to you, but then to the relevant official. Does the department agree with the analysis done by the Australia Institute that some 40% of AAT appointments in the last financial year were political appointments by the previous government. Do you accept that analysis by the Australia Institute?
Look, I'm only very broadly aware of the Australia Institute's analysis of it, but I certainly agree with the proposition that the former government politicised the AAT with an outrageous number of political appointments, yes, and the attorney's on the record saying that as well.
But has the department done any analysis of the extent of politicised appointments of the AAT? Ms Jones, do you know?
Senator, I'd probably
And
frame it
while you were
differently.
coming forward, I asked whether or not you accepted the Australia Institute's analysis that showed 40% of appointments last year were politicised, and that's like an 8-fold increase from where it was 5 years ago.
I wouldn't frame it in terms of analysis of politicisation, but obviously we broadly support the government of the day in terms of appointment processes for tribunals and courts. So I think the challenge is in terms of defining, politicisation. There are people who have had very long careers that may have had some association with government.
But this was the Prue Goward's high-level, former Liberal MPs, former Liberal heavyweights. There wasn't a question about a bunch of these. Are you saying you haven't done any analysis of the politicisation of the AAT?
I think what I can say is the current Attorney-General has asked us to do work associated with looking at implementing a new process around appointments, a transparent merit-based appointment process. We've engaged with the President and the Registrar of the AAT in relation to that. I've met with them twice to seek their input, and we provide ongoing advice to the Attorney-General about that.
My question was about analysing the current state of play and the most recent politicised appointments, and the answer is you haven't done an analysis of the politicised appointments.
I'm not quite sure what you mean by an analysis of politicised appointments.
Have you checked whether or not the Australia Institute's analysis was right? It seemed to be feature heavily in the Attorney's response. Surely you would check whether or not that analysis was right.
We provide broad general advice to the Attorney-General about appointments processes, and I don't think I can add to it anything further than that.
I'm sure you're aware, Senator Shoebridge, but when the Attorney spoke at the Press Club on the 12th of October, he made reference to the partisan appointments to the AAT and the reputational damage that had caused, and said that the government is engaged in a process of looking at reform of the AAT. So
I'm just trying to work out whether or not there's been any ground truthing in the department about that, and the answer I seem to be getting is no.
We have provided and we continue to provide advice and support to the Attorney about appointments processes.
Given the concerns about the politicisation of the AAT and the significant number of appeals that are made from the AAT to the federal court, have you reviewed the fee structure for those appeals?
Specifically, in which jurisdiction are you referring to?
An appeal seeking a review of the AAT decision in the federal court. The filing fee for that is $5,145. Has the department considered whether or not those fees are excessive?
At the moment, I don't think we've had any recent analysis done of that. In terms of the AAT jurisdiction, there's a range of things that I can talk about that we've been
But
doing.
I'd ask you to focus on the question,
Well, I
which
think
is
I've answered it then.
Well, it's more expensive to file a review in the federal court of the AAT. It's about $1,500 more expensive to file a review in the federal court of the AAT than it is to commence fresh proceedings in the High Court. How are those fee structures at all fair? The filing in the High Court, initiating process for an individual in the High Court is some $3,600. If you want to review a decision from the hyper-politicised AAT in the federal court, you're paying $5,145. How does that work?
Senator, I'd need to check. I don't
Well, I've
have
got the fee
information in
structures
front
here.
of me specifically around the fee structure. We're certainly, there are two jurisdictions in particular that we're focusing on in relation to the AAT, which goes to the migration jurisdiction and the disability jurisdiction, where we've seen significant challenges, backlogs, and we've been working across government to look at what can be done to address
But I'm
backlogs.
asking you about a core access to justice issue. If it costs more to review a decision of the AAT in the federal court than it costs to initiate fresh proceedings in the High Court, there's something wrong, isn't there?
You're asking for my opinion, Minister.
Well, Minister,
Senator.
there's something wrong, isn't there? If it costs more to seek a review of the AAT, especially given how hyper-politicised it is in the federal court, it costs more to do that than to commence fresh proceedings in the High Court. There's something wrong with access to justice and filing fees, isn't there?
I'm certainly happy to say, Senator Shoebridge, that the government considers that the AAT is broken in a range of ways.
So it shouldn't cost you $5,000 to
As I
file an
say,
application to fix it.
It is broken in a range of ways. And I remember asking questions about AAT fees myself when I was in opposition. So the government absolutely recognises that the AAT is broken in a whole range of ways, and we have a review process underway.
Yeah, Minister, I join with you in that basic analysis of the AAT, which is why I'm frustrated that it costs more to file an application in the federal court to review a decision of the broken AAT than it does to initiate fresh proceedings in the High Court.
And I think I've asked exactly those questions myself, Senator
But
Shoebridge.
now you're in government and you can fix it.
Yeah, and
that's the point.
Did you hear me say we have a review underway to fix the AAT in a range of ways?
Well, but does that review include the extraordinarily excessive fees in seeking a review of the AAT in the federal court?
I'm happy to take on notice the exact scope of that review, but I can assure you that the government thinks that the AAT needs significant overhaul in a whole range of ways. Appointments, operations, a
But if
whole
some
range of ways.
poor sod wants to challenge a decision of the AAT, they've got to get out a small mortgage in order to commence proceedings.
Senator Shoebridge, the Minister has answered the
I understand the
question.
point you're making, and as I say, I've asked questions almost exactly the same as this.
Can I then ask about the Parliamentary Business Resource Regulations 2017 and whether or not any financial assistance for legal matters was given to ministers or former ministers last year?
Senator, that relates to in the next section, the Integrity and International Group. They're responsible for that.
Cool, so they can be ready to answer how many ministers or former ministers have received financial assistance under those regs for legal matters last
They will
year,
have that information, I think.
including the names and the amounts.
We generally table that information, I think, so...
It's not tabled yet.
I think it's done once a year.
Anyhow, we can
if
get
I'm
a heads
correct.
up. We can get a heads up in the next
We're
session.
about to move to that outcome. Sorry, Senator Shoebridge, do you have more
No,
questions?
I'm being a very compliant senator and trying to keep
We
the
are about to move
timetables.
to that
So,
outcome.
yes.
You'll get an opportunity. Do you have further questions
No,
for this
that's
group?
okay.
Okay. Given there's no further questions for this group, we will move...
Can I just
sorry,
clarify
Of course,
something, Chair?
Senator
Sorry, I do have some questions on the AAT, which I was holding over to that particular section. So there will be people from the department who can answer those questions in relation to the AAT, as well as representatives of the AAT at that point in time.
Well, I will be present
You'll
when
be
the
here.
AAT
Okay.
are
Okay.
appearing, so to
Okay,
the extent
good.
that I can assist, yes.
Thanks.
We have lots of questions for the AAT. Thank you, Senators. I now call officers from the Integrity and International Group Attorney General's Department. And we'll just allow those officers to come to the table. Senator Scarr, I'm proposing to give the call to you.
Yeah, thank you.
Thank you.
I've got some questions in relation to the National Anti-Corruption Commission. So, Ms Chidgey.
I think you know which officer is going to come to the table for that, Senator.
And as Ms Chidgey comes forward, if I can just again compliment Ms Chidgey and her team on their outstanding efforts in a very accelerated time frame, and I certainly was impressed by the everything the Attorney-General's Department has done in this respect, including promptly answering the questions on notice made by humble senators at the Joint Standing Committee.
Thank you.
So thank you very much. I want to ask some questions, and I'm not going to go into the ins and outs of the draft bill. I think that's gone through a rigorous process, as we all know, and I think that's been a positive process. I do want to talk about the budget for the National Anti-Corruption Commission. So in terms of budget measures, budget paper number 2, on page 51, and I'll quote, the government will provide $262.6 million over 4 years from 2022 to 23, including $52.7 million in capital funding and $70.1 million per year ongoing to establish and support the ongoing operation of the Independent National Anti-Corruption Commission. End quote. So my question is, what were the assumptions made in terms of coming up with that figure of $262.6 million? So what were the assumptions made in terms of, say, staffing levels, location of officers, and the number of referrals that the Commission would have to deal with? Can you share with us the basis, the budget assumptions which underpin that $262.6 million?
Thanks, Senator. Sarah Chidgey, Deputy Secretary, National Security and Criminal Justice Group. And I'll also ask my colleague Lucinda Atkinson to add to my answer. Ms Atkinson's team did a lot of work looking at existing commissions, so the Australian Commission for Law Enforcement Integrity, as well as Victorian and New South Wales commissions, and funding and caseload, and had some assistance with the data team in the department to extrapolate and work out what a sort of reasonable funding base might look like, as well as costing out particular elements like staff. I think we're sort of expecting somewhere in the vicinity of about 260 or so staff, depending on elements.
And I don't need precise numbers, I'm just looking for approximations.
I mean, it's sort of, the Commission will obviously have discretion as to how it allocates at different levels of staff that might affect the overall numbers.
So for the purposes of this budget, and I note the Joint Standing Committee, when it's established under the bill, also has a role in terms of overseeing the budget. So that's a check and balance, which I think is very good. But in terms of this initial budget, about 260
so around
full-time
sort of
staff?
260, 270 staff for the Commission. Also looking at the IT systems it would need and other investigative powers capabilities and how it would acquire those.
Okay. In terms of the number of referrals a year, what assumptions were made around the caseload?
We'd need to take on notice that level of detail, Senator.
Can I ask the question this way, just to see if that helps? ACLI, the Australian Commission for Law Enforcement Integrity, has been operating for quite some time. They'll be appearing later today, and they give very transparent reporting, as I'm sure the NAC will, in relation to referrals, processing times, etc. Do you think the caseload of the NAC will be twice as much, 3 times as much as ACLI? Can you give any estimate on that basis?
So I think in terms of the resourcing required for the Commission, it's probably significantly weighted towards how many investigations it undertakes and reports it writes. Obviously, referrals, there's sort of quite a variety, some of which might not have substance, and it will be able to deal with quite rapidly. Obviously, if it moves into undertaking an investigation, that would be more of a resourcing requirement for the Commission. So we'd had a look at that, but would have to take on notice, sort of approximately the figures for investigation and reporting.
Okay. I'm just trying to tease this out a bit. So the $70.1 million per year ongoing, how does that compare with, say, ACLI's budget on an ongoing basis as it was before the change will come in place? Is it twice as much, 3 times as much?
Senator Lucinda Atkinson, Assistant Secretary, Fraud Prevention and Anti-Corruption Branch.
So ACLE's ongoing annual budget is around 25 million, and so under this measure, the portion of the 262.6 that will be allocated directly to the NAC, to the Commission, is around 67.4 million each year beyond the forward estimates.
Okay, so that's a bit under 3 times as much. Okay. Okay. Well, I should ask this question just to close out that particular topic. There is a mechanism whereby if there's a particular investigation that requires additional resources, there is a process which can be gone through to supplement the budget of NAC if required. Is that correct?
I think we have built in the idea that there'd be a review of its budget, I think after 3 years of operation, as well as a statutory, there's a statutory review built in, and obviously that scope each year for it to make requests through the budget process. And as you've mentioned, Senator, that ability for the Parliamentary Joint Committee also to examine budget sufficiency on an ongoing basis.
So we've talked about the number of referrals, we talked about number of staff, location of offices. What assumptions have been made around location of offices?
So we're expecting it will have offices in Canberra, Sydney, Melbourne, Brisbane and Perth.
Canberra, Sydney, Melbourne, Perth, Brisbane. Okay. Okay. I want to ask some questions about, and this will be my final line of questioning, Chair.
Senator Rice.
I believe very strongly in the need to have a strong inspectorate, and I think we received evidence during the Joint Standing Committee in that regard. I note that the budget for the inspectorate on page 52 of budget paper number 2 is $1.9 million over 3 years from 2023 to 24, which is only $600,000 a year. How was that budget arrived at? What are the assumptions underpinning that budget?
So it's designed around the role of the inspector as currently provided for in the legislation, where the inspector's role, so I should say too, there are a number of other oversight mechanisms for the Commission. So obviously the Parliamentary Joint Committee being one, it'll be subject to some oversight by the Commonwealth Ombudsman, the Auditor General. The inspector's role had been designed to be able to respond to any complaints in relation to the Commission, as well as any allegations of corruption within the Commission. And we had calculated, therefore, a part-time arrangement for the inspector. Again, there'd be that scope for reviewing its budget should its workload require that.
Any
design
full-time
that around the legislative scope of its role.
Sorry to interrupt. How many full-time staff dedicated to that role of the inspector?
2.
2. Okay. And you mentioned, Ms Chidgey, that there was consultation undertaken with other state anti-corruption bodies in terms of framing the overall budget for the NAC.
I should say, I think that's sort of more done on the papers with respect to...
paper review?
Yeah, looking at their caseload and funding.
Was the similar exercise undertaken with respect to budgets for the relevant state-based inspectorates?
Senator, yes, although I would note that the scope, as Ms Chidgey has said, of this inspector framework is set at a particular level, and so we took that into account in designing the budget for the role.
And when you say, Ms Atkinson, at a particular level, in the draft bill, that level is less than what applies in some of the other state-based inspectorates, is that correct?
It's different to what applies in some of the other states.
It's different. Is it different because it's less?
I think it's just different, and I mean, there's a different general oversight framework at the Commonwealth level as well. So I think, you know, as I mentioned, keeping in mind the role of the Parliamentary Committee, the Ombudsman, and other integrity agencies.
I'm not trying to trap you. I'm just.
I think that's a yes.
Yeah, I think it is a yes. And so you're aware, aren't you, that, say, for example, in the Victorian Inspectorate, which has a full-time staff of 27 employees, albeit with a broader remit in terms of their role. Evidence was given to the Joint Standing Committee by Ms Cato from that agency that about 40% of their time was spent in terms of their oversight role of Victorian IBAC, which means equivalent of, say, 9 full-time staff for the Victorian Inspectorate dedicated to overseeing Victorian IBAC, compared to what you're telling us would only be 3, or maybe the inspector's part-time, 2 full-time staff with an oversight role for a national anti-corruption commission. You recognise the disparity in terms of resourcing?
I mean, I think I go back to my previous answer, Senator, about the other oversight mechanisms as well, and the way the inspector's role is designed under the bill as it currently is.
Okay, but this bill is still under active consideration in terms of these elements. Is that correct, Minister?
As far as I'm aware, yeah. Of course, we are talking about a National Anti-Corruption Commission and an inspectorate that your government failed to introduce.
Point of order, Chair. Point of order, Chair. I made a number of points of order earlier today. My question was far from combative or loaded. It was seeking to get a cooperative answer. I was getting very cooperative answers from the Department of the Attorney General.
I was being cooperative and reminding you of history.
Minister, the Senator has a point of order.
And we have these repeated interjections from the Minister, which begs the question as to whether or not his mindset has changed from opposition to government yet. But it is most concerning in terms of this committee prosecuting its duty of scrutiny, as is our role as an opposition. I'd seek your assistance.
Senator Scarr, if you ask a question of the Minister, I can't direct him, obviously, how to answer that. And I think you should be fully aware that if you're traversing a topic, the Minister is allowed to respond and talk about what a previous government has done, but that is up to him to answer his question. If he interjects or interrupts you asking a question, I will intervene as Chair.
So you don't think there's anything unreasonable in terms of the gratuitous advice and commentary we're receiving from the Minister in terms of these questions, Chair?
Senator, if you'd like to point to a standing order that allows me to put words into the Minister's mouth, I'm happy to consider it, but if you don't have any other further questions, I can hand over the call.
Sure.
Senator Rice.
Thanks, Chair. Thank you. I want to go to reports last month that the Attorney-General had begun negotiations and consultations on the government's proposed religious discrimination legislation. And the reports were that the faith leaders were expecting a draft bill to be released in the first half of next year. So just starting off with whether that is indeed the case and whether the AG has begun consultations with religious organisations on a proposed bill.
Senator, I'll just wait for the right people to come to the table to talk. Of course, I think one of the first things I would note in this area is that the Attorney-General has made a reference to the Australian Law Reform Commission, and my colleagues that have come to the table can give a bit of detail about that.
Thank you.
Thanks, Senator Rice. Simon Newnham, Deputy Secretary of the International Integrity Group, and I'm joined by Mr Clark, who may be able to speak further about this as well. Senator, what I can say is that on the 4th of November, the Attorney-General announced the Law Reform Commission would conduct that inquiry. There were a number of principles that sat behind that in the terms of reference that were referred. He appointed New South Wales Supreme Court Justice Rothman as a part-time member for the term of that inquiry. It's going to report on the 21st of April. That's the scheduled date. For that, we think that does provide the level of expertise and resources needed to look into those issues by that time. And the government has indicated that it'll be informed by the results of that referral in future legislation. It has certainly referenced legislation in this term of government, but it has not, to my knowledge, Senator, put down any markers on the exact timing for that.
Right. And so was there consultation that began prior to that referral off to the Law Reform Commission?
Senator, I'd defer to the Attorney-General in his office, but I'm aware in the very earliest conversations with the Attorney-General, there have been ongoing consultations with a range of groups, including religious discrimination groups, stakeholders to that work.
Senator Rice, I've just checked with the Attorney-General's office and I understand he has been consulting with stakeholders on all sides of this debate.
Right, okay, which was what I wanted to get some specifics in terms of which religious leaders the Attorney-General had been consulting with and other stakeholders as well who weren't religious leaders. So have you got any further information here as to who he's been consulting with?
I don't, but I'm happy to take any specifics on notice if you'd like them.
Yes, so well, if you could. So how many and which religious leaders have been consulted with since the government came into power, and leaders from groups who could be adversely affected by legislation, such as LGBTIQA+ community members, women and disabled people. How many of those have been consulted with by the Attorney-General since then as well?
Happy to take the specifics. As I say, I'm advised that the Attorney has been consulting people on all sides of this debate.
Is the Attorney-General continuing to do any consultation now after the referral off to the Law Reform Commission has been made?
I might try and get some information on that. I'm not sure if the department knows.
The department doesn't have any further consultations scheduled at present, so I think it's a matter for checking with the Attorney-General.
Okay. And, I mean, in his statement, the opposition leader, Anthony Albanese, in February stated that a future Labor government will protect teachers from discrimination at work whilst maintaining the right of religious schools to preference people of their faith in the selection of staff. So I wanted to know, in consultations that the Attorney-General has had with with the stakeholders, has the Attorney-General explicitly ruled out allowing religious schools to use this approach in order to discriminate against LGBTIQA+ applicants under the cover of preferencing people of the school's faith?
Look, I'd obviously have to take such a detailed question on notice, Senator Rice, but this is obviously exactly the issue that's been referred to the Law Reform Commission, is that they've been asked to provide advice on the most appropriate way of protecting staff members in religious schools from discrimination at work while maintaining the right of religious schools to preference people of their faith in the selection of staff. What I've also been advised, just in relation to your previous question, is that while the matter has been referred to the Law Reform Commission, the Attorney-General and his office continue to maintain dialogue with interested parties on this issue, but the referral has been made to the Law Reform Commission to seek advice on this. Right. But it's not as if it's putting up the shutters, not talking to anyone.
So the Attorney-General will continue consulting with a range of stakeholders?
The word I've been given is dialogue, so I guess that's consultation.
Okay. Okay, look, I will leave it there. Thank you. Thanks, Chair.
Senator Shoebridge, you have the call.
Thanks, Chair. If we could go back to the David McBride matter. Oh no, sorry, that's
in
cybercrime, isn't it? We're here on OPCAT, aren't we? The obligation under OPCAT is a federal obligation, isn't it? It's an obligation of the federal government agreed to under treaty.
In terms of Australia's ratification of OPCAT, that is undertaken by the national government. Obviously, in terms of that, I think it's worth noting that at the time of ratification, no state or territory government objected to the ratification.
Yeah, but that was almost 5 years ago now, December 2017.
That's correct.
Yep, and it's the federal government's obligation under international law, isn't it?
The national government obviously is the state party that agrees to the ratification. I think one of the issues with something like the optional protocol is that it relates to responsibilities in a federation, both Commonwealth and state and territory responsibilities.
You're not trying to suggest other than at international law, the obligation on compliance is with the federal government. They enter into the treaty, they have the obligation under international law. You're not trying to suggest otherwise, are you, Ms Jones?
And I'm saying that the entering into and ratification of the treaty is a national government responsibility, yes.
Yes. And so before the subcommittee on the prevention of torture came out to visit Australia, what steps did the federal government take to ensure that that visit would be successful and that they'd have access, particularly to New South Wales and Queensland jails and detention facilities?
Be happy to share that with you, Senator, because there was an enormous amount of work with the states and the territories over a long period of
But
time.
I'm particularly focused on New South Wales and Queensland, where that work doesn't seem to have borne fruit.
I will ask my colleague to give a bit more detail on that.
Thanks, Senator. Senator, what I can say is that this actually goes back a number of years, of course, to ratification in 2017 and bodies of consultation with all states and territories across the board in that time. You'd be aware that under the OPCAT treaty obligations, there are two main components, a national preventative mechanism component, but also the visit by the subcommittee to detention facilities in Australia. And what I could suggest to the committee is that level of consultation and working through of those obligations has been over a number of years. What I could also say is that this was a visit that had been postponed from 2020 for COVID-related reasons. So it's not that it was a surprise in that sense. Then the visit was actually
more than 2 years' notice. There was more than 2 years' notice. So what did you do to ensure that the UN inspectors could get into New South Wales jails and get into Queensland detention facilities? You had 2 years.
Senator, what I was going to go on to say was after that postponement, we then got advice in July that they would be visiting in October, and they give us the broad outlines of the dates that they would be here. And that, of course, meant that we saw a significant uptick in our engagement with the states and territories on a range of fronts. We met with them, including with New South Wales, 7 times from the 28th of August through until the 10th of October, and multiple communications both on the eve of the visit and then during the visit. And what I can say, Senator, is we sought to address all of the concerns that had been registered with us.
Did you get a commitment from the different states and territories that they would admit UN inspectors? I mean, that was the key question. Did you get a commitment from New South Wales before the UN turned up that they'd be admitted into New South Wales jails and detention facilities?
Senator, all states and territories agreed to facilitate the visits to their facilities, including New South Wales.
In what form did you get that agreement from New South Wales, and who did it come from?
We'd need to take that on notice. I engaged with my counterparts. We had a team that were engaging I hesitate to say this, but almost on a daily basis with all jurisdictions. And we were only notified on the day that the subcommittee were arriving in Australia that New South Wales would not facilitate visits.
And was that, are you saying that was contrary to the earlier position that they had communicated to the Commonwealth?
All the discussions that we've been having with New South Wales to that date were about the broader compliance with OPCAT and the specifics around facilitating the visit. We had not been advised prior to that New South Wales would not admit entry to subcommittee inspections.
Well, that double negative is different to what Mr Newnham's evidence was, that there had been a positive assertion by New South Wales that they would admit UN inspectors. So is it your evidence, Ms Jones, that there was an absence of objection, or is it Mr Newnham's evidence that there was a positive affirmation from New South Wales? What's the situation?
It's a good point to have picked up because...
I just want an answer.
Well, it's in terms of the conversations, they were complex, ranging over many months. We had engaged with New South Wales and had been led to believe that they were working towards being able to admit inspectors. Up until the Friday when the subcommittee arrived in the country, we had not been told by New South Wales that they would not admit inspectors into their
we're due to
jurisdiction.
go to lunch, just to let you know. This will be your last question.
So you had no clarity from New South Wales. You'd had no clarity from New South Wales before the UN inspector arrives that they would admit the UN inspectors. It sounds to me like it was being set up for a complete mess. If you don't have clarity from the largest jurisdiction with the most prisoners that they're going to let the UN in before they turn up, what were you doing for 2 years? What were you doing for 2 years if you didn't get that answered?
So, Senator, we were doing a great deal engaging, as we did with all states and territories.
Did you ask the question?
We were engaging with all states and territories in relation to the
Senator
preparation for this trip.
Did you
for
ask the
inspection.
question? Will
Senator
you let them in?
Shoebridge,
Did you ask New South Wales the question?
Yes, we were
What did they say?
working. We were working specifically towards that, and we were advised that they were working towards facilitating inspections.
Okay, thank you. I'll just leave it there because we are due to go to lunch. We will come back to you after the break and to this group. If I can just ask a follow-up question before we go to lunch. Minister, did the Attorney-General make a statement on these matters? The Attorney-General made a statement on these matters, and what was that?
I think the Attorney-General has already said, in fact, I think it was the 24th of October, the Attorney-General said that the suspension of the UN subcommittee's visit to Australia was extremely regrettable. And what I've heard this morning is that at least since the SPT gave notification of its intention to visit, which was in July, the Commonwealth has worked closely with states and territories to facilitate that visit. So it is extremely regrettable, to use the Attorney-General's words, that New South Wales did not cooperate.
And we will come back after lunch. The committee will suspend for lunch until 1:15. Thank you. And to continue questioning of the Integrity International Group Attorney-General's Department, I hand the call to Senator Scarr.
Thank you, Chair. I wanted to ask some questions in relation to the decision that was made by the Attorney, announced on 7 July 2022 that he had declined to proceed further in the prosecution of Mr Bernard Collary, or Collary. Is there anyone you need to bring to the table?
Come under the National Security Criminal Justice Group. They were the group that was leading that, so that's the next section on
criminal justice.
That's the torturing whistleblowers section.
Okay, all right. I might ask, can I ask a question on the Anti-Slavery Commissioner in this group?
Yes.
Is that in this group?
Yes, it is. Yes, it is. Thank you. Senator, just while the officers are getting ready, so this is one of the modern slavery, one of the areas that came into the department with the machinery of government changes.
Right, one of the many changes that you've been grappling with. Thank you. Thank you, Secretary. Can I ask the department, from your perspective, where are we up to in terms of establishing an anti-slavery commissioner?
We're all racing to answer that. I'll start, Senator. Obviously, that was an election commitment of the government to establish a modern slavery or anti-modern slavery commissioner.
Yep.
And that issue will be looked at, and I'll ask Ms Finney to expand on this, but there had already been underway a review into the Modern Slavery Act being conducted by Professor John McMillan, which is well advanced and will be reporting early next year. And as part of that review, there will be consideration given of the role and scope of an anti-slavery commissioner. But I'll just see if Ms Finney wants to add anything to that.
Frances Finney, Assistant Secretary, Modern Slavery and Human Trafficking Branch. So with respect to the Anti-Slavery Commissioner, as the Secretary has mentioned, it is a government election commitment. There are two key aspects. First of all, As the Secretary has mentioned, there is consideration of the role of an anti-slavery commissioner with respect to the modern slavery legislation that is underway at the moment.
Yep.
And the second aspect is in the recent budget, there was a tackling modern slavery line in the budget that allowed for a dedicated team to be set up within the department to scope the role of the Anti-Slavery Commissioner, which will take into account the outcomes of the review, but also any other aspects to the role going forward.
Okay, so from your perspective, from the department's perspective, it's definite that we are going to have an anti-slavery commissioner. The functions, the particular functions and the scope of that role are still subject to the review that's being undertaken with respect to the existing legislation, etc. Is that correct?
That's correct, and also with respect to the scoping work, so both elements.
Okay.
Yeah.
And what sort of size of team will the Commissioner have? How large will the unit be within the Attorney-General's Department? Are there any thoughts at this stage in relation to that?
In relation to the actual establishment of the Anti-Slavery Commissioner's Office, that's the work that the scoping team will work through and to determine the role of the Commissioner and then the appropriate size of the team and set up arrangements. So that's all to come.
So, Secretary, I think there's a question for you, and that is, as Ms Finney outlined, there is a line item in the budget in relation to establishing this unit, establishing this position.
Not a very big one.
Correct. Well, in fact, it's nothing.
It's hard to see.
Dashes. So there's no extra resources being provided to the department in relation to the establishment of the Anti-Slavery Commissioner. And to quote from the budget, the cost of this measure will be met from within the existing resourcing of the Attorney-General's Department, end quote. Secretary, were you consulted or was the department consulted with respect to being able to meet the requirements of establishing that unit from existing resources?
Senator, obviously the intention to create the role was an election commitment. In terms of the implementation of that, I think from our perspective we recognise we're in the scoping stage. We're very much focused on supporting Professor McMillan in his review of the legislation and any specific recommendations he has coming from that. I think it's our view at the moment that we have sufficient resourcing within the branch to be able to undertake that work. But obviously once there's a clearer picture of what the size and scope of the role will be, we may need to consider additional funding resources for that. I've had discussions with, there's one other jurisdiction that's created a commissioner in New South Wales. I met with the New South Wales Anti-Slavery Commissioner, I think that's the right term for that, to get a sense of how he is resourced in his role and in terms of informing our thinking for what we might need at the Commonwealth level. And I think similarly, the role there started relatively modestly in terms of enabling scoping to happen and then with a view to potentially expanding later down the track.
Right.
So in terms of the specifics, until we have, I think, a clear sense, drawing on the advice from Professor McMillan and how the government responds to his review, we won't know entirely exactly what resources we'll need to support the role.
Well, Ms Jones, I understand what you're saying about it being a fledgling role in the first instance and then it growing. The concern I have, to be frank, is that the budget line item actually has nothing dedicated for the role across even the forward estimate. So, again, I repeat the paragraph, the cost of this measure will be met from within the existing resourcing of the Attorney-General's Department. So does the Attorney-General's Department have extra resources that you can just reallocate to a new function, or is that going to have a detrimental effect on some existing functions?
I think we're always in the process of determining what are the highest priorities and where we allocate resources. We do have extensive responsibilities under the Modern Slavery Act, engagement with civil society, engagement with business, engagement across government with Border Force and other agencies. So I won't... It is a busy area with a lot of important responsibilities, and an area where, unfortunately, there continues to be increased demand for further activity, and we will constantly monitor that to make sure that we've got sufficient resources to support it.
Okay, right. Thank you, Chair.
Senator Shoebridge.
Well, we might stay on modern slavery for the moment. What are the existing resources that are allocated to modern slavery and preventing modern slavery?
Senator, we have a team that we're actually increasing at the moment. So we have a core team of 17 full-time equivalent staff that were involved in the machinery of government changes when we moved from Department of the Home Affairs portfolio over to the Attorney General's Department. Plus, we are looking at bringing in 3 additional staff to assist with the initial new work that we have.
And are they full-time equivalent staff?
Yes,
Ms. Vinnie?
that's correct.
And was there a separate budget item in Home Affairs for modern slavery?
A separate budget item.
A separate budget line item?
So originally there was the National Action Plan budget item in Home Affairs, which was back in 2021, that period.
And what was that?
And that was for the National Action Plan to combat modern slavery, which had 10.6 million allocated to it, of which 4.4 million was administered funding. And then in the March budget, there was an item under the women's safety budget measures that related to forced marriage, and that was just under 0.6 million, which is also being reflected in I think it's in the PBS line item 1.6. And then there's this additional tackling modern slavery, which has 3 FTE. as well.
Given the issue has moved into the attorneys, is the $4.4 million admin line item found somewhere else in the attorney's budget?
Yes, it's in item 1.6 in the PBS, I understand.
And it's been retained at 4.4?
Yes, it has.
Secretary, how will we hold you to account for implementing the Modern Slavery Commissioner if there's not even a bare indication of what the budget will be or what resources are going to be put towards implementing the Modern Slavery Commissioner in the forward estimates? Like it's literally $0 as far as we can see in the budget.
Well, I think that the budget recognises that the department will need to commit resourcing to support it. As Ms Finney has pointed out, there's funding that came across from the Department of Home Affairs to support the branch that does modern slavery work in the department. And in the same way that we will report on the work that we're doing under the action plan, under the statutory review, under engagement with civil society, we will do the work associated with establishing an office.
Talking about the work that's been done, the most recent Commonwealth Statement on modern slavery identified a series of supply chain risks and operational risks: cleaning and security services, investments, textiles procurement, construction and ICT procurement. In undertaking that due diligence, has the Commonwealth identified evidence of slavery in those supply chains?
Senator, the way the Modern Slavery Act is constructed, it is to describe the risks. It's not constructed to identify cases of modern slavery per se, but it doesn't prohibit the identification of cases. The question that you've asked would relate to across the 98 non-corporate Commonwealth entities.
Did you identify slavery?
So as to whether they have, so we would have to take that on notice to see if any specific cases were identified, but to my awareness, no, there hasn't been.
Yep. So we have a Modern Slavery Act, which requires reports after reports to be put in by corporations and government, but none of it requires the identification of any actual modern slavery. That's not its purpose. It's not to actually identify where it happens.
It's the purpose of the Act is to to identify the risks within global supply chains and within operations, and to describe the actions taken to address those risks and the effectiveness of the actions.
Minister,
If a case of modern slavery is detected, the advice is for entities to report those to the AFP, and but they're not. So that report would be made to the AFP. It wouldn't necessarily be reported back through a modern slavery statement, because that's not the requirement.
So even when an agency finds modern slavery, they don't have to include that in their statement.
They don't. They're not prohibited from including it, but it's not required. No.
And how many
it's not.
agencies did you say had completed, were part of the statement?
In terms of the Commonwealth statement, it covers 98 non-corporate Commonwealth entities. But in terms of business, that's a different reporting requirement.
All right. No, I'm only talking about the Commonwealth. So in 98 agencies, looking across the whole of the Commonwealth supply chain, noting that there are all these high-risk elements in it, there hasn't been a single case of modern slavery identified to the best of your knowledge.
Well, I'd have to take that on notice to check. But what I would say also is just in terms of the construct of the Commonwealth statement, the way it was designed was that in the first year it was a foundation, because this is the only statement of its kind, or the only reporting requirement on government of its kind in the world. So the first year was very much around foundation establishment, and then it was always intended that the last 2 years were around discovery of the risks, and then going forward it is around doing further implementation work where if cases are identified, what the remediation action would be.
At any time in the last 3 years of full operation of the Act, has at any point any Commonwealth agency ever identified modern slavery?
Well, that's what we'd have to take on notice, because as I said, however, I do need to caveat my answer that to make it very clear that if there was a case identified,
I may not have told
it
you.
wouldn't. Yes, they would not. They're not required to report it to this agency. It would go to the Australian Federal Police.
Minister, given it's been in place for 3 years, it's not. The best evidence would suggest it hasn't once identified an instance of modern slavery. Do you accept the critique by the International Justice Mission that the Act and the reporting under it are not substantively, and I'll quote here, are not substantively reducing their risk of, let alone protecting people from modern slavery in their total value chains? It's just not working, is it?
Well, I would certainly agree that the current modern slavery mechanisms that were established by the former government are not adequate, and that's exactly why we made election commitments to strengthen them. And that's why we're undertaking that review right now.
But there's no budget for one of the key measures, which is an anti-slavery commissioner.
No, well, and
it's just going to be scrapped around from
I've heard
internal
officials
resources.
say on a number of occasions that, first of all, that their view is that that position can be funded through internal existing funding without damaging their existing activities. But also remember that the review is underway, won't be completed, I think, until March 2023, and it is likely that there will be some changes to how the modern anti-slavery commissioner operates. So I wouldn't jump ahead and just assume that the way things are at the moment is the way things are going to stay.
Well, surely, at a minimum, Minister, the anti-slavery reporting measures at a Commonwealth level should mandate the reporting of identified instances of modern slavery. And you could do that administratively. Surely at a minimum, if you're doing all this work, spending millions of dollars, at a minimum it should mandate the reporting of instances of slavery.
Well, I'm sure that's something that the review will consider.
In 2023?
No, well, the review is underway and it will be completed at the end of March 2023. And I should say, in a related sense, I'm sure you've seen that horrific reporting that we've seen recently of human trafficking, which is a related issue, and Minister O'Neill has obviously made various announcements about improvements to the migration system that are needed as well.
Well, some of that is occurring domestically, and despite 3 years of activity at a Commonwealth government, millions and millions of dollars spent, there's been better investigation and identification done by journalists than by the Commonwealth government.
Well,
that's a pretty remarkable outcome, isn't it? After 3 years, the journalists are doing it, not the Commonwealth government.
You'll have to ask what are now opposition members of the committee to answer for anything that did or did not occur.
I was asking you about the budget. There's not even a dollar set aside for an anti-slavery commission.
And I'm
You're responsible for the $0 going ahead, Minister.
Well, I can only answer for what our government has done since May, and we made a number of election commitments in recognition that the system put in place by the former government was inadequate. We're intending to deliver them. We have a review underway. It's an issue we take very seriously. I've dealt with this issue myself, Senator Shoebridge, having spoken and met with stakeholders about it over the years. It's something we've got to do better on, and that's exactly what we intend to do.
When can we expect an anti-slavery commissioner, a Commonwealth anti-slavery commissioner, to be in place?
So, Senator, I think we will await the outcome of the Professor Macmillan review. Obviously, the government will need to respond to that, and I think that will inform the final form of...
but there's an election commitment, and there's apparently a budget commitment to establish an anti-slavery commissioner. So the commitment's in place. That doesn't have to await the review. When are we going to get one?
As I said, I think...
In the fullness of time, in due course, after another year?
I don't think that's
Shoebridge,
that's a fair characterisation. I think there's a review in the legislation underway, and I think it's appropriate to see the outcomes of that review to inform the role.
Going back to the OPCAT, can you indicate when, if ever, the Commonwealth directly asked New South Wales, and the same for Queensland, whether or not they would grant access to the UN inspectors?
We can, I'll refer to my colleagues, but I think one of the things I will note is there are a range of steps that were involved in working with the states and the territories to prepare for the visit of the subcommittee, and some of them related to each jurisdiction providing us with information about their focal point that would be used to facilitate visits, as well as a list of their detention facilities. And New South Wales provided information in both of those cases. So I'll ask Mr Clark to talk to that.
Thank you, Secretary. Jessie Clark, Acting First Assistant Secretary, International Law and Human Rights Division. Just to pick up on the detail of what the Secretary has just said, Senator, on the 28th of July this year, the Department notified all jurisdictions of the SPT's visit. That included the dates, and shortly after that, I understand, the delegation. And in doing so, we requested a comprehensive list of places of detention in each state and territory's jurisdiction. All jurisdictions, including New South Wales, provided that list. New South Wales provided their list on the 15th of August.
So did that 28 July... Well, first of all, can you table a copy of the 28 July correspondence, or can you provide a copy on notice?
We can take that on notice, Senator.
Did that ask the most basic question, which is, will you grant access to the UN inspectors? Did you ask New South Wales that on the 28th of July? Remember, this is 2 and a bit years after the first indication came that the UN were coming.
Senator, we'll take it on notice and check that, but it wouldn't surprise me if we didn't, and that's for a very simple reason, and that's because the obligation to accept visits by the SPT had existed since 2017 and was very clear and never been questioned by any jurisdiction.
Are you saying that was an obligation that the New South Wales government had, in which case on what basis? They'd never nominated an NPT. They'd never indicated that they were willing to take the steps without Commonwealth funding. Are you saying it's a legal obligation, the New South Wales, in which case how?
Under OPCAT, there are 2 main obligations. One is to allow visits from the SPT.
But New South Wales never signed the treaty, the Commonwealth did.
Yes, Senator, that's correct. But if you just allow me to finish, it might be helpful to explain. In relation to the SPT, that obligation had existed since 2017. In relation to the national preventative mechanisms, that's a matter that's still to come into force for Australia, which we'll do in January. So, yes, of course, Senator, all states and territories have been working cooperatively on the basis to allow SPT visits and to allow the NPM over the years. And it was important that because all states and territories have responsibility for places of detention, that we work together to give effect to those obligations. And just to come to your point about responsibility, just as you will have seen that, of course, all states and territories and the Commonwealth share in that obligation on behalf of Australia as a whole. And that's how we had structured the OPCAT implementation.
Well, look, I think New South Wales has behaved appallingly. The Corrections Minister behaved abysmally in this, in refusing access. Don't get me wrong, they are culpable morally. But in terms of the legal obligation, it's the Commonwealth's legal obligation. And New South Wales has never indicated that they accept it without a whack of additional Commonwealth funding. So why didn't you check with them before the UN turned up that they would let the inspectors in?
Senator, I think it's a fair characterisation of all our engagement that we had all proceeded on the basis that SPT access would be given. And
but you never asked.
Can I just finish? If you made a reference to funding there. At no time did any state or territory request funding to assist with the SPT visit, leaving NPM to one side. In relation to the SPT visit, no funding was needed or requested, and in fact the UN funded that themselves.
Well, you understand that New South Wales has been obstreperous about the whole OPCAT thing and engaging and putting in place their own NPN on the basis that they are refusing to step up until the Commonwealth provides funding. That's the core of one of the core problems that we have from New South Wales. I'm not saying it's legitimate or right. In fact, I probably think it's not. But that's their position. Do you understand that?
Senator, I think that's right. But I think the reason that they did not, well, at least the reasons that were publicly given for why they didn't facilitate the visit were different to that.
No. Well, but they have indicated a lack of willingness to engage and an obstreperous attitude from the outset. So surely, given your obligation is to the UN and to the treaty, you should have asked and double-checked that New South Wales would give access. And from what I can tell, you never did. You just assumed. And given the political history, it was a pretty dumb assumption, wasn't it?
I would disagree with that, Senator. I don't think that's a fair characterisation with respect. And the amount of work we did with New South Wales, as with all other jurisdictions, all of whom we engaged with on the same basis and all of whom, other than New South Wales, facilitated the visits.
Well, Queensland also didn't allow access to some of the forensic mental health facilities. They say for statutory reasons.
Yep.
When were you first aware of that?
They have now indicated that they will legislate to address that issue.
When were you first aware of Queensland's concerns?
I'd need to take that on notice. At no time did Queensland indicate to us that they would not cooperate with the visit. The issue that arose in relation to the mental health facility came to light as the trip was underway.
And to be clear, when were you first advised by New South Wales or first informed about New South Wales' position that they wouldn't allow UN inspectors?
I think I can almost give you the date off the top of my head because it was the day that the committee were arriving in Australia.
And then between then and the committee turning up in Queanbeyan and being refused access at the facility in Queanbeyan, what did you do in that time?
I engaged with my counterpart. The attorney engaged with his counterparts. We had numerous interactions with them to try to seek an outcome that would enable the visits to take place.
Can you provide on notice the details of the first information you got from New South Wales and then what engagements you had between then and the refusal at the gates of the jail in Queanbeyan?
I'm very happy to take that on notice.
And finally, given the New South Wales government is continuing to resist and seems to be utterly unapologetic is the Commonwealth considering a legislative fix to this to require states to grant access?
Senator, we are assessing now. I would make the point that at this time, the committee has only suspended its visit, not terminated it. So the subcommittee, I should say. We are in the process of engaging with the states and the territories, including New South Wales, to consider what steps we can do. From our perspective, the ideal would be that the subcommittee can recommence its visit, and it's indicated that that is one option that it is open to doing.
But you didn't answer my question. Is the Commonwealth considering using its legislative power to require states and territories to grant access, given the recalcitrance of New South Wales?
Our focus at the moment is seeing whether we can produce an outcome with the states and the territories that would result in the visit being recommenced.
Is this non-negotiable for the Commonwealth, though, granting access? And if they continue to be obstreperous, continue to say no, will you consider a legislative fix to require them to grant UN inspectors access?
Senator, I would say we're not there yet. We're at the point of trying to work collaboratively with the states and the territories, but in particular New South Wales.
Well, we had the New South Wales Corrections Minister saying that
Senator
they should all go off
Shoebridge,
to
I'm going to
Iran.
call you
It's
to
not-
order.
it's not cooperative.
Senator Shoebridge, I have the call. You are entitled to put your questions. You are not entitled to interrupt when the Secretary is speaking. And you actually,
I appreciate that.
I hope you might not like the answer that you're getting, but you have to listen to it, okay?
If you're waiting for cooperation from the likes of the New South Wales Corrections Minister, you're going to be waiting a long time, aren't you, Secretary? A very long time.
I acknowledge the challenges associated with the consultations with New South Wales.
Thanks. There being no other questions for this group, I now call officers from the National Security and Criminal Justice Group of the Attorney General's Department and thank the officials from this morning's session. We'll just allow those officers to come to the table. And Senator Patterson, you have the call.
Can I just flag at the outset, at some point in this bracket, I'm going to need to go to ARAT for agriculture estimates, but there'll be a senator replacing me.
Thank you, Minister.
Is it an upgrade?
Sorry?
Is it an upgrade?
I think surely any new senator would be an upgrade on me. I'm sure you'd find at least 3 senators here would agree with it.
Oh, you'd be surprised.
Maybe 7.
You'd be surprised, Minister.
You should come and join us in ARAT later on, David Shoebridge.
I'll do what I can.
Hello, Linda. How are you?
Thank you, Chair. I had some questions about the new process for listing of terrorist organisations. First, I just want to check that my understanding is correct, that as a result of the machinery of government changes, it's now the Attorney-General who is responsible for issuing regulations under the Criminal Code to list a terrorist organisation.
That's correct, Senator.
And the reason why that's the case is that the Act says that it's the Minister responsible for the AFP, which issues the regulations, and the Attorney-General is now the Minister for the AFP, which was previously the Minister for Home Affairs.
That's correct, Senator.
Could you just briefly outline the interaction between the Department of Home Affairs and the Attorney-General's Department in the process of listing a terrorist organisation?
Thank you, Senator. I think I'll ask Ms Chidgey to take you through that process.
Thank you.
So the department works quite closely with the Counter-Terrorism Coordination Centre and the Department of Home Affairs and with AFP and ASIO to support the Attorney-General in making decisions about prescribing terrorist organisations. And ultimately the department's responsible for providing advice to the Attorney following those consultations to inform those decisions.
What role does Home Affairs retain in this process?
So Home Affairs to date has been working to prepare the statement of reasons that then ultimately goes to the Attorney-General with this department's advice as well.
Am I right in understanding that the statement of reasons prepared by the Department of Home Affairs goes first to the Minister for Home Affairs before it then goes to the Attorney-General?
That's been the practice so far.
Yeah. Is there a risk that, given that the Department of Home Affairs has to prepare this for the Minister for Home Affairs, and then it then needs to be conveyed to the Attorney-General, involving two different ministers before a decision is made, that some delays are introduced into the process compared to under the previous arrangements when it was just one minister who received, considered the advice and made a decision?
That's not occurred, Senator, so we work closely together to ensure the Attorney-General has the advice that he needs to make timely decisions.
I would put it to you that it has occurred already, and to illustrate that, I'm going to provide to the committee secretariat some documents for tabling, and I've got multiple copies so it can be provided to witnesses if that's necessary. For background, the documents are submissions to the Parliamentary Joint Committee on Intelligence and Security on two recent processes for listing terrorist organisations. I'll just pass that to the Secretariat so that can be distributed to witnesses and anyone who needs it. The two case studies I want to share with you is a previous listing under the old system, under the previous government, which was the relisting of Al-Shabaab, Hamas's Izin al-Din al-Qassam brigades, the Kurdistan Workers' Party, the Lashkar-e-Toiba and Palestinian Islamic Jihad as terrorist organisations. That's a process that occurred in June and July. Of course.
Senator, you said this was a submission to PJCIS?
Yep.
Is it a public document?
Yes, it is.
Okay, thank you.
Yep. And then the second one is the new listing under this new process under the new government, which is the listing of Islamic State Somalia. The key dates in these two processes, as I identify them, are as follows. In the case of the 5 terrorist organisations being relisted by the previous Minister for Home Affairs, the department provided their submission to the Minister on the 25th of June, and the Minister made a decision on the 1st of July, a period of 7 days. The new process under the new government for the listing of Islamic State Somalia, which I note is 1 terrorist organisation, not 5, and therefore a simpler and more straightforward process that should be much quicker. The Department of Home Affairs provided a submission to its Minister on the 18th of July, 18th of August, and on the 23rd of August the Minister wrote to the Attorney-General, so a period of 5 days elapsed. Then between the 23rd of August, after the Attorney-General had been written to, a further 7 days elapsed before the Attorney-General department provided a submission to the Minister, and a further 1 day elapsed before the Attorney-General made a decision, meaning a total period of consideration by ministers is now 14 days for 1 terrorist organisation compared to 7 days for 5 terrorist organisations. It seems clear to me that we've had a blowout of at least 100% in the time taken for ministers to consider it under the new process. Is that a fair summary?
Senator, ultimately the timeframes for the listings were met.
Yes, but that wasn't my question. My previous question before I illustrated these case studies to you was, given that 2 ministers are now involved, isn't there a risk that it will take longer to do a terrorist listing? And you said no, that has not occurred. And I've just demonstrated to you that in fact it does occur. It has double the length of time it takes to consider the listing of a terrorist organisation from when the advice is first provided to when a decision is ultimately made under the new system.
Senator, I suppose one thing I would note is there are 2 case studies, and I accept the timeframes that you've worked through for each of those. In terms of whether they represent standard practice over many years of doing these terrorist listings, I probably need to take that on notice and to see what type of timeframes were met over many years. I think with a process like this, obviously the critical thing is to ensure that the Minister is in a position to make a decision at the required time if the intention is to continue the listing, and that will always be paramount in our mind. But I think your point as to is it longer now based on 2 case studies, I think I'd need to go back and check some other examples as well.
Sure. Can I just add one thing here as well, Senator Patterson? This, of course, the example you've given under this government relates to the relisting of Islamic State Somalia as opposed to a new listing. And I think the key point here is that it was relisted before the existing listing expired.
Sorry, just to correct you, Minister, in both instances we're talking about relistings.
Yeah.
Yes, and I think, Senator, my advice to you was that there was no delay, and there was no delay.
Well, there appears to be twice the amount of time taken to make the decision by the relevant minister compared to when the advice is provided and when the decision is made under these case studies. 7 days under the old system, 14 days under the new system, which I think is understandable because we now have 2 ministers involved in the process rather than one.
Well, that's your opinion.
Yeah, well, I'm trying to be generous actually here, Senator Watt, and I acknowledge your point, Ms Chidgey, that there was no a lapse caused in the listing. The relisting occurred in time to continue the listing. But that actually goes to the heart of my concern. This is a very simple and straightforward relisting of an existing terrorist organisation which has been repeatedly listed before. This is the easiest decision that the ministers will have to consider. In the future, it might be a new listing, or it might be more than one listing, or it might be a contentious listing. And if we are taking twice the amount of time to do a listing compared to previously, then there's a real risk that there will be a material delay and that will have an impact on the safety and security of Australians.
Senator, I'd just say that this department and the Department of Home Affairs would ensure we work with our ministers to ensure timely decision-making in all these matters. And in the case of these instances, the timeframes were met.
What processes will you put in place to make sure that's the case? Because on the evidence that we have, which is the only case studies we can compare, because there only has been one relisting so far under this government, it has caused a delay. How will you ensure that doesn't occur again in the future?
I think the Secretary of Home Affairs and I engage very, very regularly and are absolutely committed to the effective collaboration between our 2 organisations. I think Ms Chidgey works very, very closely with the Counter-Terrorism Coordinator in the Department of Home Affairs, and we will always stay focused on ensuring that we meet required deadlines for matters like this. So
I don't doubt that at all, Ms Jones. I'm sure that the public servants working on this are just as professional and diligent as they always have been, but they're now grappling with a process which is needlessly more complex than it was before because of the machinery of government changes made by this government. It now has to go through 2 ministers, not one. So your staff will have to be even better at their jobs than normal to meet the timelines that we're previously able to meet under a more straightforward system. Anyway, I'll leave that as a comment and move on to another topic. I'd like to ask some questions about the electronic surveillance reform process. The relevant officials could come forward. Welcome, Mr Warnes. Am I right in understanding that you and your team have come over from the Department of Home Affairs as part of the machinery of government changes?
Thank you, Senator. Andrew Warnes, First Assistant Secretary, Criminal Justice Division. Yeah, that's correct. We have come across.
Yep. How many people did you bring with you?
Oh, that is a good question, Senator. I think the exact numbers I'd have to take on notice. I think budgeted was about 103 FTE. Sorry, not in electronic surveillance. That was across the division. So
right.
Just to, thank you. Yeah. I wasn't that lucky, Senator. So.
Yeah. So perhaps just for the benefit of the committee, just explain the distinction between the electronic surveillance reform process and your wider unit, which has come over.
Yeah, thanks very much. So the entirety of the Criminal Justice Division, which was the Electronic Surveillance and Law Enforcement Policy Division, came across. In terms of the task, so that encompasses a whole lot of criminal justice, the day-to-day responsibilities for grants and law enforcement reform more generally. We also have the specific task force that's focused on electronic surveillance reform. That was 27 departmental officers and 10 secondees that came across.
Okay, great. So I'm right in understanding that the electronic surveillance reform process that was initiated by the former government continues under the new government, just under the Attorney General's portfolio rather than the Home Affairs portfolio?
That's correct, Senator.
Can you give me an update on timelines? I know that there was discussion papers and submissions under the previous government. Is there going to be any changes to the process that was put in place by the previous government?
Yeah. Thanks very much, Senator. So you're correct. There was a discussion paper released on the 6th of December 2021, 63 submissions, were received, and we've been working through those submissions. Currently, we're working with the Office of Parliamentary Counsel to develop a draft bill. It's ultimately a matter for government about consultation and timing on the release of any exposure draft, as you know. We're still working to finalise that, hopeful for consultation at some point early in the new year, which is roughly the same sort of plan that we had previously, but still, as I said, a matter for government ultimately about when that might, and if that might be released.
So there's, at this stage, no changes to the process that you had in place. The government hasn't encouraged you to seek further submissions or undertake further consultation beyond what was already scheduled under the previous process?
No, that's right, Senator. We've provided advice to the Attorney-General on the process. We're working through it, and we're still working with OPC on the draft legislation.
Has the Attorney-General given you any instructions about any principles he'd like you to consider or any priorities that he has for this process?
No, I think as I just said, Senator, we've provided some early advice to the Attorney-General about the nature of the process and some of those timing questions that we just covered. Nothing further at this stage as we go on developing through the process that we were going through.
I imagine, though, just knowing the Attorney-General, having served with him on the Intelligence and Security Committee, that he might have some different views about what electronic surveillance reform should constitute compared to what the previous government might have had, and I'm not trying to make any value-based judgment about that. I'm just observing that I think they have different philosophical worldviews and he may have different priorities. So that hasn't been conveyed to you in any way by him or his office or...
We've had discussions with the office, as you would expect, Senator. We're expecting to put further advice around the policy decisions as we work through those matters. As I said, we're considering the 63 submissions in response to the discussion paper. I expect there'll be further advice to the Attorney-General in due course, and I would expect he would have views on those also.
And in those discussions with his office, have they given you any particular direction about particular issues you have regard to or priorities for him out of this process?
I wouldn't say there's been any particular direction to the department, no.
How about any general direction?
Anything else you want to add?
Senator Ashley McDonald, Assistant Secretary, Electronic Surveillance Branch. What I could say is that in our conversations with the Attorney's Office, they have confirmed the broad remit of the project of reform, which is to respond to Dennis Richardson's comprehensive review, as well as a number of other parliamentary reports and inquiries. So that work continues, and indeed we are focused on that.
Has the Attorney-General or his office communicated to you, for example, that it's particularly important for him out of this process that privacy be prioritised compared to other considerations or any other directions?
Senator, I have seen statements that the Attorney has made in relation to the significance that he places on this project. Electronic surveillance reform is something that he has emphasised and his staff have emphasised with us as a matter which he takes quite seriously. He's also been reported, for example, as being particularly focused on press freedoms and mandatory data retention, which are also matters that fall within the remit more broadly of electronic surveillance reform.
And in addition to his public comments, which I've observed as well, has his office conveyed anything more directly to you consistent with that or any different to that?
Senator, we haven't been given specific directions. I might just say that we continue to work to those principles of developing reform legislation that's clear, technology neutral, streamlined and proportionate, and that stakeholders generally have been supportive of having privacy protections, oversight and safeguards.
Of course. I think we all would be, but there will be trade-offs in that process and decisions we'll have to make. So just finally, on timing, has the Attorney-General given you any particular direction on timing?
No, Senator, no particular direction on timing at this stage.
Okay, and so you'll just give me one final update on the process from here.
Working to develop an exposure draft bill and also some of those policy considerations, providing advice to the Attorney on those are the next steps.
Okay, all right, thank you, Chair.
Thank you very much. I just have one follow-up question. I think the Minister referenced this, the previous Minister, and welcome Senator Chisholm to the table. Ms Jones, Senator Patterson was asking you about the relisting of Islamic State Somalia as a terrorist organisation. Just to be clear, a relisting process occurs while a current listing is in place, is that right?
That's correct.
Right, and the relisting was completed and finalised before the expiry of the previous listing?
That's correct.
Okay,
yes.
Thank you. I'll hand the call to Senator White.
Thanks. I want to talk about ask questions about the comprehensive review of the legal frameworks of the national intelligence community. Yep. So is that
the right people are here?
Right people here? Good, thank you. Can I ask you, how long did the review run for?
Sorry, Senator, I almost had the right people at the table. We're just getting someone else to come. Sorry, Senator, just to clarify, you are referencing the Richardson Review?
I think that's what it is, yes.
Senator, I can possibly assist to start. There are a range of recommendations made by Janice Richardson. Some are focused on electronic surveillance and some are more broader, so hence we've got two of us at the table. But I can perhaps give you an update on the timeframes in relation to Mr Richardson's report. That unclassified report was released on the 4th of December 2020 and a government response was released at that same time. In relation to the electronic surveillance work program, a task force was established on the 1st of July 2021 and one of the most significant milestones following that was the release of the public discussion paper in December last year, which Mr Warne spoke to.
So when did the review commence?
In June 2018.
Sorry, I missed that.
June 2018.
And did the intelligence agencies participate in the review?
Yes, they did.
And what was the form of that participation?
They were both, a number of the agencies had officers seconded into the task force, but then more generally, Mr Richardson and the review team consulted agencies through that process.
So you said the report was finalised on the 4th of December 2020. Was that publicly released at that time?
Yes, that's when it was publicly released.
So the previous government had the report for 12 months prior to the public release, is that right?
I'd need to take that on notice, Senator.
Okay. And, sorry, how many recommendations were made?
203.
And how many recommendations have been addressed as we stand today?
30 have been implemented and 120 are in progress.
120 in progress, 30 implemented. And how many total, sorry, again, were there? 200?
203, and there are a number that didn't require further action. 53 of those.
53. So that's 150, 203, is that right? Sorry, of the 53, how many? So 53 didn't require any further action, is that right?
That's right.
So how many are outstanding?
120.
120. And why is that?
Various reasons. Probably the most substantial number of them go to the electronic surveillance reform work that's underway.
So noting that some recommendations are classified to the government, could you outline some of the key public recommendations?
Probably the most substantial of them were the recommendations that went to electronic surveillance reform, which Ms McDonald can talk further about.
Senator, we normally would direct you to recommendation 75 as the cornerstone recommendation in relation to electronic surveillance reform. Janice Richardson recommended repealing and replacing the Telecommunications Interception and Access Act, the Surveillance Devices Act and parts of the ASIO Act, and establishing a single act which updates, harmonises and brings together the electronic surveillance legislative framework at the Commonwealth level.
Okay, so that is, and that's the work that's still ongoing, isn't it?
Yes, Senator. So recommendation 75 summarises it quite nicely. Mr Richardson made numerous recommendations focused on detail, which are guiding the work program as well.
And he did that in December 2020?
In December 2020, Senator, I understand that's when the unclassified report was released publicly, yes.
And possibly it might have been in the government's hands before that, which you're going to look at?
We can confirm the date, Senator.
So it's incredibly urgent, but it's taken 3 years and it's still not completed?
Senator, I did outline the steps that have been taken since the report was publicly released, including in the ESR context, electronic surveillance context, the standing up of the interagency task force and the release of the discussion paper. The team's undertaken over 300 consultations following the release of the discussion paper with a range of representatives from both government and outside of government. The work is quite complex. There's over 1,000 pages of legislation to work through, 35 different warrant types and a range of provisions that we are bringing together. So work has been ongoing and continues in relation to the electronic surveillance reforms.
It's not meant as a criticism. I'm just trying to, I don't know, we've just gone through the way in which terrorism organisations had been characterised in the process for that, and the implication that having 2 ministers slowed it down. And I'm just interested in something that's so as urgent as the electronic surveillance reforms have taken so long. But that's a comment, I guess, from me. That's all my questions.
I've got 2 follow-ups to that, and then I'll hand the call over. Senator Shoebridge, just another review we were interested in, the Anti-Money Laundering Counter-Terrorism Financing Act 2006 had a statutory review in 2016. How many recommendations were made as part of that review?
Just bring Mr Warnes to the table to assist with those questions.
There are 84 recommendations made as part of that review.
And how many of those recommendations remain unaddressed at the moment? Well, how many have been implemented and how many are outstanding?
Yeah, thanks very much, Chair.
Since 2016.
So my understanding is we've addressed 34 of the 84 recommendations in the statutory review.
$34 of 84. So
that's correct.
There's 50 upgraded amounts. What is the issue around? Are they dealing with states and territories, or are they requiring legislation? What are the bulk of the remaining recommendations contain? It's been a long time since 2016,
Yeah.
so there must be a reason.
Senator Alex Engel, Assistant Secretary, Transnational Crime. So there's been 2 phases of legislation that have gotten us to the 34 out of the 84. The vast majority of the remaining are around a term called simplification of the regime. So there are a number of sort of, I guess you'd call them sub-recommendations in that 84 that the large bulk of them go towards, I guess, simplifying or refining the regime to make it simpler for reporting entities to oblige. And then there was, and there is some legislation, but essentially it's legislative work that we need to do.
So some of those recommendations that are outstanding address unnecessary complexities for businesses, am I right?
Yeah, so a big part of the review was around making it simpler for reporting entities to be able to comply with the regime.
Right. And even though the review was done in 2016, they haven't been completed yet.
Yeah, so there was 2 tranches of legislation already.
Right.
So one in 2017 that came into force, and one in 2020 that did the sort of the first parts of the review.
Okay. Senator Shoebridge.
Oh, thanks, Chair. Could I go back to the McBride matter? Which agency or which part of the public sector sought to make the public interest immunity claim in relation to critical evidence that Mr McBride was putting forward in his public interest disclosure defence?
Ms Chidgey to answer that question.
So the Department of Defence, in consultation with national intelligence community agencies, gave the instructions on those public interest immunity claims.
And when were those instructions given by the Department of Defence?
In June 2021, and then there were some refinements after that, but the claims were made substantively in June 2021.
You're saying the claims were made as against
I mean, the instruction.
McBride? When was the McBride team first advised of the public interest immunity claims?
Well, they were made, I think, initially on the 24th of June 2021.
And was any consideration given to the fact that the making of the public interest immunity claims would effectively remove the evidentiary underpinning for Mr McBride's whistleblowing defence? Was any consideration given about the impact on the justice of the case in making that claim?
So we're not aware of any impact on the public interest disclosure claim, Senator.
Did the public interest immunity claim seek to have certain evidence? Did it impact the evidence being presented by Mr McBride?
Senator, the claims took out some information from the Commonwealth Director of Public Prosecution's brief of evidence, and I understand also touched on some information that was in affidavits in Mr McBride's matter.
It had the effect, didn't it, of challenging the admissibility of evidence that Mr McBride was relying upon in the defence of in the making of his public interest disclosure claim, didn't it?
So there's nothing, to our knowledge, to suggest it had an impact on his public interest disclosure claim, and certainly his counsel, when they withdrew that claim, did not say that the public interest immunity claims had meant that were the reason he could not continue.
Sorry, Ms Chidgey, I thought you said that it had an impact on the evidence that was put in affidavit form by Mr McBride in his public interest.
So some of that information was
disclosure claim
was covered by the public interest immunity claims, but that's a different matter, Senator, as to whether it led to him having to withdraw the public interest disclosure matter.
When you say it was covered by the public interest immunity claim, the effect of the public interest immunity claim was to seek to not allow that evidence to be presented by Mr McBride on the basis of an alleged public interest immunity.
So that went to just some information? That was a subset within affidavits?
That was the effect of the claim, wasn't it? To prevent Mr McBride presenting that evidence so as to establish his public interest disclosure claim. I'm not saying all of it, but that was the effect of it, to prevent the evidence that was the subject of the public interest immunity claim being relied upon by Mr McBride or even tendered in court.
So, Senator, the public interest immunity claims means that information can't be presented in evidence, but it doesn't prevent the public interest disclosure claim.
No, you can make a claim. It's just you knocked out critical evidence
made
it effectively
Senator,
and prejudiced the claim.
Senator, that is not what Mr McBride's counsel said in withdrawing the claim.
Was any consideration given in making the public interest immunity claim about the interests of justice and the impact that would have upon Mr McBride being able to make his whistleblower defence under the Public Interest Disclosure Act? Was that any part of the consideration by the Commonwealth?
Senator, as I've said, we are not aware of any impact that public interest immunity claims would have had.
Was it part of the consideration of the Commonwealth, the impact on justice and the impact on Mr McBride's case in making the public interest immunity claim? Was that part of the consideration by the Commonwealth?
You'd need to ask the Department of Defence who instructed. I would say for us, we're not aware of any impact.
They instructed, but you made the claim?
No, we didn't make the claim.
Well, which council made the claim?
The Australian Government Solicitor acting on behalf of the Commonwealth on the instructions of defence.
Did Is it your evidence, Ms Chidgey, that the withdrawal of the public interest disclosure defence had no connection with the public interest immunity claim made by the Commonwealth? Is that your evidence?
I'm saying we're not aware of an impact, and McBride's counsel did not say that.
You are aware, aren't you, of the concerns raised by Mr McBride's legal team on and since that date about the impact of the Commonwealth's claim on the Public Interest Disclosure Act defence of Mr McBride?
I'm referencing what counsel said to the court in withdrawing the claim, Senator.
Are you aware of the concerns that have been raised by Mr McBride's defence team on and from that day about the impact of the public interest immunity claim on Mr McBride's defence? I
haven't seen comments by other than that, the transcript from the court.
Did the Attorney General's Department in any way, what if any role did the AG's Department have in the articulating of the public interest immunity claim in Mr McBride's proceedings?
The department was aware that Defence was giving instructions, but we did not provide instructions on those claims.
And
obviously, the Australian Government Solicitor, which is another part of the department, was representing the Commonwealth and acting on Department of Defence instructions.
And do you say the public interest immunity claim was articulated and communicated to Mr McBride's defence on the 24th of June? Is that your evidence?
Yes, Senator, and it was subsequently refined, but the claim in substance was provided on the 24th of June 2021.
Sorry, when you say it was refined,
so
when was it finally articulated?
The main substance was, as I've said, made as a claim on the 24th of June. There were some subsequent refinements, so some information was taken out of the public interest immunity claim because there'd been consultations, I think, by Defence and other agencies with foreign partners who had said that they then consented to it being in the proceeding and it could then go back in and be covered by the NSI Act orders. But some additional information in documents was also included in the public interest immunity claims.
So some was taken out and some additional material was put in?
I think about 16 documents came out and maybe about 8 went in.
All right. And when were those 8 documents, those 8 additional documents included?
We'd need to just take on notice the exact timeframes for those adjustments, Senator.
Which foreign entities, which foreign governments were consulted in making?
I think you'll need to ask the Department of Defence.
Was the United States government consulted?
You'll need to ask the Department of Defence, Senator.
And you're not able to assist at this point about when those additional 8 documents, the public interest immunity claim in relation to those additional 8 documents was actually articulated to Mr McBride's case? Was it less than a fortnight before the commencement of the proceedings?
We'll take that on at different
the 8 additional
points.
documents?
We'll take that on notice, Senator.
Was it less than a fortnight before the commencement of the proceedings?
We'll take that on notice, Senator.
Was any consideration given for, instead of making a public interest immunity claim and preventing the material ever getting to court, was any consideration given for other measures that might be taken, such as having the proceedings held in closed session?
Senator, the National Security Information Act orders allow for those. This information was a small subset of information where, because it was very highly sensitive, it was identities of intelligence officers and information conveyed, in some cases under treaty obligations not to disclose, that public interest immunity claims needed to be made, with the assessment that Defence and National Intelligence Community agencies made.
So you're saying there was consideration given to having the potentially having it in closed session, and that was rejected.
Senator, you'll need to ask Department of Defence and the National Intelligence Community Agencies.
You just gave quite a deal of detail about the criteria.
I told you about what that information related to. In terms of the considerations about giving instructions, that would be best directed to the Department of Defence.
I have some other
I do have
questions.
to hand the call over, and for Senators' information, we are past the time to move to the next group, but I know that some Senators have some final questions. Senator Scar, you have a few, and you'll hand the call to your colleague so we can get through those, and we can come back to you, Senator Shoebridge, but we are over time now.
And I'll be as quick as I can. I'd just like to ask some questions about the attorney's exercise of powers under Section 71(1) of the Judiciary Act to decline to proceed with prosecution of Mr Bernard Collaery. Ms Chidgey, you're the person I can direct questions to on that.
Yes.
How many times has an attorney exercised that power under Section 71(1) of the Judiciary Act?
Once, Senator.
So this is the only occasion on which that power has been exercised, is that correct?
That's correct.
Did the attorney receive any advice from the department in relation to the exercise of his power under Section 71(1), and in that regard, with respect to any factors he should consider?
Yes, Senator. We provided advice to the attorney on the powers available to him to discontinue the prosecution.
Can a copy of that advice be tabled, please?
It has been the practice of this committee not to request that advice like that to ministers is tabled.
So is a public interest immunity claim being asserted?
We'll need to
Do you want to take it on notice? Why don't you take it on
and-
notice?
Yep.
That'd be simpler. Can you tell me, perhaps, so noting you're taking on the tabling of advice on notice, when was the advice given?
I know we provided some written advice in June and July, but we'll take on notice because I think there was advice beyond that as well in meetings with the attorney.
Okay. Did the, and I'll be careful in terms of my questions, did the department liaise with other departments in relation to the provision of advice to the attorney? So, for example, I note that the attorney in his media release refers to weighing the interests of national security, national interest, the proper administration of justice, and some foreign affairs issues in relation to Australia's relationships with our close neighbours. So the question I have is, was advice received by the attorney from the Department of Home Affairs, from the Department of Foreign Affairs as well, in relation to the exercise of his power?
I can assist with that, Senator, because I was involved in those consultations, and we engaged with the DFAT portfolio, the Home Affairs portfolio, the Defence portfolio, and agencies in the National Intelligence Community.
All right, so if you could take on notice then just the broad question or request to table copies of any advice that was provided either to the Attorney General's Department or the advice provided to the Minister with respect to the exercise of the power under Section 71(1) for the first time in Australia's history. Thank you. Thank you, Chair.
Thank you, Senator Van.
Thank you, Chair. Ms Chidgey, good to see you again. Can you tell us, did your department provide any advice on the return of the so-called ISIS brides to Australia?
Senator, I can start and assist. I think the process around considering repatriation of Australian citizens from Syria is something that has been primarily led by the Department of Home Affairs, but has engaged a range of agencies, including our department.
And Senator, I might just add that
Sorry, I'm having trouble hearing you.
we participated in the task force and particularly assisted in coordinating legal issues, but we didn't directly provide the advice on them.
I'm keen to hear more about those legal issues. What issues did you foresee?
I need to take that on notice, Senator. We usually don't discuss legal advice.
Okay, then I'll go down a different path. Were the wives of the ISIS fighters, were they ever proclaimed as terrorists?
Senator, I think some of these questions are probably best directed at Department of Home Affairs.
But, well, these are legal questions, and this is the Attorney General's department, and you are the division that looks after this particular area in...
I mean, there's not provision for individuals to be declared as terrorists, Senator. Do you mean there's obviously a process of potential for the Australian Federal Police to investigate and charge individuals where that's appropriate, and the AFP are on tomorrow.
Sure. But are you aware, you are aware that ISIS was a proclaimed terrorist organisation?
Yes, Senator.
So any persons that are part of that organisation are therefore proclaimed as terrorists?
Well, individuals aren't, Senator. It's a matter of then seeing whether there are criminal offences that apply to the actions of particular individuals in relation to prescribed terrorist organisations or other terrorist acts.
Can you tell us what countries that these people were transited through on their way to Australia?
No, Senator.
But there's no way for them to get here without transiting through other countries?
Senator, that really goes to operational matters that we can't comment on.
Okay, but your legal advice would be there would be a legal risk of a transnational crime if a terrorist was transported through a third country.
We can't really comment on a hypothetical like that, Senator. And in terms of the management of the process, I think it's best directed to the Department of Home Affairs.
Sadly, I've missed my opportunity to put questions to them, but I will on notice. Oh, good. We've got a spillover? Fantastic.
Like reflux.
So in terms of advice on, because under you have high-risk terrorist offenders branch, is that correct?
That's correct.
So have you provided advice? Is it safe, I'll start with this, is it safe to assume that these people would be, the adults, not the children, should be or would be treated as high-risk terrorist offenders, potentially?
Senator, the high-risk terrorist offenders branch particularly looks after the regime in the criminal code that deals with continuing detention orders and extended supervision orders, which apply after someone's release from serving a sentence for terrorist offences.
So they play no role in other parts of protecting Australians from high-risk terrorist offenders?
Those orders apply in the circumstances I mentioned, Senator.
Okay. That's all I have, Chair. Thank you. Oh, sorry, one last one. Were you given any budget, was any money allocated in this recent budget for further work on these persons?
There was some money that was available from the March budget, Senator.
Right, thank you.
Senator Shoebridge, have you got some final questions for this outcome?
I do, thank you, Chair. Can I just quickly deal with one matter, which is Commonwealth parole? I don't know if... There is no Commonwealth Parole Board, despite there being calls since, I think, 2005 for the establishment of a Commonwealth Parole Board. Are there any plans in place to establish a Commonwealth Parole Board?
I think what I can say in regard to that is it is something we have started to do some work on in the department with a view to potentially providing some advice to the Attorney-General.
And currently the Attorney-General is effectively serves the role of a parole board under statute, is that right? And
Either the Attorney General or officers who are
But
delegated to
delegate.
make those decisions in the department.
So who's currently, is there anyone currently delegated or any position currently delegated?
Yes, Senator. So there are a number of positions who could exercise that, but I'll get Ms Inverarity to talk to that.
Maybe I'll just ask a sort of omnibus question to wrap it up to indicate the information I'm seeking. First of all, how many people are in detention under a Commonwealth offence, which who would be potentially open to parole, would potentially have a claim for parole? First question, and secondly, can you provide on notice the outcome of parole determinations, the number of determinations made and claims made and the number of determinations granted over the last 3 financial years?
3 financial years.
Yes,
So
please.
I was just going to check what time frame
Yeah.
you wanted that over.
If you've got further data, if it's available, by all means, but the last 3
We'll go with the
financial
3
years. We'll go
years.
with, I thought you might.
Thank you, Senator. Tara Inverarity, First Assistant Secretary, International and Security Cooperation Division. A few different questions in there. We do have a statistic on the number of federal sentenced prisoners in full-time
Yeah.
custody in Australia. It is just over 1,100. In fact, I think it's 1,101 as at the statistics, the most recent ABS statistics. Not all of them are necessarily subject to a non-parole period, so we can come back to you on how many of those actually have a non-parole period as opposed to some other form of order. In terms of the delegations, there are multiple people delegated within the Attorney General's Department. It goes down to SES Band 1 level. And we will be able to provide you with some information about the number of parole decisions made each year. Under the federal system, there's no need to apply for parole. It's considered at the expiry of the non-parole period. So, but we'll be able to give you information about the number of people considered and whether parole was granted or refused.
So at a state level...
Sorry, one other thing I should add. If parole is refused, there is a statutory obligation to reconsider that prisoner in a period no longer than 12 months from the date of refusal. It can be shorter, but 12 months is the requirement.
At a state or territory level, there are detailed provisions and normally multi-member parole boards which consider applications and are subject to external scrutiny. But are you saying that at a Commonwealth level, there are SES 1 level officers who are making parole determinations?
It's correct that under the Commonwealth Crimes Act, the Attorney General holds the decision-making power in relation to parole, and it is delegated to officers at the SES level within the Attorney General's Department. Not all SES Band 1 officers, just those working in the International Crime
Could you
Corporation.
then provide on notice which positions are delegated and also where the decision-making was made over the last 3 years?
We can provide a
And
breakdown.
if you have a breakdown by offence too, that would be...
We'll see what we can do in relation to offence type.
Could I ask you about what, if any, steps are being taken to bring Julian Assange home?
Senator, as you know, the issue in relation to Julian Assange is proceedings involving the United Kingdom and the United States. Our International Crime Cooperation Area has no involvement in that matter. In terms of any broader issues associated with Mr Assange, I think that's broadly a matter for DFAT.
Have you provided any advice to the government about the nature of the charges that Mr Assange is subject to in the United States?
Yes, we've provided some general information.
What was the substance of that advice?
I think it just outlined what those charges were
And-
in factual terms.
None of those charges are known to Australian law, are they?
Our understanding is Mr Assange has been indicted for a range of offences in the US, including conspiracy to commit computer intrusion, conspiracy to obtain, receive and disclose national defence information, and other offences relating to unauthorised obtaining and disclosure of national defence information.
But in circumstances where he was not a US national, was not an employee, was not a contractor and had no nexus to the United States, that kind of offence is not known to Australian law, is it, Ms Chidgey?
So, Senator, I don't think we can comment on dual criminality in detail, but the Commonwealth, for example, has computer offences that can apply in a range of circumstances, and also non-disclosure offences.
None of the US offences, given the absence of citizenship, residence, employment, contractual, or any other nexus to the United States, there are no, and the extraterritoriality more generally of those US offences, they are not offences of a kind known to Australian law, are they, Ms. Chidgey?
So we can't comment on that, Senator.
Was that included in your advice?
No, Senator, we didn't undertake a dual criminality assessment.
Why not, given it's a critical part of most extradition proceedings?
But it's not an extradition proceeding involving Australia, so we have no responsibility in relation to it.
But it's an extradition proceeding involving an Australian citizen, and are you saying that despite that being a core element in any extradition proceeding, I think considered in the UK and particularly under the Extradition Act 1988, that you provided no advice and were not no advice to the attorney or to government on the nature of the offences?
Well, Ms Chidgey has already indicated that we provided factual information, but I reiterate that the matter is a proceeding involving the United Kingdom and the United States.
Is it not part of the consideration for the Australian government's actions whether or not the offences that Mr Assange is facing would be considered offences under Australian law if the same conduct related to Australia? You're saying that's not part of the advice that you've provided or the consideration that the department has undertaken?
I think we've provided factual information to the attorney. I can't add to anything further than that. Has the department done anything to satisfy itself as to whether or not Mr Assange could obtain a fair trial in the United States, given the nature of the offences and the nature of the likely court that will be trying him? Senator, obviously the Department of Foreign Affairs and Trade provide consular assistance to any Australian who is involved in legal proceedings overseas, but it is not a role for this department to evaluate proceedings in other countries.
And I'd just say, Senator, that the Australian Government, which is really the Department of Foreign Affairs and Trade, has a central role, has conveyed expectations that Mr Assange has due process, humane and fair treatment and access to his legal team.
And a secret trial and potentially 220 years in jail. That was part of the communication? Was there any concerns raised about the secret trial and potentially facing 220 years in jail for effectively the crime of telling the world the truth? That was not part of the consideration?
I've described in broad terms those expectations. If you've got more detailed questions, they would need to go to the Department of Foreign Affairs and Trade.
To be clear, Ms Chidgey, do you accept that what Mr Assange did in terms of providing access to information primarily about the manner in which the United States engaged in war, do you accept that that conduct would not be an offence known to Australian law?
I've already said I can't comment, Senator, and I think you might also be asking me for opinions.
And
just one last question.
We do have estimates with DFAT, and you will get an opportunity to ask them the appropriate questions. And we do need to move on. If you have
I'll be very
final,
rapid.
Very brief.
I think all of us would be concerned about the number of cyber attacks, and I assume that's a concern that's shared by your department, Secretary.
Yes, Senator.
Has the department been the subject of cyber attacks in the last 12 months?
Senator, I think I'd ask my Chief Operating Officer to come to the table. I think...
I understand there may be some discretion in how you answer this, so don't get me wrong, but I still maintain the question.
Can I just say, these questions also may have been more appropriate in an earlier session, so I just want to be very clear that we are speaking about National Security and Criminal Justice Group.
Correct.
And we're moving on to the next outcome very shortly.
My question,
So
Brett,
if it
still stands.
if it comes under Enabling Services Group, if we've moved to the next group, then
We haven't yet moved.
we haven't yet moved.
No. Good news. Are you,
I would like to, if you...
are you saying these questions are best answered in the next session?
Yes.
I see nodding behind you as well. Well, why don't we do that?
Thank you. There being no further questions, I call officers from the Enabling Services Group, Attorney General's Department. I'm going to kick off questions for this part of the program. Firstly, Ms Jones, I have a question in regards to possibly where some officers might sit now after MOG changes, to make sure I'm asking the correct questions. I understand the Safer Communities Fund was established in 2016 in the Attorney General's Department, moved to Home Affairs, and has now moved back to the Attorney General's Department again. Are there officials in this section of the program that I can ask questions to in regards to that?
It falls under the National Security Criminal Justice Group,
Right.
so the section that we've just finished,
No, that's fine,
Senator,
that's
but we
fine.
can take questions on notice if you would like.
No, that is absolutely fine. If that is the case, Senator Shoebridge, if you want to finish off those questions you were asking, and then I
That's
come
a
back to me.
polite description for questions that never really got started, but I will...
Sorry, Chair, which section are we in now?
We have...
We're
Have we
enabling.
moved sections?
I have called officers from the Enabling Services Group, Attorney General's
that's okay.
Department.
Yep,
There
thank
being
you.
no further questions for National Security and Criminal Justice.
Ms Harrison, do you remember the question?
I do remember the question. Michael Harrison.
I don't remember the question.
Has the department been the subject of cyber attacks in the last 12 months?
Michael Harrison, Chief Information Officer, AGD. Short answer is yes. Our network is exposed to pretty non-stop reconnaissance. We get many hundreds, if not thousands, of attempts to breach our systems daily. So far, so good, but we have also been subject to a number of zero-based day attacks they're referred to, not publicly known, and they've been experienced in software like Microsoft Exchange. There was a Log4j incident. I'm not too sure if you're familiar with that Log4j incident.
I'm not.
It's a little bit of Java software that is used commonly in many software packages to assist with logging of system events. And there was a vulnerability detected in that little bit of code some 12 months ago. And it required a number of agencies to activate their incident response plans in response to that particular vulnerability. And there are some other known attacks through the SolarWinds and some other software that is used by the department.
In terms of the zero-day attacks, were any of those successful?
No, we activate our incident response plans. We then go through a very deliberate process of trying to identify the existence of the offending code in the environment. If we find it, we contain it, and then go about a process of eradicating it. We've got very early warning through the ACSC of that particular vulnerability, and we're able to promptly run the tests to see if that code was in our environment, and it was not.
And as I understand your evidence, there weren't any successful cyber attacks in the last 12 months?
There has been an unauthorised access into our system in the last 12 months, but again, we followed our routine incident response processes and set up an incident response team and had that particular incident addressed within a 48-hour period.
Can you provide details about that unauthorised access, starting with the date and maybe working back from there?
We can take that on notice.
Yeah.
Well, was it in recent days or weeks?
It was approximately 3 weeks ago, so it was in recent weeks.
And what was the nature of the attack?
It was an unauthorised access to our environment from the internet. We run an environment where all of our citizen-facing applications are exposed to the internet, and there was access to one of our application servers that runs some of those applications from the internet.
Which application?
A particular application was, we call it Marcel, it's the marriage celebrants application.
So there was a hack on the marriage celebrants database, is that right?
No, not technically.
Run by the church or?
Senator we, during the course...
I withdraw that. No, so it was a... Sorry, Ms Harrison, you were going to describe it, I think, in some detail.
Senator, just before you asked the question earlier, you sort of said actually this line of questioning could actually get a little bit difficult in terms of the level of detail that we're able to provide. I think the other thing to keep in mind in terms of the answer that Mr Harrison's given is when you asked whether or not it had been a successful attack, there's been no data exfiltration from the department's website, as from the department's infrastructure. But details of the question that you're currently seeking is probably beyond what we would share in a public domain.
All right. But the data, what we do know is the database that was the subject of the intrusion, if not the removal of data, was relating to marriage celebrants. And you tell me that no data was removed.
Correct.
Correct, yeah.
And you're satisfied that that gap, and I'm not trying to do it in a pejorative way, but the access way has been shut?
Yes.
Could I then ask you, Secretary, about, given that the scale of cyber attacks seems to be mounting, is there a reason that your department hasn't been part of a data hub or the trials for a data hub?
Data hub, or do you mean the cyber hubs?
The cyber hubs, yes.
Cyber hub. So obviously that's a broad whole of government proposal. It will include all departments and agencies, and so we have been participating in all the consultations, planning and engagement on the hub. We are not a cyber hub ourselves because we're not large enough. It's the departments that are proposed to be the hubs, Defence, Home Affairs, Services Australia and the ATO.
Well, they have hubs.
Sorry?
They've got cyber hubs. Are you part of one of those hubs, are you saying?
No, they're the proposed whole of government cyber hubs.
Well, they're already up and running, those 4 hubs.
Yes, they have commenced.
And you're not part of it?
We are in the planning to be part of that.
But you're not part of one now?
Not at the moment, no.
And which hub are you proposed to be under?
Services Australia.
Services Australia. But despite the... and then when is it in? When do you expect to be part of the Services Australia hub, to be covered by that hub? Do you have a time frame for that?
No, there's no time frame. So the hubs are still running in pilot until July 2023. They'll be evaluated at that point, and there is very much a risk-based approach being taken to the onboarding of agencies into the hubs. So those agencies are considered to benefit the most from coverage by the hubs. At this stage, indications are they would be onboarded earlier than later.
And in that risk-based assessment, where does the Attorney-General's Department lie? Given how much of it is citizen-focused, given it's a justice system, where are you on the risk base?
So, Senator, because we are later in time, we're actually at the lower end of the risk rating, which I don't say with too much degree of confidence. The reason I say that is because, indeed, we're constantly vigilant about the need to protect our networks. We have a full suite of work to make sure that we are completely reviewing any vulnerabilities. We're going through the process of our cybersecurity uplift to make sure we're meeting the managing level for the essential 8 methodologies. And we constantly actually put our own networks under what we call penetration testing to actually test the vulnerabilities that we can be aware of and then make sure we can manage for ourselves. So our risk is relatively low.
Well, just taking that apart in bits. First of all, given that there's an assertion that the department is low risk, when does that mean you're likely to join the hub?
If I can just clarify, I don't think Mr Gifford was saying we're low risk. I think the thing that would distinguish us from other departments, I know you said that we have a lot of public-facing systems, but in fact, compared to a lot of other government departments, we have less public-facing systems. We don't do payments, the big systems payments that other departments do.
So however you wish to characterise it, not high risk or low risk, you can adopt whichever characterisation you like. What does that mean in terms of the timetable of getting the department into a cyber hub?
Well, I think consistent with what Mr Harrison said, they're in the pilot phase, they're being evaluated. When they're ready to start the expansion of other departments and agencies, will be part of that process.
But the pilot doesn't even complete until July of next year, so there's no time frame that you're aware of to bring
July
the department.
July next year when the pilot is finished, and then there'll be a process for expanding to other departments and agencies.
Well, obviously depending upon the outcome of the assessment. So something,
Correct.
but you're not suggesting to me that from 1 July next year you'll be part of the hub, are you?
I think that's probably right, Senator.
So I'm trying to get the date.
Yeah.
I'm trying to get a sense of what you expect in terms of the time frame to have uplifted, as to use Mr Gifford's terms, to have uplifted the cyber security for the AG's department.
And that's a slightly different question, so if I can maybe pause for that for 1 second. So when I talk about cyber security uplift for AGD, that's the work we are underdoing by ourselves. That's not reliant on moving into a cyber hub. So our time frame to have uplift is actually by the end of this current financial year.
All right. But there's no additional budget for cyber security for the AG's department that I can see. How is that?
We have allocated additional funding internally, and Mr Gifford can talk to that.
Yeah, thank you. So for this 2021-22 financial year, for instance, we've allocated $2.05 million across cyber security for the purposes of servicing the department's networks. So that is within our departmental appropriation, and that's to provide enough priority behind the cyber security uplift process that we've been talking about.
Did you say, I think I wrote 21-22.
Correct.
But aren't we...
And we are now in 22-23, so it is a continuing body of work. So that was the work expended in 21-22. For 22-23, a further capital budget of $1.07 million and operational budget of $2.3 million.
So what was the capital budget last year? You said there was, I think, an operational budget of 2.05.
Yeah, sorry, Senator, I'd have to take it on notice to give you the split for capital and operational for 21-22.
Sorry, I'm a bit confused. You gave me a single figure for last financial year of 2.05 for cybersecurity. Was that capital and operational?
Yes, Senator, there was. I might just say that the cyber expenditure is made up of two components. There's a direct component, and they're the figures that Mr Gifford is providing you. There's also an indirect component. So the operational teams within the division, as they go about their day-to-day work, there is a security component to that work. So the investment is in fact higher than the numbers that we provide.
But the budget shows 2.05 last year, and then I'm sorry, Mr Gifford, I'm having trouble reading my handwriting for what I wrote for this year. Can you give me that again?
Yeah, certainly. So the total cybersecurity budget for 2022-23 financial year is a capital budget of $1.07 million and operational budget of $2.3 million.
2.3 million. And that's all been sourced from other savings internally, is that right, Ms Jones?
It's part of the ongoing allocation for cyber, but I also have recently approved some additional resourcing in this area just to ensure that we can continue our efforts to strengthen.
Additional to the 3.37 that Mr Gifford just identified?
Yeah,
if so what?
Indeed. So the additional funds that Ms Jones is referring to is that there's a potential allocation of an additional $750,000, the purpose of which is to make sure that we are effectively quarantining sufficient funds and resources such that any competing priorities don't take away from the work being done within our information division while we're prioritising that cyber security uplift.
So that's a reserve for other IT work?
Indeed.
It's not cybersecurity work? No,
sorry, it's a reserve specifically for cybersecurity work so that we are not being diverted for other priorities from...
So that the email keeps working?
Indeed, so many challenges within information division.
Well, I suppose that's what I'll finish on this. It seems an extremely modest spend for cybersecurity, given the scale of the department's operations and the number of employees. Just a little bit over $3 million expressly allocated for cybersecurity. Do you believe it's sufficient to protect the data and the operations of AGs?
Well, if I can, I'll start and ask Mr Gifford to assist. I think this is an area that myself and all members of the executive board of the organisation take a extremely high interest in. We're constantly assessing whether or not we have enough investment. We do also utilise the support and services that are available from the Australian Cyber Security Centre. So there's a range of offerings that they have to assist departments and agencies to strengthen their cyber defences, such as sensors and other issues, and we avail ourselves of those. I would say I think the need to have appropriate cyber defences is incredibly important. I would never say that I think I'm totally comfortable around cyber security. I think it's an area that always requires vigilance.
So is that a yes or a no?
I think
it's a mu.
We are constantly calibrating, and I think just the fact to note that we allocated an extra $750,000 for it this financial year indicates that we recognise that more investment is sensible.
Thank you. Is that your last questions? Senator Scarr, we do have another outcome we're trying to get to as well, and we have 11 agencies to get through tonight, but you might want to take us close to the break.
Okay, what time's the break?
3:15. But
3:15.
It would be helpful if you could get through your questions. We could move to the next outcome.
Okay, I'll go as quickly as I can.
Thank you.
Mr Harrison, can I ask you a question in relation to management of the machinery of government changes and what challenges you've had to deal with as Chief Information Officer in relation to the implementation of those changes? We've only got 15 minutes, but...
I can say, Senator, that we're relatively match fit when it comes to machinery of government changes, but what was extraordinary about this year's effort were 4 simultaneous movements, 3 in and 1 out. And each of those changes has its own unique characteristics in terms of the departments we're working with as we're seeking to obtain information, files, details of people so we can establish the ICT accounts, etc. And similarly, we are passing material back to or out to agencies as part of that process. So it really just draws on all the efforts of the division, from the service desk to help onboard new people, from our operations staff to extract and transfer securely the data that needs to go to other agencies, our record keepers who are responsible for the physical files that get moved around as part of a machinery of government chapter.
So that's all been bedded down now from your perspective?
Yeah, our last transition was the Office of the Special Investigator, and that occurred in the last weekend in October. So there is a long tail for these as we tidy up the transfer of records particularly, but the substantive work is done.
Okay, well, congratulations to you and your team on a successful implementation. I can tell you're proud of your team and what they've managed to achieve, so well done. If I can ask you, Mr Gifford, I was thinking about governance in the context of the Attorney General's Department. And I've read the annual report, so if you can put your governance hat on,
certainly happy to.
in terms of enabling services. And I come from a listed public company space, so my view of governance is sort of informed by that. And most, nearly all listed public companies would have a sustainability committee that looks at ESG issues. And I was thinking about that in the context of the Attorney General's Department. And one thing that occurred to me is a key obligation in relation to the Commonwealth in this space is its obligation to act as a model litigant. Does the Attorney General's Department have any governance processes or procedures with respect to assessing whether or not, and I think it should be in the Attorney General's Department, in terms of assessing whether or not the Commonwealth or its agencies in any piece of litigation is discharging its obligations to act as a model litigant?
So, Senator, yes, we definitely do. The part of the department that's responsible for that is the Office of Legal Services Coordination. The officers were here earlier today.
Right.
But there's a whole regime in place around reporting on model litigant obligations. We have a comprehensive network where we engage with every department and agency. We have education, we have outreach, and we are constantly working with departments to remind them of that requirement.
Is that appropriately reflected in your annual report?
I'm hoping that there's a colleague in the background that will point me to the page in the annual report where that's referenced. But I'd be very happy to also take on notice to provide you with an overview of all the actions that we
I'm
take.
happy for you to take that on notice. Okay. I did go through the annual report and I couldn't, but that might be me, not the annual report, but it would be helpful if you could take that on notice. And finally, Mr Gifford, I did want to give you an opportunity to speak to something which really impressed me in the annual report, and that is the support which the department provides to employees with disability. And that appears to be something which is considered very deeply in terms of the values of the department. So if you could, how is the department engaging successfully in terms of supporting employees with disability?
It's almost a dixer that I wrote for myself. So I play the role within the department of being the disability champion, a role of which I'm very privileged to have undertaken since 2018. We're quite mature, but there's more work to be done. We have a very ambitious disability and mental health action plan, which sets out a body of work across the next 12 months and across the 3 years of our diversity and inclusion strategy to ensure that we're doing the utmost we possibly can for individuals with a disability to be able to bring their whole selves to the workplace, to make sure that we are actually quite conscious of any barriers that are either consciously or unconsciously put in place of our employees. We are really ably assisted by a very strong employee network, the Celebrating Ability Network, which has over 200 members who have gone from awareness raising within our organisation to advocacy to make sure that actually our processes, policies and procedures are as strong as they possibly can be. We do that not just because it makes a difference to our staff, but also we feel the responsibility of being the department that is responsible for the Disability Discrimination Act, that we should be an exemplar in that regard. One thing that I think we have more work to do is to see more people with disability in our workplace. Our numbers aren't commensurate with the number of people with disability within the Australian community. We are pushing through activities such as affirmative measures of recruitment to see if we can actually see that shift over time.
And I think just in that respect, I saw you reported the numbers with respect to graduates, and there's an active desire to recruit graduates who have a disability.
Very much so. We're also investing shortly in the development of a buddy or a mentoring framework as well. So as soon as the person's in the door, that effectively there is appropriate support there. Another key initiative that I think has made a significant difference over recent years is we developed a reasonable adjustments passport. So we want to make sure that it's as easy as possible to get any necessary adjustments to bring your whole self to the workplace. We're conscious though that our employees are fairly mobile, so they'll have many roles hopefully across the Attorney General's Department. So rather than necessitating having multiple conversations about the adjustments that are necessary, the idea of a passport is you have that conversation once and that passport then follows you such that actually the adjustments should already be in place before you start your next role within the department. Yeah. It's those sort of initiatives that I think are making a bit of a tangible difference, and it's one thing that we then try and use as our own employee value proposition to really draw people into the Attorney General's Department saying actually we are an inclusive and diverse workforce and we are better for that.
And presumably that increases the morale of everyone in the department because they all feel part of these positive initiatives. Is that correct?
Very much so. And while you asked the question in the context of disability, there is a range of employee networks across different minority cohorts where effectively, again, the inclusion is the emphasis so that, again, you can bring your whole self to the work no matter what your background is.
Yeah. And Ms Jones, are you actively seeking to share the positive impact of these initiatives in terms of communications with other secretaries in other departments?
Senator...
I'm doing my best in estimates to do it.
Thank you very much. I appreciate it. I think the intent and ambition that we have in our department around creating an inclusive culture and one that accurately reflects the broader Australian community is an ambition that's shared by all secretaries. And I think whilst I'm enormously proud of the efforts that have been undertaken in our department, but similarly to Mr Gifford, remain keen to uplift further in that regard. I think you'll find right across the board in departments similar efforts being made. There are networks and communities of practice across areas of First Nations, disability, gender, cold, and
the Women's Network.
Sorry?
The Women's Network. Sorry, you said gender.
So across these areas, I think everyone in the public service is working extremely hard to ensure, firstly, that we can attract and retain a diverse workforce, but also create environments where they can flourish within the community of the organisation.
Excellent. Thank you, Chair.
Thank you. There being no further questions for the Enabling Services Group, Attorney General's Department, I call officers from the Australian Government Solicitor Group, Attorney General's Department. We have a short 5 minutes before our break. Are you seeking the call for 5 minutes? And Senator Shoebridge has the call.
Mr Kingston, nice to see you.
Michael Kingston, Australian Government Solicitor. Thank you, Senator.
Could I ask you about the cost to the Commonwealth of there's at least one, but potentially up to 20 or more other challenges to 36B of the Australian Citizenship Act. These are the citizenship cancellation powers that were purportedly given to the minister but found to be unconstitutional. What has been the cost to the Commonwealth of unsuccessfully defending those cases?
Senator, I don't know the answer to that off the top of my head, and so I'd need to take the question on notice both for that reason and because normally we would consult with our clients before disclosing the costs in a matter, especially if the matter is not complete or costs are the subject of any ongoing conversation, because they may be confidential and revealing them might prejudice the finalisation of the matter.
Well, let's deal with the completed cases as one cohort, and then
Yes, I
the
still
overall
won't know
costs
the answer to the
today.
costs question, and I would still normally seek to consult with the client whether the matter was over or not, because we, at least as solicitors, are normally under an obligation of confidentiality about revealing that information. The client may, of course, decide to instruct us to do so or may do so themselves.
And in this case, who were you taking instructions from in the 36B cases? Who's your client?
Well, without saying it will be the case in every instance, normally from the Department of Home Affairs.
And is that still the case? Is it the Department of Home Affairs that's still the client for the 36B cases?
Generally, I'm not seeking to speak for every single case because it's possible there's an exception, but generally.
Has the Zehra Duman case concluded?
Has the...
I think the case, the Zehra, Z-E-H-R-A Duman case, has that concluded?
I don't know, Senator.
Will you take it on notice?
Yes.
Has the department and the AGS given any advice about procedural fairness for the new purported law, the new proposed laws to strip Australian citizens of their citizenship?
So, Senator, topics on which AGS may or may not have given advice to clients are covered by our duty of confidentiality to clients. Departments or other agencies for whom we act may reveal topics on which they've received legal advice without normally revealing the content of that advice, but we as solicitors are generally under an obligation not to disclose the subjects on which we've given advice without at least seeking the consent of our client.
How many 36B matters has AGS been instructed in? And when I say 36B, I mean 36B of the Australian Citizenship Act.
I'm aware of several, Senator, but I couldn't at the moment, without checking our records, be more precise than that.
Have any of them been successfully defended?
In terms of recent challenges following the Alexander case?
Yes.
Yes, I doubt that since then, and I take this on notice, so subject to correction, I doubt that any have come to final fruition since that decision in Alexander.
And is that because they're indefensible following the Alexander
case? No, just
case?
because the Alexander wasn't decided that long ago.
Right. Have there been any fresh applications made in challenging the 36B powers since the Alexander case?
Yes, there have been at least a couple.
A couple? How many is that?
I'm not trying to be precise. I'm just aware of 2 or 3. I would have to check the precise numbers.
All right. I asked some questions earlier, Mr. Kingston, about the Assange matter. Who was your client in making the public interest immunity claim? Who was the AGS's client, or who gave the instructions for the public interest immunity claim?
Do you, Senator, mean the McBride matter?
You said Assange. No, sorry. We'll just erase that all and start again. In relation to the McBride matter, who was your client for the purposes of making the public interest immunity claim? Who gave you those instructions?
The Department of Defence.
When were those? When was the final claim made in relation to public interest immunity, or when was the McBride team informed of the final claim, the final scope of the public interest immunity claim?
The substantive claim was made by letter on 24 June 2021. The last piece of correspondence I'm aware of, which was from us to the solicitors acting for Mr McBride, was on 18 October 2022, and that letter dealt with some matters. It said that the Commonwealth no longer pressed PII claims over 16 documents contained in the DPP's classified brief, that it had identified foreign part material in 6 other documents in the brief which needed to be redacted, that is some of the material, not the whole documents as I understand it, and that the Commonwealth wished to assert PII claims over some foreign part material in 2 further documents in the classified prosecution brief.
So there were 8 documents which either in whole or in part were the subject of fresh public interest immunity claims given to the McBride team on the 18th of October, is that
yes,
right?
Fresh in that they applied to those documents, not fresh in terms of the nature of the claims, were, as I understand it, the same as those outlined in June 2021.
Senator Shoebridge, we will come back to you. We're about to suspend for an afternoon tea break. We'll come back to the Australian Government Solicitor Group for a short period, and then we have 11 agencies to commence. For the advice of officials and agencies, I haven't been advised that there are any agencies that, well, I've been advised that all agencies currently have questions from senators. If that advice changes, I will let agencies know. Thank you. We will come back at 3:30.
Can I just clarify?
And continue questioning of the Australian Government Solicitor Group, Attorney General's Department. Do you have any questions, Senator Scarr?
No, I think, did Senator Shoebridge have...
He's not
here.
Yeah.
Just whilst I'm
sure you can put them on notice.
Yeah, if I could just take this opportunity, Chair, I had a question in relation to the Hague Convention, Secretary. I'm happy for you to take it on notice, if you could.
Very happy to, Senator. I've literally sent home
I know you did. I know you did, and I apologise. Yep. But just whilst it's something which I overlooked earlier today, but happy for you to take it on notice, and you might even be aware of where it's up to. But there has been some discussion in relation to the Hague Convention, in particular the issue of women who are in violent relationships or have been in violent relationships, seeking that terrible, terrible fact to be taken into account in relation to Hague Convention procedures and processes. And I was just wondering where the department's up to in terms of considering those, no doubt, very complicated matters in that space.
Yeah. Senator, I will take it on notice that the attorney has asked us to provide him with advice in relation to that. I think he's concerned to look at address that issue. So if I can take that on notice,
sure.
And we will provide the relevant information.
Okay, I have just a few questions on AGS, Chair. I'd just like to ask some questions in relation to the Montgomery case and the discontinuance of that case. So the case was discontinued. I'm just interested to know what advice, if any, the Attorney General's Department or Solicitor General gave to the attorney in relation to that decision to discontinue the case. And I'm just asking this question in particular, Secretary and Mr Kingston, in the context where last week, during the hearings of the Home Affairs portfolio, a question was asked in relation to an issue which has arisen regarding whether or not the law, as it currently stands, provides mechanisms or recognition of that category of people who fall into the realm of they're aliens, non-citizens, and it seems to be a bit of a lacuna, if you like, in terms of the law. And Mr Pizzullo, when he was asking questions in terms of that issue under the relevant provision, said that one of the reasons why the Montgomery case was being pursued by the previous government was to provide an opportunity for the jurisprudence to develop in that space, especially given there seems to be now a gap, at least in terms of the common law, with respect to how people in that category are treated on a range of contexts. So I'm wondering if you can give any insight into how that issue is being addressed, given the Montgomery case is not being continued, and whether or not any advice was given to the attorney with respect to the benefit of pursuing the Montgomery case in order to develop the jurisprudence in this space.
I might ask Mr Kingston to commence, and then if possible, there's someone else who I may be able to bring up to assist as well.
So, Senator, any advice that AGS may have given about that is we, the solicitors, have to regard as confidential at the moment whether we gave that advice, and if so, what it said. And we would ask to consult with our client before answering that question. So I can take that question on notice.
Happy for you to take that on notice. Yep. And Secretary, is there anything else you can provide? You're aware of the issue in relation to the thinking of the jurisprudence that might develop in the event that the Montgomery case proceeded?
Yep. Yes, Senator, and that is an issue that, as you would expect, we're working with the Department of Home Affairs and the National Indigenous Australians Agency and the Department of Prime Minister and Cabinet to not only work through the legal issues but also any related issues around supporting people in that category. So it's a matter that's still under consideration and development of advice. But at present, we're still working our way through those issues.
Okay. Thank you, Secretary. Thank you.
Thank you. There being no other questions, I thank officials from the Attorney General's Department for your time this evening, and I call officers from the the Administrative Appeals Tribunal.
Thank you, Chair.
Thank you.
Thanks, Michael.
thank you very much for your attendance today. Would you like to make an opening statement before we go to questions? Or you can table that statement. We can.
I think I've already, Michael Hawkins, Registrar Senator, I have already tabled a statement.
Great.
I'm happy to read it though, if you'd like me to kick off that way.
I think we can proceed with questions.
Okay.
That would be really helpful, thank you. I might kick off with questions. I've just wanted to go to a matter that's been canvassed in this committee a number of times, I think, previously, and that's obviously the appointment of tribunal members. Not to go over some of the territory that's already been canvassed, but I think it's clear that there's been about 90 political or appointments made by the previous government, and there certainly has been some, I would suggest, some reputational damage to the AET as a result. But I wanted to go to some comments made by the opposition leader in regards to the tribunal's potential role in a national anti-corruption committee and warrants that may be requested under that anti-corruption investigation. Firstly, can I just ask Mr Hawkins, in regards to the potential for warrants to come to the AET, what's your understanding of that proposal at the moment?
So my understanding, Senator, is that such inquiries would come to the tribunal members acting in their persona designata role, and as such the AET itself has no responsibility for it.
Okay. Sorry, just repeat that last bit for me.
So as such, the AET itself, as the tribunal, has no responsibility.
But it would go to tribunal members.
Who happen to be appointed by or authorised by the different acts.
Right. And when it comes to, I guess, those appointments, they have previously been made by the former government. This might be a question for you then, Minister. What basis would there be for questioning the politicisation of those appointments is well versed. It seems a bit hypocritical of the Leader of the Opposition to criticise the AET for potential considerations of warrants under the National Anti-Corruption Commission then, isn't it?
Yeah, I think so. And as you'd probably be aware, the government has committed to introducing a new merit-based and transparent process for the appointment of AET members. So that's something that my understanding in the department might be able to add a bit more detail to this, that that process is being finalised and it is expected that the new process will be announced by the end of the year.
Okay. Minister, the Leader of the Opposition said that members of the AET, and remembering that he and his cabinet colleagues appointed almost every current member of the AET, lack the requisite level of oversight and intellect to make important decisions. How do you...
Sorry, Chair, do you have a copy of
yes,
where
I
you're
do.
quoting from? Just to give us all the benefit
So
of
I'm referring to an article in The Australian published on the 13th of October, and I can table that for the benefit of the committee and for the benefit of the Minister. Thank you. How did you react when you read those statements from the Leader of the Opposition?
Well, it's particularly disappointing, I think, that he would choose to talk about such an important institution in that way. But I think it goes to the history of the previous government when it comes to establishing an anti-corruption commission. And the fact that I think they dragged their feet on this for so long does not reflect well on them or the Leader of the Opposition in his current role.
Can I ask you, Ms Jones, in terms of, we haven't talked about it in too much depth, but the previous model that was proposed, the exposure draft that was drafted by the previous government around a National Commonwealth Integrity Commission, under that proposal, would the AET have been able to issue warrants?
Chair, thank you for that question. Sorry, shouldn't have sounded so excited, but Sarah Chidgey is here and she is the expert. She can answer questions on that.
Thank you.
Yes, Senator, AAT members would also have been able to issue warrants under the Telecommunications Interception and Access Act.
So the model proposed by the previous government would have had warrants going to the AAT or coming from the AAT, is that right?
Yes, that's right.
Okay. And can I just make sure I understand this? I don't know if this is a question, Mr Hawkins, you can answer in your expertise, or Ms Chickley, whether this is actually something you have understanding of. But at the moment, can the AAT issue warrants to ACLI, including interception warrants?
Yes, it can.
Okay. And ACLI is, I guess, the current existing anti-corruption body, albeit not a national anti-corruption commission, but it's the body that we have at the moment.
Yes, Senator. So it's an anti-corruption commission covering Commonwealth law enforcement agencies, and I might also mention that AAT members issue Telecommunications Interception and Access Act warrants for state anti-corruption commissions.
Thanks. And in terms of other bodies that can request warrants, am I right that the AFP, the ACIC, State and Territory Police, state anti-corruption agencies, all of them can obtain approval for interception and other warrants from the AAT?
Yes, that's correct.
Okay. And that, can I ask, under the previous government, did the former Minister or Attorney General ever raise concerns about the role of the AAT in issuing warrants while in government during the last 9 years?
Not to my knowledge, Senator, but the Telecommunications Interception and Access Act was at that point administered by the Department of Home Affairs and Minister for Home Affairs.
Yeah. So, sorry, the Minister for Home Affairs, who was obviously Mr Dutton, he actually introduced powers that invariably gave the AAT the authority to approve warrants to exercise those powers, didn't he?
I'm not familiar. We need to take that on notice.
Okay, thank you. I just want to go to another question. I've submitted questions on notice with the Senate about allegations or potential bullying and harassment at the AAT. I do have a copy of that if you don't have those questions on notice. Mr Hawkins, are you aware of those questions on notice I'm referring to?
Yes, I am, Senator. They have been answered and submitted to the Minister.
Great.
Or the Attorney, sorry.
Thank you. How many members of the tribunal have had one or more bullying, harassment or discrimination complaint made about them since the 1st of July 2016?
Let's get it for you. So, Chair, I could just seek clarity from you. As I understand, we submit these answers to the Attorney for clearance. Is it appropriate for me to be answering them?
You've done your bit, in other words.
Pardon me?
You've done your bit, is the answer, but you don't know if it's been lodged.
Okay.
Thank you. That's a matter for the Minister at the table, and
Sorry.
If you have provided these questions, then you have that information at hand. This is information I would like to receive. Obviously, it's taken a little bit of time to get the answers.
It certainly has. So, sorry, could I ask you to repeat the first question, Senator?
Sure, thank you. wondering why I didn't have the answers. I have the questions, not the answers, and I'd like to get the answers. So to be clear, I'm asking in regards to the first question I put to you, how many members, including senior members and deputy presidents, have had more than one bullying, harassment or discrimination complaint made about them since the 1st of July 2016?
I can break this up into years for you if you like. So 16, 17, none.
Can you just give me the answer to my first initial question? I'd like the whole
Hold on.
number.
So your first question, how many complaints about bullying by members, including senior members and deputy presidents, were made by employees at the AAT in the following financial years?
No, Mr Hawkins, you are confusing
I'm
what I'm asking
sorry.
you. You're sitting there in estimates. I'm asking you a question. If you have the answer to that question, I'd like you to give that to me. If it's different from my question on notice,
Senator,
that's fine.
I apologise, Senator.
That's
I've got 3 questions here. I'm just trying to work out which is correct.
I'm asking you how many members of the tribunal have had one or more bullying, harassment, discrimination complaint made about them since the 1st of July 2016.
Senator Jamie Crew, Chief Operating Officer. I might be able to assist there. I think the question, rather than one or more, was how many complaints about bullying by members were made in the financial years. The first answer to that total question is 12. From 2016-17 to 2021-22.
There's been 12 complaints. And how many members does that relate to?
We don't have that answer specifically, Senator. Take that on notice.
You don't have that answer in front of you. I did put that answer to you. I did put that question to you in relation to the number of members on the 13th of October. Have you sought to find that information?
Here we go. Sorry, Senator, perhaps I'll start again. And not 12 was the answer, but 19 members, including senior members and deputy presidents, have had more than one bullying, harassment or discrimination complaint made about them since 1 July 2016.
One or more?
Had more than one.
Yes.
How many had one or more?
So I think, Senator, we've provided some clarification about how we've interpreted that phrase. So we've interpreted the phrase more than to mean one or more, 2 or more, 3 or more, 4 or more, 5 or more complaints received during that period. So more than one bullying complaint was 19, more than 2 was 6, more than 3 was 3, more than 4 was 2, and then more than 5 was 1.
Okay. So at least 19 members of the AAT, that's 19 individual members, have had more than one bullying or harassment claim or discrimination complaint made about them since the 1st of July 2016. How many of those members are senior members or deputy presidents?
I think it was Q.
All of them.
All of them are.
So the question was in relation to,
I know.
including senior members and deputy presidents.
Thank you.
We've not broken that up, Chair.
Okay.
We'll have to take that on notice.
All right. And how many of those members who have had more than one bullying claim or more than one bullying claim, harassment or discrimination complaint amount are still members of the tribunal?
Sorry, Chair, could you repeat that?
Still members.
How many of the members who have had more than one bullying, harassment or discrimination complaint made about them are still members of the tribunal? These are new questions.
We'll have to take that one on notice, Senator. We haven't broken that down.
Okay. In regards to the members of the tribunal who have had 3 or more bullying, harassment or discrimination complaints made about them, you can't tell me how many of those are still current members?
No, Senator. No, Chair.
And it's the same answer for how many have had more than 4, is that right?
We've not broken it down.
I don't seek to intervene in any processes, but you've said today that at least one member has had 5 bullying, harassment or discrimination complaints against them. Is that correct?
Since 1st of July 2016.
And is that person still a member of the tribunal?
I can't answer that question without... I can find out for you.
You don't know who that person is, Mr Hawkins, off the top of your head?
Can't tell you off the top of my head, sorry.
You've got one tribunal member that's had 5 complaints against them. You don't know who that is.
No,
I'm not asking for the name. I'm just asking if they're still a current member.
I'm
That's
sorry.
all I'd like to know.
I'm sorry, Senator. I can't tell you off the top of my head. That's across 7 years. I can't tell you who it is. I don't know who it is.
Okay, so since 2016,
yes,
one member of the tribunal has had 5 complaints made about them from employees of theirs, and you are telling me you don't know who that is to be able to explain to me whether they are still a member.
No, I cannot answer that question. I
Why
apologise.
is that, Mr Hawkins? Is that because there's a reason you don't want to give that information, or you
I honestly don't know.
don't know?
I honestly don't know the answer. Sorry, Senator, I have been the registrar for just on 6 months, and I'm not across all the member issues themselves, predating my appointment.
Okay, but I put a question on notice in relation to bullying and harassment claims to you on the 13th of October. Mr Crew, you didn't think to inform the register that there's these ongoing matters?
Chair,
You haven't provided that advice?
We provided the information in relation to the questions. We would have the information, but we haven't got it here with us.
Okay, well, I think we are going to have a series of questions for the AAT on a number of matters. Can you undertake to come back to us? It is really significant and important, I think, to understand whether that member is still a member. I'm not asking you at this stage to identify who that is, but can you come back to us, ask one of your officials behind you to come back to us and find out whether that person, somebody in your organisation knows who that person is?
Getting that information now, Chair.
Thank you. I'll be putting some more detailed questions on notice in regards to the processes, but can I understand what has the tribunal done when a member has had multiple bullying, harassment and discrimination complaints made about them? What processes do you have in place, Mr Hawkins, to deal with these types of complaints, particularly where there's been multiple complaints against one member?
Okay, so, Chair, as you're aware, the tribunal now has new leadership with a new president in Justice Fiona Maher, who was appointed on the 1st of April, myself as registrar. The first thing the President did was to recognise the significance and sensitivity of member performance, conduct and wellbeing, amongst other things, and she has brought the performance and responsibility for member capability, culture and wellbeing into her office. So she is taking the issue of member conduct very, very seriously. In terms of the processes available, it does depend on the nature of the complaint. We look at the time period and the frequency of the issues that have been raised. We look at the views of both the complainant and the subject. We look at whatever steps have been taken already to try and resolve the complaint, and we also consider the outcome sought by the complainant. And in some cases, it's necessary to elevate the matter to an external investigation.
How many times has that happened?
No, I'm sorry, Chair, I'd have to take that on
Mr
notice.
Carew?
No, sorry, Chair. Member complaints is not something that, that I deal with, but we would have to take that on notice and provide you the number as to how many.
Mr Matthews, you're the Chief Legal Officer. When have you had to escalate to an external
Christopher Matthews, Chief Legal Officer. I don't have anything to add to that answer, Chair. Yes, I'm not aware of the number of external complaints, external investigations that would have been undertaken over that time period.
Well, could you take that on notice as well? Thank you. Can I just understand then, in terms of the processes, is there an additional process when there has been multiple complaints made? Is there counselling, performance management processes in place to ensure this doesn't happen again?
So the options available to the President in any circumstances are to seek either an apology or an acknowledgement from the member involved. There may be counselling by either the division head or the President, or the President may consider changing the member's work area or practice. Unfortunately, our Code of Conduct is not supported by legislation, and consequently there is very little the President can formally do.
Okay. I find it very troubling that there are members where there's multiple complaints. In terms of the processes, were the complaints, I'll rephrase. Was the fact that particular members of the AET had multiple, 3, 4 or more complaints made against them ever drawn to the attention of the previous government?
I can't answer that question, sorry, Chair.
Mr. Crew.
I can't answer that either, Chair.
Hansard will not record a shake of the head. You can't answer that because you don't know the answer?
Don't know the
Don't
answer,
know the
Chair.
answer, sorry.
Any referral to government would have been via the President, and I'm not aware of any referrals, but that's not to say that there weren't. I'm just not aware.
Mr. Matthews, are you aware of any referrals, or not referrals, but advice given to the previous government that there were members with multiple complaints against them?
I think we'd have to take that on notice, Chair. I'm not aware of the answer.
Okay, well, can you take that on notice for me, please? I've noticed some flurry of activity at the desk. Does that mean we have an answer about whether any of these members are still members?
Yes, Chair. 2 former members, 17 current members, and the one with 5 or more is still a current member.
Okay. So of the 19 members with multiple complaints, 2 are now former members, 17 remain tribunal members, and the member who has 5 complaints is still a member. Did the previous government reappoint any of these members who had multiple bullying, harassment or discrimination complaints made against them?
We would have to take that on notice, Chair.
Okay. Mr. Crew, on that advice that you've received, it's probably clearer to you who that member is. Were they reappointed by the previous government?
Chair, I only received the answer of yes, they're a current member.
Well, whoever gave you that answer
Sorry, Chair, I'm just doing the maths in my head as we speak in terms of appointment.
I'll let you do that while I ask Mr. Hawkins another question. You can see why this is incredibly important, Mr. Hawkins. Not only is there a situation where multiple, and I'm not suggesting that every complaint serves as an indication of a factual allegation, but it is, I would suggest, a pretty serious step for an employee to take to make a complaint against an AAT tribunal member. They are people with incredible power. and standing in some sense. So I would put a lot of weight to the employees making these certain complaints without going through an investigation process. But there remains 17 members of the tribunal who have had multiple complaints against them, and one member who has had 5 complaints against them. Mr. Hawkins, is this the first time you've heard this information, that it's come to your attention that this is a current state of affairs?
Obviously, I approved the answers before they were sent to the Minister, to the Attorney.
Okay.
So I was aware of the numbers, yes.
You were aware of the numbers, but were you aware that a majority of those members are still current members?
No, I was not aware of that.
This is the first time that
Yes.
you've learnt that information?
Yes.
Okay. Mr. Crew, you've sought some additional information about whether that tribunal member was reappointed?
Yes, they were appointed by the previous government. The other thing, Chair, is not all complaints. We've documented all complaints received, not necessarily all complaints substantiated.
Sure. But 5... Yeah, the question I put to you wasn't whether that member was appointed, but whether they were reappointed.
Yes.
We'll continue to endeavour to find out for you, Chair.
Okay. I might have more questions on this topic, but I'm happy to hand the call to other senators who have questions for AAT. Senator Scarr, Deputy Chair.
Thank you, Chair. I wanted to ask some questions in relation to the performance measures that the AAT adopts, and I'm referring to the annual report 2021 to 22, and there's a summary, I think a useful summary, which I will find, with respect to the performance of the AAT over the course of the last financial year. I think it's on page 24 of the annual report. Just firstly, I want to ask a question as to how these performance measures are actually developed. Are they developed between the AAT in conjunction with the Attorney General's Department, or is this wholly determined by the AAT?
Senator, I may be able to answer that question. Yes, they're developed by the AAT.
Okay. Is there any consultation with the Attorney General's Department?
Not specifically in the development of the performance measures. The performance measures are included in the portfolio budget statements and in the corporate plan for the agency, and copies of those are provided to the Attorney General's Department, but there's no specific consultation around the particular measures.
Okay. So, for example, and I just want to drill down into one area I was particularly interested in, because from my perspective, I think it is a really relevant performance measure in terms of the performance of the AAT, and that is the proportion of appeals against AAT and IAA decisions which have been allowed by the courts. So could you just walk us through what the target is and what the result was for the year ending 30 June 2022?
Yes, so this measure, Senator, looks at the number of appeals that have been allowed by the courts when an appeal is finally determined. So the number of appeals that were allowed in the 2021-22 financial year, and compares that to the number of decisions that were made by the AAT in the previous year that could have been appealed to the courts.
Okay.
So it looks back at that full set of appeals, that decisions that could have been appealed, and then compares that with the number allowed in the current financial year.
And why is this a relevant performance measure?
So in terms of just what proportion of decisions are being set aside by the courts.
So in terms of us sitting here as a committee, Legal and Constitutional Affairs Committee, considering the performance of the AAT, without some of the rhetoric around politicisation, which you've heard, but just looking objectively at the facts, why is the proportion of appeals against AAT and IAA decisions allowed by the courts a relevant performance indicator?
Well, clearly the judicial review or appeals from decisions of the AAT reviewed by the courts is a very significant performance measure because the courts are reviewing whether the decisions made by the AAT are lawful.
So it goes to the quality of the decisions which are being made by members of the AAT, does it not?
I'd agree with that, Senator.
You'd agree with that. And the performance for the year ending 30 June 2022, what was the result as against the target?
So the target is that less than 5% of decisions are set aside on appeal, and the result for the 2021-22 financial year was 1.9.
1.9.
That's for the AAT.
Right.
And
so,
IAA together.
Okay. So the result actually outperformed what the target was by 3.1% for that year.
That's
Is that correct?
Senator, yeah.
So from the AAT's perspective, that result, as I'm looking at it and trying to work out the implications of that result, that tells me that from the perspective of the AAT, the quality of the decisions actually made by the AAT members was such that the target with respect to proportion of appeals allowed was outperformed by 3.1%. Is that correct?
That's correct, Senator.
Okay. So given you've achieved that outstanding result for the year ending 30 June 2022, what process does the AAT go through? And I note there's new leadership in relation to the AAT. What process do you go through to perhaps recalibrate that target such that potentially it's a more aggressive target moving forward to the next year? Continuous improvement, Mr Hawkins. Yeah.
Absolutely, Senator. It is something we are reviewing, as we are reviewing all 6 of those targets at present with our internal auditors.
Okay, all right. So you're still in the process of undertaking that
to determine
review.
that those targets are fit for purpose.
Okay. Then if I can go to some of the other performance measures, but I just wanted to draw out the discussion with respect to that because I think that goes to the quality of the decisions which are being made by AAT members. So that is a particularly important one.
So, Senator, it is a target that we're very proud of, an achievement we're proud of. It speaks to the training that we give our members. Appointments to the tribunal are not a matter for the tribunal, they are a matter for government, but when we receive the members, we give them training to be the best decision makers they can be.
Right, and it improved year on year from 2.3% to 1.9%, is that correct?
That's correct.
Okay.
Sorry, I just missed those numbers. What were they?
It's on page 24 of the annual report. So it was the target's less than 5%, the proportion of appeals against AAT and IAA decisions allowed by the courts. Yep. 2020 to 2021, it was 2.3%, target met, and then it improved into the 2021 to 2022 year to 1.9%. So do you think that the training that's actually provided by the AAT to members there's a direct correlation between the quality of that training that's been provided and the improvement in that outcome?
I can speak for the President, who has a strong view of judicial training and training of members in the tribunal, that it is an important part of what we do, as it is in any industry, Senator, that continuous training is an important tool.
Okay. Can we walk through the other KPIs and the performance for the year ending 30 June 2022? So the number of applications and referrals finalised. So the target for 2021 to 22 was 47,944 and the result was 43,084. So that one, the target was not met. So what are the underlying reasons for that?
So, Senator, at the point of developing the portfolio budget statement for the financial year, the AAT tries to assess the likely kind of workload that will be able to be achieved in that year, being aware of the resources that are available to the tribunal and some assessment or estimate of the likely lodgements. So in the 2021-22 period, The number of lodgements we received in certain areas of the tribunal were lower than were expected. So that was, for example, in the number of applications for review of Centrelink decisions was lower than we anticipated. Also, the number of referrals from the Immigration Assessment Authority were lower than were anticipated. And so the result is lower than the target, partially and probably principally because of those receiving fewer lodgements that we expected we would have dealt with in that year.
Okay, and I guess this is an important point to note, that the AAT has no control over the pipeline of work coming in, references to the AAT, is that correct?
That's correct.
Okay.
I mean, we try and liaise with the agencies to get some sense of what the likely lodgements are going to be, but that's always a difficult thing to ensure that you've estimated
So
correctly.
over the course of the last 12 months, 24 months, have there been any particular developments with respect to the workflow coming through to the AAT which we should bear in mind?
I can certainly respond in relation to the MRD, for instance, with border closures during the past 24 months. There's been a slowdown in a number of cohort of visas in applications, simply because people haven't been able to apply for tourist visas or education visas.
Yep. Okay. All right. One thing that surprised me, and I guess this was my first time going through the annual report in great depth, was, and I'm putting this together with the statistic you gave us in terms of successful appeals, or the very low proportion of successful appeals, and that is that in terms of the outcomes of applications for review of decisions, that the decisions that were made that are subject to review were actually varied or set aside in 30% of all applications, which seemed to me, I think, to underline the importance of the work the AAT does in terms of 30% of the applications actually resulted in a variation or a set aside of the actual decision. And also, from my perspective, underlined the fact that the members on the AAT are actually discharging their role in terms of merits review in bringing a fresh set of eyes to the decisions which have actually been made. Do you have any comment in relation to perhaps Registrar, you and also the General Counsel with respect to that figure of 30%?
Not specific to the 30%, Senator, but I would say this, as I made in my opening statement that's now on the record. I consider that the work the Tribunal does, we do very well. We make over 43,000 decisions this year, given the resources that we have. We are responsible for over 400 pieces of legislation to which can be referred to us. And as you've alluded to, the successful appeal rate is extraordinarily low.
Yep. General Counsel?
Yeah, so in terms, Senator, of that figure, that's been reasonably consistent over many years. And I guess the kind of key element of merits review at the AAT is the ability to take into account new information. So that's often that's a kind of key reason why a decision may be varied or set aside. The applicants and any other party have the opportunity to provide additional information that may be relevant to the making of the decision. And so that is frequently the reason why a decision may be set aside on review.
Okay. So,
as an example, Senator, from my own experience in protection visas, for example, a protection visa may come to us for hearing 3 years after the application is made, but there have been dramatic changes in the country in which the person has applied from. So there might be a total change of government or circumstances may have changed. So that is an advantage that the Tribunal has in being able to consider that when it makes its decision.
Okay, that makes perfect sense. I wanted to ask you, Registrar, some questions just in relation to the increase in workflow with respect to the NDIS. That seems to be an area where over the last 12 months there's been a real increase in the number of applications, and what the President and you as Registrar are considering to do in order to manage that increase in workflow under that government scheme. And again, I acknowledge the AAT does not control the workflow coming into the AAT.
Right, so Senator, you are certainly correct. We received 5,918 applications for review in 2021, which was 174% more than in the previous year. In terms of cases on hand, NDIS increased to 4,193 as at the end of 21-22, but the backlog has actually been reduced by 10% as at the end of 21-22. The number of finalisations in 21-22 increased by 131%, and I think this is consistent with the President, who was formerly the division head of the NDIS division, being very, very focused on turning these cases around and our resourcing of the division with additional conference registrars and members.
So in order to, there was a real push to try and resolve as many of these issues as quickly as possible through conferences or mediation or engagement with the relevant agency. Is that correct?
That is correct. And Senator, I might just refer to Mr Crew, who might have a couple of comments to make into some initiatives that we have in that division as we speak.
We're also undertaking a review of 150 to 200 matters at the end of November, early December. Some of our older cases that are more than 12 months old, in an effort to see if we can assist with resolution of those matters or provide some directions to keep them moving or to set them down for a hearing. So we're using a few strategies. We've diverted resources, as we've said, from other areas to assist in conferencing with the peak of the workload. And we're continuing to work on practice direction as well, in terms of what we might do, noting that the agency themselves are going through a variety of changes and looking at different things. And we're seeing a reduction in the numbers and an increase in consent applications, which are also requiring a bit of a diversion of resources as well to get those consents signed as quickly as we can.
Okay. And just, I know Senator Shoebridge is keen to have the call. I just want to ask Mr Hawkins, I've been looking at the opening statement, so thank you very much for that. And in that opening statement, you refer to, and this is probably the worst nightmare of any user of IT services, and I quote, "We inherited 3 legacy systems from the amalgamating tribunals, which are now well past their end of life. We are now without vendor support for 2 of these systems. It is an imperative for the AAT to have a modern single case management solution to support the business and achieve greater efficiencies. Additional investment by government will be needed to deliver this solution," end quote. So what practically is the AAT doing to address or evolve its case management system to address this issue?
So from its own resources, Senator, we are in a proof of concept process at present, which we expect to be a matter of weeks away from resolution. At that point in time, we'll come to the government with a NPP, we hope, for funding of a unified case management system. Okay, and this is probably a lob which you can hit over the square leg boundary. How important is it to the efficiency of the AAT in terms of managing this caseload to have one uniform case management system? So, Senator, when I came to the tribunal, I was actually pleased to see that we were so far advanced in the digitalisation of all of our files, which is fantastic news on one hand, less paper, but it also exposes us to a much greater risk when we are so totally reliant on the case management systems that we have. So as I look at our risk register, I can tell you, Senator, that the case management system is accorded a critical risk category, and we need to get there as quickly as we can. Okay. Thank you very much, Mr Hawkins. Thank you, Chair.
Senator Shoebridge, you have the call.
Oh, thanks, Chair. Thanks for coming today, Registrar. It hasn't been an easy 6 months for the AAT. I think that would be a fair summary. Would you agree?
I'm here to join you, Senator. I'm delighted to be here.
Yeah, and I accept that you're not responsible for the appointments. You deal with the appointments that the government of the day gives the AAT. But in terms of the feedback you're getting from the organisation, has the concerns about the politicisation of the membership of the AAT, is it having an organisational impact?
Are you asking for an opinion, Senator?
I'm asking about whether it's had an organisational impact. So it's a fact question. There have been repeated, and I would suggest, valid concerns about the politicisation of appointments. I 100% accept that's not the AAT's fault. You digest what you're given. But I'm asking if it's had an impact on the organisation itself.
The constant media scrutiny of our appointments has an impact on our morale.
And in terms of the way in which the tribunal is dealt with or treated or respected, if you like, by the parties who come before the AAT, have you had any feedback about the impact of that?
No, I've had no feedback about any applicants before us.
And in terms of the morale impact, are you able to shed any further light on what that morale impact has been? And I'm not trying to box
It's
you
not a
in
trick
or,
question, no.
or direct your answer.
No. Senator, the feedback I receive from the membership is one of frustration that the tribunal itself is unable to respond to it because appointments are not our concern, are not our responsibility.
Yes, you're down the end of the chain. These aren't your decisions, but you're having to carry the can for them. Hence, that doesn't work well with nods. Sorry.
As I said, it impacts our morale, Senator.
Yeah.
In relation to the applicants, though, I can advise, as it is in our annual report, that we do have a 74% user survey satisfaction number, which does exceed our own goal of 70%.
But I assume that relates primarily to last financial year.
That's last financial year.
Yeah, and
yes.
much of the concern has risen since then in the public domain.
As you say.
Yep. And I assume there's no fresh data since then.
Not since then.
Could I ask you about some fresh data? I note that the annual report indicates that there were 67,720 cases awaiting finalisation as at 30 June. Do you have any more current figures? I'll rudely ask what the number are today, but if you haven't got today, what is the most current figure you've got?
As at 30th of September,
Yep.
Senator, I can advise 67,378.
Okay. So a minor downshift.
Yes.
Yep. Your budget was reduced in the most recent budget, as I read it.
7.9 million, yes,
Yep.
Senator.
What impact is that going to have, do you estimate, on the outstanding cases at the end of this financial year?
It has to have an impact on the number of decisions that we can make.
Do you have any kind of assessment of it? Do we just simply apply a percentage to it? 7% of 220 million or whatever?
No, we don't. It also plays into the number of members that we have as well. We can have resources, but we also need to have members, and we can only advise the number of members that we would like to have in different caseloads in order to clear the decisions that we have.
All right. But
So-
it will have a negative impact, but you're not able to estimate what the scale of the negative
cannot.
impact will be. I assume your budget bid wasn't for a reduction in budget.
It was not.
Are you able to disclose what your budget bid was for?
We don't bid.
No.
It's not an auction.
Senator. What we do
Describe
is
it how you
last
what
year's-
your ask was.
Last year's appropriation, and measures either terminate from other funding that's applied to that base appropriation, or new money is received for new measures. From last year to this year, we had a number of measures terminate, which was the reason we lost funding from last year's appropriation, as well as the efficiency dividend that's applied, and a fewer number of anticipated migration and refugee finalisations.
Could I ask you about sort of any analysis you do of the decision-making of individual members? You would be aware of the analysis done by the Caldor Centre for International Refugee Law at the University of New South Wales, which found extraordinary divergence of decision-making on asylum claims. Are you aware of that, first of all, Registrar?
Yes, I am.
Have you reviewed that research, and do you accept the validity of the research?
We provided a statement to the Caldor Institute, which they were able to put up on their website, which explains the tribunal's position that there are simply multiple factors that contribute to whether a member affirms or remits a decision in the protection of refugee cases to which that study refers. And it's not apparent in quantitative data that they produce.
Well, they address that in part in their research and their response to that, noting that even when it's broken down, asylum claims are broken down country to country, the same extraordinary divergence is apparent.
But Senator, there's also our own caseload management can contribute dramatically to whether a member affirms or remits a decision. For example, we might do a roster of a particular caseload across the membership, during which for 2 weeks they might be allocated a number of cases that might have a very low engagement rate by the applicant. They might be out of date, and that can dramatically impact upon the number of affirms that any member makes.
Well, we're talking in this research only instances where tribunal members had decided 50 or more cases.
Yes.
And of those, there were 15 members that had approval rates of less than 5% of asylum claims. Now, that surely would have caused consternation in the organisation. Did it?
The research itself?
The conclusions of the research. You had 15 members who had decided 50 or more asylum cases, and they had approval rates of less than 5%. They were, in asylum matters, the equivalent of hanging judges. Surely that caused concern.
I might just refer to Mr. Matthews. Have you got a thought on that?
So, Senator, in the 2021-22 year, just looking at the range of outcomes in the protection visa decision-making.
No, but this research was from 1 January 2015 to May 2020. It wasn't for that limited period. That's the research we're talking about. So if your answer is going to be about June 2020 from 1 July 2020 to July 2021, you're outside the period of the research.
Yeah, I was just going to refer to that in the sense that the proportion of matters in which the decision is remitted or set aside in that period was 7%. Ms Haddad may have some more information here.
Yeah, but for the period we're talking about, just to be clear, so the record is clear, for the period the Caldor Centre for International Refugee Law were looking at, the approval rates, the average approval rate over that period was 28%. So that number, being for a different financial year, unrelated to the research, is not helpful.
Sabet Haddad, Senior Review Immigration Assessment Authority. What I'd add is, and I know this can sound trite, but every case is different. Every case must be assessed on its own facts.
Is that seriously the answer when you have such gross statistical disparity and we've got significant caseloads? You're saying it's simply explained by the sort of individual circumstances. It's not tribunal member bias.
Individual circumstances are extremely important, Senator.
Yes, but here we have dozens and dozens and dozens of cases by each member, and we have overt bias in the outcomes, less than 5% approvals. and not by one member, but by 15 members, the majority of which were political appointments by the former coalition government. So it actually gets worse when you look at the research. Have you stress tested this research?
I can only say, Senator, that every case must be assessed on its individual merits.
Well, that's what you'd hope, but the data suggests otherwise. The data suggests that for some tribunal members, they're not being assessed on their merits. You've lost before you open the door. That's what the data shows, doesn't it, Ms Haddad? They're not being assessed by the merits.
Cases are very complicated, Senator, asylum cases.
Yes.
I might
But
also...
how does that explain some tribunal members basically refusing all of them? The fact that they're complicated is not a reason to have a 95% plus refusal rate.
If I can take an example of, say, some countries where you may find that there's a well-founded fear of persecution in one area of the country, say Afghanistan, but the tribunal concludes that it's reasonable for them to relocate to another area.
But these researchers broke it down further by origin and by country and found the same statistical bias applies. So that's not an answer either, Ms Haddad.
What I'm saying is within an individual case, there are complexities.
I agree with you they're complex, but why do 95% or more of them get knocked off by one tribunal member and 86% get approved by another, by a very rare, I might add, member? It's not about the complexity. In the cases of this high refusal rate, it's about bias. Haven't you looked at that?
Senator, the member has to look at the individual facts before them, make findings on those facts and then apply the law. Those decisions are then open to judicial scrutiny.
Well, are you saying that when this research came that I would have thought would make any tribunal blanch, the response from the AAT was, oh, well, these are complex. They've got to be decided on their facts.
Senator, Senator, I would say consistency in decision-making is probably the holy grail of administrative decision-making.
Consistent refusals?
Consistency in decision-making. But these are not robotic decisions. These are decisions where the individual circumstances, the evidence is sometimes very complex and very intricate.
Ms Haddad, these look a lot like robotic decisions. For these 15 tribunal members, computer says no. It's almost the definition of robotic decisions. Based upon it would appear a bias against asylum seekers' claims. And if the AAT's response is simply you haven't looked into the bias, that it's all complicated, then I understand that's your answer. I'm not saying it's a good answer, but I understand that's your answer.
Senator, I'd also add that there is a lot of training and emphasis on quality decision-making in the AAT.
Senator Shoebridge, I don't mean to stop you in your tracks, but I just want to remind you we are running about half an hour late, which doesn't sound like a long period of time, but in the scheme of this evening's events, that equates to an entire agency. So just draw your attention to the time.
After receiving this research, has the AAT undertaken any independent assessment of tribunal member bias in asylum claims? Registrar.
Not that I'm aware of, Senator, but I can tell you that every one of those decisions is subject to judicial scrutiny.
Mostly by unrepresented litigants who have to pay a $5,000+ filing fee to even darken the doorstep of the federal court. Are you saying that that's the integrity measure that you're going to apply?
No.
An unrepresented asylum seeker with no income hasn't gone and challenged it in the federal court with a $5,000+ filing fee. We should be satisfied with that.
That's not the test, but each decision is subject to judicial review. The members themselves are aware that their decisions are subject to judicial review.
Well, as I understand it, there's been no assessment of tribunal bias, of individual members' potential bias in terms of their decision making. Is that how I read your evidence? You haven't looked into whether or not one member has a high approval rate, one member doesn't, has a low approval rate. You haven't done that kind of analysis on asylum seeker claims.
Senator, they are all individual and independent decision makers.
And you haven't done the analysis.
We are aware of the research, but
You haven't done your own analysis.
No, We have not. Not that I'm aware of.
Well, then, how do we deal with the evidence of Michael Mineta, who was an AAT member, I think appointed in 2016, who says that he was removed from the social security cases by the tribunal's deputy president because he was said to be too claimant friendly. He was finding against the department too often. How do we square that evidence with what we get from asylum seekers? That if you're knocking the government on the head, you get moved on, but if you're backing in the government and rejecting asylum seekers, you stay in place.
That was a complaint made to the President, and the President has consulted with the parties, and a conclusion has been reached, as I understand.
What was the conclusion?
I can't speak to the conclusion as between the President and the parties.
When you say parties, do you mean the Deputy President and Mr Mineta, the AAT member?
Yes.
Well, I'm going to ask you again, Registrar. What was the conclusion about the review of the complaint by Mr Mineta that he was moved on because he was finding against the government too often on social security appeals?
I understand that Mr Mineta is practising in the same field again.
So the decision to move him on was found to be inappropriate and he was put back in?
I can't speak to the decision itself. I can advise that Mr Mineta is now hearing matters in the SSCSD division.
Why was he moved on in the first place?
I can't speak to the complaint.
Why not?
I'm not party to it, sorry.
But surely you have a role as registrar in checking on the integrity of these of the system.
It's a matter as between the member and the President.
Does anybody know about the complaint that Mr Mineta made about being moved on because he found out because he was finding against the government too often? Anyone here?
I don't have anything further to add from...
Nothing from you? From the Chief Legal Officer? Wasn't consulted about a member making a complaint about being moved off a division of the AAT because he found against the government too often? That never came to your office?
I was aware that the matter had been raised with the President and that the President was taking steps to deal with the complaint.
Adopted the grievance.
Mr Dad, you're a senior reviewer. You had no role in this?
I'm with the Immigration Assessment Authority, Senator.
Okay. So an AAT member is moved on, he says, because he finds against the government too often, and it's just a private matter between him and the President and the Deputy President. Is that the outcome?
That is the process, Senator, that matters involving member complaints are dealt with between the member and the President.
Has there been any action taken against the Deputy President who moved Mr Mineta on because he found against the government too often?
Not that I'm aware of, Senator.
Have there been other instances where members have been moved on because of a review of their decision-making made them either too government-friendly or too government-averse?
Not that I'm aware of, Senator.
So can you explain to me how there was an assessment done of Mr Mineta's decision-making in terms of, in this case, being too averse to the government, reversing decisions of the government, but yet there's no assessment being done in asylum seeker cases where we've got 15 members who knock off every single review and back the government in on every occasion?
So, Senator,
is it just when you only get moved on in the AAT when you're against the government? Is that what happens?
That's not the case, Senator. A complaint was made by a member. The complaint process was utilised, and
you can't tell us anything about it other than he was put back in?
No, I can't. There was a complaint process. The parties are entitled to privacy of handling that complaint.
Oh, I'm sorry. If someone has a public role in an independent tribunal reviewing decisions of the government, to suggest that privacy will prevent us telling us whether or not they were moved on for a political reason is a pretty extraordinary proposition, Registrar. You're saying privacy reasons say you can't tell us whether or not his complaint was validated.
I can tell you that there was a complaint process undertaken. The process was a matter between the President and the process that she undertook may well have been a mediation or what other options she had available to her. And the outcome is that Mr Mineta is practising again in the SSCSD practice.
Was the reason he was moved on because he found against the government too often on social security matters?
I do not know that.
Can you take it on notice?
I can.
Yeah, thank you. I
Can-
was
you
going
will.
to warn you against asking tedious repetition questions, but you've gotten to your conclusion there. Do you have any further questions?
Not for the moment.
Do you have a follow-up, Senator White?
Yeah, so have you, given the answer to the questions that Senator Shoebridge has asked, you've suggested that judicial review was what the those 95% of people from the 15 members could pursue. How many of them did pursue a judicial review and how many were successful?
Senator, I may have been taken out of context in the sense that I was saying members are aware that their decisions are subject to judicial review.
Sure, I get that, but I'm trying to examine what actually happened about those ones. So there were 5%, there were 15 members who only granted 5% of the asylum cases. Your view was, well, a hard done by applicant can get a judicial review. Well, and as I understand what Senator Shoebridge said is these are people who have no income and would find it difficult. So let's, what statistics have you got about how many of them went to judicial review? And if you can't answer now, perhaps take it on notice. But and then, so I don't expect you to answer, but if you can give it to us on notice, that would be useful. Then the next question, if you take what you're saying to its logical conclusion about the 5% versus, I think, 38% of the others granting it, your theory would be then they got all the hard cases, or the ones that were all the hard cases, or the ones that were so difficult or that had no merit. That doesn't sound. No, I'm casting my mind back to my commerce degree and the statistical method, but that doesn't sound like logical when you talk about 15. If it was one, maybe, but that sounds a bit odd to me, don't you think?
As I said in my answer to Senator Shoebridge, much can depend on the actual allocation of the cases, and we do have advanced caseload management in that particular jurisdiction. And it's not impossible or improbable that a member who is rostered on to do a set caseload that might involve no engagement by the applicants, or that applications may be out of time, resulting in a large number of affirmed decisions.
Well, let's not talk hypotheticals. Somebody was running this list. What did they do? Did they do that? Did they allocate these particular hard ones to those 15 people or not?
No, I don't have the answer, sorry,
Yeah,
Senator.
see,
Yeah.
so the other way to look at this is that in fact there was bias in it. That there was that's been put to you by Senator Shoebridge, that there was bias. That is definitely another conclusion that you could draw from the statistics, isn't it?
And that's
Same
why
as your hypothetical.
Yeah, and that's why we say quantitative decisions are unreliable, given the complexity of the caseload and all the different facts that we have to confront as decision makers.
So if quantitative decisions are unreliable, wouldn't you do some qualitative decisions when you've got such a statistical anomaly as this?
We respond, Senator, that the caseload is complex, especially in protection law, and we have to deal with each case on its facts.
I get that, but as I said, 15 have got 5% and the average is 38. And this is a report, and people are going to draw that conclusion of bias, are they not, without some qualitative work on your behalf to defend the members of the AAT. That's my, I guess, political comment, but it seems odd to me. And I just wondered, are there other? I have in the back of my head that there have been other judicial bodies that have had this sort of allegation against them. I'm just trying to remember what. And they did take some further action and looked at it more closely?
The Federal Court.
The Federal Court, yeah, there you go. Yep. Thank you. The Federal Court did that too, because they've had this allegation. Has it crossed the mind of the AAT to maybe do that to defend the integrity of the members?
It's certainly something that consider what our friends in the court are doing, but we are, as I've said, independent decision makers.
I get that, but the public doesn't see that. They see the statistics and the Colville report and go, what's going on here? Thanks. That's my questions.
Thank you, Senator.
Thank you, Senator. Mr Cruz, are you still there? Just in relation to the questions I put to you before, and then I'll just have two short questions and we'll move on. I asked you around the numbers you gave me around members with complaints. You said 17 of the 19 are still members, and the one member who had 5 complaints is still a member. I wonder if you have the answers, just to break it down, of the members that have... There are 3 members who have at least 3 bullying, harassment or discrimination complaints. Are they still members?
So, Chair, I can answer your previous question in relation to the one who had 5 or more.
Yeah.
They're still serving their initial period of appointment.
Okay.
And in relation to breaking the matters down further, all we have in front of me is the actual numbers of members at this stage. So
All right,
we
well,
could
do you take
on
that on
notice.
notice? I want to understand, you've given me the numbers of members who have a certain amount of complaints.
Yes.
2, 3, 4 and 5. I'd like to know, of those cohorts, how many of those members are still current members? So there's only 2 that have essentially dropped out of that cohort. I want to know where they've come from. Okay, thank you. If there's no other questions for the AAT, I want to thank you for your time this evening. And I call officers from the Australian Law Reform Commission. Thank you.
Thank you, Senators.
Thank you. Ordinarily, I'd ask you to make an opening statement, but we did ask all agencies to, if they had an opening statement, to table. Have you had the opportunity to do that?
I haven't, Chair, and I wondered if you would indulge me for 20 seconds, just to give a very, very brief.
You'll have to say your name before
Yeah,
you...
my name's Matt Corrigan. I'm the General Counsel of the Australian Law Reform Commission.
You have 20 seconds from now.
As this is the last estimates that the Commission will be attending with the current commissioners in place, I just wanted to acknowledge the exceptional work of Justice Sarah Darrington, who's the President of the Commission and has been for the last 5 years. I also wanted to acknowledge Justice John Middleton, who's been Commissioner for the last 10 years and is retiring at the end of this year. Thank you.
That was a very good 20 seconds, Mr Corrigan. Thank you. Senator Scarr, do you have questions?
I just had some short questions, I think, in relation to the most recent referral to the Australian Law Reform Commission to review religious exemptions for educational institutions. Was the Australian Law Reform Commission involved in terms of settling the terms of reference of that referral in any way, or was the terms of reference simply transmitted to the Commission from the Attorney with no discussion about the ambit of the terms and the particular wording, the subject matter to be covered?
We were asked very briefly for comment on particular aspects of the terms of reference.
Okay, and did you, what particular input did you provide? Was your input reflected in the actual terms of the terms of reference?
Largely our input was in relation to timing. Obviously the government has particular impetus for a short review, and our view is that the ALRC can't really do a proper law reform inquiry in less than 6 months, so we pushed for 6 months, and I think we've ended up at about 5.5 months. So,
yeah, 5.5 months, but over the Christmas period as well, which probably isn't ideal. So what does that mean in terms of your process or timeline to progress the review? Have you settled on a timeline yet?
Senator, we only formally received the terms of reference on Friday. I know that the President has spoken to Justice Rothman, who will be the Commissioner in charge, very briefly on Friday, but the team as yet has not had an opportunity to meet with him and settle the timeline. I would like to reassure stakeholders, though, that we will prioritise their input into this inquiry, and most likely that will be well after the Christmas New Year break. We won't be asking people to comment on these issues over the holiday period.
Okay, and will you be looking to have public hearings, or is this something you do on the papers, or has that decision not been made yet?
That decision has not been made.
Okay. Do you have any insight into how Justice Stephen Rothman was actually selected?
The Commission was not involved in that process.
Okay, so you were simply advised of the appointment. Secretary, do you have any insight with respect to the selection of Justice Stephen Rothman?
In terms of the selection of part-time commissioners to conduct particular inquiries, the traditional approach is that they are appointed directly by the Attorney-General, and that was the case in this circumstance.
Right, so do you have any knowledge of the process that the Attorney went through in terms of identifying the relevant person to act as a part-time commissioner in this context?
The department wasn't involved in that process, so I can't provide information on that. But as I said, that is in relation to part-time appointments for commissioners to the ALRC. It tends to be a matter that's dealt with directly by the Attorney-General.
Okay. Minister, I'm assuming you might want to take this on notice just in terms of the process the Attorney went through in terms of selecting the Honourable Justice Stephen Rothman to act as a part-time commissioner, but happy to hear any insight you can provide with respect to the selection process.
Sure. I think as the Secretary outlined, he went through the normal process. If there's anything that the Attorney-General wants to add to that, I'll make sure that we include it.
And I should say here, I'm not in any way reflecting on the selection. I was just interested more in terms of the process. Okay. All right. Thank you. Thank you, Chair.
Senator Shoebridge.
Thanks, Chair. And thanks, Mr Corrigan. And I join with you in acknowledging the work of the commissioners and the Commission more broadly. Can I ask you about the religious discrimination reference? The consultation information for that specifically mentions targeted consultations with, and the list I have, I think, that's been produced by your entity is religious organisations, the education sector, unions, legal experts and other civil society representatives. Was that list drawn up by the Commission?
I think you're quoting from the terms of reference. The terms of reference are issued by the Attorney-General. They're not issued by the Commission.
All right. And in having received those terms of reference, was the Law Reform Commission consulted on the terms of reference?
Oh, we were consulted on aspects of the terms of reference, yes.
Did the Law Reform Commission raise any concerns about that description of the consultation in the terms of reference?
Our focus in terms of we were given a few hours to comment. Our focus was more on logistical matters rather than the substance of them.
But you acknowledge there are concerns describing the consultation with those limited number of stakeholders. Would you agree?
I note that there's been public concern expressed in relation to the terms of reference, and the Commission is not limited by those terms of reference and will be consulting broadly in relation to all interested stakeholders.
Well, we're talking in generalities here, but do you acknowledge that there are key stakeholders, key parts of society that are not included and on one view excluded from the proposed consultation in the terms of reference?
What I can say is that our initial stakeholder mapping in terms of the interested stakeholders is broader than expressed in the terms of reference.
Well, broader in what way?
There are a range of interested stakeholders that are not reflected in the terms of reference.
Well, such as?
Students, teachers, LGBTIQ identifying individuals, and NGOs and civil society organisations in relation thereto.
Given that the previous debate on religious discrimination ended up being in significant part targeted against LGBTIQA+ community, given the concerns they have repeatedly raised about this issue, did the Law Reform Commission raise concerns about the LGBTIQA+ community not being explicitly referenced in the consultation under the terms of reference?
No, we didn't. And as I said, we were given a very limited opportunity to comment, and we commented in response to specific questions.
Are you intending to remedy that lack in the consultation on the terms of reference by having overt outreach, clear outreach to the LGBTIQA+ community and organisations? Are you going to remedy that problem in the terms of reference?
I would say this, that we will, as I said, we will consult widely.
Well,
we're not responsible, Senator, for the terms of reference.
Well, the terms of reference excluded the LGBTIQA+ community from the consultation. I'm going to ask, well, other than in a generic phrase, other civil society representatives, so it didn't expressly reference them, are you going to clearly, unambiguously and publicly indicate that you're going to include that community in the consultation?
We will consult all stakeholders.
So you fall back on that generic phrase of all stakeholders. I'm asking you about this community, which feels particularly under threat, and particularly under threat from this process. Are you going to identify them as a distinct and clear interest group that must be part of the consultation and brought fairly into the consultation?
We will consult, yes, absolutely.
I'm just going to ask a follow-up to clear this up. The terms of reference refer to having regard to extensive consultations previously undertaken on these issues. In particular, the ARC should review submissions to previous inquiries and tailor consultations accordingly. That allows the Commission to consider the bulk amount of submissions made on this topic. Is that correct, Mr. Corrigan?
Absolutely.
And one of the reasons I don't have advice from the Attorney General, but I would consider as a member of the LGBTIQ community that having to redo a submission that I've previously already put forward to a inquiry which does have sensitive impacts, it would be a good thing for the submissions that have been previously provided to be considered so that that exercise doesn't have to occur again. Is that something that you will be doing?
Absolutely.
Thank you, Mr. Corrigan.
Chair, I think Senator Waters has just one question on this.
Sure. Senator Waters.
Thanks, Chair. Hi, folks. Just one question, please. The Senate inquiry into the Respect at Work bill recommended that the costs provisions be referred to the ALRC for review within 6 to 12 months of the bill taking effect. In the House this morning, the Attorney said that he would have more to say about that shortly. So my question to you folk is whether or not the ALRC has been consulted about your capacity to undertake any such inquiry and the time and resources that might involve.
Not to my knowledge, Senator.
Okay, nothing as yet. Were you familiar with that Senate report recommendation for such a review by ALRC within that timeframe?
I'm aware of the report, yes, but we haven't had any discussions about it.
But no contact's been made as yet. All right, thanks very much. Oh, I should ask about your capacity. What is your workflow looking like in 6 to 12 months' time?
we are very constrained, so we would need additional resources in order to complete that review.
Okay. Do you anticipate having an increase in staff or commissioners required to do that work?
Oh, that'd be a matter for discussion with the attorney. Yeah.
Okay. All right. Thank you. Thanks, Chair.
Thank you.
Excuse me,
Unless
Chair.
there's any...
Could I
Ms.
just
Jones.
clarify some evidence that I gave just a little while ago to Senator Scarr when he was asking about whether or not the department had had any involvement in the appointment of the part-time commissioner for this inquiry. And the department did provide some advice to the Attorney-General. I was framing my answer in the context of whether or not we undertook a process, but we did provide information and advice to the attorney in relation to that appointment.
Was it with your indulgence, Chair, if I can just ask a follow-up question just on that particular issue, was the advice that was provided, Secretary, in relation to the process or the identity of the person appointed to the position?
We were asked to provide advice about potential people to be appointed to the position.
Okay, all right, thank you.
Yeah. Okay, great. There being no other questions for the Australian Law Reform Commissioner, thank you for your appearance. And I call officers from the Federal Circuit and Family Court. Federal Circuit and Family Court of Australia. I'll just allow those officers to come to the table. Larissa. Yeah. Okay, Senator Waters, you have the call.
Thanks very much, Chair. Thank you for joining us today. I refer to some allegations that were reported earlier in this year that the Circuit Court had appointed a number of registrars at a low pay grade and then bumped them up to a higher level to avoid recruitment caps. And I understand that there's now a complaint that's with the Ombudsman, which had previously also been reported to the APSC more than 2 years ago. Can I just understand, please, what internal action or investigation has been taken by the court in response to those allegations?
Good evening, Senator. David Pringle here, CEO and Principal Registrar of the Federal Circuit and Family Court of Australia. I understand those specific matters may have related to registrars in another court. I just wanted to make sure that you had understood them to apply to our court.
I believe so. But if I'm wrong, I'm in your hands.
I'm sorry if that's the case. I'd understood that those matters were playing out in regard to registrars of the Federal Court.
Okay. Do we have the Federal Court appearing before us, Chair? No. They weren't called this time around. All right. Well,
No,
look,
they haven't
my
been called.
apologies. Let me check back, and if we'll work out where those questions belong. But Chair, I may well ask to be reverted to once I've got some clarity.
I'm happy to take on notice anything that might apply.
Thank you. Well, perhaps could I ask you some questions that I hope sit with you about the Lighthouse project and Indigenous liaison officers?
Yes.
Yes, I hope. Great.
Absolutely.
The budget's got some additional Lighthouse project officers and Indigenous liaison officers for the Federal Circuit and Family Court. Have you begun recruitment for those positions?
We've recruited almost all of the positions relevant to the expansion of the Lighthouse project nationally. We had existing registrars and other staff for the 3 pilot registries in Adelaide, Brisbane and Parramatta. We've retained all of that staff and on top of that been for some months now actively recruiting. Almost all of those positions have been recruited. There's a couple that are still in the process of finalisation. That's for the core Lighthouse project expansion, that is to say the case management model, the screening process, addressing the family violence issues and so forth. In regard to Indigenous Family Liaison Officers, we only received confirmation of funding fairly recently, obviously, but we have proactively recruited some positions, 5 positions recently, out of the up to 11 that were allowed under that funding. So we're in the process of actively extending that. We have utilised the services of a specialist recruitment firm, First People Recruitment. Given the cultural issues and processes there, that's very important. We consider that be done carefully and appropriately. So that's well underway, and we intend to appoint as many as quickly as we can within that funding envelope.
Thank you. So just for clarity's sake, will those 11 Indigenous liaison officers be reserved for First Nations applicants?
I'm sorry, I didn't quite hear that.
Will those 11 Indigenous liaison officers be reserved for First Nations applicants?
Oh, absolutely. Yes,
great.
it's a requirement in the
Thank you.
recruitment process.
Yep. And just hearkening back to the Lighthouse positions, can you just tell me how many new, what the budget allowed you to hire in terms of new staff to undertake the Lighthouse project?
Yes,
and how
I'll be
many of that, you said you recruited some, how many and how many still to go?
Yes, bear with me a moment, please. I'll get you those figures. So again, it allowed, including the existing staff, for a total of 71 family law positions. Do you want a breakdown of the particular positions?
Yeah, I'm just after the Lighthouse project officers specifically. Is that the 71 to which you refer?
Yes.
Okay, so 71 in total?
Yes, that's right.
And how many new ones based on the most recent budget?
We had... if you're asking me to differentiate between the existing number of pilot staff that are carrying over into, and
Yes.
therefore how many new are topped
Correct.
up out of that 71, I'll have to get clarification of that and come back to you probably within the course of us giving evidence now.
Okay, thank you. And did you publicly advertise those positions?
Yes, we did.
Yeah, okay, thank you. And forgive me, I'm also just trying to flip to the document that will tell me whether or not this registrar issue was in fact with your courts. I believe that it was, but pardon me for 1 second. Perhaps, Chair, would you mind returning to me after the next questioner while I ascertain the correct location for those questions? Would you mind coming back to me? We're just working out which court those questions belong
You
to.
have a few questions.
Sure. Thank you, Registrar, for appearing today. This must be the first time we've seen you in person for a while. I think I'm just trying to
Has
remember.
been due to COVID-19 mostly.
Yeah, absolutely.
That's
I wonder if you could provide your reflections. We're some way down the track now from the merger of the Family Court of Australia and the Federal Circuit Court. What are your reflections in terms of the success of the merger?
Well, it's been a little over a year, about 15 months or so, and in that relatively short time there's been some really positive indicators come through. We've got to appreciate there's still a very significant legacy caseload that has an impact on the ability for the new model to do what it needs to do. But the new arrangements are working very effectively from these indicators, and I'm happy to outline some of those for you. Division 2, or as was previously known, the Federal Circuit Court, docket numbers were on average around 330 for each judge in around May last year. They're now, as we speak, about 113 on average. That's taking a very significant load off the judges so that they can have more time to be able to deal with complex hearings and their judgments. The clearance rate since the reforms, and it's not only, of course, the legislative reforms that were brought in, but many other harmonisation measures of the Chief Justice, including harmonising our rules, our procedures, our practice directions and so forth, has moved up in the last financial year to 131%. Historically, that's only ever been either at or below 100%. On occasions we've been slightly over, but to my knowledge that's not a figure that we've had or anything like it in the past.
So what's the implication of that, getting above the 100% up to 131%, if you can just draw out the significance of that figure?
Yes, well, the clearance rate measures in any given financial year how many cases come into the court as against how many we dispose of through resolution or determination. And you want to be around 100% to be treading water and clearing about as many cases as are coming in. If you drop below that, you start to build backlog. And if you go above it, you start to eat into your caseload or backlog. So by being at 130 odd %, you are making significant inroads into the backlog or the pending cases in the court. And that is indicated again by the next data point, which shows that we've been able to shave just over 20% of our legacy caseload that was previously in the courts from 1 September. That's about 4,500 cases that we've taken out of the system since 1 September last year. And the trial pools that exist in Division 1 or Family Court, they've been really significantly reduced. Those cases that were sitting and waiting for trial have gone from around 363 cases waiting in those pools to about 67. Okay. So it's had a very profound impact to be able to get above 100% in the clearance rate.
Excellent. So, Mr Pringle, as you know from previous appearances before this committee, I'm a big fan of registrars, and I think registrars are absolutely crucial to the efficient running of our court system. And I think you gave evidence last time you were before this committee that something approximately, I think the figure was 18,000 case hearings had been heard by registrars. I'm just wondering if you can give an update in relation to the number of cases that are now being dealt with by registrars.
Yes, I'm very happy to. The registrars have taken a very significant load, and I'm a big fan of them too. They are highly...
That doesn't surprise me, Mr.
highly experienced, very, very capable lawyers, and what they have done is essentially shift a lot of the front-end load, all the case management and triage process across to registrars for what judges were often dealing with, together with a lot of the interim defended hearings and as well dispute resolution, which of course if a case resolves, you save all the downstream impact on the court and the costs and the stress for the parties. Since the 1 September changes, registrars have undertaken in order of 32,000 plus first and second return hearings, so that's all that front-end case management work. About 10,000 interim defended hearings and have done about 6,600 plus dispute resolution events, which are settling at around about close to 60% settlement rate. So that's again taking a lot of cases out of, safely, of course, through this out of the system. And that's not to mention the other categories of registrars who've done more than 56,000 divorces and 18,000 consent order applications or more. So it's a very significant load that's been shifted and again allowing for the complex hearings that really do need a judge's attention to be able to be directed to the judge and at a quicker pace.
Okay, I'll just ask one final question. And I'll make sure I don't use a full stop in my question. But I'm keen to get an update with respect to the relocation of the Launceston Federal Circuit Court and also an update on the Rockhampton Registry of the Federal Circuit Court, which had both been funded by the previous government.
Yes, well, with regard to both of those matters, in terms of property or building related issues, that's formally dealt with by the Federal Court of Australia entity who have responsibility under the corporate services arrangements. Right. Now, again, they haven't been called this time around, but I am able to clarify in broad terms from a Launceston point of view that there have been some delays occasioned by supply issues and some building-related issues, structural engineering-related issues, and the anticipated operational date for that courthouse is now, I think, towards the back end of January next year. But if you need any specificity on either the timing or the details, I think it may be best to have a question on notice go to the Federal Court of Australia entity.
Thank you, Mr. Pringle.
Yes,
Thank you, Chair.
I don't have anything specific unless you wanted to
I'll
raise
put it on
in regard
notice
to
to the-
Rockhampton.
yeah.
Probably be best to raise with the
Yeah,
Federal
I
Court.
will. Thank you.
And Senator Waters, did you?
Yes, thank you for your guidance, Mr. Pringle. I stand corrected and I'll place those questions on notice to the Federal Court. Thank you. Thanks, Chair.
Thanks.
Oh, yeah. Thank you, Chair. Could I ask Ms Pringle about the Indigenous list?
Yes.
First of all, is it continuing, and in which case at which registries?
Absolutely, I'll be able to clarify that for you. The first thing I should clarify, Senator, is that there are a number of different models utilised within the court to address Aboriginal and Torres Strait Islander matters. Some are formal Indigenous lists where they're separated out, those matters, and they're dealt with in a very specified way from the beginning of filing of the proceeding. And others are a variated case management approach where the matters are dealt with more in the manner of the rest of the matters that might stream into that registry, but with an appropriate arrangement for Aboriginal and Torres Strait Islander matters. So I should just clarify, we don't have one specific list.
Well, to be clear, I'm asking questions about specific Indigenous, which registries have a specific Indigenous list, and I'm familiar with the list in Sydney and some of the work that was done in the Sydney registry to initiate that model. So I'm
Yes,
asking
Senator,
about
that's
that.
right. So that is certainly continuing under the great work that Judge Boyle does in Sydney. We also have a very similar list in Adelaide, and we have similar lists, one recently set up in Brisbane, and also the Melbourne list. So all those four are dedicated Indigenous list structures. Over and above that, we have the variated or modified case management approach that I mentioned before, applying in Cairns, Darwin and Alice Springs, and also Townsville.
The court website indicates that there are Indigenous lists running in 6 locations: Adelaide, Alice Springs, Brisbane, Darwin, Melbourne and Sydney. But I'm to understand that, in fact, an Indigenous list, as properly understood, only runs in Sydney, Adelaide, Brisbane and Melbourne.
In that formal separated matter, and I think it's because there's been quite a lot of changes in that area, Senator, that information will be updated soon because there are new lists about to start as well. But the formal structured Indigenous list is formally done in those 4 locations, but there are specialised case management approaches in those other 3 locations
Can you
as well.
provide on notice details about the distinction between the Indigenous list and the case management approach taken in other registries?
Yes, very happy to.
In the registries where there is an Indigenous list, is every First Nations, every matter where there's First Nations litigants, are they all allocated to the Indigenous list?
So the first thing is to identify whether it is a matter captured as involving an Aboriginal, somebody who identifies as Aboriginal or Torres Strait Islander. So it's sufficient if one party does, another party might not be. That can be done most easily through a box that's checked when a party files, and if they identify that way, then it's so identified. But if during the course of a proceeding it becomes clear that the party hasn't checked that box but does identify that way, they can be brought into the list.
Is there any additional funding that's been given to the court? I know at the time I first saw the list, it was self-funded by the court, but has there been any additional funding given to the court to manage the Indigenous lists?
Well, we would see the recent funding that's come from government under the Lighthouse project, of which a significant component was for Indigenous family liaison officers to be part of that. But that's under the Lighthouse framework, if I can put it that way. But otherwise, the specific funding for lists is something that's managed within the court structure.
Has there been any assessment of the efficacy of Indigenous lists since I first established, I think it was 2016 or so in Sydney?
Yes, that list has been running for some time, but most of the lists are more recent than that. So in terms of a formal review process, no, but we're in the process now that we do have a much more structured environment around that, of setting up better data capturing and proper analysis of all of the work being undertaken there.
So is there funding and is there an intention to do a review, and probably the list that would be highest on the list for that would be the Sydney list, given they've got data going back 6 years. Are you intending to do a review?
The issue is with the ability to capture the data, and you know, the computer systems can obviously draw on which matters have Aboriginal or Torres Strait Islander litigants in them. But as to a substantive assessment of how each of those matters have gone and how they've been treated, that would be a much more manualised process. And we are in the process of setting up more data capturing, because part of the funding we got recently under the Lighthouse Project does involve a management structure, including a registrar position for that.
Perhaps you could, on notice, identify how that Lighthouse funding is going to support the Indigenous lists, and what proportion of what amount of funding will go to support the Indigenous lists. And I think Senator Waters asked you some other questions on notice about the Lighthouse funding.
Yes.
Can you indicate how much of that's going to support the Indigenous lists?
Yes, very happy to indicate that on notice.
In relation to court child experts, I think the court has court child experts and Regulation 7 family consultants. Is that right?
Yes.
And they perform similar tasks?
Well, actually, under the recent changes, there are some differences, and there has been historically differences. The court child experts, and I may, if you want some detail on this, throw to my colleague Janet Carmichael, who heads up that section, is here today. But the court child experts are our in-house employees, and we have a very detailed method of quality assurance and recruitment processes for them. The Regulation 7 consultants are independent contractors. And generally speaking, the Regulation 7 consultants will deal with the back-end reports, the larger family reports under Section 62G of the Act, whereas our court child experts, whilst they can do those reports as well, deal with our child impact reports more towards the front end of proceedings, which is a new form of report under the reforms. And also, of course, dispute resolution. They're now involved in dispute resolution with registrars to put the focus back on the child.
Of the court child experts, I think am I correct, they're required to be either a registered psychologist or eligible for membership with the Association of Social Workers? Is that the criteria?
I'll pass to my colleague Janet Carmichael for that.
Janet Carmichael, Executive Director of the Court Children's Service. Yes, Senator, that's correct.
Yep. Can you... do you have any data on, first of all, the number of children's court experts, and then the breakdown, how many are registered psychologists and how many are eligible for membership with the Association of Social Workers?
I can give you numbers on how many court child experts we have, but I'll have to take the question about the breakdown between the two professional groups on notice.
So what if you can give us now, but then if you could take that back for the last 3 financial years so we can get a bit of a pattern, that would be helpful too, Ms Carmichael. But what data do you have here?
So currently, including senior court child experts, we have 93 FTE of court child experts employed.
And does 93 represent 100% recruitment, or do you have vacant positions?
We have a small level of vacancy.
What's the vacancy level?
Approximately 10 positions at the moment across the country.
Would you mind, on notice, giving that data back over the last 3 years in terms of the numbers, the average numbers over the last 3 financial years and the vacancy rates over the last 3 financial years, Ms Carmichael?
Yes, I can. I can give you the last 3 years now, if you would like me to.
That would be helpful.
So in the 19-20 year, we had a budget of 88.4 and an actual staffing level for that financial year of 78.2. For the 2021 year, we had a budget of 96.4 and an actual ASL of 80.9, and 21-22, 106.9 budgeted and 85.2 ASL.
And in this current financial year, you have 103 budgeted, is that right?
We have about 107 budgeted. We have 10 positions vacant. And then we have a greater level of vacancy from other arrangements, long-term leave as such, which affects the ASL. So the ASL will be higher than 10.
In terms of eligibility for membership of the Association of Social Workers, why is the criteria eligibility rather than membership?
Because that is a membership body, whereas psychologists are required to be registered under the Health Practitioner Regulation Agency. Social workers are not. So it's a different form of body. So to practice in Australia, you need to be registered as a psychologist with AHPRA. There's no such registration for social workers. So there is a membership body, the ASW, who have certain criteria for membership. So we use eligibility for that membership body as a way of determining people meet that criteria. It's not dissimilar to the Australian Psychological Society, but we don't need to use their criteria because there is a regulation system for psychologists.
If you wouldn't mind providing that criteria on notice, I'm not asking you to.
For social workers?
For the social workers, that would be appreciated.
Yes.
In relation to the Regulation 7 family consultants, is it the same criteria?
Yes, it is.
And again, could you break down over the last 3 years the number of Regulation 7 family consultants that are registered psychologists as opposed to eligible for membership of the Association for Social Workers?
I'll have to take that on notice as to whether we can even give you that breakdown going back that period of time.
Yeah, if you take it on notice, I'll get what I get.
Senator, can I just clarify so that we can answer that going forward potentially? Are you asking for details of how many we engage or how many just exist full stop?
Well, I'm assuming that under Regulation 7, people are eligible to be as opposed to a list, or is there a list under Regulation 7?
Yes, I see. They get appointed.
Yes, so I'm after the
yes.
appointments, those that have been appointed.
How many are currently appointed? Is that the key?
Yes, and looking at over the last 3 years, how many were psychologists and how many were eligible for membership of the association?
Thank you for clarifying.
Senator, we do have 3 agencies we were trying to get to before the dinner break.
Could I ask about the training given to child court experts and Reg 7 family consultants? Are they provided specialised training, particularly on family and domestic violence, child abuse, and child sexual abuse? Is there mandatory training?
There is for court child experts. We have quite a comprehensive family violence training program, and that covers other risks as well. And for Regulation 7, the same training is offered and they are strongly encouraged to undertake it.
All right. Do you have any data about the proportion or the number of Reg 7 consultants who have undertaken the optional training?
Yes, I have that data, and so I'll take that on notice and I can provide that.
Why is it considered not mandatory, given such a large amount of the casework of family consultants would deal with family and domestic violence, child abuse, child sexual abuse? Why isn't it made mandatory?
They're not employees. As such, they're contractors that we've engaged to do the work. So we don't compel them in the same way we can compel our staff.
But they don't have to be on the list. And you could have quality control by saying you can't get on the list unless you do the training, but you choose not to. And I'm wondering why.
You're right, we can choose who we allocate work to, and we do take into account those that take up the option of training. And at this point of time, it is the majority of Reg 7s that have taken up the option of training, but some have elected to undertake training through other avenues.
But why not make it mandatory? I don't understand. I mean, it's actually critical for this work. Why not
Senator,
make the
can I
training
just
mandatory?
Perhaps jump in for a second just to clarify that there is a very careful process of assessing each Regulation 7 applicant before appointment. It's a thorough process that's gone through, and we have a specialist, very senior family consultant in-house who helps to guide all of that. So the quality in terms of the skills, the training and the experience and the like is really, really carefully assessed. We also have to be mindful of the volumes of matters that come to us and of the market pressures that are out there in terms of how many are available to do the work. But we would not appoint somebody who does not have, that we don't have complete confidence in terms of their skills and background.
All right. Well, perhaps I'll ask this, and you might take it on notice. Can you please advise on notice you're going to provide us the answers about the numbers who have undertaken the training of Reg 7s. Can you provide us any detail, if you can, about the proportion of those Reg 7 consultants who are given work, who have been trained, have undertaken the optional training? Do you have that data?
Yes, we could get that data. I'd have to say it is more often a matter of how much work they will accept rather than how much work we might choose to give them.
Understand. And then can you provide on notice details about the content, the frequency of the training and the court's monitoring of compliance? And it's of that list of training that I put to you before.
Yes,
thank you.
Do that.
Can I just ask Can I just ask one question on that? Could you also provide details of the number of hours that each of the consultants on average would work? And the number of clients that I think you asked that, but the number of hours that they work?
Well, we have both part-timers and full-timers on staff.
Sure, but part-time can be what, 4 hours a week, or it can be 35?
The minimum part-time that we take on to contract is 0.6, so 3 days a week.
3 days a week.
We may occasionally allow somebody, say, in returning from maternity leave to commence on slightly less, but generally the minimum people do is 0.6.
So can you give us the breakdown? So there might be 0.6, but how many? Give us a breakdown of what exactly they're working and so what the workload's like.
Senator, can I just clarify that, and correct me if I'm wrong, please, Janet, but this would be all manualised data. So to go in at a granular level and look at each consultant and how much they've done in any given time period, and that might vary from year to year, of course, could be a bit of an exercise.
Last 12 months.
I think we could probably take that on notice.
So
you must have some estimate, surely, because you'd have to budget for what it is. So you'd have to have some idea about what you're doing, wouldn't you?
Can I just clarify, you're talking at a service level, how many, that total number of staff?
Yeah, total number of staff and what they're... So if you say they work 0.6, but does anybody work 0.8?
Oh, yes, there's plenty that work 0.8 and
exactly.
plenty that work... So you're asking a breakdown of the number at each FTE level?
Yeah, that would be,
we can
I think, useful to get an understanding of how much is being... Well, how many people are being utilised? Because you said there's a market pressure. I'm just interested in the part-time, full-time breakdown and then the number of days that they're working.
Yes, we have a significant number of part-time staff. I think reflects the demographic of the workforce.
Yep, I can understand that.
Just one question on data.
Really quickly.
Yeah. I understand from the most recent annual report, the court's now able to capture data from the Notice of Child Abuse, Family Violence or Risk Notice forms. That's right. And there's 10 key questions you ask in relation to that. Is that right?
I'm not sure of the number, but it is a number of fields. I thought it was more than that, a number of automated fields we can capture.
All right.
I think it is 10. Yes, it is. It's been confirmed. Thank you.
Okay. So you're capturing that data at the commencement of proceedings primarily, is that right?
Yes, that notice is a document that's required to be filed at the beginning of a proceeding.
Do you know whether the court's capturing or able to capture the data as to the outcome or decisions of those cases once the notice has been filed? Are you tracking those cases as they go through the system?
No, that would be an exceptionally resource intensive. You'd have to read the judgment, look at each order manually and try and assess it as against what was said in notice of risk. With the thousands of cases we have each year, and tens of thousands of cases we have each year, we'd have to set up a huge team of people to try and do that. And of course, there are very many reasons. Many cases, of course, will resolve at mediation or through some other process. It'd be very difficult to assess the outcome there. If you're talking about judicial determinations, that would be a smaller proportion, but it would still be a very heavy manualised exercise to try and do that.
All right, we might come back to that at another estimates.
Thank you, Senator Shoebridge. Given there's no more questions for the Federal Circuit and Family Court of Australia, thank you for your time this evening. I will be calling officers representing the Independent National Security Legislation Monitor. The committee is going to suspend for a short period, 2-3 minutes max. I think some people need to quickly duck outside. We'll be back in 2 to 3 minutes.
Thank you, Chair.
Did you say 15 minutes?
2 to hearing. Before we kick off with the Independent National Security Legislation Monitor, for the benefit of officials, we are still seeking some advice about whether there are some agencies where there may not be questions this evening, but we'll get back to you around the dinner break to allow that to happen. We've asked agencies to present to table opening statements. Mr Donaldson, have you had the opportunity to do that, or would you like to make an opening statement?
I haven't tabled anything and I don't have an opening statement.
Fantastic. Senator Patterson, you have the call.
Thank you, Chair. Good to see you, Mr Donaldson. Just wondering if you could confirm for the public record whether or not you have commenced an inquiry into the espionage and foreign interference legislation.
It hasn't been formally announced, Senator. Work has commenced in relation to it. By that I mean there have been briefings that I have received from particular agencies. Inquiries have been made of different agencies and departments in relation to certain matters. Yep. And I have commenced, personally, as have my staff, reviewing particular material. As I know you know, Senator, there was it's been a committal hearing recently in relation to the foreign interference legislation. And we've paid a fair bit of regard to that. And again, Senator, you're probably aware that the British Parliament is considering introducing similar laws to the foreign interference laws in Australia, and we have had a deal to do with various officers in the United Kingdom about that. But there's not been I've not announced the commencement of that review.
Yeah. What is the next steps from your point of view in this review? When will you make a public announcement and seek external submissions and those sorts of things?
In EFI?
Yes.
The way in which the workload for my position is going at the moment is that I have a review that is nearly complete but has been delayed a little, or been delayed quite a lot actually, really as a result of the change of government, and that is the High Risk Terrorist Offenders scheme. So that's Division 105 of the capital A of the Criminal Code. That will be finished fairly shortly after a further set of public hearings on the 21st of November, so I'd hope that would be done by the end of the year. There's been referred to me by the Attorney-General a review of the National Security Information Act, and that has been, there is a time limit on that, and that is the end of, well, I think it's a date toward the end of October next year, and I've been directed to give priority to the conclusion of that report.
Yep.
And I would be hoping to also have the review of the EFI done prior to the conclusion of my term, which is November next year. But I think it's unlikely that I will conclude the EFI review by that stage at this point in time.
Yeah.
But I think that announcements about those, formal announcements and calls for submissions, will be made probably in February.
Okay. And I certainly appreciate that you are a part-time official and you have a very small agency, and that the matters you consider are complex and very important. So I appreciate the time taken, and I'm not in any way seeking to reflect on your agency in relation to that. I want to pursue, I'll come back to that observation you made about the high-risk terrorist offenders review in a second. I just want to conclude the questions on AFI. So you think best case scenario, you'd be able to conclude that by November of next year.
Yes.
There is a risk that you may not be able to complete it by the end of your term, noting the other important task the government has set you on.
Yes.
In that case, presumably your work would carry on to anyone who's appointed to replace you. They would be able to pick up, at least to some extent, where you've left off to complete a review that was in progress, or do they have to initiate it again?
No, it would be an initiated review that would follow over. That's a review which is mandated under my Act. So it would follow over. And if, Senator, I form the view at any stage during the course of next year that I'm not likely to, or I'm not going to finish it, then I will direct my efforts to concluding work that will be usefully handed on, if I can put it that way.
Yep, understood. That makes sense. Okay, so if the Parliament were contemplating any changes to foreign interference legislation, we're unlikely to have the benefit of the view of your office until into 2024, realistically.
Well, I suspect that that's right.
Yeah.
Can I say, Senator, I think it's unfortunate that is the case.
Yeah.
And again, this has been noted in at least one of my annual reports, that the review into the EFI, of course, it's not just foreign interference, it's the espionage provisions and the secrecy provisions as well.
Yep.
That is expected to be, or has been expected to be, the largest review that will be undertaken by a monitor. So it will be a very intensive process, and is already, I must say, Senator, the amount of material that has been accumulated in relation just to foreign interference probably exceeds information that has been accumulated in relation to other concluded reviews already. So there's a lot to do. And again, and I'm not making excuses, and I know that you're not asking for it, Senator, but as again I've made clear to this committee, but also elsewhere, an essential part of the role of the monitor is to look very deeply into these matters. The monitor's role is not to do a desktop review of legislation. And so it's very important to look at how things are practically operating there. And that requires, on something like the EFI, intensive involvement with the relevant departments and agencies.
Yep, understandably. My interest in this, to declare it, is that the PJCIS is currently doing a review of the Foreign Influence Transparency Scheme, which is a different scheme which you are not required to review. And interestingly, the PJCIS is not required to review the Espionage and Foreign Interference Scheme, but they were passed at a similar time as part of a kind of a cohesive package. And we have already encountered in our engagement with witnesses and through their submissions that they should be kind of viewed as a package and that they work in tandem. And so for the PJCIS to come to a view about possible reforms to the Foreign Influence Transparency Scheme, we might be required to consider possible reforms to the Espionage and Foreign Interference Scheme. Hence why I asked you for your timelines, but that's very helpful. Thank you.
Well, could I also...
please,
I'm sorry, could I also add that something that I will be raising with the PJCIS is that in any event there will be some utility in those matters proceeding in tandem, in a sense, because I have a fear that if they're siloed, there might be something in the middle that's not considered as perhaps it should be.
Yes.
And the last time I appeared before the PJCIS, there was some discussion along those lines. But I am aware that timetables are set having regard to the synchronisation of the efforts of the PJCIS and the INSULUM. But I'm afraid that with really COVID and various other matters that have delayed some work, there may be some complication in that. But it's something that I'm very conscious of and will be dealing with the committee on to see what can be done.
Thank you. And yes, I should say that's a shared fear that I have, that there is conduct that potentially falls between those two stools,
Yes.
that is malign in nature but not adequately captured by either scheme, that we need to consider.
Well, and it can't be overlooked that in relation to the foreign interference laws, they are they're criminal offences, and they're complex criminal offences. And whether there's something between the registration of those involved in representing the interests of foreign governments and criminal offences is something that needs to be thought about.
Thank you. Just coming back to the comment that you made about the high-risk terrorist offenders review that you're concluding, and you said that it had been delayed substantially by the change of government. What did you mean by that?
We had received we had received written submissions from various government departments and agencies that are involved in the high-risk terrorist offenders scheme, and there are a number of those, both departments and agencies that are involved in that. After the election, my office was contacted and asked whether there could be supplementary submissions put in having regard to what was either perceived or known to be perhaps a different view of the new government to those matters than the previous government.
Can I ask who contacted you to seek that information?
Well, it wasn't me directly. It was my office. I suspect it was the Attorney General's department.
Okay.
I can tell you. What are they called? Questions on notice.
Yeah.
I can do that if you need. But
Thank you.
It made perfect sense to me.
Sure.
So I agreed to an extension of time for a further submission. Again, the various departments and agencies weren't able to meet that time limit.
Right.
And so there's been a further delay.
Right. What was the agreed extended time limit?
There was originally going to be a public hearings in June. I then agreed for those public hearings to be held in late August, and there would be written submissions or further submissions prior to that. And the hearing is now going to be held on the 21st of November, and I have received the submissions. I don't recall now precisely when I received them, but it would have been within the last week or two.
Okay, so that has caused a delay. Are those supplementary submissions now publicly available? Would I find them on the Insulam website?
No.
No. And is there a reason why they're not public? Is it just generally?
Could you just bear with me?
Yeah.
Oh, they are. I'm sorry. They are on the website.
Okay.
It just sometimes takes a little time for them to get onto the website. That's
Okay,
all.
right, okay.
So
So
they're available on the website. There's nothing secret about them.
Right, no,
at all.
I didn't think so. So if we were to be interested in what the different point of view of the new government would be on these issues, we'd find it in those submissions. That's articulated in the submissions?
Yes, you would, but I think that if somebody were interested in that, they might also be interested in the public hearings on the 21st of November.
Yes, we should all tune in. Thank you, Mr Donaldson. I don't think I have any further questions. I appreciate it.
Thank you, Senator.
Senator White.
For those tuning in at home, I wanted to ask you about your review into the Alan Johns matter. Can you just firstly provide an overview of the circumstances of the Alan Johns matter and why you considered commencing an own motion review?
So Alan Johns, what's referred to as the Alan Johns matter, was a prosecution of a former Commonwealth official that occurred in the courts of the ACT. The various steps in that prosecution were not the subject of any publication at all. So there was no mention of the fact of that prosecution publicly. None of the orders that were made in relation to that prosecution were ever published, and the court was closed on every occasion that that matter was before the court. And it was contemplated in the orders, and this can be seen in the review, it was contemplated in the orders that were made that at the end of the process, so whether there was a trial and Alan Johns was convicted or whether he pleaded guilty, as turned out to be the case, and was sentenced, that there would be a redacted or abridged version of the sentencing remarks, and that never happened. And so it was the fact, and then it became publicly known through a rather odd set of circumstances, but it became publicly known that there had been a trial that had occurred in those circumstances, and that is a unique set of circumstances, and gave rise to a great deal of public disquiet, and quite rightly so. And so that is what inspired both my predecessor and me to announce a review of the provision of the Act that was used to give effect to that set of circumstances.
So until December 2019, what was known about the Alan Johns matter? Nothing, is that?
Well, the first time that anything publicly was known about the Alan Johns matter was when there was a statement made in the Senate.
And when was that?
When? I'm not sure off the top of my head, but it was made. The relevant Attorney General at the time was Christian Porter. If you just bear with me, I know that it is in my report. Sorry, I haven't been able to turn it up, but
that's okay. So it's pretty unusual, isn't it, to have an entire criminal trial, conviction, sentencing, and I think he served his sentence completely in secret with no public awareness of those events.
Well, it's not only unusual; it's unprecedented and extraordinary. Yes.
So, do you know if there have been any other criminal trials that have attracted such secrecy and protection?
No.
Could you provide us an overview of the recommendations you made in relation to the Alan Johns?
So the recommendations that I made I think, Senator, to be understood in this way. All of the orders that were made in the Alan Johns matter that gave rise to those circumstances were made by consent of the parties. And there's a provision in the NSI Act which enables orders to be made by effectively consent, what lawyers would understand to be consent orders, and that's section 22 of the NSI Act. There's nothing wrong with consent orders as a way of dealing with matters, even criminal matters. It quite frequently occurs. But that consent orders were used to give effect to that consequence was, unprecedented. So I made a set of recommendations in the Alan Johns report, which were directed to the officers of the Attorney General who are responsible for the making of orders under the NSI Act. So it's not done by the prosecutor, it's done by the Attorney General. The recommendations that I made were really directed to, firstly, ensuring that the court is provided with submissions as to the centrality of the open court principle and the importance of it, and also submissions to the effect that, or seeking from the court reasons in respect of all orders made for closing of court and suppression of material in these sorts of prosecutions. I also made recommendations as to public reporting, further public reporting of those orders as well. But Senator, those recommendations are fairly limited, I think need to be understood in the context that I had announced, even before it was referred to me, that it was likely that I would be undertaking a review of the whole of the NSI Act. Okay. And so the recommendations are, if you like, of a fairly limited nature, but they need to be understood in the context of there was always going to be a broader and further review of the whole of the NSI Act. And that's the matter that's now been referred to me by the Attorney General.
It was more like an interim report.
I think, yes, it was an interim report in that sense, Senator, but I think it was also what motivated me a great deal in undertaking the report was the unprecedented nature of what had happened and a great deal of public disquiet about what had happened, which I shared. And so I thought it was important that there be a review. And again, Senator, if you've had the opportunity of looking at the report, You will have noticed that during the course of that review and as a result of the review, quite a lot of information and material about that particular matter was actually published. And so even though the recommendations in the report may be thought to be relatively limited in scope, there is now quite a deal of information in the public arena about the Alan Johns matter and hopefully more.
So in your view, could the genuine national security risks be addressed with a more narrow set of NSA orders?
I think that the information that was sought to be protected legitimately in the Alan Johns matter could have been protected in a number of ways, short of closing the court on every occasion, first, and secondly, what would have solved everything and in effect cured everything was if a fulsome, and as fulsome as it could possibly be, set of the sentencing remarks were published as soon as they could have been. And that still hasn't happened.
But it was supposed to happen.
Well, I provided a set of redacted reasons, which I went through with the relevant government agency involved to ensure that there was no information in there that was in those remarks that would be particularly damaging if published. And those reasons, I think actually there's an application which is before the court presently for those reasons to be made public.
So I guess if you stand back, you'd say that there is a balance to be struck between competing interests, but in this case, the balance was struck on the wrong side of secrecy.
There's always a balance with these things, Senator, there's no doubt about that. And again, in the report, I don't question at all that there was material in that prosecution that was quite properly suppressed, and there wouldn't be a judge in Australia who wouldn't have suppressed various of that information. It's more that once the reason, and there may be some circumstance, like there are trials that happen in secret from time to time for good reasons. So often, again, trials of co-offenders that can't be dealt with together. Well, you've got to hold the first one in secret because you don't want to pollute the jury for the next one, if you follow.
Yeah.
So that happens. But what is really unusual about the really unusual thing about Alan Johns was that there was no publication of the fact that this had occurred and that a fellow had been convicted and sentenced, and here's why. And that, to be fair to those involved, the orders that were made always contemplated that would occur, and the representatives of the Attorney-General provided to the trial judge a set of observations that could have been made, but they were never made.
Thank you.
Thank you. Thanks, Chair.
We
have plenty of time, I get it. Was that what you were about to say?
No, if you...
Okay. Mr. Nelson, I'm sorry, I stepped out for 2 seconds and you'd indicated that you had provided a further document or a further report.
No, I think I indicated I haven't.
Oh, you haven't? Were you... For
the purpose of today?
No, not for the purpose of today. Is there a...
Sorry, Senator. I'm currently getting close... Well, I'm getting close to concluding a further report, which is a report in relation to the high-risk terrorist offenders scheme.
Okay.
And that should be due or should be done within a short period of time.
So can I ask you how you became aware of the Witness J or the Alan Johns matter?
Through the newspaper. I'm pretty sure I read about it in the newspaper before I was the monitor.
Right.
And my predecessor had commenced a review in relation to Alan Johns prior to his term.
And do you know how your predecessor became aware of the matter?
No.
It would would it, or in witness J's case, there were certain orders made by consent, critical orders made by consent.
All orders were made by consent, other than the first
Yep.
orders.
And by reason of that, they weren't tested in court. And that if they had been tested in court, though, would the secrecy, could we have had the same secret outcome?
You could have had, when I say could have had, like these are matters for the judge to decide, of course, but I could envisage a circumstance in which the matter proceeded to sentencing without the matters becoming the subject of public awareness. I can see how that could happen, but there is no circumstance in which there can be no publication of what had occurred afterwards.
No circumstance where there can be no public other than by consent.
No, there's no circumstance, by consent or otherwise, in which a court can convict somebody of a crime, sentence them, and there be no
public reporting.
no public knowledge that there's been a trial that's a secret trial. It's just not something that we do in this country.
Well, I know it's not something we should do, but it happened in the witness J case. So what I'm asking, and let me be clear.
Can it happen again?
100% join with you that it should never happen, but it did happen with consent orders. Could it happen under the current laws where without consent? Could it happen by application after application being brought by the prosecution?
Well, the application would be brought, I don't mean to be picky, but it would be brought strictly by the Attorney General. Oh, yes, but it's the sort, theoretically, yes, but it's they're the sort of orders that if they were contested, a judge would be loath to make them.
But there would almost certainly be an order that the contest happen in secret in a non-public trial if one
There
would
could be a
imagine.
circumstance in which, so this was a matter where the accused pleaded guilty as well, Senator, but could there be a trial that occurred with suppression of everything that occurred in the trial and in a closed court?
Yeah.
Yes.
And then that could extend to the sentencing.
Yes, to
orders
the
as
sentencing
well.
hearing.
Yeah. So in this case, it happened under consent orders.
Yes.
But there's nothing at law to prevent it happening even where it's contested all the way through. Do your recommendations address that latter case?
No, but my review of the NSI Act will.
At what stage is your NSI Act review up to at the moment, Mr Donaldson?
So work has commenced on that. I'm required by the reference to me to conclude that report by the end of October. I don't know the precise date in October, but it's in October next year.
Thanks, Mr Donaldson. And just for the record, I want to acknowledge the importance of that, the initial review you did, and the importance of the review, and acknowledge, at least on my part, and I know many people have been concerned about the space, the importance of the review you did. I don't want that to go unacknowledged in this exchange. Could I ask about the prosecutions of Witness K and Bernard Collaery? Was it similar provisions that were used in those cases to suppress?
No, sorry. There were very few, well, as I understand it, because I've not yet looked at all of the material in relation to the Collaery and Witness J prosecution. I have access to them all, but they were very often, Senator, opposed by at least Mr Collaery. That is,
Indeed.
the making of orders were opposed by Mr Collaery.
Yeah, but it was the same provisions, only they went through the contested model.
Yes, that's right.
Yeah.
So they weren't consent. They
No.
weren't done by consent, but
No,
the
indeed.
orders were made.
Very
Yes,
much
that's-
not by consent in relation to Mr Collaery.
Very much not by consent, yeah.
In relation to Witness K, though, there was a guilty plea.
Yes.
And, but it was the same provisions that were used in the Witness K case, but you're not in a position yet to tell us Any
Well,
more
there was some
detail
order-
about the Witness K case?
There were some orders that I can say to you that there were some orders that were made by consent, but again, Senator, I just don't have the full picture in relation to Witness K or Mr. Cleary's prosecution to answer detailed questions about whether particular orders were made by consent or otherwise.
Have you had any oversight of the McBride case?
No. But can I say, Senator, in the review that will happen in relation to the whole of the NSI Act, I will be looking at every invocation of the NSI Act.
There remains ongoing litigation in relation to the Cleary case about the release of certain information that was covered by secrecy orders in the Cleary case.
Yes.
Have you got any, well, first of all, have you had any role in relation to that further material?
No. I don't have an executive role in relation to that. I will be looking at it.
All right. And
sorry, I'll be looking at all of those.
No,
that information.
no, I understand. And I understand the ACT Court of Appeal is hearing arguments about that, or has heard arguments about that recently, but you weren't involved in any way in that litigation?
No. It's not part of my role, Senator.
No, that's all. Thanks.
Okay, thank you. There being no further questions for the Independent National Security Legislation Monitor, thank you for your time, Mr. Donaldson. And I call officers from the Office of the Australian Information Commissioner. Do you have a call?
I don't have any questions. I'm keen to get to the Australian Human Rights Commission.
Do you have any? Yeah. We all are, Senator Scott. Senator Patterson, you have the call.
Thank you very much. Thank you for joining us, Ms Falk. I have some questions about some possible reviews that the OAIC is considering and may have commenced doing. One of them relates to TikTok. TikTok has publicly said, we reached out to the OAIC, with whom we are now in correspondence. Given the many inaccuracies and mistakes in Internet 2.0's report, we look forward to providing a clearer and more accurate picture to the Commissioner. Are you reviewing TikTok?
Thank you, Senator. Angeline Falk, Australian Information Commissioner and Privacy Commissioner. The issue of TikTok and its handling of personal information is something that my office has under its monitoring function. I'm aware that my counterpart in the UK ICO office has proceedings in relation to TikTok. So we are in liaison with them and following their proceedings. At present, I don't have regulatory action open into TikTok, but there is communication, as you've mentioned.
And what does that communication constitute? Is that just a letter from TikTok that you received, or are you seeking information from them?
We have sought information in the form of a briefing, which we have received, but I have not utilised my regulatory powers to date.
Yep. Are you considering doing so?
As I said, Senator, it's a matter that I'm continuing to monitor.
Yep.
I'm mindful when there's a matter that has global reach to recognise the work of my counterparts internationally, and at this stage I'll await the outcome of the UK Information Commissioner's Office and then consider whether next steps are warranted.
Do you have any timeline for their review? Do you know when that is expected to be completed?
I don't have a time frame that I can provide you with today, Senator, no.
Okay. Because the impression I took, and I suspect others and possibly TikTok users took from their public comments about you, their communication with you, that you were looking into them, and I think they might have sought to portray that as something that should reassure their users that they're being investigated. If they're not in fact being investigated by you, then, and we don't know when you might commence one given you're waiting for your UK colleagues' work, what confidence can TikTok users have that someone is looking into this issue, which has been very prominent in the media?
Well, as I said, Senator, it is a matter of global concern. It is a matter that I think there are other government departments who have been considering the matter. From my perspective, I'm aware of the issues that have been raised. At present, I haven't opened an investigation, but it is a matter that we're watching very closely. And as I say, I'm in liaison and communication with my international colleagues.
Okay, thank you. I do welcome that clarification because, as the headline in the AFR said, TikTok under Australian privacy watchdog scrutiny, which is on the 1st of August, that I think certainly implied that there was an investigation taking place. And if that's not the case, that is something that it's important to clarify. Moving on to the ride-sharing app Didi. As you may know, I wrote to Didi on the 12th of August after there were reports that they had breached the personal information protection laws of China and were fined $1.7 billion. I sought their assurances that they were compliant with Australian privacy regulations and asked them to explain the steps they were taking to comply with Australian law. They essentially, in their letter to me, which I think I have forwarded to you, provide no reassurance other than the statement that they were complying with it. They have provided no evidence that they're complying with it. So I have written to you to encourage you to consider it. And on the 5th of September, you said the matter has been referred to the agency's dispute resolution branch. Do you have any update on that matter?
Senator, I don't have an update on that matter. As you're aware, there's been a number of major data breaches that my office has been recently focused on. But my dispute resolution branch we will convene a regulatory action committee meeting in upcoming weeks, and that's where staff have the opportunity to brief me on any matters that I need to give consideration to as to whether I ought to utilise regulatory powers. I think the issues that you're raising, though, do go to the centrality of the digital economy and the fact that there are global companies and Australian companies who are transferring Australians' data both through the Australian economy and elsewhere. And that's why we've banded together with other digital platforms regulators, with the ACCC, the eSafety Commissioner and the ACMA, to ensure that we have a cohesive approach to regulating digital platforms in particular and social media into the future.
Yeah, I certainly welcome that. I think that's a positive initiative. But of course, that doesn't excuse companies from their existing obligations under the law, which we should want to have confidence that they're compliant with. And in the case of Didi, I don't have that confidence based on what's in the public available material. So I look forward to any further updates that you're able to provide in due course on that. Moving on to the Optus data breach. You mentioned there's been a number of data breaches, high-profile data breaches that would have been taking up your team's time, and I know you've got limited resources. I'm interested in your kind of very brief timeline of events of Optus. When they first made contact with you, or whether it was you that first made contact with them, and how that has flowed.
Thank you, Senator. So Optus contacted my office on the day that it made the public announcement on the 22nd of September, and then it provided my office with a formal notification under the Notifiable Data Breaches Scheme the following day on the 23rd. And since that time, I initiated preliminary inquiries with Optus on the 26th, the following Monday. And then I opened an investigation on the 11th of September.
Okay. Is Optus, in your judgment, compliant with their obligations under the Notifiable Data Scheme? They appropriately notified you and have been cooperating appropriately?
So, Senator, that is still a matter that's under consideration. So my preliminary inquiries in terms of compliance with the Notifiable Data Breaches Scheme are ongoing.
Right.
And I've opened an investigation into the substantive issues.
Yep.
That is, was the information that was collected necessary for their functions and activities? Was the personal information reasonably secured? And also whether or not the information was retained for an appropriate period of time.
And we will look forward to your conclusion on that, because as you have noted in public media interviews, there already are legal requirements for companies to destroy data that they no longer have a use for. And it'll be interesting to understand why Optus was retaining the data for the length of period that they were, including on former users. I know this is a difficult question for you to answer, but I'm going to ask it anyway and do your best. How long do you expect the investigation to take?
Thank you for the proviso, because it is too soon to tell, Senator. So we have just issued our first coercive information gathering powers, utilised those. We'll need to receive that information. I have sought and received additional funding to conduct the investigation, which is very welcome, and I've sought that funding over 2 years. Of course, we will seek to execute the investigation and complete it in as timely a manner as is possible.
Understood. Okay, I will move on to Medibank, where I have a similar line of questioning. Could you outline, as you did for me with Optus, about when Medibank first contacted you, or whether it was you that contacted them, and how compliant they have been with their obligations under the Notifiable Data Scheme?
So Medibank first contacted my office on the 13th of October, and they indicated that they did so as a courtesy. Their view at that time was that they'd experienced a cyber incident, but their position was that no personal information had been accessed. They continued to keep us updated in the intervening days, and you may well have seen the updates to the Australian Stock Exchange that occurred on many occasions. On the 25th of October, Medibank formally notified my office of a notifiable data breach under the scheme.
Okay. And that was, I imagine, at the same time they made public statements about their changing understanding of the nature of the breach.
That's correct.
Yep.
And currently I have preliminary inquiries that are open into Medibank, and I'm assessing that information, deciding whether further regulatory action will be taken.
So, unlike in the case of Optus, you've not yet launched an investigation?
I've not yet reached that decision, no, Senator.
For Medibank, okay. One of the things that you've said, and I think it was in relation to Optus because it was at an earlier date, was that when an organisation experiences a data breach that is likely to result in serious harm, they must be clear and timely as possible about what kind of personal information is involved. I think it would be fair to say one of the unfortunate things about the Medibank breach is that the story has evolved quite significantly over time. We've had a number of updates, and each time a greater number of people have been involved, or a more intimate amount of data has been involved, as you noted in your previous answer. The latest one being today, when double the amount of affected customers was disclosed compared to their previous disclosure, which of course was a big increase on their initial disclosure. Are you concerned that Medibank has not been compliant with that obligation?
So, Senator, it is an active matter, and we are looking into precisely the issues that you've raised. So I won't comment on the particularity of the case, if I may. But what I can say is, as you've indicated, any entity that suffers a data breach has to ensure that, first of all, it's able to detect a data breach, and then it has to form a reasonable belief as to whether or not individuals are likely to suffer serious harm. If that reasonable belief is unable to be formed immediately, then the Act recognises that sometimes there's forensic or other investigations that need to occur to form that belief. So a reasonably expeditious assessment needs to be made, and usually I'd expect that to happen within 30 days. But the more timely the notification, then the greater the ability for individuals to mitigate their risk of harm. For example, if their credit card details are compromised, they can contact their bank immediately.
Yeah, the reason why I'm interested in that issue in particular is that from what I understand from what's in the public domain so far about this, Medibank knew at a reasonably early stage that a compromised credential was the source of the breach. And once they knew that a compromised credential was involved, and as I understand which compromised credential was involved, it should have been clear to them what access that credential had, and therefore what data should be breached. In its communications with you, did Medibank inform you of the fact that they realised that a compromised credential was involved?
As I said, the information that was provided to my office was iterative, and when information became known to Medibank, it was provided to me. But the issue of exact and precise timing and when an eligible data breach was known or ought to have been known and reported to my office is a matter that's under active consideration.
Yeah, okay, fair enough. I appreciate you are a bit constrained in answering those questions in more detail. Perhaps at a subsequent estimates you'll be in a position to be more expansive on those issues. Thank you.
Thank you, Senator.
Thanks, Chair.
Senator Roberts, you have a question?
Thank you, Chair, and thank you all for appearing today. First series of questions I'd like to ask is about data hacks. The Office of the Australian Information Commissioner has released its notifiable data breaches report for July to December 2021, revealing 464 data breach notifications, private and public, in 6 months from July to December 2021, an increase of 6% compared with the previous year. That's the notification of any data breach. Further data breaches just in 2022, and I'll read some of them out, so far reads like a who's who of corporate and government in Australia. So these include Microsoft, October 2022, Australian Federal Police, October 2022. I'll skip a few. Medibank, October 2022. Woolworths, MyDeal, Optus, Uber, TikTok, LastPass, DoorDash, WA Health, government entity. Cisco, they provide half the world's routers. Twitter, University of Western Australia. Uber, Victorian Government. Woolworths again. Deakin University, Department of Home Affairs. NDIS, with a lot of private data there. Coca-Cola, Panasonic, Microsoft again in March 2022. Samsung, Toyota Motor, New South Wales Government, another government entity. News Corp, another data corporation. Red Cross Australia, another public database with personal data. Bunnings, with ubiquitous data. So they're just some of the ones for 2022. And you can see they're quite represented heavily by big tech and also government and also academia. Have you added up, Commissioner, how many Australians have had their data breached over the now 5 years of event reporting?
Thank you, Senator. So we've received around 4,000 notifiable data breaches since the scheme commenced in February of 2018. In terms of the numbers of Australians that have been impacted, until the most recent breaches with Optus and Medibank, they had not been of the same scale. Sometimes we're unable to discern precisely the number of Australians affected, particularly if it's a global data breach that is affected individuals worldwide. But without commenting on the list that you've read out, which I don't have before me, I think the issue that you're raising is that notifiable data breaches and data breaches are a significant issue for the community. And what the last couple of months, I think, have told all of corporate Australia and government is the need to ensure cyber resilience and to prevent data breaches from happening in the first place.
And to make us robust against data breaches, because the biggest data breaches, I'm told, come from government agencies around the world, many nations, and big tech. So it seems that and quite a few of them are due to human error. So let's take it up further then. Do you maintain a KPI, for instance, showing what percentage of adult Australians were hacked each year?
No, Senator. So in terms of the performance of my office, under the Notifiable Data Breaches scheme, we seek to resolve all of those breaches within 60 days of receipt, and we meet that KPI, which is reported in the portfolio budget statements. In terms of your comments around where data breaches are occurring, my reports that I've released every 6 months since 2018 show that the highest sector for reporting data breaches is health, followed by finance. Third place changes from time to time. Currently it's insurance, but last financial year it was legal, accounting and management services.
They're pretty sensitive areas, all of them, for individuals.
They are. I should also point out that private health service providers are covered by the Privacy Act regardless of their annual turnover, whereas other entities are exempt from the Act if they have a $3 million or less turnover. So in that way, health may be disproportionately represented.
So I just said a minute ago that we need to make ourselves robust to these hacks. The companies I've just read out are going to be partners in the government's trusted digital identity with access to the whole package of data on each Australian. In effect, hacking one, if they're amalgamated into one digital identity, hacking one would make everything available for that person. Is the trusted digital identity creating a hacker's paradise? Because it certainly seems like it to me. By putting all data for individuals in the one spot under a single identity everyone uses.
Senator, I've read that digital ministers have recently met and have agreed to increase resilience and to look at a strategy around digital identity resilience. In terms of the Trusted Digital Identity Framework, that's a matter for, I think, the Department of Finance now. But from my regulatory role, what I can say is that any digital identity framework needs to ensure that it has robust safeguards in place, and we would say that it ought to also include appropriate legislative oversight mechanisms.
Well, we already have some pretty strong legislation oversight, and we're having lots of hacks. And if we amalgamate the data from many companies for each individual, then it's going to be a hacker's paradise. That was the point. But let's change the topic back to FOI. A constituent, Mr. Daniel Briggs, lodged an FOI request to the ABC on the 15th of March 2021. He lodged an appeal against the decision with the Office of the Australian Information Commissioner on the 2nd of June 2021. Why hasn't he received a reply from the OAIC even when he inquired about progress after more than a year has passed?
Senator, our ordinary process would be that an individual who makes an application for review would receive an acknowledgement of that in a timely manner, ordinarily almost immediately, but certainly within 2 business days. If that hasn't occurred in relation to your constituent, I've heard the name that you have read out, and I'll ensure that a response is provided and an apology given.
So the average time would be somewhere between up to 2 days?
Ordinarily, our early resolution and triage system would in fact often generate an automated acknowledgement. So if that hasn't occurred, I'll need to look into it.
Okay, so can you tell me on notice, please, when you've looked into this case, why the appeal has taken so long? His reference number, Mr. Briggs's OAIC reference is MR21/00524.
If it's an issue around time taken for an Information Commissioner review, Senator, currently we are resolving many matters in a timely manner, but there are a number of matters that have been unable to be allocated to case officers due to the incremental increase in the numbers of applications we've received and our resource constraints.
So you've got resource constraints on this?
In relation to FOI, yes, Senator.
Okay. I've got just to tidy up something that is a concern for people for about 2 years now. The OAIC is responsible for the data privacy on the COVID Safe app. According to your website, the data is deleted after 21 days. As the app was terminated on the 16th of August 2022, have you checked to ensure that all app data has been deleted, including data uploaded to Health Department servers?
We currently have an assessment underway to check that, Senator.
Okay. Is there any COVID Safe app data still being used anywhere? And if so, is this data anonymised?
The data store has, as I understand it, Senator, been deleted. What my assessment or audit will do is to verify that that is the case.
Thank you. When do you think the audit will be completed?
It's imminent, Senator, and it will be published on my website.
Thank you. Last question, Chair. Did you review the use of the data to ensure there were no breaches in data access or sharing rules?
So there was no complaints received from individuals, there were no data breaches reported, and my office has undertaken 4 audits of the system to ensure the information was handled in accordance with the legislative requirements.
Okay, so you're confident that there's no breaches in the data use?
There's been no breaches that have been reported to my office, Senator, no.
Okay. Thank you, and thank you, Chair.
Okay, thank you. I'm just going to, in a second, hand the call over. I just have been able to ascertain some advice, although it pains me to say this as one one of my former employers. We won't be requiring the Office of Parliamentary Counsel this evening. And they will obviously get questions on notice, but there's no questions for them in the room tonight. So thank those officers for preparing for estimates, and thank you for your very hard work. Thank you, Senator Shoebridge.
Oh, thanks, Chair. Commissioner, can I ask you about the number of outstanding FOI claims? How many are, well, do you have the most recent, what's your most recent data about outstanding FOI claims? When does it date back to?
Thank you, Senator. I'll commence providing with some information, and our fairly recently appointed FOI Commissioner Hardiman may also wish to add to this.
And you know I'm going to ask about the numbers that are 1 year outstanding for at least 1 year, the numbers that are outstanding for at least 2 years, and the longest outstanding one as well.
Thank you. So last financial year we experienced a 60% increase in the number of IC review applications made to the office at 1,956. At the same time, we increased the numbers that we finalised last financial year by 35% at 1,377. At the end of the financial year, we had 1,876 matters on hand. As at the 30th of September this year, we have around 1,000 matters that are over 12 months old, and 567 of those matters are over 2 years old.
So that's been kind of a fairly dramatic increase in delay, because I think at the end of 2021 there were 670 FOI reviews more than a year old, and we're now, did you say over 1,000? Did you have a precise figure for 30th of September?
I have Leo Hardiman, Freedom of Information Commissioner. I have a figure as of this morning. Senator, what was which figure?
Well, I think Commissioner Falk was giving a figure as at 30 September as over 1,000. What was it? Do you have the actual figure as at the 30th of September? This is more than a year old. Do you have the actual figure, Commissioner?
Oh, I'm sorry, my apologies. It's 957.
957. And there were 567 that were more than 2 years old.
That's correct.
And what was the longest outstanding matter?
The oldest matter is from 2018, regrettably, Senator.
Okay, so that's more than 4 years.
4 years, Senator.
And sorry, Commissioner Hardiman, did you say you had more recent data? Data as of today?
As of this morning, yes.
Yep. Is it good news?
No.
Okay.
Sorry, Senator. So the total on hand this morning was 2,042.
2,042?
Yes. Over 12 months old was 1,055.
Yep.
I have a breakdown by year, if you would like that.
Yeah, if you would mind.
Yep, 2018 there are 60 ongoing reviews. For 2019 there are 249. For 2020, 346. For 2021, 498. And for 2022, 889.
889. Thank you very much for that granular data. I've got to say it is distressing to see 60 matters from 4 years ago. Do you have a general explanation for that?
Senator, the explanation has been one of the exponential growth in the numbers of matters that we've received, both across Information Commission review applications as well as complaints, and indeed, at least throughout the pandemic, extensions of time applications. We have had this exponential increase at the same time through our ability to have process improvements, to focus on early resolution. We have increased our throughput, but a gap has arisen and it has compounded over time.
But I mean, how does that explain 60 unresolved matters from 4 years ago? not one, as I'd understood initially, but actually 60 from 2018. How do you explain that?
It's a matter of resources, Senator, regrettably.
There hasn't been the resources in the last 4 years to deal with those 60 matters?
Senator, it's a matter of having a large caseload and a limited number of resources. It is our intention and the efforts that we make every day to resolve all matters as quickly as possible. It's regrettable that we have a legacy caseload of this size.
But you see, the purpose of freedom of information is to gain timely access to the workings of government and the information of government. And when the review application, we're not even talking about the initial application, but the review applications in your office are taking 4 years, that defeats the purpose of FOI, doesn't it?
The object of the Act in terms of providing timely access to information is, as you've put it, we seek to address this issue in a number of ways. So there is the work that we've done internally over the last 4 years to increase that finalisation rate. At the same time, we have worked with agencies to encourage them to proactively release information and to make it available on their websites. So it's a combination of both that needs to happen. We've also provided resources to agencies to assist them to make good decisions.
But you see, this has been a matter of substantial public disquiet for a number of years now. And I recall the kind of shock about there being 667 matters that were a year or more outstanding when we first heard that in 2021. But now it's 1,055 that are more than 12 months old. That is, I put it to you, Commissioner, defeating the purpose of FOI. It's a disastrous outcome, isn't it?
There are a number of factors that are contributing, and as I say, a number of strategies that we are employing. From my perspective, I would like us to be able to resolve all matters in a timely manner. We've increased our throughput. We have, over the last 3 years, resolved 58%, then 68%, then 72% of matters within 120 days. So our early resolution and triage gives very good results. But where we have matters that are voluminous, that have multiple exemption claims, entrenched parties, added complexity, they're the ones that take additional time. We also have experienced an exponential increase in the numbers of deemed decisions from the Department of Home Affairs, where regrettably they're not meeting the statutory time frame, and that then triggers the ability for an individual to come to the OAIC. And we've been working with the Department of Home Affairs in an effort to resolve that issue, which will then decrease our caseload.
But I'm going to put it to you again, because I don't think it was addressed in your answer. Waiting more than 4 years for an FOI determination by your office defeats the very purpose of FOI. Some of these might have been in relation to now extremely former Prime Minister Malcolm Turnbull. It defeats the purpose, doesn't it?
Senator, I don't disagree with you in terms of FOI should be about timely access to information.
But it's got dramatically worse.
It has got worse because of the cumulative exponential increase in the number of matters before the office. But I must say it was welcome to have the appointment of Commissioner Hardiman. We also have an SES Band 1 officer and 2 other support staff now, and we will start to see results from that.
Well, I suppose I'm equally troubled by the fact that while we're seeing delay of this order, significant resources from your office are being spent defending a case brought by a former senator, which is just simply trying to assert that you have an obligation to answer these, to deal with these matters in a reasonable amount of time. Do you say you have no obligation to deal with matters in a reasonable amount of time?
Senator, we seek to deal with all matters in as timely a manner as possible. It's regrettable that we have a legacy caseload.
No, but you're out there opposing a case that is just simply trying to say that your office has an obligation to decide matters in a reasonable amount of time, and you're saying, no, you don't. That's the case, isn't it? That's what's happening at the moment at public expense.
Senator, I think that's an oversimplification with respect.
Tell me how I'm wrong.
So the case has been brought by an applicant. That means I have to respond to that. And as a model litigant and an officer of the Commonwealth, it's incumbent upon me to respond to the litigation that has been brought.
Sorry, Commissioner, I thought you finished. You go.
After you, Senator.
No, I genuinely thought you'd finished. I didn't mean to interrupt your answer.
Given that the litigation's been brought, it is a matter that I have to respond to. I think there's 3 factors that have contributed to the cost of responding to this case. One is that the breadth of the case and the fact that it's my office that holds the evidence of the way in which the matters have been processed. That has taken considerable resource of my office to compile that evidence and put it before the court so that they can make a decision. The second is that there's been a number of interlocutory proceedings. And the third is that it is a novel case. It has raised novel legal issues. And again, it is incumbent upon me to put before the court the proper construction of the statute.
But the core of the case, and this is what I put to you, and I'm happy for you to correct me if I'm wrong, the core of the case is that former Senator Patrick is saying your office has an obligation to decide matters within a reasonable amount of time. And you're going to all of that cost and all of that effort that you just articulated to defeat that claim. Why?
Senator Schubert,
do you not
asking the same question you've already put?
Well, what is? Do you disagree? Do you
answer.
disagree with that characterisation of the case?
Senator, I think that the matters that you're raising go to the essence of the case. It's a matter before the court. But what I can say more generally is that any delay as a result of the inability to allocate matters to case officers, staff shortages, the impact of the pandemic are all regrettable. What my office wants to do is to focus the limited resources that we have on resolving the matters that we have before us in as quickly amount of time as possible.
Well, how much have you now spent on opposing a case, Senator Patrick's case, which is simply trying to say, to establish that your office has an obligation to decide matters in a reasonable amount of time? How much has been spent to date in opposing that case?
Senator, the costs in the case have been higher than anticipated. We've been invoiced for $466,000 and there's work in progress of a further $97,000. And I expect with the hearing that's now set down for February due to the judge's unavailability in November, for that potentially to increase from there.
What's the estimate of costs that you've been given by your lawyers?
The estimate would be in the $700,000.
And this is to defend a case where the plaintiff is simply seeking to assert that you have an obligation to decide matters in a reasonable amount of time. That's how much public money has been spent.
So, Senator, I'm responding to litigation that's been brought against the office, and it may be that you consider that I could simply consent to the proceedings that have been given.
Indeed, and spend $700,000 on processing claims.
So it is my view that if delay that's been attributable for the reasons that I have outlined is found by a court to be unreasonable, that is a matter for the court. It's not a matter for me to determine that legally. And in terms of the remedy that is sought, it would require me to prioritise this applicant's matter above hundreds of other applicants merely because they have the means to bring the legal proceedings.
I understand that the legal costs are going to get to somewhere in the order of $700,000, but that's just the external costs. Do you have any estimate of how much the internal costs have been? Because you spoke about gathering evidence and the like, and I can imagine that's quite a task.
It has been a significant impost on the office, Senator.
How much?
I can't quantify it today.
And you rejected the option, the alternate option of saying you were of agreeing to the basic proposition that you should be deciding matters in a reasonable amount of time. That was a much cheaper and more direct option, wasn't it?
That's not been an option in the case. Before Senator Patrick, the previous Senator Patrick brought the litigation, my officers met with Mr Patrick and outlined to him when his matters would be resolved. He chose to conduct this litigation, and I've had to respond to it.
We chose to conduct litigation because he might be eventually in the 2018 list or the 2019 list, and it might be 4, 5 or more years until he gets his matter decided.
Senator,
it's not unreasonable, is it, given the data you've given me?
Senator, individuals have the right to bring litigation. There's consequences of so doing. I'd prefer to be using the resources of my office to deal with the matters that are before us.
You wrote to the attorney on the 8th of June indicating, amongst other things, that you frankly don't have the resources to do the FOI work. Have you had a response?
I'd have to take that on notice. I have had correspondence from the attorney, but I just can't recall if I've had written correspondence on that matter.
Commissioner Hardiman, are there adequate resources now to address the caseload on FOI matters?
In my view, taking into account the current backlog and the rate of inflow of IC review applications to the office, no, there's not sufficient resources.
And look, I do sympathise, Commissioner, all of you, with the impossibility of your task, given the resources you have to hand. I do sympathise with the impossibility of the task, but do you have some idea about what the resource gap is between what you'd need to get on top of the task in a timely fashion and what you've got now?
Senator, I've put before this committee since 2018 the need to have a funding injection for the FOI function. In November 2019, I answered a question on notice where I estimated I would need an additional 9 case officers. We were dealing with under 1,000 matters per year at that time. The number of matters that we're now dealing with is double that. So we're looking at double my estimate at that time. But I think we can also do with that, if we were to receive that resource, not only to deal with the legacy caseload, but also to do some educative work with agencies to ensure that we embed a pro-disclosure culture across government agencies.
Yes, and I agree with you about that being the better outcome if we can get there, but there's a lot of water under the bridge before we get there.
It's a work in progress, Senator, and one that we're committed to achieving.
I have a couple of other rats and mice issues, but does Senator...
We're behind time. We're due to go to the Australian Human Rights Commission. We're attempting to do that before the break. Senator Patterson has one follow-up question.
And then
if you want to... Senator Patterson?
Thanks, Chair. Ms Falk, I was just reflecting on your answer in relation to TikTok, that one of the reasons why you haven't commenced an investigation is because you're waiting for your counterpart in the UK to complete a review. And it makes me wonder, why should the enforcement of Australia's privacy law be dependent on what a foreign regulator might be doing on a similar issue? We have no control over how long that will take. It could take a long period of time. And in the meantime, if there are breaches of the Act occurring and if Australian users are being exposed to privacy harms, why shouldn't your office prioritise that investigation?
Thank you, Senator. And I will check after these proceedings whether I have any further information to give you about the timing for the UK ICO's matter. As a small regulator, I need to prioritise the resources of the office. The TikTok matter will also raise what I can envisage to be complex legal issues. It's, I think, one of the things that I need to consider is whether there is a outcome in another jurisdiction that I could seek to have implemented in Australia without the need to take litigation on my own behalf. So in this case, that's the first step that I've decided to take, but it is a matter that we continue to monitor. There are also some limitations in the Privacy Act in terms of its ability to apply to foreign entities where conduct occurs in compliance with foreign laws, and that may be an issue that inevitably would cause some difficulty with proceeding.
Okay, thank you, and thank you, Chair.
Thank you, Senator Patterson. Senator Shoebridge?
Thanks, Chair. I know that you got the $5.5 million for the Optus data breach. And do you think that'll be adequate to deal with that task?
I'm anticipating that it will be, yes, Senator.
Given the Medibank breach seems to be of a not dissimilar size. How are you going to deal with that?
So, Senator, we welcome the additional funding that's been provided for Optus. I think what that will do is it will create an uplift in capability and capacity in the office in terms of dealing with notifiable data breaches and investigations. But you do raise a point, which is that these significant breaches have continued, and it raises the point about what kind of funding a contemporary regulator requires into the future. And that's something with the review of the Privacy Act that I've put to the Attorney General's Department in my submission, that the review is an opportunity to really look at the funding base of the OAIC and decide how it needs to be constructed into the future.
Well, and then the other issue that's been raised repeatedly with my office is the potential for data breaches coming from the real estate industry. Do you have any concerns in that regard?
I do have concerns, and I saw this morning that in Western Australia, the Curtin University is partnering with the peak body for real estate agents in WA to do some work about uplifting their cybersecurity posture. One of the issues is that some real estate agents are in fact not covered by the Privacy Act if they have an annual turnover of $3 million or less.
Yeah, and so in fact, that huge amount of private data, particularly of renters, isn't even covered by the Privacy Act if the revenue falls under the $3 million.
That's correct. And that's of concern. It's an issue that I've raised again in the review of the Privacy Act, where I think the small business exemption needs to be reviewed. And I appreciate that small businesses will be concerned about what that means and regulatory impost. But I'd like to assure small businesses that we would make privacy simple, create templates, and that the times of saying that small businesses don't deal with personal information, I think, are behind us.
And could you take on notice what kind of funding would be required to have a sustainability in your office to deal with the data breaches and the privacy breaches?
Senator, I'd like to say yes to that, but I think that is a whole-scale review that is required, and my current thinking is that is best done alongside government's consideration of the full review of the Privacy Act.
Well, we could comfortably say for the moment the data injection that you got for Optus, whilst welcome, is not going to be sufficient to deal with the other. I could give you the list of data breaches that we've seen just in the last 2 months.
Well, I'm giving close consideration to that. And
we will go to the dinner break in a moment with the short amount of time we have left over. Can I just ask a follow-up question just in regards to the litigation brought by former Senator Rex Patrick? When did Senator Patrick lodge those proceedings against your office?
my recollection is it was September 2021.
And did the claim relate to delays in conducting Information Commissioner reviews?
Yes, Senator.
And did Mr Patrick's request, did he request that the IC reviews be suspended? That is, that your office stop the progression of the reviews while the court proceedings were underway?
Senator, during one of the interlocutory proceedings, counsel for Senator Patrick did make representations to the court that the matters that were the subject of the proceedings not be decided until the hearing.
Okay. And what was the decision of the federal court on the issue of suspension of reviews requested by former Senator Patrick?
My understanding is that that was not granted, Senator.
Okay. Thank you. The committee will suspend for the dinner break and will return at 8 p.m. Oh, can I just ask, you don't have any further questions for OAIS?
I think it's unfair to keep them.
I think it is as well. We will return at 8 p.m. with the Australian Human Rights Commission. the hearing, and I invite officers from the Australian Human Rights Commission. We have asked officers and agencies to table their opening statements this evening. We have asked officers and agencies to table their opening statements this evening. I hope that is okay with everyone. We've got a lot of questions for you. And I'll hand the call to begin with to Senator Price.
I just have a couple of questions for June Oscar with regard to the Wiyani Yuthangani Women's Voices project. I just want to understand a little bit further if the project objectives can be outlined. I want to understand the practical outcomes that it has delivered.
Chair, are you happy for Commissioner Oscar to take that question directly? Chair?
Oh, sorry.
Senator Price directed a question to Commissioner Oscar. Can Commissioner Oscar take that question directly?
Of course. Commissioner Oscar, can you hear us there? Have you got us okay?
Yes, I can.
Wonderful. And did you hear that question from Senator Price, or would you like her to repeat that question?
Thank you, Chair. Could Senator Price repeat the question, please?
No problem. I'm just, with regard to the Wiyani Yuthangani Women's Voices project, can you outline what the objectives of investing in this project were and I guess the practical outcomes for its delivery?
Thank you, Number Jinpa, and congratulations on your presence here and on this committee. Thank you for asking the question. Wiyani Yuthangani, which means women's voices in my Bonobo language, was an opportunity to, as the first Aboriginal woman in the role of the Aboriginal and Torres Strait Islander Social Justice Commissioner in 25 years. Can you hear me? Because there's a lot of noise coming through.
We can hear you.
Yes. I wanted to mark this, this historic moment at the Australian Human Rights Commission to elevate the voices of Aboriginal and Torres Strait Islander women and girls around the issues that impact them on a daily basis. What are their ideas and aspirations around the change that they would like to see, and how it is that they want to participate and be part of designing any responses to the issues that they had identified. Now, can I say that the last time this opportunity to hear nationally from a national collective of Aboriginal and Torres Strait Islander women was in 1986, when the Women's Business Report was commissioned by the Department of Aboriginal Affairs. And I think you would agree with me that that's, a long time for First Nations women to have an opportunity to speak as a collective on the issues that are important to them in their communities across this country. So we had the opportunity of visiting Aboriginal and Torres Strait Islander women and girls in urban communities, in city communities, regional towns, remote communities, and very, very remote communities across the country. We visited women in prison, and we visited young women in detention centres to hear directly from them. So that, Senator, that engagement that was undertaken in 2018 became my first report presented to the Federal Parliament on the 9th of December 2020. And it carries with it over 2,000 women's voices and girls on the issues that are important to them from their lived experiences in their communities and their solutions. So we weren't responding directly to any practical issues in communities, but elevating the voices of all of these women and girls, and through the submissions also that we received from organisations across the country. We weren't able to get to every single community, but I think we did an excellent job in going to places that are often left out of national engagement processes, and to sit down with women and hear directly from them. And the We Yani Udangani report is available, and we can ensure that you receive a copy if you like. And the current situation is that we're now focused on stage 3 of the project. We had received funding from the National Indigenous Australians Agency, a commitment provided by the previous government to fund stage 3, where we're speaking with women across the country around and having critical focus on 4 key thematic areas, and working towards a summit to be held in Canberra in May next year, which I hope you will attend. We'll certainly extend an invitation to you. So this is where we're at with the project itself, and I'm happy to provide detailed responses to any particular question you might have about the actual project.
Can you outline what those 4 key focuses will be for the summit? Start with that.
Yes, of course. The 4 key thematic areas that we're focused on is economic empowerment. We're focused on the issues of Indigenous women's roles in leadership and decision making. We're focused on the need to acknowledge the unpaid care work that Aboriginal and Torres Strait Islander women provide, the need for an acknowledgement of Indigenous women's knowledges and their cultural knowledges that informs what it is that women do in their communities, and how their cultural knowledge, their cultural responsibilities, their languages can be better supported in and across the country. That was something that we heard very loud and clear. And we also want to focus in that issues around women's knowledges and the impact of climate change and water rights, and the issue of intergenerational trauma and how that is impacting the lives of so many families across the country, and how we can do better in responding to how it is that women and girls aspire to the response, and how do they want to design that. So there have been some key areas. We, as you will see in the report, we have covered quite an extensive range of issues that impact the lives of Aboriginal and Torres Strait Islander women.
Was domestic violence an issue that was particularly brought up? And with some of those key issues, you talked of solutions being formed. What might have they been, and has there been a way to implement some of those solutions?
Yes, very important. Thank you, Senator. The issue of family and community violence was sadly one of the key issues that women raised across the country and girls raised across the country, and we have covered that in the report. I have been participating with the previous government committee around Aboriginal and Torres Strait Islander women's advice to the national plan around the safety, in short, the safety of safety of women and children from all forms of violence. So myself, as the Social Justice Commissioner, I have been engaged as an advisor along with Professor Marcia Langton to that committee chaired by Ms. Sandra Creamer. I had in early last month established a national policy forum, which we were very successful in engaging with over 150 Aboriginal and Torres Strait Islander women who are working at the coalface, working in communities, women who are researchers that have been so focused on issues around the experiences of First Nations women's protection and safety and exposure and vulnerability to violence. So we have provided a statement out of that gathering, and we are providing a report to NIAA and DSS of that forum. But we're pleased to be part of the process that is focused on the need for a standalone First Nations plan to address and respond to the unique issues impacting Aboriginal and Torres Strait Islander women and families across our communities. So I think we have a critical opportunity here that we must grasp and ensure that the issues of the experiences of First Nations people's exposure to violence is being able to be included in the process that this country is embarking on in terms of the national action plan process. So I want to be able to say here that I have been advocating for a standalone First Nations plan that will give opportunity to First Nations women and girls and families to provide the solutions to the issues around violence and the experiences of violence as it impacts them.
This will be your last question for this block, but we can come back to you, Senator.
Sure. Can you please outline the costs that have been involved in terms of the consultation and development and what you see the costs will be to implement the report?
Well, that's a very important question. This is a project that was initially funded by NIAA, and just recently, on the 25th of November, the Australian government publicly announced a $2.76 million commitment to stage 3 of Wiyaniwitangani. This is part of the work that needed to be undertaken leading to the summit, and the MOU between the Australian Human Rights Commission and NIAA was extended to 30th of June this year, under which the first $429,000 of stage 3 funding was provided. and an Indigenous Advancement Strategy funding agreement was signed on the 30th of June 2022 to provide the remainder of the Stage 3 funding commitment, which is $2.331 million. So in addition to government funding, the Commission is seeking corporate and philanthropic sponsorship also to support Stage 3, and we are currently in talks with potential partners. So the funding received from government will and has in no way covered the total cost of the project, but we're very grateful for the investment from government to date.
Thank you, Senator. I'll just hand the call over to Senator Waters.
Chair, would you mind going to Senator Faruqi first?
So, Senator Faruqi.
Thank you. Good evening, everyone. I just have a few questions for Commissioner Tan. I've been told that Commissioner Tan is here.
Joining us by video.
Yeah, thank you. Senator. Yeah, I'm well. Thanks, Commissioner Tan. The government is providing $7.5 million over 4 years from 2022 to 23 for the Commission to develop a national anti-racism strategy. I'm just wondering, what is the timeline for the completion of this national anti-racism strategy?
Thank you, Senator Chin Tan, Commissioner. The government has allocated funding for a period of 4 years, totaling $7.5 million thereabout for a period of 4 years. Now, I'm not assuming that that means that we have 4 years to get things in place, but it gives an opportunity to canvass the issues that are important. I believe that we can get the framework, which is a component of that strategy, in place within the next couple of years. We have now the funding, and that will allow us to have the capacity to expand and deepen the consultations we have, get a sense from the community about what it is that we're looking to put into the framework, or what the framework will look like. I like to imagine that we will culminate in a summit that will allow Australians, representative right across the sectors of communities, to come together to decide on what it is that we want to see in the framework and how we can establish and implement that.
So, Commissioner Tan, this is the framework that the Commission started work on last year. Is that the one you're referring to?
Yes, it is.
Which a lot of people made submissions to, and I know I did. So that work is ongoing, and that is going to be completed when?
We are in the process of scoping, and bear in mind that we started without the funding needed. So we ran practically a project on the back of very little capacity, but we did manage to get a consultation at the initial phase that will now give us the opportunity to scope it within that limit of what we have done to determine the next step. That within that scoping will be the issues that we have heard from communities about what are the important themes and the issues that we need to canvass in that framework.
And the framework will feed into the strategy, I'm presuming.
It will be. The framework is part of that strategy. The strategy will also encompass ongoing education and issues about how we can promote better understanding and obviously elimination of racism as a component of that strategy. So, and it will encompass, Senator, more when we hear more about what we need to do, education, workplaces, and issues that are important in trying to tackle racism within our community.
And Commissioner Tan, with this funding that is now being allocated, do you see an expansion of the team that will be working on the framework and the strategy?
I envisage it will. It will give us the opportunity to now speak to communities, as Commissioner June has referred to. Communities have been left out up to this point. We want to reach out to those communities as well, because it's important to hear from them and to be able to collate that, but also to be more specialized in what we're doing, talking to government stakeholders about developing a framework that we can implement and that will have ongoing outcomes and results.
Commissioner Tan, no doubt you've read your colleague Commissioner Jenkins' report titled Set the Standard. The report found that Parliament was considered by participants to be inherently unsafe for people who are Aboriginal or Torres Strait Islander, people of colour, people with disability, and or LGBT plus people. Given your role as the Race Discrimination Commissioner, I'm just wondering if you think that training for First Nations cultural awareness and anti-racism training should be mandated for parliamentarians and those who work in parliaments.
Senator, this is an important element of that framework. I think the ongoing discussions about what we need to do about workplace safety, in particular, including Parliament, of course, it is my view that in due course we should be able to take the lead and replicate much of the work that my colleague, Senator Commissioner Jenkins have done in respect at work, and say we need to also explore race issues and race relations within the workplaces and in schools as well, and our society. So it is my view that we are exploring and canvassing broadly all the possibilities and opportunities to make this work for all of us right across community. As to whether any particular item should be mandated, I would like to explore that and obviously hear from you in due course about what your views might be about extending that opportunity.
Well, I can give you my view now. I think it should absolutely
I
be mandated.
know you will.
Given what we see around this place, it should absolutely be mandated. And my last question for you, Commissioner, is that the government has identified increased representation of First Nations peoples, gender equality, and disability employment in the APS as priorities in its October budget. And this is obviously a good thing. But do you think people from ethnically diverse backgrounds, and especially non-European backgrounds, should also be prioritized, given that their representation has remained either low and stagnant for more than a decade? I mean, from where I sit, I feel like this is a real missed opportunity here. I'd just like your opinion on that.
This is the area which we are passionate about in ensuring that we canvass broadly and advocate for representation and for inclusion and diversity issues that refer to people of color, as you mentioned. And I think it is remiss when there's opportunity that's been taken up, and we will in fact endeavor to alert or in fact make representation those organizations of the need to in fact provide for that sector, which is people from colored background.
Thanks very much, Commissioner Tan, and thank you for being here to answer my questions.
Very
really
smart.
appreciate that. Thanks, Chair.
Thank you, Senator. I'll give the call to Senator Scarr, and then I'll come to you, Senator Waters. Thank you.
If I can first ask some questions in relation to the Respect at Work and the bill that was passed earlier today, I think, in the House of Representatives. Hello, Commissioner Jenkins.
Kate Jenkins, Sex Discrimination Commissioner.
I wanted to ask you first a question about resourcing to implement the additional functions which the Australian Human Rights Commission are going to have under the bill which passed through the House of Representatives earlier today, as I understand it. And in answers to questions on notice, when this committee was conducting the inquiry into the bill, you provided some very helpful information with respect to the additional employees that would be taken on board by the Australian Human Rights Commission to discharge the following functions: the initial phase of implementation, which is to develop education and training materials and guidelines for employers, and then secondly, the subsequent phase of implementation to conduct the compliance assessments, issue compliance notices, reconsider compliance notices, negotiate enforceable undertakings, etc. And you provided a cost estimate for the implementation of those new commission functions of $500,000 in the 22-23 year and $1.8 million in subsequent years. I assume that's over the forward estimates. But how did you make your assessment of what additional resources the Human Rights Commission would require in order to discharge those new functions?
in coming up. And I think since that those estimates were given to you, the budget has since happened, and the actual funding was as you have described, except we received 400 in the 22-23 financial year. We, and I can provide you more detail on notice, but we assessed within the Commission what we estimated was required to put in place in terms of staffing, the appropriate education in the first instance, and then the forward projections of what we felt would be required in terms of both skills and people to put in place the enforceable undertakings and compliance regime with an ongoing education function as well. Having said that, we also know this is a new jurisdiction, and so we also will, I expect we will talk to the government as the jurisdiction unfolds to ensure that what we are resourced for matches the demand for our work.
Okay. And I'll just ask you two supplementary questions just in relation to that to perhaps tease out the issues. One of the messages I was left with going through the committee review inquiry into the bill was that different stakeholders, employers in different groups are really hungry to receive bespoke guidance with respect to how they can discharge the reasonable and proportionate positive duty, taking into account there are many workplaces, each workplace is different, and some of the workplaces have very complicated interactions between employer and their employees, potentially contractors, potentially customers, other stakeholders. Some of them are customer focused, everything from a public hospital through to a local pub to an IT company. Yes. There are so many different sorts of workplaces. The Housing Institute of Australia talked about residential construction work sites and the issues there. Are you looking to actually develop bespoke guidance for different types of workplaces to provide as much direction and assistance as possible?
We are very mindful of the different types and the different needs of employers. That was a really strong theme that came out of the national inquiry that resulted in the Respect at Work report, and in particular those small businesses. We definitely heard that large businesses had been putting in money and efforts, I determined, towards reactive rather than the proactive actions. Yep. But the small business really asked very outright that they didn't have the resources or the skills to be able to figure this out themselves. Yep. So we're not starting from a standing start, happily, because of both the community momentum and the government support. The Respect at Work Council has already started coming together. So Safe Work Australia has produced resources, Fair Work Commission and the Human Rights Commission has already started producing resources to better explain obligations, and particularly COSBOA has been actively involved in that and has been, particularly through their CEO Alexi Boyd, very active. So we've heard loud and clear that, and I know the new duty really recognises reasonable and proportionate measures, so that is very different for a local milk bar versus a large mining company. We've also this week released the Respect at Work .gov.au, or launched it. The Respect at Work Council, of which I'm chair, and the Commission has launched this new one-stop shop website, which is also very much tailored to starting or providing those resources. So we will build on all of those. Everyone is very much, as you know, Senator, from the inquiry, aware of the need for us to, all the different regulations to really come together and make it easy, clear and easy to comply from a workplace point of view, both to meet the law but also to just stop harassment.
Okay. Just my final question on that chain of questions, but I have some other questions just on the annual report, is I know from page 124 of the annual report that 123 of the employees are actually located, of the Human Rights Commission, are located in New South Wales, and presumably that's the main office is in Sydney. So the question I have is, given what you've said about engaging additional staff, how logistically are you going to assert your presence across the whole of Australia and the thousands and thousands of workplaces all across Australia? How's that going to work in practice so that your additional staff don't spend their entire lives on planes but are actually doing what they need to do?
So one of the benefits for many employers has been that COVID has enabled us to find ways to work with staff across the country. So whilst we have one main office that's in Sydney, as you might know, I live in Melbourne and I travel, but I also, as of sort of the 8th of March or around 2020, have done and found ways to work both by people meeting together and remotely. So I expect when we're looking at those teams going forward, we will draw from people in the Sydney area, but we will also draw from them nationally, and we will also make sure that we are doing outreach to make sure we reach out to ensure that we've got ways to reach all those parts of the country. I know from our work we're really aware that the experience in places like Western Australia and the Northern Territory is very different to metropolitan Melbourne.
Okay, thank you
Thank
very
you.
much. Can I keep going?
Well, if you have a short block, now is a good time to do it, and then
so-
I'll hand over the call.
Okay, so President, if I can ask you some questions just on the annual report. So I've been through the annual report and congratulations to the team who put that together. The first question I've got is in relation to the your overview, the year in review. There's a paragraph where in 4.1 you refer to the Commission undertaking substantial changes to strengthen our systems, procedures and operations over the entire financial year period. I'm wondering if you can just provide, or someone could provide, a high-level summary of what those changes were and why they are necessary.
Certainly, Senator. Emeritus Professor Rosalind Croucher, President of the Australian Human Rights Commission. Yes, Senator, we undertook some serious shifts in our financial management, internal accountabilities. I can call on our Chief Executive, Leanne Smith, to provide some specific detail in response to your question.
Thank you, Senator. Thank you, Senator. Leanne Smith, Chief Executive at the Australian Human Rights Commission. Following two independent reviews that have revealed both the causes of the Commission's financial situation, which we discussed at the last Senate estimates, and the resource requirements that the Commission has to function effectively, a number of initiatives or recommendations have been implemented. Initially, that involved freezing all recruitment and all non-essential expenditure. It was followed by a downsizing of the Commission through a formal change process that reduced our core staff from 123
So
to
Ms.
95.
Smith, sorry to interrupt, but we've got limited time, so maybe I wasn't precise enough. It's in particular, I'm interested in, say, the financial controls, the measures you implemented in order to track expenditure.
Yep.
So there were no surprises within the Commission with respect to, maybe we're running out of money.
Yep, sure. Some of the more specific examples of work that's happened since have involved the establishment of an internal budget steering committee, a project steering committee. We have a new audit and risk committee that's fully staffed by external members that oversees the work of both of those committees. We established a new governance framework, a new financial reporting tool that's provided to all cost centre managers to keep them tracking on their expenditure. We have a new budget management policy that is being rolled out with training now to all new staff. There are some examples of some of the measures we've put in place.
Excellent. And President, you're happy with the implementation of those measures from your perspective as the accountable authority in accountable person?
Yes, indeed. And particularly the tracking of cash, which was a key issue that was a problem before. The systems that Ms Smith has described have all been tracked very carefully through the measures that we've introduced since then.
Okay. There had to be, I've got two more quick questions just on the annual report. There had to be a restatement of last year's financial statements because there was a prior period error. I've read the description in the annual report and it's a very fulsome description, so I understand the reason for the restatement. Have you adjusted your mechanisms, internal procedures to ensure that sort of error doesn't occur again?
Absolutely. Again, I'll call on our Chief Executive to reply.
Thank you again. The changes that we've put into place since that prior period error was identified have come about partly through the role of the new Director of Corporate Services and the new Chief Financial Officer who are in place overseeing the finances. Two things we've undertaken. First, to ensure that we've reviewed our contract register to make sure that all liabilities are captured, especially for projects that run over a series of years. And the second thing we put in place is a new review process of all new agreements. That's for externally funded projects that the Commission signs on to make sure that the terms and conditions are clear in terms of expectations.
Okay. Now, my last question is relation to remuneration on page 114 of the annual report. Now, I think Commissioner Jenkins has done an outstanding job, and I'm trying to work out in the first column, it lists base salaries for the different commissioners, and there's a difference in the base salaries between, say, the Age Discrimination Commissioner, $349,676, and Ms Jenkins, $306,248. And I'm trying to work out why there's that difference in terms of base remuneration, because I would have thought the base remuneration for each of the commissioners would be the same.
I'll open on that, Senator, and then pass to Ms Smith.
Yep.
The base salary it's all determined by the Remuneration Tribunal. In the annual report, there is some element of leave that is factored into the reporting, but the salaries are all set by the Remuneration Tribunal. The base salary and the allowances are all subject to the independent analysis and determination by the Remuneration Tribunal.
But I thought the base, President, I thought the base salary for each commissioner was the same. I find it very odd that there'd be a difference between the Sex Discrimination Commissioner and the age.
There is. She's just sorry. The Senator might have missed your statement about leave being factored in.
There is as I've been advised, because I asked the same question, the determination is all set by the Remuneration Tribunal. The base salary for all of the commissioners, apart from myself, is the same. Some commissioners have an allowance for reunion travel that for some of our commissioners who are based outside Sydney. And that is all determined on an equal basis by the Remuneration Tribunal. There is a leave component that is factored into the amounts that are in the table, and there might have been one commissioner who was prorated for the year as well.
But is that factored into the base salary? Because there's a column that says other benefits and allowances, so I would have thought that would be considered in the other benefits and allowances?
It's our understanding, I mean, it's set by the REM Tribunal, but it's our understanding that the base salary for all commissioners is $370,160, and that the differential in that base salary column relates to annual leave. The other forms of leave are set out, but annual leave is not contained. But we could take that question on notice.
Leave not taken, do you mean?
As a liability.
You need a holiday? No.
Yes.
So the base salary is, the Remuneration Tribunal for each commissioner is how much?
$370,160.
All right, so I'm just, maybe take it on notice, I'm just struggling to work out why Commissioner Jenkins is down getting $306,248 in terms of base salary. That's a big difference between...
Senator, may we take the specific answer? I can assure you that the base salary is all the same. It's exactly as the REM Tribunal determines, and any adjustment as per the leave that I was advised, we will provide you on notice.
Because I can't believe Ms Jenkins has taken any leave over the last 3 years.
I don't think so.
I might be wrong, but...
Okay, thank you, Chair.
That's the problem. Senator Waters, you have the call.
Thanks very much, Chair. And my questions are for Commissioner Jenkins as well. Thank you for joining us in person here today. Senator Scarr raised some of the issues about the budget. So the $5.8 million allocation over 4 years and then the $1.8 for education and compliance around the positive duty. Can I ask how many systemic investigations, excuse me, and investigations of complaints regarding compliance with positive duty would you anticipate could be achieved each year with that amount of funding?
Could I take that on notice? We
Sure.
did go into significant thinking at the time that we worked with the Attorney General's Department on our estimate, but I don't have it before me.
Sure, that's fine. And I missed the very beginning, but I get the impression that that was an amount that you both sought and then received. Is that right? So that was the amount that you were hoping for?
So yes, we were funded for 3 functions, which was to provide a disclosure process, which is not ongoing, but then also the funding for the new positive duty, which includes the compliance function, and something that we've called the one-stop shop, which is the recommendation where we recommended there be a place that people who come to us about sexual harassment rights and remedies in one spot, and that would sit within the Commission.
And all of that comes out of the 5.8 over 4 years?
So that all comes out of the 10.5 over 4 years, and some of that is ongoing.
Okay,
for
thank
the ongoing
you.
functions.
Thank you. Do you have an amount of how many additional staff will be employed to assist with the compliance work related to the positive duty?
I can find that number. You mean in the first one? Can I please also provide that on notice?
Yes,
because we're having a bit of
absolutely.
a disagreement about it, so that means neither of us are clear.
Okay, thank you. And likewise, just whether or not your assessment is that that's an ample amount of staff to do that compliance work, and if there's any possibility for reviewing that as the obligations, as you start to undertake them, and form a view that perhaps you might need some more staff.
Yes,
after all.
Senator, I can tell you enough about that to say that it is the amount of staff that we project we will need.
Yes.
However, this is a new function.
Indeed.
And we are not really certain.
Yeah.
So we will work, as I understand it, with the Attorney General's Department on an ongoing basis to identify if that varies from what we've expected.
Okay, thank you. Now, the compliance provisions under the bill won't take effect for 12 months. What work is the Commission intending to do in that 12-month timeframe to prepare for a potential influx of complaints?
Our first function is to really quickly build on the education and the information sharing that we've already done, the engagement with employers, recognising that employers have 12 months, also recognising that many over the last year or two have really increased their focus on preventing sexual harassment. So the initial function on the positive duty work will be about educating and supporting employers to be able to meet that positive duty. In terms of the complaints, the positive duty is something where we will identify where we reasonably believe there is a breach before we undertake our compliance activities. I'll just make a comment, and our head of complaints is in the room, is that the sex discrimination and sexual harassment complaints have increased over the recent couple of years, and we view that as a positive development, that we think that the focus in the community of understanding the rights and the ability to bring a complaint forward has increased the focus and increased the demand for our services. And that isn't as a result of necessarily the new reforms, although the legislation that passed the House today and the legislation last year definitely has improved and strengthened the laws for people to bring complaints forward.
Yes, we're heading in the right direction, albeit slowly. From memory, the last statistic I can remember is that 1 in 3 people in the workplace experience sexual harassment, but only 17% of those proceeded to a court resolution or sought court determination. Can you tell me if there's a more recent figure, given that spike in actions relating to sex discrimination and sexual harassment? Do we have any updated figures on that?
Thank you, Senator. Your memory is absolutely spot on, so it gives me
Even
great
a broken
joy
clock
that you could
is correct
quote
twice
those
a day.
numbers straight back. And fortunately, there will be new statistics. We are right in the throes of finalising the next survey that I expect to release the results at the end of this month. So at that point in time, we'll be able to provide updated information. Okay, thank you. Senator, I have got a note passed to me that looks much more like what I remembered, which is we expect to get 10 full-time or FTE for implementing the positive duty overtime, and 5 to work in our information service to be what I've been calling the one-stop shop for providing people with information on sexual harassment.
Great. Now, the budget also allocates $2.6 million for 3 years for a fixed project to hear and confidentially document the experience of victims of historical workplace sexual harassment. I'm sorry to ask a staffing number question again, but will there be additional staff appointed for that work, or will that come from folk that are already on the books?
That's additional funding, but it's short-term funding over 3 financial years. It'll be 7 FTE for 2.25 years.
And are new folk?
There'll be new staff on non-ongoing contracts.
Okay, great. How will the project be promoted so that past victims can understand that there is an opportunity to share their story via the AHRC?
So we will, not that I have a favourite recommendation, but this is one of them. Recommendation 27 was about this disclosure process, the idea that not everybody wanted to bring a complaint, but the process of coming to the National Inquiry to tell their story. People over and over again said it was of great benefit to both tell the experience and know that it would be used towards something positive. So this is a short-term funded disclosure process. We will promote it far and wide, both through our normal channels, but given we have these 3 new functions and given the success of the growing awareness and the engagement of other agencies and the Respect at Work Council, we will be in whatever ways we feel is appropriate, in the same way that we promoted the National Inquiry to encourage people to come to us, that we will be doing promotion work as soon as we can to get that process up and going.
Will similar protections from FOI apply to disclosures made in the course of that project as occurred with Set the Standard?
I'll just give you what I expect to be the answer, and then we can check with our legal as well. So Set the Standard was quite unusual in that there were exemptions from the FOI process. The Commission is governed by secrecy provisions, so in the normal course we don't disclose information about certain of our functions, and we cannot disclose it. In addition, where we have had FOI applications for other pieces of sensitive work, generally there has been an ability or an exemption that has enabled us to keep personal information or make sure the information's de-identified. So in my period as Sex Discrimination Commissioner, whilst we definitely get FOI applications, the information we've been able to provide has not been disclosing anyone's personal information.
Okay, thank you. That's a comfort. And are you intending to produce a report at the end of that project, or what other outcomes are you anticipating that might flow from those disclosures?
Well, this is an opportunity for me to speak into the future to my successor, but the intention of that recommendation was both to provide that service for individuals to be able to share their stories, but also for the Commission to be able to do, as it has done in other pieces of work, to gather those stories to identify systemic issues and to share them externally. So what form that will take will be for others to decide. But yes, the intent is that the de-identified systemic and thematic information that we can get for that would be able to be shared externally, but also feed back into our positive duty function and other parts of the Commission's work.
And my maths has served me poorly because I thought we might see you for another estimates before your term expires. We do have one more. There you go. So I was going to farewell you at that point, but I'll hold off on the praise for now. Except obviously, widely regarded by I think everyone in this building as having done an outstanding job. So well done, and thank you for all of the women and all of the people who've benefited from the work that you've done. Just a few more questions, Chair, and then I'm finished. In relation to the sexual harassment survey that you do for secondary students' consent education, what's the status of that survey? And when might we see an update on that? There are so many surveys. You've got a fifth national survey of workplace harassment that I want to ask about as well, but I think that's what you just told me would be released by the end of the month.
That's right.
Yes, okay.
So the workplace sexual harassment survey, which is our fifth, is the end of the month.
Yes, okay. I'll come back to that one. What's the status of the Commission's survey of secondary students' consent education and the understanding and experience and nature and reporting of sexual harassment amongst secondary students?
Yes, I'm leading that with Commissioner Hollands, the National Children's Commissioner, and I believe she's online, so she could give that update if you would like, if it would assist.
I might finish up with her contribution, if you wouldn't mind waiting just 1 minute, Commissioner Hollands. That might make it a bit smoother transition. So just coming back to the fifth national survey for workplace harassment that we'll see at the end of the month. Have you got any sort of sneak peeks on whether we'll see any significant change from the fourth report to the fifth?
I have some sneak peeks
that you can share
can't
with us.
wait to share. It hasn't been finalised quite yet, so I'm not prepared to disclose, but I will be very keen to share some of those results at the National Press Club address that I'm giving on the 30th of November, and we will at that point be able to make public our report. But as I said, we're still drafting the report.
Okay. And does the Commission, just on family and domestic violence leave, which is another positive bill that the Parliament's just passed, does the Commission have any process for monitoring whether there is any increase in discrimination against employees who take family and domestic violence leave? That was something that we sought to address through amendments. Were not successful. Is there any sort of oversight that the Commission might have if that is a grounds for discrimination that women might experience?
I can answer that it's not currently. I know it's been considered in some of the state jurisdictions as a ground for discrimination. It is not currently on its own a ground of discrimination under the Sex Discrimination Act. However, we will, as we follow trends, it might be something that's raised under the Sex Discrimination Act, particularly as it's an issue that might affect people on the basis of their gender or marital status. And I'm confident that our complaints function and our head, Rachel Holt, who regularly keeps me informed of what are the trends and noticeable changes. So as we go forward, I'm sure that we can monitor that informally, but it wouldn't be the basis of a complaint explicitly.
Not yet. Yeah. Thank you. Thank you so much, Commissioner Jenkins. And Commissioner Hollands, thanks everyone for your patience. If you could just update us on that survey of secondary school students' consent education. If you can hear us,
Thanks,
okay.
Senator. Yes, can you hear me, Senator Waters?
We can, thank you.
Okay, thank you. Anne Hollands, National Children's Commissioner. Thank you very much for your question. This is a very large survey of secondary students that we will be commencing work on shortly. The funding was announced in the budget on the 25th of October. So we're currently waiting on a grant agreement from the Department of Education that we'll respond to, and it will proceed from there.
Do you have a time frame for finishing off that work?
Well, it's a very long, complicated process, and that's because we're dealing with, it will be running through the schools, through the state education department. We're working with the state education departments, but of course, within the education departments, there's the public education and Catholic education divisions, as well as independent schools. And we're going to have to negotiate with all of those various bodies. So we expect that by the time we've negotiated and co-designed the survey questions, that we won't be able to go out into the field until early 2024 at this stage. And that's to do with the school terms. Of course, we have to work within the school terms as well.
Okay. So I don't test anyone else's patience in the room, would you mind providing on notice just a little more detail about what you anticipate will be the length of the survey, how many participants you'll seek to include, and will there be a report, or what sort of actions will be taken once you collate the information from the survey? That'd be very helpful to the best of your ability.
We can certainly provide as much as we can at this stage, but the scoping of the survey itself hasn't been completed, so there will be a number of things I won't be able to provide just yet, but we can provide whatever we have to hand.
Much
Happy to do that.
appreciated. Thank you, and thank you, Chair.
Thank you, Senator. I just have one follow-up question, Commissioner, in relation to that survey, and then I'll hand over the call. Commissioner, have you put any thought into how you will talk about what consent means in different jurisdictions? Of course, I'm referring to the fact that there are different models of consent in different, well, I'm talking about the legal definitions of consent in different jurisdictions. And it sounds to me that you're anticipating this is a survey across the entire country.
That's correct. And that's one of the complications, Senator. It's exactly that there are many factors many variables that need to be attended to here. We are consulting very closely with all of the jurisdictions, but we are also going to be consulting with parents and indeed students themselves. So all of that work needs to be done to ensure that we are able to frame the survey in a way that is meaningful and achieves the purpose that it's set out to achieve.
Okay. All right. Thank you. I look forward to those questions on notice. Senator Price. Thank you.
Commissioner Hollands, I have a few questions. I wanted to understand what is the Commission doing to uphold the rights of Aboriginal children in remote communities to live lives free of violence and child sexual abuse?
Thank you for the question, Senator. And this is one of the, issues that's really deeply concerning to me and to all of us, of course. Unfortunately, the way that this role is funded, there is very limited capacity to deal with this or indeed many of the other issues that are affecting children and young people, particularly First Nations kids. For example, the disproportionate number of kids are removed from their families or who enter the youth justice system. So these are matters that really do require very serious attention. Unfortunately, with the resources that are available for this I'm not unable to fulfil those sorts of functions currently with the resources available.
Does the Commission recognise prioritise the human rights of a child to live a life free of violence and sexual abuse over the right for the child to live within its culture, even if that culture is dysfunctional and unable to uphold the human rights of a child?
Again, a very complex question, Senator, and what I've been trying to do, and I have visited some remote communities in the short time I've been in this role, and am working with, for example, the Northern Territory government on trying to assist them on some of these matters. I think what we really need to do is to review how we are trying to support kids and their families, whether the support systems are fit for purpose. And I think the feedback from kids and families themselves, as well as the evidence from many Royal Commissions and inquiries over past decades, is that indeed those service systems are not fit for purpose. So we've got a lot of work to do. But in direct answer to your question, safety has to come first. Obviously, safety first, but then I think we need to really look at how are we ensuring that kids are able to be kept safe and well within their families and communities with the right level of support around them. And currently, those supports are not fit for purpose.
Would the Commission agree that Indigenous children are being left in circumstances that are dysfunctional, that are leading to further traumatisation because of sexual abuse, based on the fact that those children are Indigenous and largely authorities are concerned with being regarded racist for removing those children?
Senator, I think you're asking me to give an opinion on something that I have not been able to investigate. So I don't have the facts to hand on this matter, but there are Royal Commissions, there's many Royal Commissions that have been held and many inquiries that certainly have expressed concerns about the safety of First Nations children.
What do you think, what is being done in terms of amplifying the voices of Indigenous children suffering sexual abuse?
Senator, I can't answer that question in terms of, I can't point to anything that's being done proactively other than there are calls for an Aboriginal and Torres Strait Islander Children's Commissioner to be able to work more closely with those communities. That is one call for a specific commissioner for those kids. But I think also it is the various efforts of the Indigenous leadership groups that are working on the national framework for protecting Australia's children. There are a number of initiatives as part of that are seeking to really transform the way that we try to keep those kids safe and well.
So, I mean, I can just, hearing your responses, it appears evident to me that Indigenous children have been treated differently and or left in circumstances that are dire for them, and clearly there needs to be more work done, and more immediately, I guess. Can you tell me how many children do you have knowledge of across Australia that have died from suspicious circumstances over the last decade, where there are current matters before the courts or that have been heard through the coroner and criminal court system?
I don't have that information to hand, Senator, but I could try to find out for you.
If you could take that on notice, that I would really appreciate that. And perhaps if there could be a breakdown between state and territories with regard to that information, that would be very helpful. Thank you.
Senator, we are due to have a break. If you have a further block of questions, we can come back. Or if you have a couple more
just a couple more questions for Commissioner Tan, if I can.
Look, if they're very quick, then we can get through them and get you out of here, but otherwise we'll have to come back.
Yeah, they'll be quick.
Okay. Commissioner Tan?
So, I'm here. I'm sorry, taking my jacket off. It's very warm here in Melbourne.
Good evening. Look, I will try to be quick, but I guess just a quick couple of questions. with regard to some of the responses that Senator Faruqi had earlier. I'm just interested to understand, am I at a disadvantage to my colleagues here because of the colour of my skin or my racial heritage?
Sarah, you might want to rephrase that. I don't quite understand.
Am I at a disadvantage because of my racial heritage in comparison to my colleagues here on this table?
Is that an issue you feel strongly about? Why should you be at disadvantage? The question can be equally posed to me because of my cultural heritage.
I'm just interested to know the idea that cultural training, if cultural training to be delivered within my workplace, does that put me at an advantage then because of the colour of my skin or my heritage?
So it's not meant to single out people for exemptions or to be exceptional. It is about protection and ensuring that we are all able to understand how to be able to deal and interact with people from different cultural backgrounds and appreciating their response.
Sorry, Commissioner, I can't.
Commissioner Tan, your audio is going in and out. I apologise. We might need to. I don't know if there's a way that you can have a look at that.
Maybe cut the video, it sometimes helps.
Yeah.
Maybe if you drop the video off, it sometimes opens up the data for the voice.
Show my face, but I sound better now.
No, it's still. Look,
Sorry
Senator. What I'm suggesting we do is go to the break that we were due to have at 9. We can come back and see if Commissioner Tan can fix that link for you. Thank you, Commissioner. The committee will suspend for a short break. We'll return with the Australian Human Rights Commission at 9:20. Oh, and apologies. We've had some further advice. We won't be requiring questions for the Commonwealth Ombudsman this evening. I thank those officials. Mr. Anderson and your team, thank you for waiting patiently. You won't be required this evening, but you might have some questions on notice. So thank you.
I'm going to ask about disadvantage because
Casting. We'll resume the hearing, Senators. Thank you. And Commissioner Tan, do we have you back there? We'll test your audio and see if we can't get a few more.
Can you hear me better, Chair?
We can. Senator Price, did you want to follow up your last couple of questions? And then I do have to hand over the call.
Yes, thank you very much. So I think my question was along the line of, should my colleagues undergo cross-cultural training? Will that put me at an advantage, considering supposedly I'm at a disadvantage because of the colour of my skin?
I understand your question, I get it, but it's never a question about advantage or disadvantage. It's not coming from a deficit position. It's about learning, respect for others, and being given the opportunity to learn, to understand how to be able to appreciate and respect other people from different cultures, but also about being able to interact with others. I mean, I personally have gained a lot in my work in the multicultural field in terms of understanding others who might have a different cultural background. So it is not a deficit, it's a positive thing to be able to learn to understand each other because of their cultural differences and to be able to appreciate and to be able to accept that.
And look, I couldn't agree more with regard to the idea of understanding. I was a cross-cultural educator for a couple of decades myself. I guess it's this idea of it being based on the shallow notion of skin colour that we hear a lot about in this workplace. And I guess going on then to the idea of cross-cultural training and delivery, what is the annual spend on cross-cultural training and delivery? And in a workplace like this, who would in fact deliver that?
I would like to be able to sit down with you, Senator, and to work that out because we don't currently have a plan or initiative to deal with that particular aspect within Parliament. But if you welcome me, I'm happy to sit down with you and work that through and say, this is what we need to do. and work through exactly what we need to spend on. But in terms of what's been spent, I can say that within the commission, we don't have a program for it. But there are many community groups and entities, corporate sectors that spend a lot of time and money in doing that within the organizations within community.
Very well, and I guess that concerns me as to where the line is drawn to creating an understanding of culture and politicisation of race, I guess.
It's a matter of balance, Senator, and we need to get it right.
That I can agree with you on. Okay, well, I guess that is all in terms of my line of questioning. Thank you, Commissioner Tan.
Thank you.
Thank you, Senator. Senator Shoebridge, have you got the last block of questions, I think, for this section?
Commissioner Gauntlet, thank you for your patient attendance today. Have we still got you?
Yes, thank you, Senator.
Yep. Late last week, a video was published by the Commission, I think marking 30 years since the Disability Discrimination Act became law. And in that, I think it was you stated that over those 3 decades, disability employment rate has pretty much stagnated, that only about a third of disabled people finish year 12, and many disabled people are living in poverty. And you quite rightly noted that reforms are needed to the Disability Discrimination Act. First of all, is that a sort of accurate summary of at least an element of the video?
Ben Gauntlet, Disability Discrimination Commissioner. Yes, it is, Senator.
Yeah. Well, look, thank you for the frankness of the communication. Often, anniversaries like that are kind of rah-rah events where achievements are noted. I think there clearly are some achievements with the Disability Discrimination Act, but given the nature of how much work there is to do, it really is a time to acknowledge rather than celebrate. Can you give detail about what those reforms are that are needed, you think, the key reforms to the Disability Discrimination Act?
Yes, Senator. So to give you another perhaps sobering statistic, 52% of all complaints made to the Australian Human Rights Commission are for disability discrimination. So when you consider the existence of the Age Discrimination Act, the Sex Discrimination Act, the Human Rights Commission Act and the Race Discrimination Act, that shows that there is a very significant issue. We do have some policy reforms coming out in the Free and Equal report, but we need to look at, first of all, our enforcement mechanism relating to people with disability. It is heroic for an individual with disability to have to bring a claim against a large multinational corporation in relation to disability discrimination. We also need to look at the efficacy of the 3 legislative instruments that sit underneath the Disability Discrimination Act, being the Disability Standards for Accessible Public Transportation, the Education Standards and the Premises Standards. We need to revise the Disability Discrimination Act to get rid of a decision or to change the application of a decision called Sklavos in the full Federal Court of Australia. And above all, we need to resource the advocacy sector and the Commission in relation to disability issues to ensure that people with disability are properly represented in policy settings, but also when they bring a claim, they're appropriately represented. And this applies not just in relation to the Australian Human Rights Commission, but also in areas such as the Administrative Appeals Tribunal and claims in that area where people with disability are often having to contest matters against well-briefed lawyers, and that can be very, very problematic for their human rights and how they're treated by society.
Commissioner, did you say 52%?
Yes, I did.
What is the staffing that you're given then to deal with 52% of complaints?
The Commission staff is that each Commissioner receives 1 Executive Assistant and 2 Policy Officers, one being APS 5 and EL2. Because of hiring freezes in the Disability Royal Commission, for the totality of my 3.5 years, I've averaged 1 Policy Officer to support me. To give you an idea of the workload, Senator, I do about 50 to 70 speeches per year. I've sat, I think, approximately 30 committees during that time, and I've chaired the Disability Employment Services Reference Group, the National Disability Data Asset Reference Group, chaired the Disability Advisory Council under the Australian Disability Strategy. I'm the expert advisor for the National Disability Insurance Scheme Independent Advisory Council.
Professor Croucher, how do you ensure that, given that volume of work going to the Disability Commissioner, and given the proportion of the claims going to the Disability Commissioner, what are you doing to ensure that there's adequate organisational resources to not break the Commissioner and actually to fairly reflect the caseload?
Thank you, Senator. I need to just clarify one thing. The Commissioners do not have any role in the complaints handling load. Commissioner Gauntlet was speaking of his work as the Disability Discrimination Commissioner. We have here the Senior Executive of the who heads our Investigation and Conciliation Service, who can give you some details of the particular people that we have that manage our complaints load. But they are very discrete functions, Senator, so I want to make sure that the picture is understood.
No.
Commissioner Gauntlet was speaking very well to the load he carries in his role, and each of the commissioners has as core staff the 3 people that Commissioner Gauntlet described. But the complaints handling, we can provide you lots of information on that if you'd like that as a separate question.
But surely the complaints handling, if 52% of complaints go to the Commission are in relation to disability, that should acknowledge the kind of resourcing that should go into the broader disability, the policy work, the advocacy work, the work that is essential for the Commissioner to do. Do you accept that there's a relationship between the two?
The same is true, I would say, Senator, for all of our statutory office holders, each of whom has a national responsibility, and their ability to discharge their work fully is limited by the team that we can provide them within our core funding. With respect to our complaints handling, we have teams that are dedicated to each of the streams within the Act. And as I mentioned, Ms Holt is with me tonight, and she could give you information about how she manages the load of those complaints across the various areas that we get.
Well, we may get to that if time permits. But talking about the budget, and I assume the commissioners are funded, the core funding that goes to each of the commissioners for the 3 staff, is it?
That's correct.
That comes out of the core budget?
That's correct.
But in the 2022-23 budget, I think I saw that more than $9 million of the income, about a third of the budget, is generated through the sales of goods and services.
Yes, Senator. If I may, I'd like to call on Ms Smith to provide you some of the breakdown of that. I can see there are other questions that are
we'll do it in
on your
pieces.
lips.
We'll do it in pieces. Thanks, Professor.
May I ask Ms Smith to respond to that?
Thank you, Senator. Yes, in this financial year, the Commission has brought in $9 million in what we've called own source revenue that's come through individual commissioners engaging in projects with other partners under the operation of an MOU or an agreement.
That's in effect a kind of almost consultancy role, is it, for the commissioners? They go out and provide their services to government agencies, Parliament, or other private entities. Is that what happens?
If I may speak for commissioners, and their feedback to me as Chief Executive is that to enable them to conduct programmatic or project work, they need to find partners to do that work with, because the core funding for the Commission at this point in time enables them to have 3 staff to attend to the kind of functions that Commissioner Gauntlet was speaking about.
So then if they're successful in getting that funding, they can expand their staffing?
That's correct, but as you'd be aware, if it's short-term project funding, then that's not an ongoing staff profile.
But, Professor, surely that puts a conflict in a body like the Commission. It surely puts a conflict because you're meant to be sort of above it, above the fray, above government, sometimes passing judgment on government agencies or private enterprise. But if at the same time you've got to be approaching them for contract work and for core income, that must make it awkward at times.
It certainly is a challenge and requires extraordinarily careful management in terms of judging what projects we will undertake. The contracts are very carefully calibrated, but the extent to which, in order to conduct those pieces of work, like Respect at Work, like Set the Standard, the quality of which has been testified throughout this evening on many other occasions, the ability to do that has been dependent on raising additional support to do those very worthy projects. And what it does, I think that the nub of your question is it does go to an element of independence, so that our commissioners, in order to undertake that significant extra project work, we are not able to do it, as Commissioner Gauntlet has said, we're not able to do it well within that small core team of resources, which has led to the additional projects. But they are monitored, I have to say. It's not, we don't take any project work on. It's very carefully considered.
No, I'm not suggesting it comes without checks and balances, but it does come with an inherent compromise, at least on one level, of the fundamental statutory independence. If you have to go out and seek other revenue streams with agencies or private entities, it does impact on that core statutory independence, doesn't it?
It can be seen to impact on the independence, absolutely, which is why we've advocated in the longer term to secure a greater possibility for the commissioners within their teams to be able to do more independent work.
Can you provide on notice sort of a breakdown of where that revenue is expected to come from, the $9 million?
Yes, the project revenue?
Yes.
Yes, absolutely.
And I think it was $6.5 million last year, and if you could do the same for last year?
Yes, I believe we may have provided some guidance on a question on notice last time, but I will make sure that we can certainly provide the breakdown of that. I'm sorry, Senator, I do appreciate that I've cut across Dr Gauntlet in his answering of questions, so I hope I have not interrupted your flow of questioning.
That's it. I took it to you, I think, Professor. That's all right. And Commissioner Gauntlet, in the disability space, is there the same opportunity, an equal opportunity, if you like, to go out and seek that kind of maybe corporate or government funding?
No, there is not the same opportunity to seek corporate funding. There are 4.4 million Australians living with disability and 2.65 million Australians are in caring roles. But within those statistics, the participation rate is 53% for people with disability in the workforce. So we're not talking about so much economic participation as we are often talking about far more important issues in relation to the humanity of individuals, such as the operation of the National Disability Insurance Scheme or the Royal Commission to Violence, Abuse, Neglect and Exploitation, and some of the issues that are dealt with that from, for example, a safeguarding perspective.
And Professor, do you see that a kind of lumpy kind of returns, or not all commissioners have an equal capacity to go out and generate that kind of revenue, notwithstanding the seriousness of the work they do or the community need for the work that they do, and the contracting indeed having to go out and seek that third-party funding, it doesn't fairly reflect on the different commissioners and their workloads.
That's certainly something we have to take on board. We have to prioritise our scarce resources, and there are some areas for which we couldn't possibly try to seek support because of the intrinsic nature of that sort of work. But I am very conscious all the time of ensuring at least that the commissioners have an equal core set of staff, and from there we have to work with them to see what additional resourcing we can provide.
Yeah, and that decision to provide that very, very modest staffing profile, that that's purely an internal decision. There's no guaranteed statutory funding to any of the commissioners. Is that right?
That's absolutely right.
Could I ask specifically then about, to move to a different aspect, the Attorney-General has said that the Commission's work in the LGBTQI plus space is being led by the Sex Discrimination Commissioner, Commissioner Jenkins. First of all, I'll ask you, while Commissioner Jenkins is coming forward, Professor, is that your understanding?
Yes. The amendments the SOGI amendments, as they're known, were amendments to the Sex Discrimination Act. So the portfolio under the Sex Discrimination Act and the Sex Discrimination Commissioner was expanded in response to those amendments in 2013. How we manage that work internally depends on various matters. While Commissioner Jenkins was finishing the landmark work that she was doing in Respect at Work, there was an important intersex project that I finished off that had been overseen by the Human Rights Commissioner, Ed Santo. So there's an ability to support that work across the portfolio because it is an important cross-sectional issue that is of great concern to the Commission.
Well, indeed, the most recent LGBTQI plus work that I'd been able to identify from the Commission was the Intersex Rights Project. I think that completed a year ago. And
yes.
And you correct. Well, obviously you're correct in this regard because you did it. You finished that work off.
I did.
Not Commissioner Jenkins?
No, because at the time Commissioner Jenkins was finishing the Respect at Work and then the Set the Standard report.
I'm not suggesting Commissioner Jenkins hasn't been busy. Don't get me wrong. That's not what I'm suggesting. But and I understand why you may have done that work. But is there any specific work related to that community at play at the moment in the Commission?
Thank you for the question. You have already asked questions about our resourcing. We did have a director who supported me as part of the downsizing or the redundancies that we had to implement due to our financial circumstances. That role was taken out of the system, and as has been discussed, for a range of reasons up until now, my core team has been a director and an executive assistant, and I haven't had a specialist advisor. So whilst I absolutely believe that portfolio is very important and the human rights in that area are crucial, my engagement has had to be through continuing my connection with communities and particularly in sport.
It's almost as though there should be a standalone LGBTQI plus commissioner, isn't it? Because you can't do it all, can you, Commissioner Jenkins?
So I think whether there's another commissioner for that or other areas is something that is for government, but I would confirm that to do that work properly and well, we need to be resourced for it, and at the moment we're not resourced for it.
When was that? I think there was your specialist advisor for sexual orientation, gender identity, expression and sex characteristics, is that right? When was that advisor position made redundant?
At the end of June, I understand.
June this year?
Yeah.
I don't have the date on me, but it was in the first quarter.
So it was...
April to June.
It was part of the restructure that we had to put in place, Senator.
And to be clear, I asked you about whether there are any, whether there's any outstanding specific work in relation to LGBTQI plus community, and I think the answer is no specific work in relation to that on foot at the moment.
That's right. There's no project work ongoing. We're, through Play by the Rules and through Pride in Sport, a member of that. We have maintained what we can. You might be aware I led a project looking at guidance on transgender athletes in sport. But other than that, it is just the voice that I have. But in terms of dedicated work that I would dearly love us to do, we are simply not resourced.
And that officer who was made redundant, was that the only dedicated officer?
That's right.
Professor, Do you find it troubling that given the human rights issues that community faces, the threats and the pressure they've been under, particularly in the last 5 years, that there's not a single identified staff officer for that community in the Commission?
The work indeed is of continued concern for us, as is the work across many areas, Senator, and the ability to undertake the work in specialist areas that cross across the whole Commission. While the Specialist Advisor was assisting the Sex Discrimination Commissioner in that portfolio, the issues cross across the whole Commission, as do issues of disability and other areas. And we'd love the capacity to be able to give more focus to work that is of such importance across the whole spectrum.
But as under-resourced as it is, and as impossible as the workload that Commissioner Gauntlet has, there is a Disability Commissioner and 3 staff associated to that. But there's not a single staff member, not one, for the LGBTIQA+ community, not one. How does that work out?
In the contraction that we had to undertake in the last financial year, that was one of the roles. It was not the only role. It was one of the roles that went in the restructure of the Commission. We would dearly like to be able to put such a specialist role back in, because it is an area that is of great concern to us, and it does cross across the whole of the portfolios.
Could I,
Senator Shoebridge, we
one
are
final question?
dramatically over time.
So it's just one final question.
Yeah.
I'm doing 4 senators' questions in one here. So
Sure.
could I? There's been multiple concerns raised, particularly about Don Dale Detention Centre, and the previous Royal Commission report would suggest, ongoing media reports would suggest, there are chronic and continued human rights breaches in that detention centre. Has it come? Is there any intention in the Commission to review Don Dale, given that despite the recommendation for the Royal Commission to shut it 6 years ago, it continues in place? And last time I checked, 100% of the kids there were First Nations kids.
It's the situation in Don Dale has been one that's been of acute interest to at least 3 of our commissioners who've spoken publicly about it on many occasions. It's not an area that we can initiate our own inquiry into, Senator. That's within the limitations of our Act. But we have three commissioners, Commissioner Oscar, Commissioner Hollands and Commissioner Finlay, who've come out on a number of occasions and voiced very clear concerns about the ongoing situations of youth detention centres nationally.
Are you saying you have a statutory prohibition to undertake an investigation of human rights breaches at Don Dale? Surely you could do it on a case basis, if not otherwise.
If we were to receive a human rights complaint related to a situation like that under one of the international treaties, we could potentially look at a human rights complaint of that kind. It's not within our legislative mandate to investigate a particular detention centre as such.
I was envisaging it happening through the casework and through a complaint work. Are you saying you have not received a complaint?
I would like to call up, I'm getting an indication we have not received a specific complaint about that. Obviously, in terms of the complaints matters, I have to be very circumspect. We can give some generic information about that.
Perhaps you might give any answers you can on notice about the advocacy that's been done in relation to youth detention centres, but perhaps with a focus on Don Dale.
Youth detention?
Yes. And then B, if there have been any individual complaints in relation to that facility.
Yes. Okay, to the extent that we can provide that information.
No, I understand. Thank you.
Thank you, Senator Shoebridge. There being no other questions, I want to thank the President and your Commissioners, and thank you for all the hard work that you are doing. We will be moving on now, and I call officers from the Australian Criminal Intelligence Commission and the Australian Institute of Criminology.
I'm going to get a glass. Is that your order? Did you want a fresh glass? Someone stole my glass earlier.
Yeah. Thank you very much. Thank you. Hello. Thank you very much. We've asked officers and agencies today to table opening statements. Have you had an opportunity to do that, Mr. Felon?
That's all right, Chair. I have no opening statement.
Thank you so much. I know that some senators do have questions. Senator Scarr, would you like?
I've only got a very short line of questioning, Mr. Phelan, but
Thank you.
You've been very, very patient. I've been watching you in the background, so thank you. Not too closely, but I was aware of your presence.
I always enjoy estimates.
So weird.
That sounds like a warrant.
No,
I was aware of your presence.
I didn't have Mr. Phelan under surveillance. I wanted to ask you about a speech which the Assistant Treasurer, Mr. Andrew Lee, gave as an opening address at the Australian Institute of Criminology conference. And he argued, and I just want to give you one quote from the speech, and I'm just interested in your perspective in relation to the point he was making. And he was talking about incarceration rates, and clearly all of us would prefer that there were less people in prison and we're spending less money on people in prison. But he made this comment. I'm interested in your views, given your background. I quote, "Stricter policing, tougher sentencing and more stringent bail laws appear to be the main drivers behind Australia's growing prison population," end quote. And I'm just wondering what your take is on that assessment and what other factors we need to consider in terms of this overall picture of incarceration rates and how we deal with the issue in a balanced way.
Michael Phelan, the Chief Executive Officer of the ACIC. I've probably made a habit over the last 38 years of not making comments in relation to decisions that are made by courts or indeed incarceration rates. It's difficult to say. I mean, from my perspective, this agency particularly deals with serious and organised crime, or the ACIC does. And one of the biggest drivers for serious and organised crime in this country is drugs. It is by far the biggest problem that's facing this country. And it's demand reduction strategies rather than some of the other strategies that are going to help us through this particular issue. So I wasn't actually at the particular conference I was at. The Deputy Director, Rick Brown, was of the AIC. He may have some particular comments in relation to incarceration rates. I mean, one of the things that we do, of course, is the annual deaths in custody report, where clearly, if you look at the data in that report, then clearly people of Indigenous background in our country are, whilst in custody, there is a less percentage of death in custody. They are well and truly overrepresented in custody, and therefore deaths in custody as well. Like, it's 8 times more likely than to die in custody as a percentage of the population than you are if you're a non-Indigenous person. We're only half as likely to have a death in custody if you're Indigenous as opposed to non-Indigenous. So clearly there the problem is the incarceration rate, not necessarily what happens inside prison. But I might hand over to Deputy Director Rick Brown, Dr. Rick Brown, if possible. Senator.
Senator Rick Brown, Deputy Director, Australian Institute of Criminology. Just to extend what the Director said, if you look at the rates of incarceration for Indigenous people, what we're observing over really the last 30 years is a deterioration of the situation. So back in 1981 to 82, 13% of the prison population were Indigenous, and that now stands at almost 32%. So really significant change over that period we've seen. As the director said, it is a complex area. It's a multifaceted issue that explains those differences. For example, just one example, some recent New South Wales Bureau of Crime Statistics research shows that recidivism rates over a 10-year period were 56% for non-Indigenous people that have been in prison compared to 86% for Indigenous people. So part of the issue there is return to imprisonment. The second, so there were two parts to the Assistant Minister's speech. The first part was actually the good news story that everyone seems to have missed, which is that actually crime has fallen tremendously in the last 20 years. And so really the speech was about juxtaposition between those two trends that were at odds.
Just sorry to interrupt, just in relation to that observation, that part of good news, in a Queensland context, and I'm Senator from Queensland, what we see in Queensland is that there are particular crime hotspots. So if you were to look at Queensland overall, you might well come to that view. But there are particular areas where there's stubborn crime rates, and no doubt it's a very complicated process. In terms of the analysis that's done, does it take into account geographical disparities in terms of crime rates?
Certainly, the individual state agencies such as Boxar in New South Wales and the Crime Statistics Agency in Victoria undertake those kinds of analysis at the LGA level, and there is a disparity between metropolitan and regional areas, absolutely. Yeah. I think that there has been larger declines in metropolitan areas compared to regional areas.
Yeah, and then, sorry, I interrupted you. You're going to give you're moving on to the second limb, the juxtaposition of the good news with the bad news.
I just want to give the good news side as well,
good.
if you like, which I say is the part that's always missed. And the Assistant Minister pointed out that armed robbery, homicide, property crimes like burglary and vehicle crime had all declined significantly in recent times. But I would also just point to one of the reasons for that, or the underlying change, is that it's a change in prevalence of offending. So what we saw over that decline was that fewer young people were committing crime rather than it being just about a general fall in incidence of crime. So actually, up to the age of, if you're tracking people through to the age of 20, what we found was that a smaller proportion of people are committing crime, and actually that decline has been larger for the Indigenous population than it has for the non-Indigenous population.
Has there been any research done in relation to what the drivers are for that?
Actually, this is an area of actually huge conjecture internationally. There's arguments that it's about. There's what's called the debut crime hypothesis, which says that.
Sorry, the which hypothesis?
Debut crime hypothesis, which says that some crimes like vehicle crime have fallen, and that's meant that vehicle crime being a debut crime, it's the sort of crime that people get into as one of their early crimes, because that's been harder to commit. Vehicle crime's been harder to commit. Young people haven't been getting into crime in the first instance. There's also a theory around just opportunity structures, that young people don't go out and play on the streets as they did in my day so much. My son's idea of playing was playing on the Xbox with his friends, so which meant that the opportunities to engage in crime on the streets are different for more recent generations than earlier generations. So there are a whole range of, actually it's an area of significant debate internationally, because these are trends that aren't just Australian, but actually across the Western world.
So is Australia out of step? Obviously, there's a huge issue in terms of the rates of incarceration of our Indigenous population. That's a lot of work has been done in that respect, and it's a huge issue. In terms of other trends, are they generally consistent with what's happening in equivalent jurisdictions?
On the whole, certainly in those major categories where we've seen reductions, they have been they've been relatively similar patterns that we can see in the US and the UK, New Zealand, and parts of Europe. One of the issues that is, we're grappling with here is around family domestic violence, and that's, talking about crime types that have fallen. This is a crime type where we're not seeing the same kinds of declines, although we are seeing declines in intimate partner homicide.
Okay. Thank you very much, Chair.
Thank you. Senator Shoebridge, do you have questions here?
I
Will
do.
you head off?
Thanks, Chair. My first question is to you, probably Mr. Phelan. I asked a question of the attorney on notice. The question was, is a former member of the ACIC currently being investigated for links to the, I think it's called, pronounced Nandretta Mafia Gang, Ndrangata. Yep, sorry. Nandragata, yes. So I'll start again. Is a former member of the ACIC currently being investigated for links to the Nandretta Mafia organisation?
I think, as we answered in one of the other committees, that is a matter for ACLI. So, I'm aware of the media reports.
But are they accurate? Is a former member of your organisation being investigated for links to that?
Being investigated?
Being investigated.
That is a matter for ACLI as to whether or not they are or not. I actually don't know the answer to that question as to whether or not they are currently being investigated or not.
Did your organisation have concerns about a now former member of your organisation having links to that mafia outlet?
No.
And have you had concerns raised with you since that individual left, that they had links to that mafia outlet?
Only what was in the Daily Telegraph.
So you're telling me the only information you've had about a potential investigation of a former senior member of your organisation for mafia links has come through the Daily Telegraph?
No, what I'm saying is that the components of the investigation that I'm aware of are not direct links to the mafia.
Well,
I'm being very circumspect here, Senator. I'm happy to help you, but I've still got privacy considerations for individuals to look after here. I can tell you that the activities that have been investigated by internally by my own organisation, others, I have no concerns in relation to the activity that was raised in the Daily Telegraph.
Well, the attorney said this in answer to the question. The Australian Criminal Intelligence Commission has contributed to an Australian Commission for Law Enforcement Integrity-led joint agency investigation into a former ACIC staff member for links to Italian organised crime.
Yeah, that's accurate.
Is that true? Have you contributed to the investigation?
Indeed, we have.
So there is an investigation. Is it in relation to a different mafia outlet?
No. You asked me whether or not it's still on foot. I am not aware of where ACLI is with their current investigation into the individual.
You must have seen a distinction in my question that I didn't hear when I asked it. So you're saying you know that there at least was an investigation, you're just not sure whether it's still current. Is that now your evidence?
And the component of the investigation that I'm aware of, which we did some internal work ourselves, is and working with ACLI, I have no concerns in relation to the allegations that were raised in the Daily Telegraph. And that's based on my 38 years of working in internal investigations and internal security and doing organised crime. There is, in my view, there was nothing there to see in terms of a risk to my organisation.
Has the individual who was investigated, have they left have they left your organisation?
They are no longer with the organisation.
Did they leave the organisation for reasons related to the investigation of them?
In relation to our components of our investigation, yes, but I don't know whether that covers components done by ACLE because I do not know 100% what ACLE are doing in their investigation. And that's rightfully so.
You can ask them soon if you like.
Yeah, I understand. Could I ask you about a number of constitutional cases that have been brought against your organisation?
Yes, certainly.
One of them is, it's got a Roman numeral, I think it's Roman numeral for 88, but it is CXXXVIII.
Okay, well, I don't know off the top of my head that one, but what are the circumstances, Senator?
Well,
It
that
might
was
trigger my memory.
There was a summons issued by your organisation. It was eventually challenged in the High Court.
On what basis, Senator?
On the basis that the statutory basis upon which the summons was issued, or the warrant was issued, was unconstitutional, and it was settled on the basis that the case was eventually withdrawn, but so too was the summons and or warrant.
Indeed, yes.
Was that because it was unconstitutional?
No, it's because we believe that well, it's not unconstitutional till the High Court says it is, but...
was it about to, and that's why the deal was done?
It was our view that the legal risks that existed with that particular matter warranted us withdrawing the summons.
So it was August 2020, the summons and the notice were both withdrawn, and the proceedings before the High Court were discontinued by consent. So
Indeed.
You were worried the High Court was going to rule against you and say cut a deal. Is that what happened?
Well, we've been continually litigated in this organisation well before I joined, and since 1984. We take every piece of litigation that is against the statutory powers of the organisation on their merits, and in some cases, matters have come before the High Court where we have discontinued that action, and the government of the day has sought to make legislative changes, which occurred in 2019. We had a set of amendments that were also as a result of a potential...
I'm asking you about this matter that was discontinued in August 2020. You don't have any independent recollection of it?
No, I know the case you're talking about, Senator.
Well, I put it to you again. Was a deal done to avoid a successful constitutional challenge?
Well, I don't know whether the challenge was going to be successful. I think I just said there was legal risk associated with it, and from time to time we make decisions as to whether or not we discontinue a summons or not, and on this particular case we withdrew the summons.
Did you pay costs?
I believe we did in that matter.
How much?
I'll take that on notice, Senator.
You did the same in X and Sage, didn't you? Pretty much exactly the same pattern in X and Sage.
I don't remember that particular case.
Well, X court-ordered pseudonym, summoned to attend an examination.
Yep.
In May of 2020, filed an application for judicial review, works its way through. Then you cut the same deal in X and Sage.
Yeah, there's been a lot of times where we've been litigated, Senator, and the purpose of our working with the government, both the current government and former government, is to maintain the coercive powers that sit within the organisation.
Even if they might be unconstitutional?
There are sometimes technical challenges to our legislation.
Constitutional challenges, not technical challenges.
Well, none of those challenges have got up on constitutional
Because you cut a
grounds so
deal
far.
each time.
No, I'm not saying that
You paid costs, pulled the notice, pulled
Senator
the summons, you cut a
Shoebridge.
deal every time.
Senator Shoebridge. Mr Felon is attempting to answer your questions. I assure you, if you ask them at a reasonable level or yell them, he will still give you the same answer.
Cut a deal every time.
Please
I
let
don't cut
him
deals,
answer the
Senator.
question.
Well, how many times have there been constitutional challenges in the last 3 years to the coercive powers of the organisation, and the result has been proceedings discontinued, but the summons, the notice, the coercive power pulled, and then you end up paying cost? How many times has that happened in just the last 3 years?
I'll have to take that on notice, Senator, but it's not too many because we've actually won more on constitutional challenges than we've lost, and more costs have been paid to us than we've lost, both on challenges in the full Court of the Federal Court and also at the Judge of First Instance. So we
D1
are...
and the Commonwealth,
Sorry?
ASQ 22, BGE 21. Those three more cases where it's happened?
I don't know the case references.
Well, can you take it on notice? D1 and the Commonwealth?
I can take them all on notice.
ASQ 22 is another pseudonym, and BGE 21.
Certainly, I'll take those on notice.
Were they discontinued by consent? Were there constitutional issues? And was the underpinning cause of the challenge, the notice, the warrant, the coercive powers, were they discontinued in those three cases?
I can take that on notice, Senator.
Did you pay and also did you pay costs in those cases, and if so, how much?
Oh, if we lost it, we would have paid costs, and if we would have discontinued, of course, we always pay our costs.
Normally, when a party discontinues, they pay the costs.
Yeah, that's what I said. If we discontinued it, we would pay the costs.
But they brought the challenge, and you still paid their costs when they discontinued. That's contrary to the ordinary arrangements.
Sometimes we don't always pay the costs.
Sometimes you don't always?
No. Sometimes when we win them, we pay the costs.
Sometimes when you lose them, you pay the costs.
Yeah, of course.
Senator Shoebridge, you've had a decent chunk of time, and other senators have questions for this organisation, and we have two more agencies to get to tonight. Have you got a couple of questions you can finish up on, and then I can hand over the call? Otherwise, we'll have to come back to you.
Well, I'll hand it over for the moment.
Okay. Senator White, you have the call.
Could you provide an overview of the work that the ACIC undertakes with respect to outlaw motorcycle gangs?
Yeah, thank you, Senator. Obviously, outlaw motorcycle gangs are one of the biggest issues facing our country from an organised crime perspective. We work very, very closely with our state and territory colleagues. We actually have a very specific reference that deals with outlaw motorcycle gangs. So we run what's called under the task force model inside the organisation, Task Force Morpheus, which is our attack on outlaw motorcycle gangs. We collate a lot of intelligence in relation to those individuals that are working in those gangs, and also provide a lot of that information for actionable intelligence to the states and territories and the AFP. It's important to put it in context, exactly what these people do. They are not just thugs riding around on their bikes. They are actually responsible for serious and organised crime at the highest echelons. In excess of billions of dollars worth of crime and harm that happens in our society. And they are one of the number one targets for us. We have specifically worked on the Comanchero gang to the extent that work with our state and territory colleagues to degrade them as best we possibly can, to make it very hard for them to operate in the current environment, where at the moment most of their leadership group is incarcerated or has left the country, and those that have left the country are ineffective to conduct their operations. So that is a major focus with us.
So how sensitive would you say these operations are?
They're very sensitive.
And how do you protect these operations and the intelligence you gain from them from compromise?
Well, most of the information is contained within our systems, and then products and reports that we write are appropriately security classified and then expected to be handled in that way.
So how regularly does the ACIC appear before the Joint Committee on Law Enforcement and Integrity?
Maybe 2 or 3 times a year, maybe 4 times a year perhaps.
And do you provide classified briefings to the committee?
We do.
And does that include classified or otherwise sensitive information on the ACIC's work against outlaw motorcycle gangs?
On occasions it does, yes, depending on the specific questions that are asked.
What kind of damage could be done to your work if that information was compromised by a member of that committee?
It does depend on what information was actually supplied to the committee at the time. Some of it's pretty granular, which has names and details and so on. We're very careful about things like informant information and so on like that. But certainly the information can be harmful in the wrong hands, depending on what it was we supplied at the time.
So as you'll be aware, Senator Thorpe has such a connection and served as a member of that committee. I don't wish to ask questions in relation to the work of the Joint Committee on Law Enforcement and Integrity, and that's rightly a matter for that committee, the Privileges Committee and the Senate itself. But do you have concerns about sensitive information potentially being compromised?
In a general sense or in that specific sense?
Both senses.
Generally, yes, I always have concerns about information, but ending in the wrong hands, given the sort of... In this specific case, though, we've done an assessment on the material and at this stage consider it to be low risk.
Thank you.
For the agency.
So you have reviewed your records of what sensitive information may be provided to that committee?
At the time, yes. At the relevant times, yes.
So do you think there is any risk that sensitive information has been compromised, or do you think not?
Well, there is some sensitive information there, but in terms of its risk to the operations, we assess that as being relatively low.
Right. Thank you.
Senator Shoebridge, I can come back to you with this witness. We do have 2 other agencies to get to by the end of the night.
No, that's okay. I'd largely rounded that out.
Oh, you finished with?
Yep. Okay. Oh, sorry. No, I did have one other question. That's just a reminder.
Take the chance, Senator Shoebridge.
Your evidence, Ms. Phelan, about organised crime was one of the, I think you said one of the principal concerns you have is unlawful supply of drugs. Is that right?
Oh, absolutely, yes.
Could I ask you, do you have any estimate of the size of that market?
Yeah, pretty good. So, for example, our biggest problem is meth, right? Yep. Where annually this country consumes 8.8 tonnes of pure meth a year, which at the retail level sells for about $7.8 billion in cash from mums and dads, uncles, aunts on the street.
What about other classes of drugs?
Yeah, sure. I've got that information here exactly for you. Bear with me a sec. It's just that I remember meth off the top of my head because it's the one that keeps me awake at night rather than any of the others.
So to speak.
10. Okay, so when it comes to cocaine, we roughly, and these are figures from 2021. We just haven't updated them from the latest wastewater report, but we have seen an increase in the latest wastewater report of increase in meth. A lot of the others have stayed stable.
So this is looking at the amount of residue of these drugs in the wastewater stream, then you extrapolate it out on a population basis.
That's right, yes.
And then you plug it into what you understand to be the retail price.
Yes.
Okay.
Based upon our intelligence figures that we put out, because we put out a national illicit drug report as well annually, that talks about the amount of the price at street level, wholesale level, and at ounce level, by jurisdiction, and at seizure data as well. So we've got a pretty good idea of how much it all costs. So if you're talking about cocaine, roughly 4.7 tonne of pure cocaine was used. So, if that comes in at 80%, then you're talking about just over 6 tonne of cocaine.
Yep.
At a cost at the retail level of 1.88 billion. MDMA, roughly 1.2 tonnes at $95 million worth. And heroin at just under a tonne, so at 984 kilos, with an estimated street value of just over $400 million.
And do you have an assessment on cannabis?
No, I don't.
Do you have any assessment about the size of that?
I think we might. I'm happy to take that one on notice. I just don't have it in my figures here because we've only been looking at cannabis for the last couple of years. You haven't got anything? No. So I'm happy to take that on notice and get all the information we do have for you.
If you track the street price of the drugs that you're aware of, have you noticed a measurable, sustainable decrease in the street price of any of those drugs over the last... I think we've had the wastewater thing going for 8 years.
No, because 5 years wastewater.
5 years.
Because the issue with our drug market in Australia is we are a massive net consumer of drugs, right? So, and it's basically controlled by a small group of individuals and networks in this country. So, for example, and it's all basically based offshore because 100% of heroin, 100% of cocaine, almost 100% of MDMA comes from offshore, and out of the meth that consumed, roughly 70% comes directly as manufactured product from overseas, and the other 30 that's domestically...
precursors.
Yeah, the other domestically produced, the precursors come from overseas. So everything has an overseas nexus.
So over the last 5 years, you haven't really seen an impact on street price?
No, because the market is so robust, right? The supply side is so elastic here that even when law enforcement make large seizures over a period of time, we see a short-term dip in the amount of usage, which is attributable to large seizures, which is great, but then it goes back up
Rapidly
again.
made up.
One of the things that we've been able to show that, how it works is there was one particular year, it's either 2018 or 19, I can't think off the top of my head, where seizures of cocaine, both domestically in Australia and offshore that were destined for Australia, so 100% we knew would come here, was over 8 tonne. Okay, now you add the 8 tonne to the 4.5 tonne that was consumed, there is no way we were going to consume 12 tonne of cocaine in Australia. Everybody would be walking around doped up. So it just goes to show how robust the market is.
So at the end of the day, all of the police activity, all of the expenditure on it, and given the nature of the market, and given I think you say that the robust nature of demand, what's the end
supply
of supply? Yeah. Well, and obviously it's fairly inelastic demand. What's the end result of all of the activities of law enforcement? Street price is the same, supply is the same. What's the end result?
I've been saying this for years and years and years. Anybody who's willing to listen, is that the market is so robust that the only thing that's going to stop the drug market and the harm in Australia is demand reduction strategies. We've got to stop people using it, is what we have to do, because the price is set. As we know, standard economics, supply and demand, right? And supply will always meet demand in this country. That's just how the system works.
Senator Shoebridge,
I'd love to have this
It's late
debate.
at night.
It's fantastic,
I feel like the both of you are not going to agree on this matter.
I
think we are agreeing on this one.
I don't think we were disagreeing.
Okay.
No.
I thought I'd agree with you too, Senator Green, but
I don't think you're reading the room, Chair.
Well, I'm just suggesting...
I think she is, Senator Shoebridge.
She might be reading the rest of the room. This is true.
I think she is.
I'm just suggesting whether there are further questions you could put on notice so we can get to the last two agencies. If this is a line of questioning you need to explore in the room, that's up to you. But
well, it is about, billions of dollars of law enforcement activity and the utility of it, which is kind of some of what budget estimates is about, Chair.
We do need the utility. Law enforcement's got to keep their foot on the throat of organised crime, though, because
of course, of organised crime, but the cocaine market, you seized roughly in a given year twice what the annual consumption is, but other than a short-term dip in supply, it basically went back to normal.
That's correct, for cocaine and meth, yeah.
And that would have been a, red letter year in terms of seizures.
It was, yep.
So I suppose, is the summary of your evidence is that this year you can go out and make huge drug seizures in each of these markets, but at the end of the year, when it all sort of washes through over the end of the financial year, street price will be the same, basic availability will be the same. That's the likely outcome.
Yes.
Okay.
okay, thank you, Senator Shoebridge. And yes, Senator Chisholm.
I was just going to, on indulgence, I was just going to acknowledge that this is Mr. Phelan's last appearance at Senate Estimates as he retires this week after a long and consequential career in law enforcement. I think we got a sense of his knowledge and experience here tonight. He's had an exceptional career at the AFP as the Chief Police Officer of the ACT and then Deputy Commissioner for National Security in the AFP. From November 2017, he has been the CEO of the Australian Criminal Intelligence Commission and Director of the Australian Institute of Criminology. And as CEO, he's provided exceptional leadership of the ACIC and contributed to efforts to disrupt criminal networks and driven intelligence gathering and emerging crime threats and methodologies. And he's been a critical contributor to national efforts to address serious and organised crime in Australia. On behalf of the government, I wanted to extend our thanks for your long and distinguished career in the public service and wish you all the best for the future.
Thank you very much.
Happy retirement.
Thank you. It's 25 years I've been coming to this place to give evidence. I'm going to miss it.
can always pop in
Why
for
are
a
you
hobby.
laughing? Why are you laughing?
You can always pop in for a hobby.
You can come back at 10:25 p.m. anytime, Mr. Phelan. Thank you very much for your evidence tonight, and thank you for your service.
Thank you.
I now call officers from the Office of Commonwealth Director of Public Prosecutions. You're the... He's doing on the side of his questions. You're the only side.
Won't be long.
No, it's fine. Thank you. Acting Director. We have asked agencies and officials to put their opening statements, to table their opening statements. Did you have an opportunity to do that if you did have one?
Thanks, Senator. I don't have an opening statement to tender.
Thank you so much. Senator Scarr, you have the call.
Thank you very much. Acting Director, are you aware of where the recruitment process is up to in terms of a permanent director?
That's a matter for the department and the attorney, and my position is under an instrument that operates until April of next year. So I'm anticipating that we would have a new director in place by then, but that's a matter for the attorney.
Okay, excellent. Thank you. You're aware of the matter involving Mr. Bernard Kalari and the exercise, or Kalari, and the exercise of the attorney's discretion under the Judiciary Act to decline to proceed with the matter?
Yes, Senator.
Did the CDPP, was the CDPP consulted with respect to the attorney's exercise of his power under Section 71 of the Judiciary Act?
No, Senator.
So, just to be clear for the record, the attorney did not seek the advice of the Commonwealth Director of Public Prosecutions with respect to his decision, the first time in Australia's legal history that the power under Section 71 of the Judiciary Act was exercised. The attorney did not seek the input of the Commonwealth Director of Public Prosecutions.
That's correct, Senator.
Okay, thank you. No further questions. Thank you.
Thank you. Short but sweet. Thank you, Acting Director. Thank you for your time, officials. Thanks for hanging around. Now, if there's no further questions, I call officers from the Australian Commission of Law Enforcement Integrity.
Sometimes it's good to be scheduled at 10:30.
Yeah. I should have had a defensive brief on that though. Anyway.
Exactly. Oh, that's the Kalari. There's no point asking.
No, that's fine. I think we've won there.
He asked the advice of the Attorney General. That's fine.
Thank you, Deputy Integrity Commissioner. We have a opening statement tabled from the Integrity Commissioner. Are you happy? Oh, sorry. I'm so sorry. I didn't see you there on the video conference.
That's great.
I apologise for that. Commissioner, we have asked officials and organisations to table their opening statement, and you've had a chance to do that. Is that okay if we can proceed with questions?
Thank you, Chair. Darla Hinchcliffe, Integrity Commissioner. Yes, that's fine. Thank you.
Lovely, thank you. Senator Scarr, you have the call.
Thank you very much, Chair, and welcome, Commissioner. It's good to see you again and see your team here. First question I have is in relation to the concept of serious or systemic corruption. And I've gone through the annual report for the year ending 30 June 2022, and I compliment everyone involved in putting that annual report together. I thought it was extremely useful, so thank you very much. I want to refer to Operation Denmark. I'm not sure why it's called Operation Denmark, but there might be a background to that, but put that to one side. If I can quote from page 23 of the annual report, the investigation identified that the staff member made 59 unauthorised transactions with their work-issued credit card for personal expenditures totalling $1,578. They pleaded guilty to one offence under the Criminal Code. The staff member was discharged without proceeding to conviction upon giving recognizance of $1,500 and being a good behaviour for 12 months. Commissioner, is that serious or systemic corruption?
Thanks, Senator. And I'd just like to start by thanking the committee for allowing me to appear by video link tonight. I'm just getting over an illness, which means that I have some COVID-like symptoms, though I don't have COVID, but under the protocols, I can't appear with you there today. So thank you for enabling me to go by video link. Senator, under my Act, the definition of serious corruption in Section 5 means corrupt conduct engaged in by a staff member of a law enforcement agency that could result in a staff member being charged with an offence punishable on conviction by a term of imprisonment for 12 months or more. The charges that were laid in relation to Operation Denmark were charges that met that definition. So yes, under the definitions of my Act, it falls within the definition of serious corruption. As we've discussed previously, both at the Joint Select Committee on the NAC bills and also at the PJC ACLI, that definition is a relatively low bar. We have matters that come to us that the initial allegation looks more serious than what ends up being the case once we've undertaken an investigation. And this matter probably falls within those cases. And I note that given that under my Act, I have a mandatory requirement to then refer matters which contain evidence of a criminal offence to the Commonwealth DPP. That is what happened in this case.
Okay, so under your Act at the moment, there's actually, you start an investigation, maybe you think it's more serious than what it is, you conduct the investigation and it comes to pass that the evidence is there to support preparation of brief to the Commonwealth Director of Public Prosecutions in relation to 59 unauthorised transactions, total expenditure of $1,578. And what you're saying is you're obliged, it's mandatory for you then to refer it to Commonwealth Director of Public Prosecutions.
That's right. Under Section 142 of my Act, it's a mandatory requirement for me where I have evidence of a criminal offence to refer it either to the AFP or to the CDPP. I've raised this previously that that's an unusual provision, that it's a mandatory provision rather than in the Commonwealth. It is more usual for investigation agencies to have a discretion whether or not they refer a matter to the CDPP, and then it's the CDPP's decision to decide whether to lay charges. And I note that in the NAC bills, that mandatory provision is no longer there.
So, Ms Chidgey, if I could ask you, just in relation to this scenario of this particular case of unauthorised transactions, under the NAC bill, as it's currently drafted, is this a matter that would come before the NAC?
Senator, I don't think I can comment on specific situation, but if the National Anti-Corruption Commission identifies what it thinks is criminal conduct, it's got the ability to provide a brief of evidence to the Commonwealth Director of Public Prosecutions.
So the concern is that this sort of activity in terms of, and let's take it back a step. Misuse of a Commonwealth credit card for personal gain at this sort of level is, say, under $10,000. Is that the sort of thing that would be referred to the NAC at all, or should it be really dealt with by the department internally and not take up the time of the NAC?
I'm not familiar with that particular matter, but the National Anti-Corruption Commission obviously has that threshold of serious or systemic corruption for its investigations. So it would depend on all the circumstances of a matter, but it would have to be the Commissioner's opinion that a corrupt conduct could be serious or systemic before conducting an investigation.
What's the threshold for serious under the NAC bill?
It's not further defined. The Commissioner would consider in all the circumstances whether he or she was of the view that it was serious.
So the NAC is not under the same constraint, as it were, that the Australian Commission for Law Enforcement Integrity, the Commissioner, is under the ACLI legislation in terms of the definition of serious, simply being you could be found guilty of an offence which could lead to imprisonment of up to 12 months or 12 months or greater.
That's right, Senator. That definition wouldn't be appropriate in the case of the National Anti-Corruption Commission because it can look into both criminal and non-criminal matters. So if clearly a definition that requires a criminal offence of a certain penalty wouldn't be appropriate in the context of the National Anti-Corruption Commission.
Okay. I just want to ask some questions, Commissioner, in relation to the corruption prevention activities of ACLI. Can you please give us an outline with respect to the performance of ACLI up to the year ending 30 June 2022 in relation to those prevention activities and how important they are in terms of the ACLI discharging its obligations?
Thank you, Senator. So I've said on numerous occasions that I think that the corruption prevention work that we do is really where we get the biggest bang for our buck. We will always spend resources on our investigations, and investigations is incredibly important work as well. But in an investigation, you get to see one particular matter or maybe a systemic matter. But in the prevention work, you get to look across, you get to look at what's happening more broadly, but also to be working with agencies in relation to what their vulnerabilities are and helping them to put controls in place in relation to those vulnerabilities. So hopefully we have to investigate something into the future because that has been prevented. We have a very small corruption prevention team at ACLI at the moment. As we start to expand to get ready for the NAC, that team is likely to grow slightly. Some of the work that we do in that corruption prevention space includes our quarterly corruption prevention community of practice work, which I get reports back from agencies regularly about how useful they find that forum as a place to come and talk about best practice, to talk about particular issues, to bring in some speakers from elsewhere to talk about the ways that other agencies are dealing with things. Another piece of work that we do through our corruption prevention is our corruption vulnerability brief. And in this, our corruption vulnerabilities brief for last financial year, I published for the first time because I'm of the view that the vulnerabilities that are contained in there apply more widely than just to my own agencies. I have 10 jurisdictional agencies, but I believe that there was useful information in there for across the Commonwealth. And so I published that and also sent it out to APS secretaries to help them to think about some of their corruption risks and vulnerabilities and start to control for those. We also provide a range of fact sheets on our website, which we also push out through our corruption prevention space. One of the things that we'll need to think about as we move into the NAC is the fact that the corruption prevention work that we do at the moment, which we get a lot of positive feedback in relation to, is quite intensive with the agencies that we work with. As I said, I've got 10 agencies in my jurisdiction. The NAC will have a significantly large number of agencies in their jurisdiction. And so we're working this year to think about different ways that we can still provide this great service, but provide it in a way that we can reach out to a significantly larger number of agencies than are currently within our jurisdiction.
So I noted that you undertook an inaugural biennial stakeholder survey for the first time, and I just want to quote one paragraph. I can't resist this opportunity, even though it is 10:40. And I quote, this is someone's comment in relation to Ackley, quote, "They are seen as a high-quality team player who aren't just there to kind of steamroll others, which is quite a beautiful thing when it comes to collaboration and consultation," end quote. There was no corruption involved in terms of eliciting that sort of response in your biennial survey, was there, Commissioner?
No, Senator. And it's to be really frank, it's a little bit scary as an agency head to decide to have a performance measure where you're going to survey the agencies that you oversight to see whether or not you are providing a service that's timely and that is hitting the mark, particularly when then what you are doing is investigating corruption within those agencies. And what I was really pleased to see in relation to this survey is that ACLI is noted for their professionalism and is noted for their ability, for our ability as corruption specialists. There's clearly some work for us to do in relation to timeliness, and that's been an issue that we've been discussing. I've been discussing with this committee and with the PJC ACLI over my time as Integrity Commissioner. We've put a number of things in place to deal with that, and we're particularly thinking about some of those issues going into the NAC to make sure that we are ready when the NAC is established to be able to deal with the higher throughput of matters, particularly in that intake and assessment space for us, and making sure that we've got our processes right to be able to deal with what I suspect will be a large number of matters that will come in through that front door.
And just in relation, my final question, just in relation to that timeliness issue, that was the issue, the feedback which warranted attention from that survey. And I know ACLI has made considerable improvements in terms of processing those initial referrals and engaging in that early triage process, and that's been a great positive. What further steps can you... Is there a disconnect between people's perceptions as to how quickly you can actually engage in investigations? Is there education needed in that regard? Because some matters are quite complicated, presumably, and just of necessity require some time. So is it more the issue of perception rather than the reality, or is it a bit of both?
I think, to be frank, it's a bit of both. There's been a backlog of investigation reports that we have had to finalise. So some of our agencies have seen has been investigations that have seemed to have taken a long time because it's taken us a long time to get to the investigation report. We're nearly through those now, but that's been an issue that's affected our timeliness. But you're right in that sense that there are some investigations that will just take a long time because of their very nature, and we're quite clear about that. But there's some more work I think that we can do in terms of making sure that agencies are aware of where those matters are up to. We've done a lot of work in that space already, but we're using this survey as a bit more feedback to make sure that agencies understand where those matters are up to, and understand what the rest of the process looks like.
Thank you very much, Commissioner. And if I can take this opportunity just to thank you for the service you've provided as Commissioner. I think it's been absolutely outstanding, and I commend you and I commend your team who are going through this time of flux and haven't missed a step in terms of carrying out and discharging their role. So thank you, Chair.
Thank you, Senator Scarr. I just have one last question for this evening, Commissioner. And thank you for that information about the role in terms of education, corruption prevention and education. I just have a question about the issuing of warrants. How does ACLI currently access warrants for use in investigations? And I'm particularly asking about warrants for access to telecommunication information and the use of surveillance devices.
Thank you, Chair. We are an agency that has access to powers under the Telecommunication Steps and Access Act, both in relation to telecommunication intercepts, telecommunications data and stored communications, and we are also an agency that has access to surveillance device warrants. The way that we access those is exactly the same way that any other agency that has access to those powers. Where it is a warrant that is issued by an issuing officer, then the legislation will tell us who those issuing officers are, and then we go to the list of people who are able to issue those warrants and make an appointment and go before them to apply for those warrants. So in relation to those warrants that you have raised, both in relation to that have eligible judges and AAT members operating in their personal capacity, not in their judicial capacity, then we appear before them to apply for those warrants.
And do you have any concerns about the current arrangements or the current procedures? Are there's anything around that process that you've just explained to me that you see as an issue or a current concern?
No, not in terms of who the issuing officers are. That works. That works the same for us as it works for everyone else. I think there's a broader conversation that's being had in relation to the electronic surveillance review, the electronic review work that's happening through the Attorney General's Department, and what came through the Richardson review was really in relation to all of those different regimes and the differences between them and the age, and that they're not technologically neutral at the moment. I would agree with all of those comments and see the need for the work that's going on at the moment in terms of refining those regimes. But I think the issue that you're getting to is in relation to the issuing officers. I'm not aware of there being any issues in relation to that. I have Mr. Ratcliffe at the table. I'll just, who is the Executive Director of one of my operations branch, I'll just ask him quickly from a operational perspective, Mr. Ratcliffe, was there anything you wanted to add to that?
Peter Ratcliffe, Executive Director, Operations. Nothing much to add. We find the process to be timely. We can get the warrants when we need them. And also we find clearly that the process is extremely thorough and we are tested on our cases in a most appropriate way.
But the review that occurred, I think, started or may have been the report given to government in 2018, the Richardson review. That's ongoing work that is, needed or being participated in by your organisation. Is that right?
Yeah, and we have a specific team who work alongside the investigations teams to ensure that as those reforms happen, our standing operating procedures are updated appropriately, and that we're able to use the new powers in the same way that we would have used the old ones.
Fantastic. Thank you, Commissioner. I don't think there's any other questions, and I want to thank you for joining us tonight, even though you are a little under the weather. It's a valiant effort late at night, so thank you very much, and thank you for the work that you do. That concludes today's proceedings, and I thank the Minister and the departmental officers for their attendance, Hansard Broadcasting, and of course our wonderful Secretariat staff. I'll just move a motion to accept all tabled documents received during the day. That's accepted. Senators are reminded that written questions on notice should be provided to the Secretariat by 5 p.m. Friday the 18th of November 2022. The hearing is now adjourned and we'll be back here tomorrow, 9 a.m.